Preamble of the Indian Constitution. Preamble is an introductory statement, that is, it is the summary or essence of the Constitution. So it declares the philosophy, objectives and core values of the Constitution, acting as a key to the mind of the framers of the Constitution and serves as a guiding light for interpreting the Constitution. So meaning and significance: guiding light. It acts as a key to the mind of the framers and serves as a guiding light for interpreting the Constitution. Is the preamble an integral part of the Constitution? Yes, the preamble is an integral part of the Constitution as ruled by the Supreme Court in Keshavananda Bharati case. That is Keshavananda Bharati versus State of Kerala in 1973. And though the preamble is not justiciable, non-justiciable, that is, it cannot be enforced in the court of law. Voice of the people. It reflects the aspirations of the people. The text of the preamble, it starts with "We, the people of India," so, and embodies the basic philosophy of the Constitution. Historical background, that is objective resolution. The precedent to the preamble is the objective resolution. That is, the ideals of the preamble are derived from the Jawaharlal Nehru's objectives resolution, that is drafted and moved by him in the Constituent Assembly on 13th December 1946 and adopted on 22nd January 1947. This resolution laid the foundation for a sovereign democratic republic committed to justice, liberty, equality and fraternity. So the key dates are: the objectives resolution drafted and moved by Nehru was drafted and moved by Nehru in Constituent Assembly on 13 December 1976 and adopted on 22nd January 1947. So, four key components of the preamble, that is source of authority, nature of the Indian state, objectives and the date of adoption. So, source of authority, that is the text of itself, text of the preamble itself reveals that source of authority is the people, that is, it starts with "We, the people of India." So, popular sovereignty, that is, in a democracy, the people are sovereign. And nature of the Indian state, that is, sovereign, socialist, secular, democratic republic. The words socialist and secular were added by 42nd Constitutional Amendment Act 1976 along with the word integrity. So, the objectives, that is justice, liberty, equality and fraternity. Justice, socio-economic political justice, liberty of thought, expression, belief, faith and worship, equality of status and opportunity and to promote among them all, status and opportunity and to promote among them all, and fraternity, that is dignity of the individual and unity and integrity of the nation. Date of the adoption: the Constitution was adopted, enacted and given to us ourselves on 26th November 1949. So, the four key components of the preamble are the source of authority, nature of the Indian state, objectives and date of adoption. And the preamble does not mention the date the Constitution came into force, that is 26 January 1950. The Constitution was adopted on 26 November 1949 and it came into force on 26 January 1950. The preamble does not mention the date of the Constitution came into force. The key words and their meaning: sovereign, that is India is independent, free from external control, that is both within, that is no one can dictate terms to India, that is India is independent and free from external control. Socialist, added by 42nd Amendment Act 1976, that is democratic socialism, welfare state and social justice. Secular, added by 42nd Constitutional Amendment Act, that is the state does not have any religion. That state has no official religion and equal respect. No official religion and equal respect for all religions. Democratic, that is the government by the people through universal adult franchise. That is Article 326. So, the democratic and republic. Republic is head of the state, the president is the president. That is, head of the state in India is elected, that is president, by an electoral college, okay, indirectly elected for a period of 5 years, and it is not hereditary. And democratic, by the people, for the people, of the people. So, government by the people through universal adult franchise, that is periodic elections. Universal adult franchise, that is every citizen who is registered in the electoral rolls and above 18, who is registered in the electoral rolls, who is above 18 years, can cast his vote. Universal adult franchise. Justice, liberty, equality and fraternity are the core objectives inspired by the French Revolution and India's freedom struggle. So these are the key words and their meanings, that is sovereign, socialist, secular, democratic, republic. That is, nature of the Indian state is sovereign, socialist, secular, democratic, republic. So first, constitution with a preamble. The American Constitution, or the Constitution, American Constitution, that is was the first constitution to have a preamble, and India followed this practice of American Constitution. So American Constitution 1787 was the first to have a preamble, and India followed this practice. The key themes: aid to interpretation, that is the preambles, the role of the preamble as an aid to interpretation of the Constitution. That is, the preamble helps the, who is the final interpreter of the Constitution? Supreme Court is the final interpreter of the Constitution. Though the preamble helps in interpreting the Constitution. If the preamble gives effect to any provisions of the any law, or any law gives effect to any provisions in the preamble, then that law will be upheld by the Supreme Court. So, it aids in interpreting, that is the preamble, the role of the preamble as an aid to interpretation of the Constitution. Democratic and social ethos, significance in shaping India's democratic, social and economic ethos. And basic structure doctrine, relationship with the basic structure doctrine, that is Keshavananda Bharati case 1973, and the preamble is a basic structure of the Constitution. And governance and judicial review, how the preamble guides governance, legislation and judicial review. That is, the provisions in the preamble, they guide the governance, legislation and judicial review. So, the Supreme Court, current affairs. Supreme Court upholds socialist and secular, November 2024. So, the Supreme Court, there were petitions filed in the Supreme Court challenging the word socialist and secular in the preamble added by the 42nd Constitutional Amendment Act 1976. So, the Supreme Court has dismissed the petitions challenging the insertion of these two words by the 42nd Amendment. The court held that the Constitution is a living document and the Parliament's power under Article 368, that is the power to amend the Constitution, extends to the preamble. So, the Parliament can amend the Constitution, and the procedure to amend the Constitution is mentioned in the Constitution itself, Article 368. So, with the constituent power, that is the power of the Parliament to amend the Constitution, the Parliament has amended the preamble. So, the Supreme Court has dismissed the petitions challenging the insertion of these words by 42nd Constitutional Amendment Act. The court held that the Constitution is a living document and the Parliament's power under Article 368, that is to amend the Constitution, extends to the preamble. It clarified that These terms have gained widespread acceptance and they do not restrict elected governments' policy choices as long as they do not violate the fundamental rights or basic structure. So, these the word insertion of the word socialist and secular in the preamble, they have gained wider acceptance and they do not restrict the government's policy options as long as they do not violate the fundamental rights and basic structure. Supreme Court invokes preamble for secularism 2025. That is, in a case concerning the inauguration of Mysuru Dasara, the Supreme Court reminded that the preamble enshrines secularism, liberty of thought and faith, equality, fraternity as cardinal principles of national unity. The court rejected attempts to exclude individuals on religious grounds from state events, reinforcing that secularism is a part of the basic structure of the Constitution. That is, the court rejected any attempts to exclude individuals on religious grounds from state events. So, reinforcing secularism is a part of the basic structure of the Constitution. Key principle affirmed, that is, secularism is part of the basic structure of the Constitution and cannot be violated by the state action. Initiatives on Preamble 2024-26. Several state governments, including Karnataka, have emphasized teaching Preamble to school students as a part of their curriculum. Preamble to school students as a part of the curriculum to instill constitutional values. This initiative aims to build awareness of the constitutional values among the next generation of citizens. So, many state governments have taken initiative teaching the preamble to students to instill constitutional values. So, this initiative aims to build awareness of constitutional values among the next generation of citizens. Why the preamble matters? Philosophy and objectives. The preamble, it declares the philosophy, objectives and core values of the Constitution. Popular sovereignty, we the people of India. The text of the preamble starts with we the people of India, the ultimate source of the constitutional authority. Justice, liberty, equality and fraternity, that is the core objectives inspired by the French Revolution and India's freedom struggle. Living document, that is upheld by the Supreme Court as a living document, that is integral and it is a evolving part of the Constitution. So, our Constitution is a living document and it is evolving, and it is clearly evident by the number of amendments that have been made to the Constitution. So, the Supreme Court has upheld it as an integral part, that is, the preamble is an integral part of the Constitution and it is an evolving part of the Constitution. Basic structure doctrine. So, the basic structure, the ultimate safeguard, the basic structure doctrine, the ultimate safeguard for the identity and soul of the Constitution, a judicially evolved principle that defines, it is a judicially evolved principle, that is, it is a judicial innovation that defines the limits of the Parliament's amending power. The Parliament amending, can the Parliament amend the Constitution? Yes. The procedure to amend the Constitution is mentioned in the Constitution, Article 368. And is it unlimited? No, it is limited. By what? Basic structure of the Constitution. So, what is basic structure of the Constitution? It is a judicial innovation. It is a judicial evolved principle. So, what is basic structure doctrine? The basic structure doctrine is judicially evolved principle that serves as an ultimate safeguard for the identity and soul of the Indian Constitution. It limits the Parliament's amending power. It limits the Parliament's amending power under Article 368 and prevents any amendment that alters or destroys the Constitution's essential features. That is, there are certain core features of the Constitution, core principles, core values of the Constitution, which cannot be amended by the Parliament. So it prevents any amendment that alters or destroys the Constitution's essential features. So, meaning the doctrine holds that while the Parliament can amend any part of the Constitution, including the fundamental rights, it cannot change or alter the basic structure of the Constitution, and any such amendment is liable to be struck down by the Supreme Court through judicial review, Article 13, Article 32. Judicial review is what? Judicial review is the judicial scrutiny of legislative enactments and executive actions. If they are not according to the provisions of the Constitution, they can be declared null and void. So, Parliament's amending power. The Parliament has wide but not unlimited amending power. Means what? It has limited amending power. The permanent core, the Constitution has a permanent core, that is the core values that even the constitutional amendments cannot erase. So the Parliament can amend the Constitution, but it cannot alter or destroy, change the permanent core values, that is nothing but basic structure of the Constitution. In essence, the Parliament has wide but not unlimited amending power. The Constitution has a permanent core that even constitutional amendments cannot erase. So, origin and evolution of the basic structure doctrine. Keshavananda Bharati versus State of Kerala in 1973 established a 13-judge constitutional bench, judge decision bench, and it ruled 7:6 majority. This landmark case has introduced the doctrine and overruled the earlier positions on unlimited parliamentary amending power. So earlier, before Keshavananda Bharati case, 1973, the power to amend the constitution, that is the constituent power of the parliament, was unlimited. But by the Keshavananda Bharati case 1973, it is now limited. Limited by what? Basic structure of the constitution. So, 2023, 50th anniversary of the judgment of Keshavananda Bharati case 1973, limiting the parliamentary amending power. So, it marks 50th anniversary of this historic judgment, widely celebrated as a cornerstone of constitutional democracy in India. Minerva Mills versus Union of India case 1980, the doctrine further strengthened and clarified this landmark case. That is, it upheld the Minerva Mills versus Union of India case 1980. It upheld the Keshavananda Bharati case 1973. The Supreme Court has deliberately, so what actually constitutes basic structure of the Constitution? Did the Supreme Court give an exhaustive list? No. The Supreme Court deliberately has not provided an exhaustive list of the basic feature. It examines the amendments on case-to-case basis. That is, it scrutinizes the legislative enactments on case-to-case basis, allowing flexibility while protecting the core values. So, the exhaustive list of basic structure is not provided by the Supreme Court. So, basic structure concept is also evolving. That is, the Supreme Court in its various judgment is giving various judgment. The exhaustive list of the basic structure of the Constitution is being created on the basis of the various judgments of the Supreme Court. So, present judicial position. The Parliament, can it amend? Yes, the Parliament can amend any provision under Article 368, but it must not damage or destroy the basic structure. So, key elements of the basic structure. The key elements, exhaustive list is not given by the Supreme Court, but the Supreme Court in various judgments has given the basic structure. So, recognized across various Supreme Court judgments, the list is illustrative and it is evolving. This is not an exhaustive list. So, it is illustrative and it is evolving. So supremacy of the constitution, basic structure of the constitution, sovereign, democratic and republic nature of the Indian polity is also basic structure of the constitution. Secular character of the constitution, federal character of the constitution, federal, that is the division of powers between center and states, separation of powers between legislature, executive and judiciary, unity and integrity of the nation, welfare state and socio-economic justice embodied in the directive principles of the state policy. Judicial review itself is the basic structure of the constitution. Rule of law, independence of judiciary, freedom and dignity of the individual, principle of equality, free and fair elections, harmony and balance between fundamental rights and directive principles of the state policy, limited amending power of the parliament, and effective access to justice, and powers of the Supreme Court under Article 32, 136, 141 and 142. Article 36 is judicial review. Article 136 is special leave for appeal, and Article 141 that is judgments of the Supreme Court, that is law declared by the Supreme Court, is binding on all courts within the territory of India. And Article 142, that is complete justice, that is the Constitution grants the Supreme Court the Constitution grants the Supreme Court the plenary power to pass any decree or order necessary for complete justice in any pending case, ensuring justice prevails over strict procedural laws. And Article 226 and Article 227, that is the power of the High Court to grant writs, to issue writs, and Article 226 handles the original jurisdiction of the High Court. So it grants High Court supervisory powers over all courts and tribunals throughout their jurisdiction. So these are the key elements of the basic structure of the Constitution. This list is illustrative only, not exhaustive, and it is evolving. That is the Supreme Court. That is the Supreme Court. In various judgments, it is pronouncing the key elements of basic structure of the Constitution. So, role of Minerva Mills case 1980. The Indian Constitution is founded on the bedrock of the balance between Part 3, Article 12 to 35, Fundamental Rights, Part 4, Directive Principles of the State Policy, Article 36 to 51. This harmony and balance between fundamental rights and directive principles of the state policy is itself a basic feature of the Constitution. So, the Supreme Court in Minerva Mills case has ruled that the fundamental rights and directive principles of the state policy, that is the balance between fundamental rights and directive principles of the state policy, is itself the basic structure of the Constitution. In Minerva Mills versus Union of India 1980, the Supreme Court has struck down parts of 42nd Constitutional Amendment Act 1976 and held the above key rulings were, that is, amending fundamental rights. Directive principles can be implemented by amending fundamental rights, but such changes must not damage the basic structure. So, the key rulings in Minerva Mills case, which struck down some parts of the 42nd Constitutional Amendment Act 1976, that is amending fundamental rights. So, directive principles of the state policy can be implemented by amending the fundamental rights, but such changes should not damage the basic structure. Absolute primacy rejected, that is giving absolute primacy to directive principles of the state policy over the fundamental rights. It violates the basic structure, and harmony between fundamental rights and directive principles of the state policy is the core. That is, the division or absolute conflict between fundamental rights and directive principles of the state policy is not part of the basic structure and their harmony is part of the basic structure. This case reinforced that social reform through directive principles of the state policy is valid only if it respects the constitutional core balance. So, current affairs 2025-26, active invocation, that is the doctrine continues to be actively invoked by the Supreme Court and examine the constitutional amendments and executive actions. EWS reservation, in EWS reservation, that is Janhit Abhiyan case 2025, the Supreme Court referred to the basic structure in discussions on 1 or 3rd Constitutional Amendment Act relating to EWS. The judges examined whether economic criteria based reservation violated the principle of equality. So, economic criteria based reservation violated the principle of equality. The court upheld the amendment while reaffirming that affirmative action, that is reservations, must align with the constitutional goals of an egalitarian social economic order, that is equality in the society. Presidential reference, December 2025, a presidential reference on the powers of the president and governor under Article 200 and 201 regarding the regarding bill assent, that is regarding giving assent to a bill, led to the Supreme Court observation on separation of powers, federalism and judicial review. All separation of powers, federalism and judicial review, all core elements of the basic structure. The court emphasized that the constitutional design must prevail over delays and inaction that could undermine the federalism. So, ongoing relevance 2026, the doctrine remains a key tool against attempts to limit judicial review or independence of the judiciary. It has been cited in debates in federalism, gubernatorial overreach, that is the governor, he is exceeding his authority, acting as an agent of the center against the elected state governments, and judicial appointments. Legal scholars and judgments continue to describe it as India's pride and world's envy for protecting constitutional democracy against majoritarian excess while allowing evolution. So, fundamental rights availability. Next, fundamental rights availability, that is to citizens and foreigners. So, whether the fundamental rights are available to only citizens or whether they are available to citizens and foreigners. So, most of the fundamental rights, all of the fundamental rights are available to citizens. Some of the fundamental rights are available to foreigners as well. So, the Indian Constitution distinguishes between rights available only to the Indian citizens and those available to all persons. Means some fundamental rights are available to, that is, most of the fundamental rights are available to citizens. Some fundamental rights are available to all persons, including foreigners, except enemy aliens. Enemy aliens are the subjects of another country that country, subjects of any country, and that country is at war with India. This distinction is crucial for understanding the scope of fundamental rights. So, Article 21A, right to education. Right to education was, that is Article 21A was introduced by 86 Constitutional Amendment Act 2002 and it provides for right to education. The constitutional provision, the state shall provide free and compulsory education for all children in the age group of 6 to 14 years. Scope of the right, It makes elementary education a fundamental right, not higher or professional education, and it is available to both citizens as well as foreigners except enemy aliens. Historical significance described as the dawn of second revolution in the chapter on citizens' rights. Article 26, freedom to manage religious affairs. Every religious denomination or any section thereof has the right to establish, that is, establish and maintain institutions for religious and charitable purposes, manage its own affairs in matters of religion, own and acquire movable and immovable property, administer such property in accordance with law. So, the Supreme Court has laid down 3 conditions for a group to be recognized as a religious denomination. So, Supreme Court itself has given some guidelines or rules, that is conditions for a group to be recognized as religious denomination. First, it should have common beliefs, that is a collection of individuals. That religious denomination should be a collection of individuals having a common system of beliefs, a common organization, and a distinctive name. That is, examples Ramakrishna Mission and Ananda Marg have been held to be denominations, religious denominations within Hinduism, available to both. That is, freedom to manage religious affairs is available to both citizens and foreigners except enemy aliens. Article 15, prohibition of discrimination. That is, prohibition of discrimination on the grounds of religion, race, caste, sex, and place of birth. So, core provision, the state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, or place of birth. The word only is crucial, as discrimination on other grounds is not prohibited. So, Article 15(2) prohibits discrimination by both states and private individuals in access to shops, restaurants and hotels, places of public entertainment, wells, tanks, bathing ghats and roads. So, Article 15 is available only to Indian citizens and not to foreigners. Article 14, equality before law and equal protection of law. So, the state shall not deny to any person equality before law or equal protection of the law within the territory of the India. The term person includes citizens, foreigners, except the term person includes citizens, foreigners except enemy aliens, and even legal persons, companies, corporations and societies. So, equality before law is a negative concept, that is British origin. No special privilege means no special privileges, equal subjection to ordinary law, and equal protection of laws, that is a positive concept, American origin. Likes should be treated alike, that is every citizen is not under equal circumstances. So, it is the duty of the government to provide equal circumstances, that is equal treatment under equal circumstances. Like should be treated alike. So, Article 14 is available to both citizens and foreigners except enemy aliens. So, summary and current affairs context 25-26. So, Article 14, equality before law and equal protection of the law, available to all persons including foreigners except enemy aliens, both negative and positive concept. Prohibition of discrimination on the grounds of religion, race, caste, sex. Prohibition of discrimination only on the grounds of religion, race, caste, sex, place of birth. That is available to only citizens and only on specific grounds, that is religion, race, caste, sex, place of birth. Right to education, Article that is free and compulsory education for all the children in the age group of 6 to 14 years. Article 621A was inserted by 86 Constitutional Amendment Act 2002. Available to both citizens and foreigners. Elementary education only. Article 26, freedom to manage religious affairs, available to citizens and foreigners and religious denominations. So, Article 21A, 2025, the Supreme Court heard petitions regarding the implementation of RTE Act, Right to Education Act, especially the 25% reservation for economically weaker sections in private schools. The court reiterated that Article 21A imposes a positive obligation on the state to ensure quality elementary education even for migrant and foreign children except enemy aliens. So, Article 21A is available to all, even migrant and foreign children except enemy aliens. Article 15, 25, 26 continued to be invoked in cases relating to reservation policies, women's rights and discrimination in public places. Several high courts used Article 15.2 to strike down discriminatory practices in public utilities, private establishments open to the public. Article 14 remained the most frequently invoked fundamental right, extensively used in challenges to government policies on data privacy, electoral bonds, aftermath, and the differential treatment of foreigners versus citizens in certain economic sectors. The Supreme Court reaffirmed that Article 14 applies to non-citizens as well, except in matters of national security. So, Article 14 applies to non-citizens, but except in matters of national security, it is available only to citizens. Article 26, 2025, the Supreme Court delivered important judgments on the rights of religious denominations, particularly regarding management of temples and waqf properties. The court reiterated threefold test for a religious denomination while balancing it with public order and reforms. So, fundamental duties versus directive principles of the state policy. So, the key clarification, the duty to promote equal justice, key clarification. The fundamental duties versus directive principles of the state policy. The fundamental duties are enshrined in the Constitution. The directive principles are enshrined in the Constitution, Part 4, Article 36 to 51. And the fundamental duties are enshrined in the Constitution, Part 4A, only single article, Article 51A. So, the fundamental duties versus directive principles of the state policy, key clarification, the duty to promote equal justice and provide free legal aid is not embodied in Part 4A. So, it is not fundamental duty. So, Part 4A, that is Part 4A scope. The Part 4A Article 51A exclusively deals with fundamental duties of the citizens. These are moral and civic obligation. These are non-justiciable, cannot be enforced in the court of law, not enforceable by the courts directly, and were introduced to create a balance with the fundamental rights. That is, citizens enjoy not only fundamental rights, but they have a civil, moral and civil obligations. So, fundamental duties are not justiciable, not enforceable by the courts directly, and they were introduced to create a balance between the fundamental rights and the equal justice and free legal aid. Article 39A is not embodied in fundamental duties. So part 4A, fundamental duties, Article 51A. Fundamental duties are enshrined in the Constitution, part 4A and 51A. Fundamental duties were not part of the original Constitution. They were added by 42nd Constitutional Amendment Act 1976 on the recommendations of Swaran Singh Committee. So the Constitution originally did not contain any fundamental duties. They were added by 42nd Constitutional Amendment Act 1976 during the emergency, that is 75-77, on the recommendations of Swaran Singh Committee. Originally there were 10 duties, but the 86th Constitutional Amendment Act 2002 has added a 11th duty. That is, in 42nd Constitutional Amendment Act 1976 added 10 fundamental duties during emergency and 10 original duties introduced on the recommendations of Swaran Singh Committee, and it added 86th Constitutional Amendment Act 2002. It added a 11th fundamental duty to the Constitution. The 11 fundamental duties under Article 51A, as of now there are 11 fundamental duties under Article 51A. It shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem, to cherish and follow the noble ideas which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity and integrity of India, to defend the country and render national service when called upon to promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional or sectional diversities, and to renounce practices derogatory to the dignity of woman, to value and preserve the rich heritage of our composite culture, to protect and improve the national environment, including the forest, lakes, rivers, wildlife, and to have compassion for living creatures, to develop scientific temper, humanism, and spirit of inquiry and reform, to safeguard public property and abjure violence, to strive towards the excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and attachment, and parent or guardian to provide opportunities for education to his child or as the case may be ward between the age of 16 to 14 years. So these duties are inspired partly by the Constitution of former USSR. So the fundamental duties are taken by the Constitution of former USSR. Though the fundamental duties are non-justiciable, the Supreme Court has occasionally used them as an interpretative tool. Example, to uphold the validities of laws and to read them along the fundamental rights. Means any law, if it gives effect to any provisions of these fundamental duties, then it will be upheld by the Supreme Court. So it is used to interpret the Constitution. Contrast with part 4, that is contrast of fundamental duties with directive principles of the state policy. The directive principles of the state policy are enshrined in the Constitution, part 4, article 36 to 51. It contains the directive principles of the state policy, which are essentially, directive principles of state policy are essentially the duties or obligations on the state, and they are non-justiciable but fundamental in the governance of the country. Article 37. Article 37 says that these principles are fundamental in the governance of the country, and it is the duty of the state to implement these principles in making laws. So, role of the directive principles of the state policy. Directive principles of the state policy reflect the socio-economic philosophy of the Constitution and guide the state in making laws and policies, while fundamental duties while the fundamental duties bind the citizens, directives, principles of the state policy bind the state together, forming a comprehensive constitutional framework of obligations. So, the fundamental duties are moral and civil obligations on the citizens, whereas the directive principles of the state policy are fundamental. These are fundamental in the governance of the country, and it is the duty of the state to implement. So, fundamental duties are binding to the citizens, and directive principles of the state policy is the duty of the state. So, together a comprehensive constitutional framework of obligations. So, part 4A, fundamental duties, Article 51A, obligations of citizens, non-justiciable, added in 1976. Part 4, directive principles of the state policy, Article 36 to 51, obligations of the state, again non-justiciable, fundamental in the governance, socio and economic philosophy. So, Article 39A, equal justice and free legal aid, falls under Part 4, Directive Principles of the State Policy. So, the 42nd Constitutional Amendment Act 1976 and the same amendment which has added the fundamental duties, it has inserted Article 39A, and the text of Article 39A, the state shall secure, that is, it is the duty of the state to secure the operation of legal system and promote justice on the basis of equal opportunity, and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure opportunities for securing justice or are not denied to any citizen by reason of economic or other disability. So, it is the duty of the state under Article 39 to provide equal justice and free legal aid. Significance Article 39A, it is the preamble ideal, that is, it operationalizes the ideals of the preamble of justice, socio-economic and political justice. Constitutional basis for NALSA, National Legal Services Authority, established under Legal Services Authority Act 1987 to provide equal justice and free legal aid under the provisions of Article 39A along with state and district legal services authority. That is, the Article 39A, it forms the constitutional basis for Legal Services Authorities Act 1987 and the establishment of NALSA, that is National Legal Services Authorities, along with state and district legal services authority. Judicial activism and Article 21. Judicial activism has elevated the spirit of Article 39A by reading it with Article 21, right to life and personal liberty, making free legal aid as a part of fundamental right, that is fundamental right to free trial and access to justice. Example, Hussainiara Khatun case and subsequent rulings. So, Article 39A is a fundamental right under Article 21. So, Article 21, under Article 21, the right to free trial and access to justice is a fundamental right. So, Article 29A, that is judicial activism, that is the Supreme Court has elevated Article 39A to a fundamental right by making free legal aid as a part of Article 21. Socialist in the preamble of Indian Constitution. Socialistic in the preamble of the Indian Constitution. So, the term word socialist was not the part of the original constitution. So, it was added, the term socialist was explicitly mentioned in the preamble of the Indian Constitution. It was added by the 42nd Constitutional Amendment Act 1976 during the emergency period. Original preamble 1950, Sovereign Democratic Republic. So, later socialist, secular and integrity words were added by the 42nd Constitutional Amendment Act. So, after 42nd Constitutional Amendment Act 1976, now The preamble reads sovereign, socialist, secular, democratic republic. This is the nature of our Indian polity. So, socialistic content before 1976. So, the word socialist was added to the preamble by 42nd Constitutional Amendment Act 1976. So, were there any socialistic provisions in the Constitution? Yes, the socialistic provisions were implicit in the Constitution by the presence of directive principles of the state policy. So, the provisions which are hitherto implicit are now being made explicit by the addition of the word socialist. So, even before the word socialist was inserted, the Constitution already had a strong socialistic tilt through the directive principles of the state policy in Part 4. These principles direct the state to strive for socio-economic justice, reduction of inequalities, equitable distribution of resources and welfare of the people. So, Dr. B.R. Ambedkar and other members believed that the Constitution has an inherent socialistic content which has been made explicit by 42nd Constitutional Amendment Act. Nature of Indian socialism is democratic socialism, not communist socialism. So, Indian socialism is democratic socialism, not communist socialism, that is state socialism. It believes in a mixed economy, that is simultaneous presence of both public and private sectors. They coexist. And aims and objectives, it aims to end poverty, illiteracy, ignorance, disease, inequality of opportunity as observed by the Supreme Court. So, the Supreme Court has stated that the socialism in Indian context, it aims to end poverty, ignorance, disease and inequality of opportunity. So, it's a unique blend of Marxian and Gandhian with a stronger tilt towards Gandhian socialism, emphasizing decentralization, village economy and social justice rather than complete nationalization. Important historical note, the Congress party has already adopted a resolution for a socialistic pattern of society at its Avadhi session 1955, much before the 42nd Constitutional Amendment Act. So, the relation with other parts of the Constitution, directive principles of the state policy strongly reflect the socialistic ideals. Example, Article 38, 39, 40 and 38, 39, 41 and 42. 38 deals with welfare state, that is, promotes a social order for the welfare of the people by minimizing inequalities in income, status and opportunities. Article 39, it directs the state to secure adequate livelihood and adequate means of livelihood and equitable distribution of resources of the community for the common good and equal pay for equal work and protection of workers and children. Article 41 provides for right to work, that is, ensures right to work, education and public assistance in case of unemployment, old age, sickness and disability. And Article 42 mandates just and human work conditions and maternity relief. Article 43, living wage, aims to secure a living wage, decent standard of living, social and cultural opportunities for all workers. Article 47 deals with public health, places a duty on the state to raise the level of nutrition and improve public health and prohibit intoxicating drinks and drugs. Fundamental duties added by the same 42nd Amendment Act but do not specifically mention socialism. Fundamental rights do not explicitly mention socialist, but several rights, especially Article 14, equality before law and equal protection of law. Article 15, right against discrimination on the grounds of religion, only on the grounds of religion, race, caste, sex, place of birth. Article 16, right to equal opportunities in matters of public employment. Article 19, 6 fundamental rights, that is right to freedom of speech and expression, right to assemble, right to form associations, freedom of movement, freedom to reside and settle, and freedom of profession. Article 21, right to life and personal liberty, have been interpreted by the judiciary in a socialistic welfare direction. And preamble ideals, the preamble ideals of justice, social, economic and political, liberty, equality and fraternity are closely linked with socialistic philosophy. Current affairs relevance 2025-26, new economic policy of 1991 and its legacy. The new economic policy of 1991, liberalization, privatization and globalization, significantly diluted the socialistic character of the Indian state by reducing the role of public sector and encouraging private enterprise. The shift from a predominantly socialist economy to a market-oriented one continues to be debated. And modern democratic socialism in welfare state. In recent years, 2024-26, there has been a renewed political and judicial discourse on democratic socialism in the context of welfare schemes. The government emphasizes on the schemes like Pradhan Mantri Garib Kalyan Yojana, Ladli Behna Yojana, free ration, targeted public distribution system, housing and healthcare is often projected as modern democratic socialism aimed at reducing inequalities. And 2025 budget debates and Supreme Court. In 2025, during the debates on union budget and economic survey, several opposition parties and economists have argued that India needs to recalibrate its socialist commitments in the lights of growing inequality. That is, India's Gini coefficient remains very high. The Supreme Court, while hearing the cases related to reservation and economic justice, has reiterated that socialist ideals in the preamble continue to guide the state towards achieving substantive equality and welfare. Wealth redistribution and inclusive growth. The term socialist has also been invoked in discussions about wealth redistribution, farm laws aftermath and labor reforms. Some experts argue that while economic liberalization has brought growth, the constitutional commitment to socialism requires state to ensure inclusive growth and protect the vulnerable sections. Article 3, next topic, Article 3, formation of new states and alteration of areas, boundaries and names. Article 3 empowers the Parliament, not the state legislature, to reorganize the states and union territories of India. It is one of the most important provisions reflecting the federal character of the Indian Constitution. So, Article 3, that is Article 1 to 4, deals with Union and its territories. So, Article 3 deals with the power, or it empowers the Parliament to organize the Indian states and union territories. It is one of the most important provisions reflecting the flexible character of the Indian Constitution. Powers of Indian Parliament under Article 3. The Parliament can exercise the following powers, that is to form a new state, increase the area, diminish the area, alter the boundaries, alter the names. So, to form a new state by separation of a territory from another state or by uniting two or more states or parts thereof. Increase in area, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the names of any states. It also includes the power to merge two or more states or parts to create a new state or union territory, and to split a union territory into two or more states or union territories. So, it also has powers with regarding to union territory. So, important procedural safeguards or conditions. So, what is the procedure? The presidential recommendation is required, that is, a bill under Article 3 can be introduced in the Parliament only, and either house of the Parliament only, and on the prior recommendation of President. So it cannot be introduced in the state legislature. It can be introduced in either house of the Parliament only on the recommendation of the President, and before recommending the bill, the President must refer it to the concerned state legislature for expressing their views within the specified times. Are the views binding? No. The views expressed by the concerned state legislature are not binding on the President or the Parliament. The President or the Parliament is not bound by the views of the state legislature. Even if views are received in time, they can be accepted or rejected. And what about an amendment? When an amendment is made to the bill, the President has to refer the bill to the state legislature? No. No fresh reference needed, that is, no fresh reference to the state legislature is required if the bill is amended in the Parliament. And Union Territories direct action, in case of Union Territories, no reference to the legislature of the Union Territories is needed. 3 Union Territories have legislature: Delhi, Pondicherry and J&K. So no need to refer to the state legislature. The Parliament can directly act. The views of the state legislature are consultative only. They are not binding, and therefore the Parliament can redraw the political map of India without the consent of the state legislatures, concerned state or state legislature. Key constitutional principles and related provisions. The core principle: the Constitution guarantees the indestructibility of the Union but not the territorial integrity of the individual states. That is, the states do not have the power to cede from the Union, whereas Union can change the boundaries, increase the area, diminish the area, alter the boundaries, change the name, create new states. Okay, so the Constitution guarantees the indestructibility of the Union but not the territorial integrity of the individual states. Hence, India is described as an indestructible union of destructible states. The Union government can destroy or reorganize the states, but the states cannot destroy the Union. That is, the states cannot move away from the Union because the Indian Federation is not the result of an agreement like the American Federation, and the states cannot cede from the Union. Related provisions. Laws made under Article 3 and Article 2 are not considered as amendments under Article 368. That is, they can be passed by simple majority in the Parliament. Article 4, and cession of Indian territory to a foreign country, example Berbari Union, to Pakistan, East Pakistan in 1960, required a constitutional amendment under Article 368. Current affairs 2025-26. So the power under Article 3 continues to be relevant on ongoing debates on state reorganization demands. So there are demands for reorganization. So the ongoing statehood demands, that is demands for separate Gorkha land from West Bengal, Harit Pradesh from Uttar Pradesh and Vidarbha from Maharashtra remain active. Ladakh 2025, a demand for a separate union territory status for Ladakh has gained fresh momentum after protests. The union government cited Article 3 while maintaining that any decision would be taken after due consultation. And Andhra Pradesh early 2026, the Andhra government formally requested the centre to consider the creation of new districts and boundary adjustments under Article 3, citing administrative convenience and Supreme Court's reiteration. The Supreme Court in recent cases has reiterated that while Parliament has wide powers under Article 3, the process must follow the constitutional procedure, that is presidential recommendation plus reference to state legislature, even if the views are not binding. So the Supreme Court in recent cases has reiterated that the Parliament has wide powers with regarding to under Article 3, but the process must be followed, and the constitutional procedure, that is presidential recommendation plus reference to the state legislature, even if the views are not binding. Article 3 and the federalism debate. The article has been discussed in the context of federalism debates. Critics argue that the non-binding nature of the state views makes Indian federalism tilt heavily towards the center, while the government defends it is necessary for national integration and administrative efficiency. Critics view the non-binding nature of the state views make Indian federalism tilt heavily towards the center. States have no real veto power over their own reorganization, raising concerns about autonomy of subnational units. And government's defense, that is, the center defends the wide powers under Article 3 as necessary for national integration and administrative efficiency. The consultative process ensures that the states are heard even if their views are not determinative, that is, not binding. Article 3 ultimately reflects India's choice of indestructible union, and Parliament holds sovereign power to reshape the political map in India in the national interest. Formation of new states in India. Nagaland, 16th state of India. Key facts: formed on 1st December 1963. Capital Kohima, formed from Naga Hills, Tunsang area of Assam, a tribal area under 6th schedule, and a legal provision, State of Nagaland Act 1962. Special provision, it is protected under Article 371A, that is, the Parliament cannot legislate on Naga religious practices, religious social practices, customary law and land resources without state assembly consent. So, the Parliament, before legislating on the subjects Naga's religious social practices, customary law and land resources, it has to take the consent of the assembly. Current affairs 2026. In February 2026, the Centre signed a tripartite agreement with the government of Nagaland and the Eastern Nagaland People's Organization ENPO to create a special administrative or special autonomous administrative authority for 6 eastern districts of Tungsan, Mon, etc. This aims at faster development without altering Article 371A. Issues like demands for relaxation of protected area permit and free movement regime with Myanmar continue. Nagaland remains important for Northeast peace and insurgency resolution. So, the Centre has signed a tripartite agreement between Government of Nagaland and Eastern Nagaland People's Organization to ensure or create special autonomous administrative authority for 6 eastern districts. It aims for faster development without altering Article 371A. Arunachal Pradesh, 24th state of India, created on 20th February 1987 till 1972 Northeastern Frontier Agency, and from 20th January 1972 Union Territory and renamed as Arunachal Pradesh. Legal provisions elevated via 55th Constitutional Amendment Act 1986. Strategic importance, shares long international border with China, McMahon Line, Bhutan and Myanmar. Current affairs. Arunachal Pradesh remains a flashpoint on Indian-China border tensions. China continues to claim the state as South Tibet and has renamed places in the region. Incident of military attacks, especially National Socialist Council for Nagaland Keplang faction in Changlang district in March 2026 reported the Vibrant Villages program aims to develop border villages, but implementation gaps persist in infrastructure, that is infrastructure versus functionality, development of border infrastructure and security remains the highest priority for national security. Himachal Pradesh, 18th state, established on 25th January 1971, status before Union Territory, it was Union Territory, legal provision, State of Himachal Pradesh Act 1970, bordered by Jammu and Kashmir in the north, Punjab to the west and southwest, Haryana to the south, Uttarakhand to the southeast, and China to the east. A classical Himalayan state. Current affairs. Himachal Pradesh economy is projected to grow by 8.3% in 25-26 economic survey, with per capita income at rupees 2.83 lakh above national average. Focus areas include tourism, green industries and hydropower. Challenges: frequent national disasters, monsoon floods, landslides, climate change impact on glaciers and springs, and fiscal deficit, that is fiscal stress due to reduced revenue deficits, grants from the center, drug overdose deaths among youth also highlighted in assembly debates. Uttarakhand, 27th state of India, established on 9th November 2000, previous name Uttaranchal, renamed Uttarakhand in 2007, formed from Northern Hills districts of Uttar Pradesh, legal provision, Uttar Pradesh Reorganization Act 2000. In 2000, 3 states were created: Chhattisgarh, Uttarakhand and Jharkhand. So, geography, largely hilly at the foothills of the Himalayas, international borders with China, Tibet in the north and Nepal in the east, bounded by Himachal Pradesh northwest and Uttar Pradesh in the south. Current affairs. In November 2025, Uttarakhand celebrated its silver jubilee, 25 years. PM Mr. Modi visited and inaugurated projects worth 8140 crores, and it is the first state to implement Uniform Civil Code, Article 44 of the Directive Principles of the State Policy in January 2025, excluding scheduled tribes. Push for sustainable tourism, infrastructure and reforms. Land laws, challenging frequent disasters like floods, landslides, over 135 deaths in 2025 episodes. Environmental concerns for projects like Chardham Highway and human-wildlife conflict. And economic focuses on tourism, hydropower services. Youth movement for statehood is often recalled in political discourse. So, the Uttarakhand, 27th state of India. Article 18, abolition of titles. So, Article 18 of Indian Constitution deals with abolition of titles. So, the Article 18 key features or key provisions and features. Article 18 prohibits the conferment of titles by the state and restricts the acceptance of titles from foreign states. So, Article 18, it prohibits the conferment of titles by the states. The state cannot confer any title except military and academic titles, and restricts the acceptance of titles from foreign states. So, it's a significant provision aimed at ensuring equality of status among the citizens and eliminating feudal and colonial practices of conferring hereditary titles of nobility. So, what does the text of Article 18 read? No title not being a military or academic distinction shall be conferred by the state. That is, the state can confer only military and academic titles. Other than that, it cannot confer any titles. No citizen of India shall accept any title from any foreign state. So, a citizen of India cannot accept any title from any foreign state, and no person who is not a citizen of India, shall, while he holds any office of profit or trust under the state, accept without the consent of the president any title from any foreign state. That is, a person who is a citizen of India and who is holding an office of profit or trust under the state can accept any title from any foreign state only on the consent of the president, and no person holding any office of profit or trust under the state shall, without the consent of the president, accept any present, emolument or office of any kind from or under any foreign state. So, a person who is holding any office of profit or trust under the state cannot accept any present, emolument or office of any kind from or under any foreign state except on the consent of the president. So, what are the features of Article 18? That is, it prohibits hereditary titles of nobility, that is Raja, Maharaja, Rai Bahadur, Diwan Bahadur, Khan Bahadur, conferred during the colonial period, and it allows only military distinctions and academic distinctions. That is, the state can confer only military and academic distinctions, and it does not, that is, it does not violate equality of status because they are based on achievement. So, it allows military distinctions like Paramveer Chakra, Ashoka Chakra, and academic distinctions like PhD, DLit. So, it bans indigenous citizens from accepting titles from any foreign governments, and foreigners holding any office of profit or any office under the Indian state need the president's consent to accept foreign titles, and public servants holding office of profit or trust require the president's consent even to accept gifts, presents or emolument from foreign states. So, important Supreme Court rulings: Balaji Raghavan versus Union of India 1996. The Supreme Court upheld the constitutional validity of national awards like Padma Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri. The court ruled that the awards do not amount to titles within the meaning of Article 18. They are mere recognitions of exceptional service and they do not violate the principle of equality. However, these awards cannot be used as suffixes or prefixes to the names of the recipients. Example, Dr. Abdul Kalam, Bharat Ratna is not allowed. Violation leads to forfeiture of the award. So, these awards, national awards, the national awards, they do not amount to titles within the meaning of Article 18, and they are mere recognition of exceptional service and they do not violate the principle of equality. However, these awards cannot be used as prefixes or suffixes to the names of the recipients. Example, Dr. APJ Abdul Kalam, Bharat Ratna is not allowed and violation can lead to forfeiture of the award. Current affairs context 25-26. So, Padma Awards controversy 25-26. The issue of national awards and Article 18, which was already dealt in Balaji Raghavan versus Union of India 1996, again resurfaced in 2025. When several opposition leaders and civil society groups criticized the timing and selection of Padma Awards announced on Republic Day 2025 and 26, the bill on misuse of Padma titles, January 2026. In January 2026, a public interest litigation was filed in Supreme Court alleging that some Padma awardees were using the Padma titles as prefixes and suffixes before and after the names in official documents and public platforms, violating the 1996 Supreme Court guidelines. In Balaji Raghavan versus Union of India case 1996, the court issued notices and reiterated the national awards are not titles under Article 18 and must be used as such and must not be used as such. So, the court has again upheld the Balaji Raghavan versus Union of India case 1996 in that it has clearly ruled that national awards are not titles and must not be used as such, that is used as prefixes and suffixes. Foreign honors debate 2025. The debate also extended to foreign honors. In 2025, questions were raised in Parliament about Indian citizens, including some public officials, accepting honors from foreign government. Example, the France Legion of Honor, UK's Order of the British Empire, without proper clearance from the government, that is without the consent of the president. The government clarified that all such cases require prior consent of the president under Article 18.3 and 18.4. Okay, so foreign titles can only be accepted with the prior consent of the president under Article 18.3 and 18.4, which is nothing but the consent of the government. Continuing relevance. The provision continues to be relevant in the context of diplomatic protocol, conflict of interest, and maintaining republican values in the globalized world. So it is still relevant. That is in the diplomatic protocol, conflict of interest, and also maintaining republican values in the globalized world. Article 22. Next topic, Article 22, that is protection against arrest and detention in certain cases under Article 18. That is fundamental rights. These articles, Article 18 and Article 22, are part of the fundamental rights. That is, fundamental rights are enshrined in the Constitution, Part 3, Article 12 to 35. So, Article 22, protection against arrest and detention in certain cases under the Indian Constitution. So, protection against arrest and detention. Article 22 of the Indian Constitution provides for protection against arbitrary arrest and detention, that is unreasonable arrest and detention. It is divided into two parts. First part, clause 1 and 2. Second part, clause 3 to 7. So, the first part, clause 1 and 2, Article 22, deals with punitive detention, that is arrest and detention under ordinary criminal law. And part 2, clause 3 to 7, preventive detention, that is it deals with preventive detention. Rights under first part of Article 22, that is ordinary and punitive detention. This part confers the following fundamental safeguards on any person arrested or detained under ordinary criminal law. So, right to be informed on the grounds of arrest as soon as possible. That is, when a person is arrested or detained under ordinary criminal law, the following fundamental safeguards are available to the person. That is, right to be informed on the grounds of arrest as soon as possible. So, on what grounds he is being arrested has to be conveyed to him as soon as possible. And right to consult, right to inform. The grounds, right to consult, and defended by a legal practitioner of his and her choice. So, he has the right to be consult and defended by a legal practitioner, that is advocate of his or her choice, and right to be produced before the nearest judicial magistrate within 24 hours of the arrest, excluding journey time. So, he has the right to be produced before the nearest judicial magistrate within 24 hours, excluding journey time, and right to be released after 24 hours unless the magistrate authorizes further detention. So, the right to be released after, that is after the person has been produced before the nearest judicial magistrate within 24 hours of the arrest, then he has the right to be released after 24 hours unless the judicial magistrate authorizes further detention. So, exceptions, these safeguards are not available to enemy aliens, that is the subjects of foreign country, the subject of a foreign country with which India is at war, and the persons arrested or detained under preventive detention law. So, these two are the exceptions. So, the Article 22, first part, that is clause 1 and 2, dealing with ordinary and punitive detention, they are not available. These safeguards, that is right to be informed on the grounds of arrest as soon as possible, right to consult and be defended by a legal practitioner of his or her choice, and right to be produced before the judicial magistrate within 24 hours of the arrest, excluding journey time, and right to be released after 24 hours unless the judicial magistrate further authorizes further detention. Exceptions: the safeguards are not available to enemy aliens and persons arrested or detained under preventive detention law. Supreme Court's clarification: the protections apply only to arrests of a criminal and quasi-criminal nature or activities prejudicial to public interest. They do not cover arrest under court orders, civil arrest, arrest for non-payment of taxes or dues, deportation of foreigners. So, Supreme Court has further clarified that the protections under Article 22, Clause 1 and 2 apply only to arrests of criminal, quasi-criminal nature or activities prejudicial to public interest. They do not cover arrest under court orders, civil arrest, arrest for non-payment of taxes and duties, and deportation of foreigners. So, second part of Article 22, that is preventive detention. So, what is preventive detention? Preventive detention is detention without trial based on suspicion to prevent a person from committing an offense in future. So, ordinary detention or punitive detention is when that is detention after the trial. But preventive detention is the detention without trial based on suspicion to prevent a person from committing an offense in future. This preventive detention is precautionary and it is not punitive measure. It is just precautionary, it is not punitive measure. So, safeguards available to citizens and aliens, that is 3-month limit. Detention cannot exceed 3 months unless an advisory board consisting of the persons qualified to be High Court judges reports sufficient cause for extension. Communication of the grounds, that is, the grounds of detention must be communicated to the detainee as soon as possible, and right to representation, the detainee must be given an opportunity to make a representation against the detention order, and public interest exception, that is facts against public interest, need not be disclosed to the detainee. Public interest exception, facts against public interest need not be disclosed to the detainee. So these are the safeguards available to citizens and aliens, that is 3-month limit. Detention cannot exceed 3 months unless an advisory board consisting of persons qualified to be High Court judges reports sufficient cause for extension, and communication of the grounds of detention must be communicated to the detainee as soon as possible, and for right to representation, that is the detainee must be given an opportunity to make representation against the detention order, and public interest exceptions, facts against public interest need not be disclosed to the detainee. The Parliament's power under Article 22(7), the Parliament can prescribe circumstances where the detention can exceed 3 months without the advisory board's opinion. Normally, the limit is 3 months, that is, detention cannot exceed a period of 3 months unless an advisory board reports sufficient cause for extension. But the Parliament can prescribe under Article 22(7), the Parliament can prescribe circumstances where the detention can exceed 3 months without advisory board's opinion, and fix maximum period of detention in different classes of cases. The Parliament can fix the maximum period of detention in different classes of cases and lay down procedure for advisory board inquiry, and it can lay down the procedure for advisory board inquiry. Note, on the 44th Constitutional Amendment Act 1978, it sought to reduce the initial detention period of 3 months period without advisory without the opinion of the advisory boards from 3 months to 2 months. However, this provision has not been notified till date, and so the original 3-month limit continues. That is, the detention under preventive detention should not exceed 3 months, and if it has to exceed 3 months, the advisory boards should report with sufficient cause. So this 3 months limit, that is 44th Constitutional Amendment Act, sought to reduce the initial detention period without advisory board from 3 months to 2 months. However, this provision has not been notified till date. So the original 3-month limit continues. Protection against arrest and detention, Article 22. Article 22 of the Indian Constitution provides protection against arbitrary, that is unreasonable arrest and detention. It is divided into 2 parts. First part, clause 1 and 2, deals with punitive detention, that is arrest and detention under ordinary criminal law. Second part, that is clause 3 to clause 7, deals with preventive detention, that is detention without trial based on suspicion. So, what are the rights under ordinary and preventive detention? So, Article 22, clause 1 and 2 deals with rights under ordinary and punitive detention. That is, this part confers the following fundamental safeguards on any person arrested or detained under ordinary criminal laws. Okay, so both any person, citizen or foreigner. So first, right to know the grounds, that is right to be informed of the grounds of arrest as soon as possible. Right to legal counsel, that is right to consult and be defended by a legal practitioner of his or her choice, and 24-hour magistrate rule, that is right to be produced before the nearest judicial magistrate within 24 hours of arrest excluding the journey time, and right to be released after 24 hours unless the magistrate authorizes further detention. So these are the following fundamental safeguards available to any person who is arrested or detained under ordinary criminal law. So who is not protected under Part 1? So what are the exceptions to Part 1? Article 22, Clause 1 and 2. So exceptions, that is safeguards not available for enemy aliens, that is subjects of any country which is at war with India, and persons arrested or detained under the preventive detentions laws, that is under 22 clause 3 to clause 7. So the Supreme Courts also gave further clarification, that is protections under Article 22 clause 1 and clause 2, they apply only to arrests of criminal or quasi-criminal or activities prejudicial to public interest. They do not cover arrest under court orders, civil arrest and arrest for non-payment of taxes and dues, and deportation of foreigners. So preventive detention concept and safeguards. Preventive detention is detention without trial based on suspicion to prevent a person from committing an offense in the future. It is precautionary, not punitive measure. So preventive detention is without trial, that is detention without trial based on just suspicion to prevent a person from committing an offense in future. It is precautionary, not punitive measure. So 3-month limit. So the detention cannot exceed 3 months unless an advisory board consisting of the persons qualified to be High Court judges reports sufficient cause for extension and grounds communicated. Grounds of detention must be communicated to the detainee as soon as possible, and facts against public interest need not be disclosed. And right to representation, the detainee must be given an opportunity to make a representation against the detention order. and 44th Constitutional Amendment Act 1978, it sought to reduce the initial detention period without advisory board from 3 months to 2 months, but however, this provision has not been notified till date, so the original 3 months limit continues. Parliament's powers and legislative authority. Under Article 22(7), that is Article 22(7), empowers the Parliament to prescribe the circumstances where detention can exceed 3 months without the advisory board's opinion. Normally, the detention cannot exceed 3 months, and it can exceed 3 months only on the advisory board's opinion. But under Article 22(7), the Constitution empowers the Parliament to prescribe the circumstances where the detention can exceed 3 months without advisory board's opinion and fix maximum period of detention in different classes of cases and lay down procedure for advisory board inquiry. So, it can fix the period of detention in different classes of cases and also lay down procedure for advisory board's inquiry. So, authority, subject covered and example. So, only Parliament has the authority to make laws on defense, foreign affairs and security of India, like it has made acts like National Security Act and Unlawful Activities Prevention Act. National Security Act 1980, Unlawful Activities Prevention Act 1967, and authority. Both Parliament and states have the authority to make laws on security of states, public order, essential supplies and services. And what are the examples? State Public Services, Public Safety Act. Punitive detention after trial and convention. Example, Bharatiya Nyaya Samhita. That is, Bharatiya Nyaya Samhita replaced the IPC 1860, and preventive detention without trial to prevent future harm under National Security Act and Unlawful Activities Prevention Act and State Public Safety Act. So, National Security Act, Article 1980 and Unlawful Activities Prevention Act 1967 and Public Safety Acts. So, Supreme Court preventive detention as a draconian measure. So, Supreme Court has the preventive detention continues to generate significant judicial and public debate due to the alleged misuse of laws under National Security Act 1980 and Unlawful Activities Prevention Act 1967. So, in 2025, the Supreme Court repeatedly described preventive detention as a draconian measure that must be used sparingly and only as an exception, not as a substitute for ordinary criminal prosecution or to bypass bail orders. Example, Dhanya M versus State of Kerala, June 2025. So, the Supreme Court has ruled that preventive detention is a draconian measure and it should be used sparingly and only in exceptional circumstances or as an exemption and not as a substitute for ordinary criminal prosecution or to bypass bail orders. Example, in Dhanya M versus State of Kerala, June 2025. So, judicial activism and checking misuse of preventive detention. So, strict compliance with Article 22(5), that is, grounds must be communicated promptly and in language understood by the detainee. Failure vitiates the order. Orders quashed. Several detention orders quashed for lack of application of mind. failure to consider bail conditions, or when the case was merely a law and order issue rather than a threat to public order. So several detention orders were squashed by the Supreme Court or the High Courts for lack of application of mind and failure to consider proper or consider bail conditions, or when the case was merely a law and order issue rather than the threat to the public interest. And right to effective representation, that is in Jasila Shaji versus Union of India 2024, reaffirmed in 2025, the court reiterated the right to effective representation of the detainee, and High Court squashing NSA, National Security Act orders. High Courts, example Allahabad and Guwahati, have squashed a large percentage of NSA orders, historically around 70 to 78% in some periods, citing procedural violations. So, the judicial activism is checking the misuse of preventive detention. So, strict compliance with Article 22, 23 and squashed orders and right to effective representation, High Court squashing NSA orders. So, judicial activism is a proactive, often progressive interpretation of laws by judges to protect the citizens' rights, fill legislative gaps, and ensure constitutional compliance, often when the executive or legislature fails to act. It contrasts with judicial restraint, prioritizing active interpretation to address public issues. So, judicial activism is the proactive and often progressive interpretation of law. So, the judicial activism is checking the misuse of preventive detention. Preventive detention against dissenting voice. So, the government is often using preventive detention laws against dissenting voices. So, notable incidents: the recent detention of climate activist Sonam Wangchuk under the National Security Act in 2025, late 2025, that is Ladakh protests, sparked debates on using preventive detention against political and dissenting voices. In a democracy, the people have right to dissent, but the government is using preventive detention against political and dissenting voices. The order faced legal challenges on grounds of Article 22 safeguards. So, on the 50th anniversary of emergency, that is 1975 to 77, 50th emergency, several legal experts and articles called for reviewing or even deleting Article 22's preventive detention provisions, arguing that it provides constitutional sanction for detention without proof of guilt. So, the 50th anniversary of emergency in 2025, several legal experts and articles called for reviewing or even deleting Article 22, that is the preventive detention provisions, arguing it provides constitutional sanction for detention without proof of guilt. These developments highlights the tension between the state security needs and individual liberty under Article 21, that is right to life and personal liberty. So, Article 22 at a glance. Article 22(1), Clause 1 and 2, ordinary arrest, that is grounds, should be mentioned, and right to be represented by a lawyer, and right to be produced before the magistrate in 24 hours, and right to be released after 24 hours unless the magistrate authorizes the person to be detained. And Article 22(3)(7), preventive detention, that is limited safeguards, 3 months detention, and beyond 3 months advisory board's opinion should be taken. And not available to, that is punitive detention is not available to, that is these safeguards under punitive detention are not available to enemy aliens, that is the subjects of the countries with which India is at war with, and preventive detention cases. And Supreme Court calls the preventive detention as draconian and stresses on strict compliance. Multiple orders of preventive detention were quashed and debates on misuse against activists is going on. Criminal defamation in India. Criminal defamation is codified under the Indian criminal law. It involves making or publishing any imputation, that is accusation concerning a person with the intention or knowledge or reason to believe that such imputation will harm the reputation of that person. The offense covers imputation made by words, signs, that is spoken or written, signs or visible representations. It applies whether imputation is made directly to that person or published or the person concerned or published to a third party. So, key elements of the offense. Imputation, any statement that lowers a person's reputation in the eyes of others. Mens rea, that is intention to harm reputation or knowledge or reason to believe that it will harm reputation. Publication, essential for the offense in most cases. Making an imputation or communication only to the concerned or aggrieved person. Publishing an imputation, communication to a third person. This completes the offense in most practical scenarios. So, the punishment under old IPC section 500. IPC now is replaced by Bharatiya Nyaya Samhita. So, punishment under old IPC section 500, that is simple imprisonment up to 2 years or fine or both. So, there are 10 exceptions. There are 10 exceptions to the criminal defamation. That is criminal defamation. The meaning of criminal defamation, section 499 defines, 499 of IPC defines criminal defamation, and section 500 prescribes punishment, that is up to 2 years or fine or both. The law provides, that is the IPC section 499 and 500 provides 10 specific exceptions where a statement, although potentially damaging to reputation, is not considered criminal defamation. So, 10 exceptions of defamation under section 499. So, the provision is subject to 10 exceptions unchanged in subject. So, the IPC which was replaced, IPC, Indian Penal Code 1860, which was replaced by BNS, also retained the 10 exceptions. So, the first and the most important exception is imputation of truth which is made or published for public good does not constitute defamation. So, the first and the most important exception is imputation of truth which is made or published for public good does not constitute defamation. So, there are 10 exceptions under section 499 for criminal law of IPC. So, first one is imputation of truth for public good. Second, public conduct of public servants. Third, conduct of any person touching public questions, and reports. Fourth, reports of court proceedings. Fifth, merits of a case decided in court or conduct of witnesses. Sixth, merits of public performance. And seventh, censure by person in authority. Eighth, acquisition preferred in good faith to authorized person. 9, imputation made for protection of interest, and 10, caution conveyed in public good. So, in good faith. So, the 10 exceptions under section 499 of IPC are retained in BNS. IPC was replaced by BNS. So, transition from IPS to Bharatiya Nyaya Samhita, that is the journey from the old penal code to the new Bharatiya Nyaya Samhita, marks a significant legislative shift in how criminal defamation is defined and punished in India. So, IPC 1860 defamation covered under section 499 definition and section 500 punishment. BNS 2023 replaced the Indian Penal Code 1860 with effect from 1st July 2024. Section 356 of the BNS now defines and punishes the criminal defamation. So, definition remains largely the same as the old section 499 of IPC, and punishment continues. That is the same, simple imprisonment up to 2 years or fine or both. New reformative element, the court can award community service as an alternative or additional punishment, especially in minor or first time cases, and the 10 exceptions under the IPC section 499 were retained under BNS section 356 with minor linguistic updates for modern relevance. Constitutional validity in Subramaniam Swamy versus Union of India case 2016, Supreme Court upheld the constitutionality of criminal defamation. The reasonable restriction, that is, the court held that criminal defamation as a reasonable restrictions on the right of freedom of speech and expression under Article 19(2). Fundamental rights are not absolute, they are qualified. Reasonable restrictions can be imposed on them. So, the Supreme Court has upheld the constitutionality of criminal defamation. That is, the court held that criminal defamation is a reasonable restriction on right to freedom of speech and expression under Article 19(2). And right of reputation, right to reputation, that is, the court observed that right to reputation is an integral part of the right to life with dignity under Article 21. So, in Subramaniam Swamy versus Union of India case 2016, the Supreme Court has upheld the constitutional validity of criminal defamation. So, Article 19(2), that is on two grounds, that is reasonable restrictions. So, the court held that criminal defamation is a reasonable restriction to the right to freedom of speech and expression. That is under Article 19(2), that is reasonable restrictions for right to freedom of speech and expressions, and right to reputation, that is the court observed that right to reputation is an integral part of Article 21, that is right to life and personal liberty. So, the Supreme Court has upheld the constitutional validity of criminal defamation. Current affairs relevance 2025-26. Since 1st July 2024, all new criminal cases, including the defamation complaints, are registered under Bharatiya Nyaya Samhita (BNS) and investigated as per Bharatiya Nagarik Suraksha Sanhita, that is Criminal Procedure Code, CRPC, Criminal Procedure Code 1973, and the evidence is governed by Bharatiya Saksha Adhiniyam, that is Indian Evidence Act 1872. So the since 1st July, that is Bharatiya Nyaya Samhita replaced the Indian Penal Code. Replaced the Indian Penal Code of 1860, and the criminal cases, all new criminal cases of defamation complaints are registered under Indian Penal Code, that is BNS, which replaced the Indian Penal Code of 1860 IPC, and investigated as per Bharatiya Nagarik Suraksha Samhita, that is BNSS, Bharatiya Nagarik Saksha Samhita, BNSS, and that is it replaced the CRPC, Criminal Procedure Code 1973, and evidence is governed by Bharatiya Saksha Adhiniyam, Indian Evidence Act 1872. It increased the scrutiny, that is in 2025-26 criminal defamation cases have seen an increased scrutiny, especially in the context of online social media defamation, fake news and political statements. Community service in practice, that is it provided for community service, that is the courts are actively applying the community service option under the BNS, Bharatiya Nyaya Samhita, to reduce overcrowding in prisons for non-serious offences. And Madras High Court petition, March 2026, the Madras High Court admitted a petition challenging the procedural aspects of criminal defamation trials under the new BNSS, Bharatiya Nagarik Suraksha Samhita provisions, particularly the requirement of preliminary hearing before taking the cognizance. This highlights ongoing debates on balancing free speech with protection of reputation in the digital age. And high-profile cases and misuse concerns. The provision continues to be used in high-profile cases involving celebrities, politicians, journalists, public figures, raising questions about potential misuse to stifle dissent, a recurring theme in editorials and public interest litigations. So, a quick revision, that is the section 499 deals with the definition of criminal defamation of IPC, and 500 deals with the procedure, that is the punishment. So the old law IPC section 499 and 510 exceptions to the criminal defamation are mentioned in section 499, and 356 a new law, that is the IPC was replaced with Bharatiya Nyaya Samhita, that is IPC of 1860 was replaced with Bharatiya Nyaya Samhita. So the new law, that is under Bharatiya Nyaya Samhita, section 356 deals with criminal defamation, and the same punishment was carried on, that is 2 years punishment, up to 2 years plus fine. Now the new BNS, it has a provision of community service. The old IPC, the punishment was 2 years or fine or both, but the new BNS, it has a new provision that community service is also community service has also considered to reduce the burden on the prisons which are overcrowded. And 2016 Subramania Swamy versus Union of India, the Supreme Court has upheld the constitutional validity of criminal defamation. So the first exception of criminal defamation is truth spoken or published for public good does not constitute defamation. So the 10 exceptions under section 499 of IPC are retained under BNS section 356, and the same punishment is also retained, that is up to 2 years or fine or both, plus the community service is also added in BNS section 356. Joint sitting of the Parliament, Article 108. The President may call for a joint sitting when there is a deadlock on an ordinary bill. So, joint sitting and private members bills. Joint sittings, till now, joint sitting has been invoked only thrice since the commencement of the Constitution on 26 January 1950. The provision for a joint sitting of both the houses of the Parliament when there is a deadlock on a bill, that is Lok Sabha and Rajya Sabha, to resolve a deadlock on ordinary bill has been invoked only thrice. The bill passed through joint sittings are the Dowry Prohibition Bill 1960, passed in 1961, the Banking Service Commission Bill, Repeal Bill 1977, passed in 1978, and Prevention of Terrorism Bill 2002, quota. Okay, so no constitutional amendment bill has to amend the constitution. A constitutional amendment bill has to be introduced in either house. So no constitutional amendment bill has ever been passed through a joint sitting. That is, a joint sitting cannot be used for money bills and constitutional amendment bills, or when the Lok Sabha is dissolved. So there is no provision of joint sitting for money bills or constitutional amendment bills, or when the Lok Sabha is dissolved. Private member bills. Key facts. A bill introduced by private members, that is members of the Parliament, who is not a minister, is called a private member bill. Okay. So private member bill is a bill which is introduced by a member of the Parliament who is not a minister. So it is called a private members bill. And such bill, can it be introduced in both the houses? Yes, it can be introduced in either houses. And do we need the prior consent of the President? No, without the prior permission of the President. So only 14 private member bills have been passed by both the houses and received presidential assent to become acts till date. So till date, only 14 private members bills have been passed and both the houses and have received presidential assent to become acts. So 6 of these were passed in a single year, 1956. And the last one was the Supreme Court Enlargement of Criminal Appellate Jurisdiction Bill 1968, which became a law on 9th August 1970. So till now only 14 private members bills have been passed by both the houses and received the assent of the President to become an act, and 6 of these were passed in a single year, 1956, and the last one was the Supreme Court Enlargement of Criminal Appellate Jurisdiction Bill 1968, which became a law in 1970, 9th August 1970, and no private members bill has become a law in the last 5 decades as of 2026. And the 86th Constitutional Amendment Act 2002, which introduced the Right to Education Act 2009, was a government bill. It was introduced because it was introduced by a minister, not a private member's bill. So, regarding the 86th Constitutional Amendment Act 2002, Right to Education, the amendment is one of the most significant post-independent changes in the Indian Constitution. It gave effect to the long-pending goal of universal elementary education by converting directive principle into a fundamental right. So, insertion of Article 21A, that is Fundamental Rights Part 3. That is, the Article 21A was inserted by the 86th Constitutional Amendment Act 2002. That is, it reads, the state shall provide free and compulsory education to all children in the age group of 6 to 14 years in such a manner as the state may by law determine. And the 86th Constitutional Amendment Act 2002, it introduced a new article 21A, that is the fundamental right. Fundamental rights are enshrined in the Constitution Part 3, Article 12 to 35, and it has changed the subject matter of Article 45, that is the directive principle of the state policy. Directive principles of the state policy are enshrined in Part 4, Article 36 to 51, and it has introduced a new fundamental duty under Article 51A, Part 4A, fundamental duty. Okay, so substitution of Article 45, that is change the subject matter of the directive principles. That is, previously universal elementary education was a directive principle. Now it is changed into the fundamental right by introducing Article 21 by 86th Constitutional Amendment Act 2002. So subject matter of Article 45, that is directive principles Part 4. The original Article 45, which talked of free and compulsory education up to 14 years, was replaced with the state shall endeavor to provide early childhood care and education for all the children until they complete the age of 6 years. So earlier, the directive principle of the state policy 45, it talked about free and compulsory education up to 14 years. Now it has been replaced, that is the state shall endeavor to protect early childhood care and education to all the children until they complete the age of 6 years. So it changed the subject matter of Article 45 and addition of clause K to Article 51A, fundamental duties, Part 4A. It added a new fundamental duty, that is 86th Constitutional Amendment Act 2002. It added a new fundamental duty, that is a parent or guardian to provide opportunities for education to his child or ward, as the case may be, in the age group of 16 to 14 years. So 86th Constitutional Amendment Act had added a new clause, clause K to 51A. And significance, it operationalized the vision of Article 45 as originally envisaged, that is free and compulsory education up to 14 years, and Article 21, right to life and personal liberty, interpreted by the Supreme Court in cases like Mohini Jain 1992 and Uni Krishna 1993. This amendment paved the way for right of children to free and compulsory education, RTE 2009, which is enabling legislation for Article 21A. So, 9th schedule and judicial review. The origin of the 9th schedule. The 9th schedule was added by the first Constitutional Amendment Act 1951 along with Article 31B. Its original purpose was to protect land reforms and zamindari abolition laws from being challenged in the court on the grounds of violation of fundamental rights, especially Article 14, 19 and 31. Article 31 is right to property. So, the zamindars who has vast acres of land, they also enjoyed the fundamental right Article 31, that is right to property. So, in order to carry out land reforms and zamindari abolition laws, the states laws, to protect these laws from the violation of fundamental rights, they were placed in the 9th schedule so that the state can carry out its welfareist aspects. So, in I.R. Coelho versus State of Tamil Nadu 2007, in this landmark case, the Supreme Court ruled that laws placed in the 9th schedule after 24th April 1973, the date of Keshavananda Bharati judgment, are subject to judicial review if they violate the basic structure of the Constitution. So, one of the landmark judgment of the Supreme Court in I.R. Coelho versus State of Tamil Nadu 2007, in this landmark case, the Supreme Court ruled that the laws placed in the 9th schedule after the 24th April 1973, date of Keshavananda Bharati judgment, are subject to judicial review if they violate the basic structure of the Constitution. Basic structure of the Constitution are core principles of the Constitution which cannot be changed or altered. No connection with 86th Constitutional Amendment Act 2002. That is, 86th Constitutional Amendment Act 2002 has no connection with the 9th schedule, because 9th schedule provides immunity to laws placed in the 9th schedule from judicial scrutiny for violation of fundamental rights, whereas 86th Constitutional Amendment Act 2002 provides for that is introduced in Article 21A, providing free and compulsory education for all, the universal elementary education, that is free and compulsory education for all children in the age group of 6 to 14 years. This is an important distinction to note, especially in the context of the exams. And amendment of the Indian Constitution. That is, can the Parliament amend the Constitution? Yes, the Parliament can amend the Constitution, and the procedure to amend the Constitution is mentioned in the Constitution itself, Article 368. The Indian Constitution is neither fully rigid nor fully flexible. It represents a synthesis of both. The Parliament can amend the Constitution in 3 ways. So, the Indian Constitution is neither, when you are talking about whether it being rigid or flexible, you are talking about the procedure to amend the Constitution. So, the Parliament can amend the Constitution, and the procedure to amend the Constitution is mentioned in the Article 368. So, the procedure to amend the Constitution, that is, the Parliament can amend the Constitution in 3 ways. Simple majority, so it is flexible, that is majority of the members present plus voting. Special majority and special majority plus ratification by half of the state legislatures. Here special majority in case of non-federal features and special majority plus ratification by half of the state legislatures in case of federal features. So, the Constitution can be amended in 3 ways: by simple majority, that is, the Constitution is flexible, and non-federal, special majority, and federal, that is, it is rigid. So, it is a synthesis of both flexible and rigid. Simple majority, by majority of the members present plus voting, not considered as an amendment under Article 368. So, the Constitution is amended in 3 ways: simple majority, special majority, and special majority plus ratification by half of the states. But simple majority, amendment of the Constitution by simple majority, is not considered as an amendment under Article 368. Example, formation of new states, Article 3, citizenship laws, Article 4 to 10, and special majority, that is majority of total membership of the House plus majority of not less than 2 by 3rds of the members present plus voting in case of non-federal features. And the non-federal features are fundamental rights, directive principles of the state policy, etc. And federal features with relation to the center-state relations, example, election of the president, distribution of powers. So, in case of federal features, not only special majority but also ratification by half of the state legislatures. So, what are the key features? The Constitutional Amendment Bill, can it be introduced in the either house? Yes, it can be introduced in the either house of the Parliament, and it cannot be introduced in the state legislatures. It can be introduced by either a minister or a private member. So, it can be introduced in either houses, Lok Sabha or Rajya Sabha. It cannot be introduced in the state legislature. It can be introduced by a minister or a private member. Private member is a member of the Parliament who is not a minister. And what about the presidential permission? That is, for the introduction of the Constitutional Amendment Bill, the presidential permission is required? No. That is, no prior permission of the President is required for the introduction of the Constitutional Amendment Bill. And can the President withhold the Constitutional Amendment Bill? No. The President cannot withhold his assent to the Constitutional Amendment Bill. 42nd Constitutional Amendment Act 1976 and made it obligatory for the President to give his assent to the Constitutional Amendment Bill. Right to silence under the Indian Constitution. Right to silence is a vital safeguard in Indian constitutional jurisprudence. It protects individuals from being forced to incriminate themselves and upholds the principle that freedom of expression includes freedom not to express. So, the constitutional basis, Article 23 is the primary source, that is, no person accused of any offence shall be compelled to be a witness against himself, and this provision explicitly guarantees the right against self-incrimination. It is the fundamental canon of criminal jurisprudence, that is, fundamental principle of criminal jurisprudence, and forms the core of the right to silence during investigation, interrogation, and trial. Its purpose is to prevent torture, coercion and forced confessions during police or investigating or during confessions by police or investigating agencies. It protects personal liberty and dignity under Article 21, that is right to life and personal liberty. Key linked protections, that is presumption of innocence, that is until unless you are convicted of your offense, you are presumed to be innocent, and burden of proof on the prosecution, and fair trial rights. So these are the key linked protections, that is presumption of innocence, burden of proof on the prosecution, and fair trial rights. Secondary source. Primary source is Article 23 and secondary source is Article 19(1)(a), that is freedom of speech and expression. It includes right to remain silent, and the Supreme Court has held that right to speak necessarily implies right not to speak, and forcing someone to express something against their will, like singing, making statements, violates their freedom, subject only to reasonable restrictions under Article 19(2). So, landmark judgment, Bijoy Emmanuel versus State of Kerala, 1986. 3 school students of Jehovah Witnesses stood respectfully during national anthem but refused to sing due to their genuine religious beliefs. They were expelled from the school by educational authorities. So these 3 students, they stood respectfully for the national anthem and they did not sing the national anthem because of their respectful or genuine religious beliefs, and they were expelled from the school authorities. So the Supreme Court ruling, that is OP Justice O. Chinnappa Reddy ruling, that is expulsion violated Article 19(1)(f), that is right freedom of speech and expression, and Article 25(1), that is freedom of religion and conscience. So what are the key observations? No law in India obliges anyone to sing national anthem. That is, there is no law in India that is obliging anyone to sing national anthem, and standing respectfully during national anthem shows respect, and not singing does not amount to disrespect. And right to freedom of speech and expression includes right to silence, and mere departmental instructions or circulars without statutory backing cannot impose restrictions on fundamental rights. So there should be a law. Law should be there to impose restrictions on fundamental rights, and mere departmental instructions or circulars cannot impose restrictions on fundamental rights. Compelling singing would force the student to act against their conscientious religious belief, that is their conscience and the religious beliefs. So the court squashed the expulsion order and directed the readmission of the students. This judgment is landmark for protecting the minority rights, freedom of conscience, and the principle that respect does not require compulsion. So this is a landmark judgment by Justice O. Chinnappa Reddy, Bijoy Emmanuel versus State of Kerala, that is upholding the right to silence. Important related judgments, that is Nandini Satpathy versus P.L. Dhani, 1978. The Supreme Court held that an accused person has the right to remain silent during police interrogation, and forcing answers that may incriminate violates Article 23. And Selvi versus State of Karnataka, 2010. Use of narco analysis, brain mapping or lie detectors without the consent of the detainee violates the right against self-incrimination, Article 23, that is the primary source. and right to privacy under Article 21. What are the other affirmations? The right to silence is linked to fair trial guarantees under Article 21 and Criminal Procedure Code provisions section 313, that is examination of accused where silence cannot be used against them as proof of guilt. CRPC is replaced by Bharatiya Nagarik Suraksha Samhita. So the right to silence is linked to fair trial guarantees under Article 21 and CRPC provisions. Scope and limitation. It applies to accused persons during investigation, trial and any compelled testimony. Does not apply to civil cases, voluntary statements or fingerprints or voice samples. In some contexts, they are not testimonial compulsion in as stated by the court, ruled by the court in Ritesh Sinha case. So, it does not apply, right to silence does not apply to civil cases, voluntary statements or fingerprints or voice samples. That is, a person has to give his fingerprints and voice samples, and these are not testimonial. Evidentiary value. Example of Ritesh Sinha case. Restrictions. Reasonable restrictions under Article 19(2), that is, the state can impose reasonable restrictions are possible, but they must be made by law, not executive orders, and must satisfy the test of proportionality. So, reasonable restrictions should be proportional to the goal they want to achieve. Significance. Next topic. Sources of Indian Constitution. So, our Constitution is a borrowed Constitution. Okay, we borrowed many features from other constitutions of the world. So, some of the sources. An in-depth exploration of key constitutional features borrowed from global models, that is judicial review, directive principles of the state policy and procedure established by law and their evolution within the Indian legal framework. So, let us try to understand the features like judicial review, directive principles of the state policy, procedure established by law and their evaluation within the Indian legal framework. So, judicial review. The concept of judicial review, that is, the power of judicial review is to examine the constitutionality of legislative enactments and executive actions and declare them ultra vires, that is, null and void, if they violate the Constitution, was borrowed from the US Constitution. So, judicial review is scrutiny of legislative enactments and executive actions. If they are not according to the provisions of the Constitution, then they can be declared null and void by the court. This is taken from the US Constitution and it is implicit in the Constitution. In India, it is not explicitly mentioned, but it is implicit in Article 13, 32, 226, 136, 142. Article 13. Laws that are inconsistent or in abrogation of fundamental rights can be declared null and void to the extent of their inconsistency by the Supreme Court. And Article 32, that is the right or the Supreme Court can issue writs for the enforcement of the fundamental rights. Article 226, High Courts can issue writs for the enforcement of the fundamental rights. That is, an aggrieved person can approach when the fundamental rights are violated. An aggrieved person can approach either Supreme Court under Article 32 or High Court under Article 226. And Article 136, special leave for appeal, and Article 142, complete justice. The Supreme Court, the Constitution has provided the special power on the Supreme Court to provide complete justice. So, striking down unconstitutional laws, the judiciary can strike down any law or executive order of the central and states if they found unconstitutional, that is, not in accordance with the Constitution, not in consonance with the Constitution or in contravention with the Constitution. Adopted to the Indian context. It was adopted to the Indian context particularly after the evolution of the basic structure doctrine in Keshavananda Bharati case 1973. Directive principles of the state policy. Directive principles of the state policy are enshrined in Part 4 of the Indian Constitution, Article 36 to 51. Dr. B.R. Ambedkar described them as the novel features of the Indian Constitution. They represent the philosophy and soul of the Constitution, containing the vision of socio-economic justice and welfare state. So, the nature and significance, though non-justiciable, the directive principles of the state policy are not non-justiciable, that is, they cannot be enforced in the court of the law, not enforceable by the courts. They are fundamental in governance of the country. Article 37, that is, these principles are fundamental in the governance of the country, and it shall be the duty of the state to implement these policies in making laws and serve as guiding principles for law making. Courts often use them to interpret fundamental rights, especially under Article 21. So, the directive principles of the state policy, that is, laws that give effect to the directive principles of the state policy, they are upheld by the Supreme Court. So, the Supreme Court, which is the final interpreter of the Constitution, it uses the directive principles of the state policy to interpret fundamental rights, especially under Article 21. Article 21 is the most interpreted right, fundamental right. So, procedure established by law. Article 21 states that no person shall be deprived of his life except or personal liberty except according to the procedure established by law. So, origin, this phrase was borrowed by the Japanese Constitution, and A.K. Gopalan case 1950, the initial interpretation was narrow. The court initially in A.K. Gopalan case 1950 interpreted in a very narrow way, and mere existence of law was not enough to deprive life and mere existence of law was enough to deprive life and liberty. That is, just by the presence of law, a person's life and liberty can be deprived. But in Menaka Gandhi versus Union of India case 1978, it expanded significantly to mean a procedure that is fair, just and reasonable. That is, it incorporated the elements of due process of law. So, in A.K. Gopalan case, the procedure established by law was interpreted in a narrow way, that is a law made by the competent authority and the procedure has been followed. It can restrict the life and personal liberty. But the law itself, whether it is fair, just or reasonable, is not considered. But in Menaka Gandhi versus Union of India case 1978, it expanded significantly, that is, the procedure should be fair, just and reasonable, incorporating the elements of due process of law. Summary: the feature judicial review is borrowed from USA. What are the three articles? Article 13, Article 32, Article 226. And Article 13, laws that are inconsistent or in abrogation of fundamental rights can be declared null and void to the extent of inconsistency. Judicial review, Article 32 and Article 226. The aggrieved person whose fundamental rights are violated can approach the Supreme Court or the High Court. Remark: the power to declare laws unconstitutional. That is, if the court finds, there is judicial review, the court scrutinizes the legislative enactments and executive actions, and it can declare them as null and void, unconstitutional, if they are not according to the provisions of the Constitution. Directive principles of the state policy taken from Ireland 1937, and they are enshrined in the Constitution Part 4, Article 36 to 51. They are the novel features, according to Dr. B.R. Ambedkar. Directive principles of the state policy are novel features and soul of the Constitution, and procedure established by law is taken from Japan. Article 21, that is right to life and personal liberty, evolved into due process post Menaka Gandhi. That is, due process of law is taken from USA. So, current affairs 11th 2025-26. Judicial review, it remains a cornerstone of the Indian democracy in 2025-26. The Supreme Court continued to exercise robust judicial review in cases involving electoral reforms, online gaming regulations, and challenges to the executive action. It reaffirmed that The judicial review is part of the basic structure of the constitution and cannot be curtailed. Discussions around the scope of judicial review vis-a-vis the parliamentary laws gained attention in 2026, especially in matters concerning federalism and separation of powers. So, the judicial review is continued to exercise in a robust way by the Supreme Court involving the electoral reforms, online gaming regulations and challenges to executive action. And judicial review is part of the basic structure, cannot be curtailed, and the scope of judicial review vis-a-vis the parliamentary laws is gaining attention in 2026, especially in matter concerning with federalism and separation of powers. Directive principles of the state policy. Courts frequently invoke the directive principles of the state policy while expanding the scope of Article 21, that is right to life. In recent judgments 25-26, directive principles of the state policies were used to support socio-economic rights, environmental protection and welfare measures. The judiciary continued the harmonious construction approach. Harmonious construction approach when the different provisions of the same law are contradicting each other, then the court applies harmonious construction approach so that both the provisions can coexist. So, the judiciary continued the harmonious construction approach, reading directive principles of the state policy into fundamental rights to achieve social justice goals, even though they are non-justiciable. The directive principles of the state policy are non-justiciable. So, in directive principles of the state policy versus fundamental rights, the court has used harmonious construction approach, that is, these two contradictory provisions of the constitution, the court has followed the harmonious construction approach for their coexistence to achieve social justice goals, even though the directive principles of state policy are not justiciable. Procedure established by law. Article 21, jurisprudence, that is, no person shall be deprived of his life and personal liberty except by procedure established by law, saw further expansion, that is in March 2026. The Supreme Court delivered a significant judgment on passive euthanasia and right to die with dignity, reinforcing that any procedure depriving life or liberty under Article 21 must be fair, just and reasonable. The court has consistently moved closer to the American due process of law through judicial interpretation, and which formally retained the Japanese phrase. So, the due process of law has been now, that is, the court has consistently moved closer in relation to Article 21, that is, procedure established by law. Now, the law should not only follow the procedure, but also it should be fair, just and reasonable. These three features highlight how the Indian system is a synthesis of various global models adapted to suit India's socio-political needs. The basic structure doctrine further strengthened the judicial review, making it living instrument for protecting constitutional values. Oaths and affirmations in the Indian Constitution. So, the Indian Constitution prescribes specific oaths and affirmations for various constitutional authorities before they assume the office. The oaths are solemn declarations of loyalty to the Constitution and commitment to perform duties impartially. So, the Constitution provides various oaths and affirmation to various constitutional authorities before they assume the office. These oaths are solemn declaration of loyalty to the Constitution and commitment to perform their duties impartially. So, the key provisions and correct analysis. The following table summarizes the oath provisions of major constitutional authorities, including the article which administer the oath, whether the form is mentioned in the third schedule. The third schedule deals with oaths and affirmation of various constitutional authority. So, who are the authorities and the form and oath or oath or affirmation is mentioned in the third schedule. So the President, Article 60 deals with the oath and affirmation of the President, and the Chief Justice of India administers the oath to the President, and in case of his absence, senior most judge of the Supreme Court. And is it mentioned in the third schedule? No. And judges of the Supreme Court and judges of the High Court, it is mentioned in Article 124, and judges of the High Court, Article 214. So the judges of the Supreme Court and judges of the High Court, Article 1246 and Article 214, and who the President or the person appointed by him, Controller and Auditor General, Article 148(2), again the oath is administered by the President, and members of the state legislature, Article 188, the governor or person appointed by him. So the third schedule does not contain the provision with relating to oath and affirmation of the President, Article 60. So the President, Article 60, the oath requirement, the President must take oath before entering upon his office. It is administered by the Chief Justice of India or senior most judge of the Supreme Court in his absence. The third schedule status, the form of oath is not given in the third schedule. It is mentioned directly in the Article 60, making it unique among major constitutional offices. Second and third, that is the Supreme Court judges and CAG. Supreme Court judges, Article 2146, the oath is taken before the President or any person appointed by him. The form of oath is prescribed in the third schedule. Controller and Auditor General, Article 148(2), the C&AG takes the oath before the President, and the oath is given in the third schedule. Members of the state legislature, Article 188, the oath, they take the oath before the governor. Every member must take the oath before the governor or any person appointed by him before taking his seat in the house. Consequences of not taking the oath: without taking the oath, a member cannot vote or enjoy privileges. The third schedule status, the form of oath is mentioned in the third schedule. So the members of the state legislature, the form of oath is mentioned in the third schedule, and before taking the oath, they cannot vote or they cannot enjoy the privileges, and oath is administered by the governor or any person appointed by him before taking his seat in the house. The third schedule, forms of oath and affirmation. The third schedule contains forms of oath and affirmations for the following constitutional authorities, that is the Union Minister under Article 75(4), the members of the Parliament, Article 99, the judges of the Supreme Court and High Court under Article 3rd Schedule 2, 124, 214, and the Controller and Auditor General, Article 148, State Ministers, 3rd Schedule under Article 1, State Ministers and members of the State Legislatures, 3rd Schedule. So, the election candidates and also the election candidates, the candidates for election to the Parliament and state legislatures, their oath should also is also prescribed in the 3rd Schedule. The President's oath is only major constitutional office where oath is not placed in the 3rd Schedule. Current affairs context 25-26, the presidential oath. In August 2025, the President Shri Draupadi Murmu took oath for her 2nd term. The event once again highlighted the unique position of the President's oath administered by the Chief Justice of India and not listed in the 3rd Schedule. This ceremony served as a prominent reminder of the constitutional distinction that sets the President's oath apart from all other constitutional offices in India. Current affairs, the judges and CAG oaths 25-26. In 25-26, several newly appointed Supreme Court and High Court judges as well as the new Controller and Auditor General took their oaths as per the forms prescribed in the third schedule. These ceremonies were widely covered and used in constitutional awareness programs. Judicial independence, the oath of office has been frequently discussed in the context of judicial independence and constitutional morality. And 2025 Supreme Court judgment, in 2045 Supreme Court judgment related to the appointment of the judges, the court reiterated that the oath taken by the judges under Article 124(6) binds them to uphold the Constitution and the rule of law above all other considerations. So, current affairs, MLAs and anti-defection and floor tests 25-26. So, during debates on anti-defection law and floor tests in the state assemblies 25-26, the importance of oath taken by MLAs under Article 188 was emphasized, as violation of the oath is often cited in disqualification cases. So, the oath of the member of the state legislature is not merely ceremonial, it carries direct legal consequences. Violation of the oath is frequently invoked in disqualification proceedings under anti-defection laws. Anti-defection law, 10th schedule, 52nd Constitutional Amendment Act, (1985). So, a quick recap and key takeaways. The presidential oath is unique. The presidential oath, Article 60, is the only major constitutional oath not mentioned in the third schedule. It is embedded directly in the Article 60 and administered by the Chief Justice of India. Third schedule covers most others. Oaths of the Supreme Court judges, Article 124(6), C&AG, Article 148(2), judges of the Supreme Court and High Court, C&AG, Article 148(2), members of the state legislature, Article 188, are all prescribed in the third schedule. And the oath, constitutional commitment. The oaths are solemn declarations of loyalty to the Constitution and commitment to perform duties impartially with real, legal and constitutional consequences for violation and relevance. From that is 25-26, the President Murmu's second term oath to judicial appointments and anti-defection debates. Constitutional oaths remain center of India's democratic discourse. So, constitutional oath are at the center of India's democratic discourse. Article 22, protection against arrest and detention. Article 22 is a fundamental right enshrined in the Constitution, Part 3, Article 12 to 35. So, Article 22 provides protection against arrest and arbitrary detention. So, Article 22 of the Indian Constitution provides protection against arbitrary arrest and detention. Article 35 of the Indian Constitution, that is the fundamental right, Article 35, that is the Parliament's exclusive legislative power for certain fundamental rights. That is a crucial yet often overlooked provision of Part 3, fundamental rights, is Article 35. It ensures uniformity across the country, India, in implementation and enforcement of specific fundamental rights by vesting exclusive legislative power in Parliament and explicitly denying the same to the state legislatures. So, according to Article 35, the power to legislate is conferred on the Parliament and not on the state legislature. So, to bring about uniformity across India in implementation and enforcement of specific fundamental rights. by vesting exclusive legislative powers in the parliament and explicitly denying the same to the state legislatures. Why Article 35 exists? Article 35 is part of the fundamental rights. So fundamental rights are meant to be enjoyed uniformly by all the citizens throughout the country. If state legislatures were allowed to make laws on certain sensitive matters, especially those involving punishments for violation, it could lead to inconsistencies, varying standards, and potential dilution of rights. So Article 35 eliminates this risk by centralizing lawmaking authority with the parliament and ensuring no state can create arbitrary or inconsistent standards for the enforcement of fundamental rights. So, with regarding to Article 35, the Constitution empowers the power to enact the laws in the parliament and exclusively denying the same to the state legislatures. That is, it brings about uniformity throughout the country for implementation and enactment. So, the textual essence of Article 35, notwithstanding anything in the Constitution, are Clause A, Clause 1, that is Article 22, Article 35, Clause A, Clause 1, the Parliament shall have and the state legislature shall not have the power to make laws with respect to matters specified under Article 16.3, Article 32.3, Clause 3, 33 and 34. So, Clause A, Clause 2, Article 35, Clause A, Clause 2, the Parliament shall have exclusive power for prescribing punishment for acts declared as offences under Part 3 Fundamental Rights. So, Clause A and Clause 2, Article 35, who has the exclusive power? The Parliament has the exclusive power for prescribing punishment for acts declared as offences under Part 3 Fundamental Rights. And transitional provision. The Parliament was required to enact punitive laws as soon as possible after the Constitution came into force. Pre-existing laws on these subjects continue until altered by the Parliament. So, key areas, residence and courts. So, Article 16.3, the Parliament has exclusive powers to make laws under Article 16.3. So, the Article 16.3 deals with residence requirement for public employment. So, Article 16.3, the Parliament, not the states, may prescribe residence as a qualification for employment, certain employments or appointments under the state, union territory or local authority. What is the rationale? It prevents arbitrary state level barriers and maintains uniformity, that is national integrity in public jobs. So, the Parliament, only Parliament, not state legislature, can prescribe local residence or residence as a qualification for certain employment under the state, union territory or local authority, and it prevents the arbitrary state level barriers and maintains national integration and public jobs. Empowering the courts other than the Supreme Court and High Courts. Article 32.3, who can empower the other courts? Courts other than Supreme Court and High Court? Only Parliament. So, only Parliament can empower subordinate courts to issue writs or directions, orders or writs for the enforcement of fundamental rights. Right now, an aggrieved citizen, when his fundamental rights are violated, he can approach the Supreme Court under Article 32 and High Court under Article 226. But the provision in the Constitution, Article 32.3, the Parliament can empower even the subordinate court to issue directions, orders and writs for the enforcement of fundamental rights. The state legislatures are completely barred from exercising these powers. So, Article 16.3, only Parliament, employment, residence as a qualification for employment, and Article 32.3, that is empowering the subordinate courts to issue directions, orders and writs. The Parliament can. Key areas: armed forces and martial law. Article 33, that is the parliament who can impose restrictions, that is the application of the fundamental rights to the armed forces can be restricted by a law made by the parliament. So restriction or abrogation of fundamental rights for armed forces, police, etc. Article 33, the parliament alone can modify or restrict the application of fundamental rights to the members of armed forces, police forces, intelligence agencies, etc. to ensure discipline and national security. So, who can restrict the application of the fundamental rights or modify the application of the fundamental rights to the armed forces, police forces, intelligence forces, analogous agencies, etc.? That is the parliament only. Parliament alone can. Why? To ensure discipline and national security. Indemnity under martial law. Indemnity is providing immunity. So, Article 34, who can provide immunity to the public servant? Indemnity under martial law. Indemnity is providing immunity to the government servants or persons for acts done during the operation of martial law. So, who can indemnify? The parliament can indemnify any government servant or person for acts done during operation of martial law in any area. So, punishment for offences under specific fundamental rights. This is the most important and frequently, that is the aspect of Article 35. So, the parliament can alone prescribe punishment for acts declared as offences under Part 3. Two major examples illustrate this exclusive power in action. So, who can make laws for punishment for the violation of fundamental rights? Only parliament. In both cases, state legislatures are completely banned from prescribing penalties for those offences. Only parliament has the authority. Article 17, abolition of untouchability. So, the constitutional prohibition, that is untouchability, is abolished and its practice in any form is forbidden. Enforcement of any disability arising out of untouchability is an offence. The original legislation, that is the parliament, only parliament can enact. So, the parliament has enacted the Untouchability Offences Act 1955 to give teeth to this fundamental right. It was strengthened in 1976, that is, it was comprehensively amended and made more stringent in 1976 and renamed as Protection of Civil Rights Act 1955, and state legislatures were barred. That is, state legislatures have no power to legislate on this matter. It is the exclusive domain of the parliament. Article 23, prohibition of traffic in human beings and forced labor. So, constitutional prohibition on beggar or other forms of forced labor, that is work without pay, that is beggar or other forms of forced labor, are prohibited under Article 23 of the Constitution. Who has the exclusive power? The parliament has the exclusive power. Article 35 empowers only parliament to prescribe punishment for violations of Article 23, and state legislatures are barred. The state legislatures are barred from making laws prescribing penalties for these offences. And key legislation, the Bonded Labour System Abolition Act. The Bonded Labour System Abolition Act is the primary example of Parliament exercising this exclusive power. So, who can make laws under Article 23? Only Parliament can. The state legislatures are barred. Article 23 deals with the prohibition of tariff in human beings and forced labor. So, the Parliament, example of the Parliament exclusive powers under Article 23 is Parliament has enacted a law under the Bonded Labour System Abolition Act. So, the Article 35, the following table consolidates all provisions under Article 35 where the parliament holds exclusive legislative power and the state legislatures are debarred. So, provision related article, exclusive power of the parliament, state legislature barred, and key legislation. So, residence for employment, article 16.3, yes, the parliament has exclusive powers. That is, the parliament can prescribe residence as a qualification for certain employments in the state, local authorities, etc. And state legislation is debarred. Certain lower level jobs, okay, not gazetted jobs, writs by other courts. Okay, so right now the writs, an aggrieved person on the violation of his fundamental rights can approach Supreme Court or the High Court for the violation of his fundamental rights. The Supreme Court under Article 32 can issue writs and High Court under Article 226 can issue writs. So, the Parliament has the exclusive power to make laws that empower the subordinate courts to issue writs, directions and orders. So, writs by other courts, Article 32.3. Yes, the Parliament has the exclusive power. The state legislature is debarred. Yes. Fundamental rights, application of fundamental rights to the armed forces, Article 33. The Parliament can make law and restrict or modify the application of fundamental rights to armed forces, police forces, intelligence services, or analogous services, etc. Article 33. So, who has the power? Exclusive power. Parliament has the exclusive power to make laws and state legislature is debarred. Example, Army Act. Martial law indemnity, that is Article 34, that is providing immunity, indemnity to the public servants or officers during martial law, when the martial law is in force. So, Article 34, who has the power? The Parliament has the power, state legislature does not have. And punishment for untouchability, Article 17, yes, only the Parliament has power to make laws, not the state legislature. That is Protection of Untouchability Offences Act 1955, and it was amended in 1976 to provide for and amended, and it was strengthened. The law was strengthened and it was renamed as Protection of Civil Rights Act 1955. And punishment for trafficking and forced labor, Article 23. Who can make laws? The Parliament can make laws and the state legislature is debarred. So, the Parliament has made the law Bonded Labor System Abolition Act. What are the key takeaways? Article 35, uniformity of fundamental rights. Article 35 ensures that the fundamental rights are enjoyed uniformly by all the citizens throughout the country, preventing inconsistencies across the states by empowering the Parliament alone to make the laws. Centralized legislative authority, that is by vesting exclusive power in the Parliament and explicitly denying the same to the state legislatures, Article 35. Eliminate the risks of varying standards and potential dilution of the rights. And most tested aspect, the Parliament's exclusive power to prescribe punishment for offences under Part 3, especially Article 17 and Article 23. Article 17, untouchability, and Article 23, that is protection against trafficking and forced labor, that is provision of traffic in human beings and forced labor. The most important and frequently examined dimension of Article 35. Continuity of the pre-existing laws, that is pre-existing laws on these subjects continue until altered by the Parliament, ensuring no legal vacuum arises in the interim. So, the laws which are already existing continue to be enforced until the Parliament makes a new law, so that no legal vacuum arises in the interim. Historical background and sources of our Indian Constitution. Our Indian Constitution is not a product of single source, that is, it is a synthesis of provisions borrowed from various foreign constitutions as well as the Government of India Act 1935, which remains its most profound and material source. The Government of India Act 1935, the most important source, that is the Government of India Act 1935, had the greatest influence on framing of the Constitution, Indian Constitution. Many structural features were directly adopted from it, although the provision of All India Federation proposed in the 1935, that is Government of India Act 1935, never materialized due to non-accession of princely states. Its structural blueprint heavily influenced the federal structure of independent India. So, the All India Federation, the provision of All India Federation contained in the Government of India Act 1935 was never realized due to the non-accession of the princely states, but its structural blueprint heavily influenced the federal caste structure of the independent India. So, what are the key features borrowed from the Government of India Act 1935? So, the federal scheme with a strong center, that is division of powers into federal, provincial and concurrent lists. Provincial autonomy, that is abolition of diarchy in the provinces. Diarchy in the provinces was introduced by the Government of India Act 1935. That is, Government of India Act 1919, that is Montague-Chelmsford reforms, was a system of dual provincial government operating from 1921 to 1937. So, the abolition of diarchy, that is diarchy in the provinces, that is diarchy in the provinces was introduced by the Government of India Act 1919, Montague-Chelmsford reforms, that is it was in force from 1921 to 1937. So, diarchy means dual provincial government, that is operating from 1921 to 1937, that is it divided the provincial subjects or provincial administration into reserve subjects and transfer subject. So, reserve subjects were administered by the governor with the help of his council, and transfer subjects were administered by the government with the help of the minister responsible to the provincial legislatures. So, the diarchy in provinces, which was introduced in the Government of India Act 1919, Montague-Chelmsford reforms, was abolished by the Government of India Act 1935, and introduction of responsible government, that is provincial autonomy, was introduced by Government of India Act 1935. So, the abolition of diarchy. So, provincial autonomy was established by the Government of India Act 1935 and implemented in 1937, granted Indian provinces self-governance. That is, it granted Indian provinces self-governance, and not only self-governance but also allowing them to act as independent units with elected ministers, abolishing the previous diarchy system. So, it granted Indian provinces self-governance, allowing them to act as independent units with elected ministers, abolishing the previous diarchy system. So, 3 legislative lists. Another key feature of the Government of India Act 1935, 3 legislative lists, that is union list, state list and the concurrent list, the basic framework of legislative relations. Federal Court, that is the predecessor, that is the prototype of the Supreme Court of India, established in 1937. So, the Supreme Court of India, which was established in 1937, its predecessor was the Federal Court, and public service commissions, that is federal and provincial public service commissions, established, and Reserve Bank of India, established under this act, also included the Governor's Office and emergency provisions. So, Governor's Office and emergency provisions were also included. So, the key features borrowed from the Government of India Act 1935, that is the federal scheme with a strong center, that is division of powers into federal, provincial and concurrent lists. Provincial autonomy, that is abolition of diarchy in the provinces and introduction of responsible government. 3 legislative lists, union list, state list, concurrent list, the basic framework of legislative relations. Federal Court, prototype of the Supreme Court of India, established in 1937. Public Service Commissions, that is federal and provincial public service commissions, established, and Reserve Bank of India, established under this act also includes the governor's office and emergency provisions. So Charter Act of 1953, the foundation of parliamentary system. So the Charter Act of 1953, not the Cripps-Michel plan of 1942, laid the foundation of parliamentary form of government in India. Key contributions of the Charter Act of 1853, that is, for the first time, it separated legislative and executive functions of the Governor General's Council, and it added 6 legislative councillors, creating a separate Indian Central Legislative Council. This council functioned as a mini parliament. This legislative council, Indian Central Legislative Council, it functioned as a mini parliament, adopting procedures similar to the British Parliament, and legislation was recognized as a distinct governmental function requiring special machinery and process. So these are some of the key contributions of Charter Act of 1857. That is, for the first time, it separated the legislative and executive functions of Governor General's Council. It added 6 legislative councillors, creating a separate Indian Central Legislative Council, and this council functioned as a mini parliament, adopting procedures similar to that of the British Parliament, and legislation for the first time was recognized as a separate or distinct governmental function requiring separate machinery or requiring special machinery and process. What about the Cripps-Mission 1942? The Cripps-Mission 1942 proposes a dominant status and a constituent assembly, but failed due to disagreements between the Congress and the Muslim League. It did not introduce any parliamentary system. So the parliamentary system was introduced by Charter Act of 1853. In the Cripps Mission, it proposed the dominion status and constituent assembly, but it failed due to disagreement between the Congress and Muslim League. It did not introduce parliamentary system. So the Cripps Mission did not lay the foundation of the parliamentary system. That credit belongs to the Charter Act of 1853. So Cabinet Mission Plan 1946, the formation of the Constituent Assembly. The Cabinet Mission Plan 1946 played a crucial role in the formation of the Constituent Assembly. It proposed a Constituent Assembly to frame the Constitution of India. That is the Cabinet Mission Plan. It proposed a Constituent Assembly to frame the Constitution of India. Indirect election method. Members were to be indirectly elected by the provincial legislative assemblies, elected in January 1946 on limited franchise. That is, election to the Constituent Assembly was indirect. That is indirect election method. Members were to be indirectly elected by the provincial legislative assembly and elected in January 1946 on limited franchise. So there was no universal franchise. And representative composition, that is assembly was to consist of representatives of major political groups. Practical compromise on suffrage. Although adult suffrage was ideal, the Cabinet Mission Plan felt that there was insufficient time, so indirect election through provincial assemblies was adopted. So the Cabinet Mission Plan, it felt that is, though universal adult suffrage is ideal, it felt that there is insufficient time, so indirect election through provincial assemblies was adopted, and the first meeting was held on 9th December 1946. The Constituent Assembly met for the first time on 9th December 1946 and eventually drafted the Constitution of India. So Cabinet Mission Plan 1946 played a crucial role in the formation of the Constituent Assembly. Constituent Assembly was established under the provisions of the Cabinet Mission Plan. That is, it proposed the Constituent Assembly, and the election was indirect elections. That is, the elected members of the provincial legislatures elected their representatives, and it was a limited franchise, and representative composition, that is assembly, was to also consist of representatives of major political parties, and it was not universal adult suffrage because of insufficient time, indirect election through provincial assemblies was adopted, and the first meeting was held on 9th December 1946, and the Constituent Assembly drafted the Constituent. So summary table for quick revision, that is feature most profound influence on the Indian Constitution. It is the Government of India Act 1935, and key contribution, that is the federal structure, lists, provincial autonomy, the Federal Court of India, okay, the Public Service Commissions, the Federal Court of India, Reserve Bank of India, Governance Office, emergency provisions, 3 legislative lists. Laid the foundation for parliamentary system. Which act laid the foundation for parliamentary system? It is the Charter Act of 1853, not the Cripps Mission. And separation of legislative and executive functions. Formation of Constituent Assembly, that is the Cabinet Mission Plan, 1946. The Constituent Assembly was established under the provisions of Cabinet Mission Plan, that is indirect election by provincial assemblies. So, current affairs relevance of the Government of India Act 1935. In 2025, while commemorating the 90th anniversary of the Act passed in 1935, several constitutional experts and Supreme Court observations highlighted how the federal scheme and the emergency provisions of the 1935 Act continue to influence the center-state relations even today. So, the Government of India Act 1935, its federal provisions and the emergency provisions, that is the federal scheme and emergency provision, they continue to influence the center-state relations even today. So, debates on asymmetric federalism, that is the center, that is distribution. Federalism is distribution of power between center and states. So, the asymmetric federalism means the central government is more powerful than the state. So, this asymmetric federalism, governor's role and residuary powers, resting of the residuary powers in the center often trace their root back to this Act, that is 1935, Government of India Act 1935. Current affairs relevance, parliamentary system 2025-26. In 2025-26, there has been a renewed discussion on the suitability of the parliamentary system for the India's diverse polity. Some political voices suggested exploring a presidential system, but the Supreme Court and most constitutional scholars reaffirmed the strength of parliamentary system, that is the Westminster model. The Charter Act of 1853, separation of legislative and executive functions, Montfort reforms, that is Montague and Chelmsford reforms, expansion of legislative councils, and Government of India Act 1935, provincial autonomy and responsible government. Independent India, that is it's followed. The Westminster model was fully followed. So, the efficient functioning of the parliament and state legislatures during the budget session of 2026 was cited as an example of resilience of the parliamentary system of government. So, the current affairs relevance, Cabinet Mission and Constituent Assembly. The 80th anniversary of the Cabinet Mission Plan, March 2026, was saw nationwide seminars and articles recalling its role in making of the Constitution. So, anniversary significance, nationwide seminars and articles recalled the Cabinet Mission Plan's pivotal role in making of the Constitution and contemporary relevance. It was also used as a reference point in ongoing debates on electoral reforms and the need for a more representative Constituent Assembly-like body for future major constitutional changes or reforms. So, conclusion, the enduring legacy of historical sources. These historical sources continue to shape contemporary constitutional discourse on federalism, parliamentary democracy and center-state relations. The Government of India Act 1935, federal structure, 3 legislative lists, the emergency provisions, center-state relations remain deeply rooted in this Act. That is, the provisions of the Government of India Act 1935, that is a federal court, public service commissions, both federal and provincial public service commission, the Reserve Bank of India, the Governor's Office and Emergency Provisions, Provincial Autonomy, Abolition of Diarchy in the provinces, Introduction of Responsible Government, Federal Scheme with a strong center, that is division of powers between federal, provincial and concurrent list. So, the Government of India Act, Charter Act of 1853, the foundation of the parliamentary system was laid to the Charter Act of 1853, that is the separation of legislative and executive functions that underpins India's Westminster model, that is parliamentary system of government, and Cabinet Mission Plan 1956, formation of the Constituent Assembly through indirect election, the mechanism that gave India its democratic constitution. So, Indian constitution is not a product of single source. It is the synthesis of provisions borrowed from various foreign constitutions as well as the Government of India Act 1935, which it remains its most profound and material source. So, landmark Supreme Court judgment. Next topic, the landmark Supreme Court judgments. Key cases for UPSC, that is right to marry a person of one's choice. Shafin Jahan versus Ashokan case 2018, Hadia case. The Supreme Court held that the right to marry a person of one's choice is an integral part of Article 21, that is right to life and personal liberty. So the court emphasized individual autonomy, privacy and liberty. Choice of the partner lies in the exclusive domain of the individual and cannot be overridden by parental or societal concerns. So, the Supreme Court has emphasized on individual autonomy, privacy and liberty, and it has noted that the choice of the partner lies in the exclusive domain of the individual and cannot be overridden by parental or societal concerns. So, the Supreme Court has held that right to marry a person of one's choice is an integral part of Article 21, that is right to life and personal liberty. In Shafin Jahan versus Ashokan 2018 Hadia case and UPSC relevance, it reinforces the concept of personal liberty and right to privacy, that is Puttaswamy case linkage, frequently asked questions on Article 21 expansion. So, it reinforces the concept of personal liberty and right to privacy in Puttaswamy case. So, it is frequently asked question on 21 expansion. And decriminalization of homosexuality, that is Navneet Singh Johar versus Union of India case 2018. In Navneet Singh, that is the judgment, the Supreme Court read down article, that is section 377 of IPC, now replaced by BNS, Bharatiya Nyaya Samhita, decriminalizing consensual homosexual acts between adults. So, constitutional basis, the judgment recognized LGBTQ rights as part of Article 14, 15, Article 19(1)(a) and Article 21. Article 14, equality before law and equal protection of law. Article 15, prohibition of discrimination on the grounds of religion, race, caste, sex and place of birth. Article 19(1)(a), freedom of speech and expression, and Article 21, right to life and personal liberty. So, UPSC relevance, the key case on transformative constitutionalism, dignity, non-discrimination, often compared with other Article 21 expansions. Right to abortion of unmarried women. So, like married women, the unmarried women also have right to abortion. So, Principal Secretary Health and Family Welfare 2022. So, the ruling, in September 2022, the Supreme Court held that unmarried women have the same right to abortion as married women, that is up to 24 weeks under the MTT Act of 1971, that is Medical Termination of Pregnancy Act 1971 as amended in 2021. Marital status cannot be a ground to deny access to safe abortion. The court clarified that the term woman under MTP Act, that is Medical Termination of Pregnancy Act, includes all women irrespective of marital status. So the court ruled that marital status cannot be a ground to deny the access to safe abortion. So the court clarified that the term woman under MTP, Medical Termination of Pregnancy Act 1975, includes all women irrespective of marital status. So 2021 amendment expanded access, that is rape survivors, to rape survivors, minors, women with change in marital status, that is widowhood or divorce, women with disabilities, women with fetal anomalies, and humanitarian crisis. So UPSC relevance: progressive interpretation of reproductive rights under Article 21 highlights gender justice and bodily autonomy. So this interpretation of the Supreme Court providing right of abortion to unmarried women is a progressive interpretation of reproductive rights under Article 21, right to life and personal liberty, and also highlights gender justice and bodily autonomy. So balancing two virtuous cases, that is climate action and endangered species protection. The case M.K. Ranjit Singh and others versus Union of India case 2024 and 25. This case presented a unique dilemma before the Supreme Court, choosing between two good causes. One is renewable energy, the promotion of solar and wind power to combat climate change, and the other endangered species, the protection of GIB, Great Indian Bustard, a critically endangered species, population of 140, around 140. So what is the core issue? The core issue is the overhead power transmission lines in Rajasthan and Gujarat caused the bird collisions. This bird, that is the Great Indian Bustard, had poor vision and large size. So petitioners sought undergrounding of lines and embargo on new projects and bird diverters. So the court's balanced and nuanced approach, that is, it recognized the right to clean environment and right against adverse effects of climate change as part of Article 21 and 24 and 14, modified earlier directions and restrict 21 and 24, and emphasized the constitutional duties under Article 48A, that is constitutional duty of the state, and Article 51AG of the citizens for protection, for environmental protection. So modified earlier directions, that is restricted strict undergrounding and project bans only to revised priority areas for Great Indian Bustard conservation, allowed limited renewable projects with mitigation measures, bird diverters, corridor routing outside core zones. So it acknowledged India's international commitments, that is Paris Agreement for clean energy transition while protecting biodiversity. So this case, M.K. Ranjit Singh versus others versus Union of India 2024, is balancing between two virtuous cases relating to climate action and endangered species protection, acknowledging India's commitments to the Paris Agreement, that is international commitment for clean energy transition while protecting biodiversity. Another important Supreme Court ruling is regarding electoral bonds scheme, that is Association for Democratic Reforms versus Union of India 2024. The verdict: the Supreme Court declared the electoral bond scheme as unconstitutional, and the reason is anonymous donations. They violated the citizens' right to information under Article 19(1)(a). So, because of the anonymous donations received through the electoral bond scheme, it violated the citizens' right to information under Article 19(1)(a). Non-disclosure of donor details to a political parties, non-disclosure of donor details to political parties undermined transparency and free and fair elections. So, Supreme Court has declared electoral bond scheme as unconstitutional because the anonymous donations violated the citizens' right to information under Article 19(1)(a), and non-disclosure of donor details to political parties undermines transparency and free and fair elections. So, key constitutional principles at stake: Article 19(1)(8), right to information, transparency in electoral funding, and free and fair election as the basic feature of the Constitution. That is the basic structure of the Constitution. National next topic, National Register of Citizens (NRC) and related provisions. So, a comprehensive overview of the legal framework, history and current status and latest developments surrounding the India's National Register of Citizens, National Identity Card provisions and National Population Register. NRC, National Identity Card and National Population Register. So, legal provisions for National Identity Card and NRC. The key legal framework, according to Section 14A, Clause 3 of the Citizenship Act 1955, inserted in 2004, the central government may compulsorily register every citizen of India and issue identity card to him or her. The central government is empowered to maintain National Register of Indian Citizens (NRIC). For this purpose, it may establish a National Registration Authority. Institutional structure: the Registrar General of India acts as the National Registration Authority and functions as the Registrar General of Citizens Registration. Important fact: the Registrar General of India is also the Census Commissioner of the country. So, the Registrar General of India acts as a National Registration Authority and he functions as the Registrar General of the Citizen Registration, and he is also the Census Commissioner of the country. So, Current Affairs 2025, in August 2025, the Ministry of Home Affairs informed the Parliament that the Citizenship Act 1955 empowers the central government to compulsorily register every citizen and issue national ID cards. So, what is National Register or Register of Citizens (NRC)? That is, National Register of Citizens (NRC) is the register containing the names of Indian citizens. Historical preparation: it was prepared only once in the history of Indian independence in 1950, in independent India in 1951, not in 1957. So, it was prepared in 1951. And how it was prepared? In 1951, NRC was prepared after the conduct of census of 1951. So, after the 1951 census, the NRC was prepared. NRC, National Register of Citizens, is a register containing the name of Indian citizens by recording particulars of all the persons enumerated during that census. And current status of National Register of Citizens (NRC), only state which published NRC as of January 2022 and continuing till 2026 is Assam. Assam is the only state in India where National Register of Citizens has been prepared and published. Governing authority, that is, the updation of NRC in Assam was done under the directives of the Ministries of Home Affairs, the Government of India, and not under the Ministry of Development of Northeastern Region. And Assam remains the sole state where NRC has been both prepared and officially published as of 2026. So, key facts about Assam NRC. The NRC in Assam, National Register of Citizens, was updated to identify and weed out illegal Bangladeshi and other neighboring immigrants. The entire exercise was carried out under the supervision of the Supreme Court of India. 1st Jan 2018, the first draft released containing 1.9 crore names out of 2.9 crore applicants. 30th July 2018, the first NRC list published containing 2.89 crore names, and 31st August 2019, the final list contained approximately 3.1 crore names out of 3.3 crore population, excluding about 19 lakh applicants. So, current affairs 2025-26, the Assam NRC finalized in 2019, that is August 31st August 2019, remains in legal limbo as Registrar General of India has not yet notified it officially. In November 2025, the Supreme Court issued notices to the centre and Assam government on multiple petitions, one seeking comprehensive time-bound re-verification of NRC due to alleged irregularities filed by former State NRC Coordinator Hitesh Dev Sharma, and another petition by Jamaat Ulema-e-Hind and AAMSU demanding the completion of pending statutory steps. The Election Commission excluded Assam from the Special Intensive Revision SIR of electoral rolls in 2025, citing the incomplete NRC process. The opposition parties and civil societies continue to debate the fate of 19 lakh excluded persons and linkage issues, that is proposed NRC and Aadhaar linkage, National Register of Citizens. So, National Population Register often compared with National Register of Citizens. So, National Population Register is a register of usual residents of the country, not necessary citizens. It contains details of persons usually residing in village, rural area, town, ward or any demarcated area, and National Population Register was first prepared in 2010 and updated in 2015 under the Citizenship, Registration of Citizens and Issue of National Identity Card Rules 2003. National Population Register will be updated along with the house listing and house operations of the forthcoming census, that is 2026. Objective: to create comprehensive database of usual residents of the country, and no documents are collected during this exercise. Current Affairs 2020. As of March 2026, the Registrar General of India has stated that no decision has been taken yet on the updation of the National Population Register. The Union Budget 2026-27 has allotted 6,000 crores for the upcoming census 2027 and NPR related activities. The next digital census is scheduled in 2 phases, likely starting from October 2026 and March 2027. National Population Register updation is expected to be linked with the house listing phase of this census, and the government has repeatedly clarified that no decision has been taken for nationwide National Register of Citizens or National Register for Citizens and National Register for Indian Citizens. Scheduled areas and tribal areas. Next topic is scheduled areas and tribal areas in the under the Indian Constitution. So Article 244 and 5th and 6th schedule. 5th schedule deals with the administration and control of the scheduled areas and scheduled tribes, and 6th area deals with the administration, or that is control and control of the tribal areas in the states of Assam, that is in the states of Assam, ATM square, that is Assam, Meghalaya, Tripura and Mizoram. Okay, so The constitutional provision, Article 244, Part 10 of the Constitution provides for a special system of administration of areas notified as scheduled areas and tribal areas to safeguard the interests of the tribal communities, protect their culture, land rights, and promote socio-economic development. So, Article 244(1), the provisions of the 5th schedule apply to the administration and control of the scheduled areas and scheduled tribes in all states other than or except Assam, Tripura, Meghalaya, and Mizoram. Whereas Article 244 Clause 2, the tribal dominated areas in the states of Assam, Tripura, Meghalaya, and Mizoram are administered under the 6th schedule as tribal areas. So, Article 244, Part 10 of the Constitution provides for a special system of administration of areas notified as scheduled areas and tribal areas to safeguard the interests of tribal communities and protect their culture, land rights, and promote socio-economic development. Key distinction: 5th schedule deals with the scheduled areas. 6th schedule deals with the tribal areas, technically different from the scheduled areas, and these two schedules are constitutionally distinct. Tribal areas under the 6th schedule are not same as the scheduled areas under the 5th schedule. So, why special provisions? At the time of framing the Constitution, the framers recognized that certain tribal communities, due to their isolated and primitive lifestyle, require special safeguards for the protection, cultural preservation, and socio-economic advancement. So, the Constitution seeks uniformity but provides exceptions through these schedules. So, the comparison between 5th and 6th schedule. So, applicable to the states. 5th schedule, that is scheduled areas, is applicable to all the states except the state of Assam, Meghalaya, Tripura, and Mizoram. So, 10 states have notified scheduled areas, that is Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan. So, 10 states have notified scheduled areas. So, all states have scheduled areas. That is, scheduled areas are applicable to all the states except the 4th northeastern states, that is Assam, Meghalaya, Tripura, and Mizoram. But till now, 10 states have notified the scheduled areas, that is Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan. 6th schedule tribal areas only related to the 4 states of Assam, Tripura, Meghalaya, and Mizoram. Institutional mechanism. The 5th schedule consists of Tribal Advisory Council created by the state legislature. 6th schedule consists of Autonomous District Council, ADCs. Here it is Tribal Advisory Council created by the state legislature. That is the institutional mechanism for administration of the 5th schedule, that is scheduled areas, is Tribal Advisory Council created by the state legislature. And 6th schedule, it is Autonomous District Councils or Regional Councils, constitutional bodies. Powers: mostly advisory and executive, that is Tribal Advisory Council, mostly advisory or executive. It has limited powers, that is no legislative, judicial, or significant financial powers. Whereas the Autonomous District Council, they have extensive legislative, executive, judicial, and financial powers derived directly from the Constitution. And governor's role with regarding to the 5th schedule, scheduled areas, significant, the governor has significant regulatory powers. Executive powers of the state extends to the scheduled areas. And with respect to 6th schedule, that is tribal areas, the governor can organize or reorganize district and assent required for the laws. Land and resources, that is the 5th scheduled area, it protects against land. Tribal Advisory Council protects against land alienation. Pisa Act, Panchayat extension to the Scheduled Areas Act 1996 strengthens the Gram Sabha, and here the autonomous district councils. Tribal Advisory Council, Autonomous District Council. Autonomous District Council can make laws on land, forest, minerals and customs, and they have to be approved by the state legislature. And the autonomy level, lower autonomy, Tribal Advisory Council, lower autonomy, and state control remains strong. Here the Autonomous District Council, higher autonomy and self-governing bodies. So note on 5th schedule and UPSC relevance. Under the 5th schedule, that is regarding to scheduled areas, the executive administration and control of the scheduled areas, the executive power of the state extends to the scheduled areas subject to the scheduled provisions. Tribal Advisory Councils, TACs, have limited powers. The institutional mechanism for scheduled areas have limited powers and are often criticized for being ineffective due to rare meetings and lack of binding authority. So, the current affairs relevance 2024-26, the following developments make this topic especially important. So, demand for 6th schedule status. So, Ladakh, 97% tribal population, ongoing protests since 24-26, demanding 6th schedule for protection of land, jobs, environment and tribal identity after its UT status in 2029. That is through Jammu and Kashmir Reorganization Act 2019. The state of Jammu and Kashmir was divided into Jammu and Kashmir and Ladakh, 2 union territories. Okay. So, after its union territory status in 2029, the Ladakh, there are ongoing protests in Ladakh where 97% population is tribal for demanding 6th schedule for protection of land, jobs, environment and tribal identity. Arunachal Pradesh, the state assembly passed a resolution demanding inclusion of the entire state under the 6th schedule to strengthen the tribal land rights and autonomy beyond the Article 371H. So, Autonomous District Councils, recent developments. March 2026, Meghalaya Cabinet extended the term of Garo Hills Autonomous District Councils, GHADC, by 6 months amid protests over non-tribal participation in elections. And November 2025, 10 Northeast Autonomous District Councils urged the center for more financial resources and administrative powers through a sit-in at Jantar Mantar. And ongoing Manipur Hills areas, demands for 6th schedule in Manipur Hill areas to resolve ethnic tensions and granting law-making power over land and customs. So, the 5th schedule issues and broader context. The 5th schedule issues, the Tribes Advisory Council continue to function weekly. Meetings are infrequent and recommendations often ignored. The government encourages the states to strengthen the Tribal Advisory Councils, and only about 41% of Indian scheduled tribes live in notified scheduled areas. The rest, 59%, remain outside the special protection. So, the governor's role and implementation of Pisa remain key concerns in tribal land alienation cases. So, 45% of scheduled tribes in notified areas, that is only 41% of India's scheduled tribe lives within the notified scheduled areas, and 59% outside the special protections, that is the remaining 59% of the scheduled tribes live outside the special protection framework, and 10 notified states currently notified under the 5th schedule for scheduled areas. So, border context, these schedules frequently appear in debates on tribal rights versus development, land reforms, forest rights and federalism. Supreme Court and High Courts occasionally interpret the governor's powers under the 5th schedule for tribal welfare. Supreme Court of India versus Supreme Court of the United States, a comprehensive comparative analysis of two of the world's most powerful judicial institutions, their structure, jurisdiction, powers and evolving jurisprudence, alongside an overview of India's transformative Prerna program for students, leadership and nation building. So, the SCOTUS, Supreme Court of India, United States, the inscription "Equal Justice Under Law" is written above the main entrance of the Supreme Court building in Washington, D.C. It symbolizes ultimate responsibility of the court, highest tribunal. The SCOTUS is the highest tribunal in United States for all cases and controversies arising under the Constitution or laws of the United States of America. The guardian of the Constitution as the final arbiter of the law, it ensures the promise of equal justice under law and functions as the guardian and interpreter of the Constitution. The Supreme Court of India, unified judicial system. India has a unified integrated judicial system, that is single integrated judiciary, single hierarchy of the courts. Unlike double judicial system in USA, that is in India there is a integrated judiciary, that is the same set of courts, interpret both central and state laws. So in USA it is double judicial system, that is one, the parallel set of courts, that is federal courts and state courts, that is federal laws implementing. You have federal constitution and the state constitution. So federal laws are implemented by the federal courts and state laws are interpreted by the state courts. So it's a dual judicial system in USA, one federal and one state system. Inauguration. The Supreme Court of India was inaugurated on 28th January 1950. It succeeded the Federal Court of India, established under the Government of India Act 1935, and it replaced the Privy Council as the highest court of appeal, giving it wider jurisdiction than its predecessor. So, the Federal Court of India under the Government of India Act was not the highest court of appeal. So, it was Privy Council. So, the Supreme Court of India, which was established on 28 January 1950, it succeeded the Federal Court of India, which was established under the Government of India Act 1935, and it replaced the British Privy Council as the highest court of appeal, giving its wider jurisdiction than the predecessor. And constitutional provisions, the provisions relating to the Supreme Court are contained in Articles 124 to 147, Part 5 of the Constitution. The Parliament can regulate certain aspects. So the differences between Supreme Court of India and SCOTUS, that is feature Supreme Court of India and Supreme Court of USA SCOTUS. Judicial system, it is a unified, integrated, single judicial system. Same set of courts, single set of courts for both central and state laws. That is Supreme Court at the top, below the Supreme Court there are High Courts, and below the High Court there is hierarchy of subordinate courts. And here you have dual judiciary, that is parallel set of courts, the federal court and state courts. Federal courts, they have federal constitution. Federal courts for federal courts to interpret the federal laws and state courts to interpret the state laws. Original jurisdiction, that is the power of the court to hear the cases in first instance. So the original jurisdiction of the Indian Supreme Court of India is confined mainly to federal and center-state disputes, whereas the Supreme Court of USA, it is wider, not only federal cases but ambassadors, public ministers, admiralty and maritime cases. Appellate jurisdiction is very wide, that is as a matter of appeal, that is very wide, that is constitutional. In India, it is Supreme Court of India, it has appellate jurisdiction and it is very wide, relating to constitutional cases, civil cases, criminal cases, special leave petition under Article 136, plenary power. And here the SCOTUS limited mainly to constitutional cases. and advisory jurisdiction under Article 140 Supreme Court of India. That is, the President can seek the advice or opinion of the Supreme Court on any matter of law or fact. So it has advisory jurisdiction, Article 143, and SCOTUS does not have advisory jurisdiction. Judicial review, it has wide judicial review, but it is limited, subject to the constitutional provisions, and its judicial review is very wide. Judicial review is taken from USA. And protection of rights, according to the procedure established by law, Article 21, that is no person shall be deprived of his life and personal liberty except by procedure established by law. Article 21 taken from Japan. And here the SCOTUS, according to the due process of law, substantive plus procedural. That is scope of powers. Yes, the powers of the Supreme Court can be enlarged by the Parliament. Here it is limited to what is conferred by the Constitution. SCOTUS and superintendence. The Supreme Court has judicial superintendence and control over the high courts, and here the SCOTUS no such power over the state courts. So fundamental rights and limitations in India. Fundamental rights are not absolute. Limitations are mentioned in the Constitution itself. So fundamental rights are not absolute. That is, they are qualified. That is, reasonable restrictions are imposed on the fundamental rights, and they are mentioned in the Constitution itself. Article 19(1)(a), freedom of speech and expression is subject to reasonable restrictions like on the grounds of public order, decency, morality, etc. Article 19(1)(b), right to assemble peacefully without arms. The government can impose restrictions and declare assembly of 5 or more persons as unlawful in certain cases. So, the current affairs relevance 2025-26, SCOTUS ruling on presidential tariffs February 2026, in learning resources, INC versus Trump, the US Supreme Court 6:3 struck down the Trump's sweeping tariffs imposed under International Emergency Economic Powers Act. The court held that only the Congress has the power to impose tariffs, access to the pockets of the people. This case highlights the strict separation of the powers and limited executive overreach, drawing comparisons with India's basic structure doctrine and judicial review of executive actions. And India-US comparison in separation of powers 2026. Indian analysts noted that while SCOTUS exercises very wide judicial review, the Indian Supreme Court restrains itself from purely economic policy matters unless they involve violation of fundamental rights, manifest arbitrariness or bad faith. Example, R. Ranjit Singh judgment in 2025. The Indian court continues to expand the procedure established by law into more substantive form through proportionality and anti-arbitrariness tests. Ongoing trends in Indian Supreme Court 2026. Active judicial review in recruitment, exams, electoral rolls revision and judicial appointment. Continued emphasis on transformative constitutionalism while showing deterrence or while showing difference to the executive in policy domains. Debates on whether Indian jurisprudence is moving closer to substantive due process in practice, that is privacy, dignity and reasonable tests. So, the Indian jurisprudence is moving closer to due process of law, that is substantive due process in practice. Example, privacy, dignity and reasonable test. So, Brits under Indian Constitution. A comprehensive guide to 5 prerogative writs, their scope and limitations and the current relevance for UPSC 2025-26. The constitutional basis of writs. The Constitution empowers the Supreme Court, Article 32, and High Courts under Article 226 to issue 5 prerogative writs for the enforcement of fundamental rights, and in case of high courts, other legal rights. So, when an aggrieved citizen's fundamental rights are violated, then the citizen can approach the Supreme Court under Article 32 and High Courts under Article 226. The Supreme Courts can issue only writs only for the enforcement of fundamental rights, whereas High Courts can issue writs not only for the enforcement of the fundamental rights but other purposes also. So, Dr. B.R. Ambedkar called Article 32 as the heart and soul of the Constitution, as it guarantees the rights to constitutional remedies. Habeas corpus, the first writ, to have the body of, and what it does, the court orders the detaining authority, whether it's public or private, to produce the detained person before it. It examines the legality of detention and orders release if unlawful. Bulwark, this habeas corpus writ is the bulwark of personal liberty against arbitrary detention. When not used, when the detention is lawful, that is, the writ of habeas corpus cannot be issued when the detention is lawful, by competent court, when the detention is by competent court, for contempt of court or contempt of legislature outside the court's jurisdiction. So, UPSC relevance, it protects Article 21, that is right to life and personal liberty, using or used in illegal detention, preventive detention challenges, and missing person cases, not applicable if no illegal detention. Example, that is Odisha High Court 2023 ruling. Mandamus, we command. Definition: command issued to public official, body, corporation, tribunal or government to perform a mandatory public duty that they failed or refused to perform. When a public official, corporation, body, tribunal or government, it fails to perform its mandatory obligated public duty, then the mandamus is issued by the court. Cannot be issued against private individuals or bodies. For discretionary duties, for contractual obligations, cannot be issued against president or governors and chief justice in judicial capacity. Current relevance, frequently used for the enforcement of statutory duties, environmental protection, continuing mandamus, and directing authorities in bills. So, mandamus we command. Prohibition and quo warranto. So, prohibition to forbid, that is, it directs inactivity, it is preventive in nature, that is, it is issued by a higher court to a lower court or quasi-judicial tribunal to prevent it from exceeding its jurisdiction or acting without jurisdiction. So, it is available only against judicial and quasi-judicial authorities, not against administrative bodies, legislatures or private persons. So, it differs from mandamus, which commands action, whereas prohibition commands inactivity and it is preventive in nature. Certiorari, to be certified or informed, again issued by a higher court to a lower court or tribunal to quash or cancel an order passed by the lower courts without jurisdiction, in excess of jurisdiction or with error of law, apparent on record, issued after the final order. It is curative in nature, whereas prohibition is preventive in nature. It is issued after final order, it is issued before final order to stop. So, while prohibition is issued before to stop proceedings, it is available only against judicial and quasi-judicial authority, not purely administrative, legislative and private bodies. Quo warranto, by what authority? It inquires into the legal claim of a person or legality of a person's claim to a public office of substantive permanent character created by the statute or constitution. So, by what authority the person is holding public office of substantive and permanent character created by statute or constitution? It prevents illegal usurpation of public office, can be filed by any persons, any public spirited person, not necessarily aggrieved party. That is not issued, it is not issued for ministerial or private offices. UPSC relevance used in cases of disqualification of MLAs and MPs, appointment of unqualified persons to constitutional posts. So, key differences, quick recall for prelims. Prohibition, it is preventive, issued before final order. Certiorari is curative, issued after final order to quash. Habeas corpus and quo warranto, they can be filed by any interested person. No local standi is required, and mandamus against public duty only. So, current relevance for UPSC 2025-26, Article 32 trend. The Supreme Court increasingly directs petitioners to approach the High Courts first under Article 226 before invoking Article 32. Example, 10 temple control petitions in AP Telangana 2025, Ramzan leave case, Hathras stampede pill. This reflects judicial restraint, that is, and workload management while preserving Article 32 as a fundamental right. So, an aggrieved person, when his fundamental rights are violated, he can approach both Supreme Court and High Court. Supreme Court under Article 32 and High Court under Article 226. But the High Court is increasingly directing the petitioners to first approach the High Court under Article 226 before invoking Article 32. So, this reflects judicial restraints and workload management while preserving Article 32 as a fundamental right. Writ jurisdiction in pills. Writ jurisdiction remains vital in public interest litigations for environmental issue, anti-defection delays, privacy, like in Puttiswamy case, and protection against arbitrary state action, and recent emphasis on limits. Recent emphasis on limits of writs in criminal investigation and against purely administrative acts. So, recent emphasis on limits, that is recent emphasis on limits of writs in criminal investigation against purely administrative acts. So, this is regarding the writs. Article 21 and Article 15. Article 21 of fundamental rights are enshrined in Part 3, Article 12 to 35. So, the fundamental rights, Article 21 and Article 51 of the Directive Principles of the State Policy. So, Directive Principles of the State Policy are enshrined in Part 4, Article 36 to 51. So, a comprehensive look at two pivotal constitutional provisions, that is right to life and personal liberty, Article 21, and India's commitment to international peace under Article 51, and their real world significance in law and foreign policies. So, let us try to understand. So, Article 21, right to life and personal liberty, that is, no person shall be deprived of his life and personal liberty except by procedure established, except according to the procedure established by law. Article 21. So, who is protected? That is, this fundamental rights is available to both citizens and non-citizens, including foreigners. And what is the core guarantee? That is, no arbitrary deprivation of life or personal liberty is permitted. Any restriction must follow procedure that is reasonable, fair and just. So, this procedure that is reasonable, fair and just has been evolved. So the Maneka Gandhi versus Union of India case 1978, a significant landmark shift. That is, in this landmark Maneka Gandhi versus Union of India 1978 case, the Supreme Court gave an expansive interpretation of Article 21. It overlooked the narrow view taken in A.K. Gopalan 1950 and held that the procedure prescribed by law must be reasonable, fair and just. That is, due process of law should also be followed. So, in A.K. Gopalan case 1950, there was a narrow interpretation, that is the procedure established by law. That is the procedure of law taken on face value and no scrutiny of fairness. So, if the legislature is enacting a law and that law is made by the competent authority and the procedure has been followed, then the judiciary will not declare it as null and void. So, the A.K. Gopalan case 1950, there was a narrow interpretation of Article 21, that is the procedure of law taken at face value. Okay, if procedure is followed, then the judiciary will not declare it as null and void, and no scrutiny of fairness, that is whether the law itself is fair, just or reasonable or not, you will not take into consideration. But in Maneka Gandhi case 1978, the Supreme Court gave an expansive interpretation. Here the interpretation in A.K. Gopalan case was narrow, and in a Maneka Gandhi case, the Supreme Court has given an expansive interpretation, that is the procedure must be not only the procedure established by law should be followed, but also the procedure must be reasonable, fair and just, that is due process of law. So, procedure established by law is taken from the Japanese constitution and due process law from the American constitution. So, due process introduced, the court effectively introduced the American concept of due process into India's jurisprudence. So, this judgment transformed Article 21 into the heart and soul of the Constitution and serving as the foundation for many public interest litigations and judicial activism in India. So, this Article 21, because of the expansive interpretation of the judiciary in Maneka Gandhi case, Maneka Gandhi versus Union of India case 1978, this judgment, it transformed Article 21 into the heart and soul of the Constitution and serving as the foundation for many public interest litigations and judicial activism in India. So, key expansions under Article 21. Protection under Article 21 is available not only against arbitrary executive action, but also against arbitrary legislation or legislative action. So, both executive, legislative enactments and executive actions. If they are arbitrary, then the court will declare it as null and void. The scope of both right to life and personal liberty has been dramatically widened. So, right to life not limited to mere animal existence, but includes the right to live with human dignity. So, the right to life and personal liberty, Article 21. So, right to life has been expanded, and now it is not limited to mere animal existence, but includes the right to live with human dignity and meaningful existence. That is, it encompasses all aspects that make life meaningful, complete and worth living. Example, right to livelihood, right to health, right to education, right to clean environment and right to privacy, etc. And personal liberty has the widest amplitude and covers a variety of rights beyond mere physical freedom. So, personal liberty has the widest amplitude. So, it covers a variety of rights beyond the mere physical freedom and legislative check. Even the parliament cannot enact a law that arbitrarily deprives a person of his life and liberty. So, there is a legislative check also, that is check on the powers of the legislature, that is even parliament cannot enact a law that arbitrarily deprives a person of his life and personal liberty. That is, whenever the parliament enacts a law, the judiciary will declare it as null and void. So, India's peace mediation in Russia-Ukraine war. So, India has, you all know that the Russian-Ukraine war has been going on since 2022, ongoing, and also the West Asia war is also going on, that is between India, Israel and Iran. So, India's peace mediation in the Russia-Ukraine conflict. So, India has consistently advocated for peace resolution of the ongoing Russia-Ukraine conflict, which began in February 2022 and continues into 2026. PM Narendra Modi, he engaged with both the sides through visits to Moscow in 2024 and Kyiv in 2024, capital of Ukraine, the first by an Indian Prime Minister to Ukraine. Phone calls and public statements urging dialogue and negotiation, or dialogue, negotiation and cessation of hostilities. India has positioned itself as a neutral voice, emphasizing diplomacy over conflict. So, India, the Prime Minister has visited both Moscow and Kyiv, and is the first Prime Minister to visit Ukraine, and phone calls and public statements urging dialogue and cessation of hostility between the two countries. India is positioned as a neutral voice, that is, it has not sided with any of the country, and it has been a neutral voice emphasizing diplomacy over conflict. So the correct constitutional provision, that is rooting this diplomatic stance that India has taken with respect to Ukraine and Russia war. So the rooting this diplomatic stance is Article 51, Part 4 of the Directive Principles of the State Policy. So Article 51, India's constitutional mandate for international peace. So Article 51 directs the state to endeavor, or direct the state to endeavor to international peace and security, that is promote international peace and security as a core objective of state policy. Just and honorable relations, maintain just and honorable relations between nations. International law, that is foster respect for international treaties, law and treaty obligations. And the arbitration of dispute, encourage settlement of international disputes by arbitration. So Article 51, that is the India's constitutional mandate of the Directive Principles of the State Policy, India's constitutional mandate for international peace, that is Article 51, directs the state to endeavor to promote international peace and security as a core objective of the state policy. Just and honorable relation, maintain just and honorable relations between nations. International law, foster respect for international law and treaty obligations, and arbitration of disputes, that is settlements of encourage settlements of international disputes by arbitration. Directive principles, though non-justiciable, directive principles are non-justiciable, they cannot be enforced in the court of law. Fundamental rights are justiciable, they can be enforced in the court of law, that is whenever the fundamental rights of a citizen are violated, he can approach the Supreme Court under Article 32 and Article 226 High Court. And the High Court and Supreme Court, they issue writs for the enforcement of fundamental rights. So directive principles, though non-justiciable, serve as fundamental principles of governance. That is, Article 51 reflects India's commitment to Panchashil, non-alignment and strategic autonomy in foreign policy. India's balanced approach, maintaining strong defense and energy ties with Russia while engaging the West and the Ukraine, is guided by this constitutional mandate. So India's neutral stance, that is India's commitment to Panchashil, non-alignment and strategic autonomy in foreign policy, that is India's this balanced approach of India, maintaining strong defense and energy ties with Russia while engaging the West and Ukraine, is guided by constitutional mandate. So why other articles are incorrect? That is, understanding why Article 21, 19 and 30 does not apply to foreign policy. So only Article 51 applies to foreign policy, whereas Article 21, 19 and 30 does not apply to foreign policy. Mediation role is essential for clarity. Not apply to India's foreign policy mediation role. and is essential for clarity. So, Article 21, it is a fundamental right dealing with individual life and liberty. It has no direct link with India's foreign policy or mediation efforts in international conflicts. Article 19 guarantees 6 freedoms to citizens only, that is freedom of speech and expression, freedom to assemble peacefully without arms, freedom of association, movement, residence, profession and occupation. It is unrelated to international peace mediation. And Article 30 deals with the right of religious and linguistic minorities to establish and administer educational institutions of their choice. It was strengthened by 44th Constitutional Amendment Act 1978 after deletion of the right to property as the fundamental right. It is irrelevant to foreign policy. So, Article 31, Article 19 and Article 30, they are not related to India's foreign policy mediation role. So, Directive Principles of the State Policy, Part 4. Directive Principles of the State Policy are enshrined in the Constitution, Part 4, Article 36 to 51. So, origin and nature. We have borrowed the Directive Principles of State Policy from Irish Constitution, 1937, which in turn has borrowed from the Spanish, and Dr. B.R. Ambedkar called them the novel features of a Indian Constitution, and they are non-justiciable. That is, they cannot be enforced in the court of law for their violation. But the fundamental rights, but these directive principles of the state policy are fundamental in the governance of the country. Article 37. So, role and classification. The courts often use the directive principles of the state policies to interpret the fundamental rights and guide the legislative enactments. So, the court are the supreme final interpreter of the constitution, so the Supreme Court. So, while it is they use the directive principles of the state policy, that is, any legislative enactment, if it gives effect to the provisions of the directive principles of the state policy, then they shall not be declared null and void, and uses the directive principles of the state policy to interpret the fundamental rights and guide legislation. They are classified into 3 categories: socialist, Gandhian and liberal intellectual. The constitution does not provide for this this classification. We have classified it for our convenience. So, Article 15 falls under Article 51 falls under the liberal intellectual principles and forms the philosophical basis of independent foreign policy of India. So, current affairs link 24-26. So, Article 51 in action. So, India's mediation attempts in the Russia-Ukraine war highlights the practical application of Article 51. Despite global pleasures, India has avoided taking sides, prioritizing energy security and strategic interests, and promoted the dialogue and negotiations, that is cessation of hostility. And neutral stance, India has avoided taking sides despite significant global pressure from Western nations and international bodies. So, it has maintained a neutral stance. Strategic interests, India has prioritized energy security and strategic interests, maintaining strong defense and energy ties with Russia. So, strategic interests, India has prioritized energy security and strategic interests, maintaining strong defense and energy ties with Russia, and unique facilitator role. The US and several global observers have acknowledged India's unique role as a potential facilitator due to its trusted relations with both Russia and the West. So, US and many global powers have acknowledged India's role as a unique role as a potential facilitators due to its trusted relations with Russia and the West. So, the summary of Article 21 and 51 at a glance, that is, Article 21 and 51, part of the Constitution. Yes, Article 21 is a part of the Constitution. Part 3, Fundamental Rights, Article 12 to 35, and Article 51, part of the Directive Principles of the State Policy, Part 4, Article 36 to 51. And justiciable, fundamental rights are justiciable. That is, they are enforceable in the court of law. Whenever individuals' fundamental rights are violated, then he can approach the Supreme Court or High Court for the enforcement of the fundamental rights. The courts will issue writs under Article 32 Supreme Court and Article 226 High Court. So, Article 51, non-justiciable. Directive principles of the state policy are non-justiciable. They cannot be enforced in the court of law, and they are available to this. Available to fundamental rights are Article 21 are available to both citizens and non-citizens. Article 51, it guides state policy broadly. That is, these are fundamental in the governance of the state, and it is the duty of the state to implement these policies. And key landmark, Maneka Gandhi versus Union of India 1978, and India Russia Ukraine mediation 24-26. So Article 21, the scope has been expanded in Maneka Gandhi versus Union of India case 1978. That is, now due process, the procedure should be fair, reasonable and just. And Article 51, India Russia Ukraine mediation 24-26. Core idea, that is, right to live is not just animal existence but also human dignity due to the process. And Article 51, it promotes peace, arbitration and just relations. Significance, it is Article 21 is the heart and soul of the Constitution because of the pills, various pills that are being introduced, public interest litigations, and it is the philosophical basis of strategic autonomy. That is India's defense policy, which follows strategic autonomy, that is having relationships with all the countries, and it is autonomous in taking decisions, not to be pressurized by any countries. So Article 21 and Article 51, they demonstrate how Indian Constitution operates at both individual and global level, protecting personal dignity at home while guiding India's role as a responsible peace-seeking nation abroad. Okay, so Article 21 and Article 50. Article 21, that is individual, and Article 51, that is global level, that is Article 21, protecting the dignity of an individual at home, and Article 51, India's role, guiding India's role as a responsible peace-seeking nation abroad. Article 39B and 25th Constitutional Amendment Act 1971. So, a deep dive into the socialistic vision of the Indian Constitution, the landmark 25th Constitutional Amendment Act 1971, and the continuing tension between the directive principles of the state policy and the fundamental rights from 1971 to 2026. So, Article 39B, the constitutional provision, that is 39B of the directive principles of the state policy, Part 4, provides that the state shall direct its policy towards ensuring that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. So, equitable distribution of resources of the community for common good. So, socialistic vision, this provision reflects the socialistic vision of the Constitution. It seeks to prevent the concentration of wealth and resources in few hands. Equitable distribution, that is, it promotes equitable distribution of material resources of the community for the welfare of the society as a whole. So, background, the bank nationalization case, that is in the context of 25th Constitutional Amendment Act, in 1969, the bank nationalization, that is the 1969, in 1969, Indira Gandhi government nationalized 14 major commercial banks. The move was challenged before the Supreme Court in the landmark case of R.C. Cooper versus Union of India 1970, particularly known as the bank nationalization case. So, the Indira Gandhi government, as in 1969, it has nationalized 14 major commercial banks, and this move of the Indira Gandhi government was challenged in the Supreme Court in the landmark case of R.C. Cooper versus Union of India 1970, popularly known as the bank nationalization case. So, the Supreme Court ruling, the Supreme Court struck down parts of the nationalization law, holding that the compensation provided was not adequate. That is, when the banks were nationalized, the state did not provide the adequate compensation, and it violated the fundamental right to property under Article 31, and it violated the right to carry on business of, that is, it violated right to carry on business under Article 19(1)(g), that is, to carry on his profession or business. The individual has a right to carry on his business. So it was passed by Parliament on 28th April 1972. So the objectives of 25th Constitutional Amendment Act: it overcame the Supreme Court's judgment, that is, to overcome the Supreme Court judgment in R.C. Cooper case. It facilitated easy property acquisition, that is, easier property acquisition, that is, to facilitate easier acquisition of property by the state for public purposes. The key challenges introduced by the 25th Amendment: the amendment to Article 31, Clause 2. The word compensation was replaced by the word amount. This allowed the government to fix any amount, even nominal, by law for acquired property. The adequacy of this amount could not be challenged in any court. So these are the key challenges. This is one of the key challenges, that is amendment to Article 31(2). The word compensation was replaced by the word amount, and this amount was fixed by the government, that is any amount, even nominal, by law for acquired property, and the adequacy of the amount cannot be challenged in any court. Insertion of Article 31C, that is, Article 31C was inserted by 25th Constitutional Amendment Act 1971. That is, it says, Article 31C, that is, no law giving effect to the directive principles of the state policy, Article 39B and Article 39C, could be declared void on the ground that they violate the fundamental rights of Article 14, equality before law and equal protection of the law, Article 19, 6 freedoms. So, if any law is giving effect to the directive principles of the state policy 39B, that is equitable distribution of resources of the community for common good, and Article 39C, that is prevention of concentration of the wealth. So, if any law is giving effect to these two directive principles of the state policy 39B and 39C, and it is violating Article 14 and 19, then they cannot be declared void. So, the laws implementing these two directive principles were given protection against the judicial review on the above grounds, and for state laws to get full protection, they have to be reserved for the consideration of the president and receive his assent. So later developments and evolution of right to property. So the 44th Constitutional Amendment Act 1978, it removed the right to property from the list of the fundamental rights by deleting Article 19(1)(f), right to property, Article 19(1)(f) and 31, dealing with right to property. So it was reintroduced as a constitutional right. Right to property was reintroduced as a constitutional right under the new article, Article 300A. And Minerva Mills case 1980, the Supreme Court struck down the part of Article 31C that gave unlimited powers or unlimited immunities to law for implementing Article 39B and 39C to protect the basic structure of the Constitution. So, Minerva Mills case 1980, the Supreme Court struck down the part of Article 31C which was inserted by 25th Constitutional Amendment Act 1971, that is giving unlimited immunity to laws implementing Article 39B and 39C to protect the basic structure of the Constitution. So, current affairs context, Article 39B has regained relevance in recent years. A 9-judge bench of the Supreme Court is currently examining the scope of material resources of the community under Article 39B. in the Property Owners Association versus State of Maharashtra case pending as of 2026. So, the court is deliberating whether privately owned properties and resources can also be considered as material resources of the community. So, the verdict is expected to have significant implications for the urban land reforms, that is the urban land reforms and redevelopmental projects, the private property rights, that is the private property rights of individuals and associations, and community welfare balance, that is the balance between individual rights and community welfare. So, this case highlighted the continuing tension between the fundamental rights, directive principles of the state policy, which promote social justice, and fundamental rights, which promote individual liberty, even 5 decades after the 25th Constitutional Amendment Act 1971. So, the tussle between the fundamental rights and directive principles of state policy is going on even 5 decades after the 25th Constitutional Amendment Act 1971. Recently, the Supreme Court, a 9-judge bench of the Supreme Court, is examining the scope of the material resources of the community under Article 39B in the Property Owners Association versus State of Maharashtra case pending as of 2026. So, the court is deliberating whether privately owned properties and resources can also be considered as material resources of the community. The verdict is expected to have significant implications for urban land reforms and redevelopmental projects, private property rights of the individuals and associations, community welfare balance, that is the balance between the individual rights and community welfare. So, UPSC relevance, that is the prelims, that is the provisions and objectives of the 25th Constitutional Amendment Act 1971, key changes to Article 31 and Article 31C, that is key changes to Article 31 and Article 31C, evolution of right of property from fundamental right to constitutional right, that is 44th Constitutional Amendment Act has changed the has taken away the Article 31 and Article 19(1)(f) and it has been made a constitutional right under Article 300A. So, the key takeaways: the 25th Constitutional Amendment Act 1971 was a major legislative effect to strengthen the implementation of socialistic directive principles by limiting judicial interference in matters of property acquisition and resource distribution. While the right to property lost its fundamental status in 1978 by 44th Constitutional Amendment Act, 44th Constitutional Amendment Act 1978 has taken away the right to property as a fundamental right, and that is both Articles 19(1)(f) and Article 31, and inserted a new article, that is Article 300A, and now it is a constitutional right. Debates around the Article 39B continue to shape India's legal and policy landscape even in 2026. So, 1971 25th Constitutional Amendment Act inserted Article 31C, that is the compensation was replaced by the word amount. 1978 44th Constitutional Amendment Act, right to property was removed from fundamental rights and Article 300A was introduced. Now, right to property is a constitutional right by taking away Article 19(1)(f) and Article 31. And 1980 Minerva Mills case, unlimited immunity of Article 31C was struck down to protect the basic structure. So, Article 31C by 25th Constitutional Amendment Act 1971. And 2026, the Property Owners Association and Maharashtra 9-bench judge is re-examining the Article 39B. The concept of equality in the Indian Constitution. So, the preamble of the Indian Constitution provides for equality of status and opportunity, that is explicitly secures to all its citizens equality of status and opportunity. This reflects the core idea that every individual as a human being is entitled to the same rights and opportunities to develop their skills, talents, and pursue their goals without any discrimination. So, the concept of equality in the Indian Constitution, that is the preamble of the Constitution, it explicitly secures to all its citizens equality of status and opportunity. This reflects the core idea that every individual as a human being is entitled to the same rights and opportunities to develop their skills, talents, and pursue their goals without any discrimination. So, key aspects of equality. The key aspects of equality, that is, equality is not equal to uniformity. People naturally differ in their choices, preferences, talents, and skills. Some may achieve greater success in their chosen fields than others. The diversity is natural and acceptable in a democratic state. So, equality, that the preamble pro equality of status and opportunity. So, the equality is not uniformity. That is, the people naturally differ in their choices, skills, the preferences, talents. So, some may achieve greater success in their fields, chosen fields than others. This diversity is natural and is acceptable in a democratic society. And what matters? Removal of unjust barriers. That is, true inequality arises not from differences in status, wealth, and privileges per se, but from unequal access to the basic goods and services such as education, healthcare, housing, nutrition. These create structural disadvantage and perpetuate an unjust society. So, equality implies equal rights and opportunities for all to develop their potential while allowing natural differences in talents and outcomes. The core issue is not the mere existence of inequality in status and wealth, but the denial of equal access to essential opportunities and basic services. So, the constitutional framework for equality. The Indian Constitution provides a comprehensive framework of equality through the three broad dimensions, that is civic equality, political equality, and economic equality. Civic equality through the fundamental rights part 3, that is article 14 to 18, guarantees equality before law, non-discrimination, that is article 14, equality before law and equal protection of law, article 15, that is prohibition of discrimination on the grounds of religion, race, caste, sex, and place of birth, and article 16, equality of opportunity in matters of public employment, and article 17, abolition of untouchability, article 18, abolition of titles. So, the Indian Constitution provides for a comprehensive framework of equality through three dimensions, that is civic, political, and economic. Civic equality, that is fundamental rights enshrined in the Constitution part 3, article 12 to 35 provides for civic equality, that is article 14 to 18 guarantees equality before law, non-discrimination, equal opportunity in employment, and abolition of untouchability and titles. Political equality through electoral rights under article 325 and 326, which ensures that no exclusion, that is no person shall be excluded from inclusion in the electoral rolls on the grounds of religion, race, caste, sex. And article 326 provides for universal adult suffrage, that is all the individuals who are enrolled in the electoral rolls and are above 18 years can cast their vote. So, the voting age was reduced by 61st Constitutional Amendment Act 1988 from 21 to 18 years. So, all the individuals who are above 18 years and who have enrolled in the electoral rights can cast their vote. This 61st Constitutional Amendment Act 1988 came into force in 1989. So, political equality through electoral rights, that is article 325 and 326, ensures no person shall be excluded from inclusion in the electoral rolls on the basis of religion, race, caste, sex, and universal adult suffrage. Economic equality through directive principles of the state policy part 4, that is article 39. It ensures equal right to adequate means of livelihood, equal pay for equal work, and prevention of concentration of wealth. 39b. Civic equality, fundamental rights part 3, that is article 14. Fundamental rights provides for civic equality, that is article 14 to article 18. Article 14, equality before law and equal protection of law. Article 15, prohibition of discrimination on the grounds of religion, race, caste, sex, and place of birth. Article 16, equality of opportunity in matters of public employment. And Article 18, abolition of untouchability, a landmark provision for social justice. And Article 18, abolition of titles except military and academic distinctions. Political and economic equality. So, political equality is promoted through Articles 325 and 326. 325, no person shall be excluded from inclusion in the electoral rolls on the grounds of religion, race, caste, sex. And 326, elections to Lok Sabha and state legislative assembly are on the basis of universal adult suffrage. That is, every individual who is above 18 years and has been enrolled in the electoral rolls has a right to vote. And economic equality, Article 39, that is equal right to adequate means of livelihood for men and women, equal pay for equal right, and prevention of concentration of wealth and means of production. So, important distinctions for UPSC, that is equality of opportunity, not outcome. The Constitution guarantees the equality of opportunity and absence of special privileges, not equality of outcome or identical results. Adequate opportunities without uniformity, that is the Constitution provides for adequate opportunities for all without discrimination, but does not promise the same opportunities to everyone as individual capacities and circumstances differ. Removal of unreasonable restrictions. So, equality in Indian context means removal of unreasonable restrictions and discriminatory barriers while allowing merit, effort, and diversity to play their role. That is equal access. So, current affairs context 24-26. In recent years, the discourse on equality has gained prominence in several contemporary issues, that is reservation policies, the ongoing debates and Supreme Court judgments on reservations in promotions, EWS quota 103 Constitutional Amendment Act, and subclassification within SC and ST 2024 judgment, and gender equality, that is implementation of Women's Reservation Act 2023, that is Nari Shakti Vandan Adhiniyam, which reserves 23% of seats for women in Lok Sabha and state assemblies to be implemented after the delimitation 2026, and digital divide and access, post-COVID emphasis on bridging the gaps in access to education and healthcare through the schemes like PM E-Vidya, PM E-Vidya is a comprehensive one nation, one digital platform. PM C-Vidya is a initiative, that is, it is a one nation, one digital, comprehensive one nation, one digital platform initiated by the Ministry of Education in May 2020 to under the Atmanirbhar Bharat to enable multi-mode access to education. It unites online, on-air and offline education to support 25 crore school-going children, emphasizing digital learning, quality education and equity. And Ayushman Bharat. Ayushman Bharat is launched in 2018, is the world's largest launched in 2018, is the world's largest government-funded health assurance scheme aimed at achieving universal health coverage. It provides 5 lakhs per family per year for secondary and tertiary care to over 12 crore poor families, covering 55 crore individuals, featuring pan-India portability and 1.5 lakh health centers. And the PM JANMAM, that is Pradhan Mantri Adivasi Nyaya Maha Adhiniyam scheme. So PM JANMAN is Pradhan Mantri Adivasi Nyaya Maha Abhiyan, Pradhan Mantri Janjati Adivasi Nyaya Maha Abhiyan scheme, launched in 2023 with a budget of 24,105 crore, aim to empower 75 vulnerable tribes. That is, these are particularly vulnerable tribal groups, that is PVTGs, across 18 states and 1 union territory. It focused on 11 critical interventions, including housing, healthcare, education, through 9 ministries to improve quality of life for these communities. So, the digital divide and access, the post-COVID emphasis on bridging gaps in access to education and healthcare through the schemes like PM E-Vidya, Ayushman Bharat and PM Janman of particularly vulnerable tribal groups. So, the social justice initiative and judicial interventions. Social justice initiatives, they focus on saturation approach under the schemes like Pradhan Mantri Awas Yojana, equitable access to housing, Jal Jeevan Mission, equitable access to water, and PM Poshan, equitable access to nutrition. These directly address the unequal access to basic goods, highlighting the concept of equality. So, the judicial interventions, the Supreme Court continues to expand the scope of equality under Article 14 by striking down the arbitrary state actions and emphasizing the substantive equality over mere formal equality. So, UPSC relevance for prelims, that is identification of correct and incorrect statements on the meaning of equality, a common pattern in UPSC prelims MCQs, and matching constitutional articles, that is matching constitutional articles with dimensions of equality, civic, political and economy across part 3 and part 4. So, key articles to remember: Article 14, equality before law and equal protection of the law; Article 15, absence of discrimination, that is prohibition of discrimination on the grounds of religion, race, caste, sex and place of birth; Article 16, equality of opportunities in matter of public employment; Article 17, untouchability; and Article 18, titles; Article 325 and 326, political equality; and Article 39, economic equality. So, UPSC relevance for mains. So, democracy in the Indian Constitution. So, the word democracy in the Indian Constitution, that is, democracy is a system of government in which the laws, policies, leadership and major decisions of the state are directly or indirectly decided by the people. That is, in a democracy, there is sovereignty of the people. Democracy means by the people, for the people and of the people. So, democracy is a system of government in which laws, policies, leadership and major decisions of the state are taken either directly or indirectly by the people. So, the preamble of the Indian Constitution declares India as sovereign, socialist, secular, democratic, sovereign, socialist, secular, democratic and republic. The words socialist and secular were added later. So, constitutional foundations of democracy. Democracy forms part of the basic structure of the basic structure of the Constitution as held in Keshavananda Bharati case 1973. And key elements of democracy include rule of law, free and fair elections, universal adult suffrage, and independent judiciary, and fundamental rights and minority rights. So these are the key elements of Indian democracy. There is rule of law, free and fair elections, universal adult franchise, independent judiciary, fundamental rights and minority rights. So franchise and universal adult suffrage. What is franchise and suffrage? The right of the people to vote and elect their representatives is franchise or suffrage, and universal adult franchise is every adult citizen who is 18 years or above has the right to vote without any discrimination. So that is universal adult suffrage. And constitutional provisions, these are enshrined in Article 326, universal adult suffrage. Elections are conducted by secret ballot to ensure freedom and fairness. So secret ballot protects the voters from coercion and ensures genuine expression of democratic will. So majority rule versus minority rule. So the democracy operates on the principles of majority decision making, that is the people. Ours is indirect democracy, that is the people elect their representatives through periodic elections. The people elect their representatives, and these representatives, they occupy the positions in the legislative bodies and they make laws on the behalf of the people. So democracy operates on the principle of majority decision making. However, it must simultaneously protect the rights and interests of the minorities, religious minority, linguistic minorities, cultural and others. So independent majority rule, minority rights, constitutional safeguards and independent judiciary. These are the key aspects of democracy, key features of democracy. So this balance is ensured through fundamental rights, Article 14 to 13, and independent judiciary and federal structure of the constitution. So this balance between the majority rule, independent judiciary, minority rights and constitutional safeguards is ensured through the fundamental rights, Article 14 to 30, and independent judiciary and federal structure of the constitution. So role of the opposition. So what is the role of the opposition in a democracy? It is a very important, the role of the opposition in democracy, that is watchdog on the government. That is, it acts as a watchdog on the government, ensuring the accountability and preventing authoritarian tendencies of the government, alternative policies and leadership. It provides, the opposition provides credible alternative policies and leadership to the electorate, and democratic legitimacy. It strengthens democratic legitimacy by offering choices to the electorate. Current affairs with regarding to electoral reforms. So continued debates on key electoral issues have shaped India's democratic discourse, that is one nation, one election, that is conducting simultaneous elections across the country. That is a major ongoing debate in the parliament for both Lok Sabha and state legislative assemblies. Electoral bonds struck down. The Supreme Court has struck down the electoral bonds in 2024, reigniting the push for state funding of elections. And the Law Commission and Parliament, the 63rd report of the Law Commission and the ongoing parliamentary discussions highlight concerns over money and muscle power in the elections. So the Law Commission report, 63rd report and the ongoing parliamentary discussions, they have highlighted concerns over money and muscle power in the elections. So opposition, voter participation and democratic challenges. The 18th Lok Sabha, that is from 2024 to 29, active opposition participation on issues like farm laws aftermath, reservation demands, delimitation and economic inequality. However, the frequent disruptions and walkouts have raised questions about the effectiveness of parliamentary opposition. So the voters, the opposition has actively participated, active opposition participation on issues like farm laws aftermath, reservation of demands, delimitation and economic inequality. However, the frequent disruptions and walkouts by the opposition have raised questions about the credibility or effectiveness of the parliamentary opposition. Voter participation. India has recorded higher voter turnout in 2024 general elections, and the Election Commission's SVEEP, that is the Systematic Voters Education and Electoral Participation Initiative, continues to promote voter awareness. And challenges to democracy, that is polarization, misinformation on social media, decline in public trust, judicial delays, and global reports like Freedom House flagging concerns about democratic backsliding in several countries, including debates on India's democratic health. So these are the challenges of democracy. That is misinformation. One of the challenge of democracy is misinformation. You also have polarization. So polarization, political polarization is the divergence of political attitudes towards ideological extremes, dividing societies into opposition camps and often viewing the other side as an existential threat. So polarization, misinformation on social media, decline in public trust in democracy, judicial delays, and global reports. These global reports are highlighting or flagging concerns about the democratic backsliding and in several countries, including debates on India's democratic health. So, women's representation, Nari Shakti Vandan Adhiniyam, the Women's Reservation Act 2023, Nari Shakti Vandan Adhiniyam, aims to reserve 33% of the seats for women in Lok Sabha and state assemblies. Implementation is scheduled post delimitation after 2026 census, strengthening inclusive democracy in India. This landmark judgment or landmark legislation represents a significant step towards genuine partnership between men and women in governance on the basis of equality. So, additional principles of democracy, that is human dignity and social justice. Democracy aims to preserve human dignity, promote social justice, and foster social and economic development. Free political competition, that is, it requires free political competition, equality before the law, and no one being above the law. Continuously evolving system. Its equality depends upon political, social, economic, and cultural factors. It is never static. And gender partnership in governance, that is, genuine democracy involves partnership between men and women in governance on the basis of equality. So, what are the key takeaways? Constitutional bedrock, that is, democracy is a part of India's basic structure. It cannot be amended or taken away. It cannot be amended away or taken away, as declared by the Supreme Court in Keshavananda Bharati case 1973. And rights and representations, that is universal adult franchise article 326 and fundamental rights article 14 to 30, and the minority protections are the pillars of Indian democratic practice. And accountability and opposition. A strong active opposition is essential for democratic health, acting as a watchdog and offering credible alternatives. And evolving and inclusive. From electoral reforms to women's reservation, Indian democracy continues to evolve towards a greater inclusivity, fairness, and social justice. So, next, directive principles. Next topic, directive principles of the state policies. That is, key provisions for promoting social justice and welfare. So, the directive principles of the state policies, DPSPs, are enshrined in the Constitution Part 4, Article 36 to 51 of the Indian Constitution. They serve as instruments of instructions to the state or to the government for establishing a welfare state based on the ideas of social, economic and political justice as outlined in the preamble. So, the directive principles of the state policy enshrined in the Constitution, Part 4, Article 36 to 51, they aim or they are instruments of instructions to the government for establishing a welfare state, and it is based on the ideals of social, political and economic justice as outlined in the preamble. So, origins and constitutional basis. The DSPs are borrowed from the Irish Constitution of 1937, which itself drew inspiration from the Spanish Constitution. They represent the positive obligations of the state. That is, Part 4, Article 36 to 51, the constitutional home or the provisions of all directive principles laying out the framework of a welfare state. The directive principles of the state policy lay out the framework of a welfare state. And Article 37, directive principles of the state policy are non-justiciable, that is, they cannot be enforceable in the court of law. So, the directive, Article 37 of the Constitution, it declares that the directive principles of the state policy are non-enforceable, and though the directive principles of the state policies are not enforceable in the court of law, yet they are fundamental in the governance of the country, and it is the duty of the state to implement these policies in the formulation, implement these in the formulation of the policy. So, these are like instruments of instructions for the government. So, role and significance of the directive principles of the state policies. DPSPs, they complement the fundamental rights and fundamental duties. Fundamental rights under Part 3, Article 12 to 35, and fundamental duties Part 4A, Article 51A, guiding policy making, legislation and judicial interpretation. They are instruments of instruction, that is, they guide the governments in establishing a welfare state based on social, political and economic justice and harmonious construction. The courts have used the doctrine of harmonious constructions, that is, they have used directive principles of the state policies for harmonious construction with the fundamental rights. Example, in Minerva Mills case, they were held to be part of the basic structure when read with fundamental rights. So, Minerva Mills case, the harmonious balance. In Minerva Mills case, the Supreme Court ruled that there should be a harmonious balance between directive principles of the state policy and fundamental rights. That is, they were held to be part of the basic structure when read with fundamental rights. So, the doctrine of harmonious construction, that is, the court uses the doctrine of harmonious construction when the two provisions of the Constitution are against each other, so that a harmonious relationship can be made. So, policy and legislation guide. So, directive principles of the state policy guide policy making, that is, these are instruments of instruction and it is the duty of the state to implement these principles in formulation of policy. So, policy making, legislation and judicial interpretations. Any law enacted, any legislative enactment, if it gives effect to the provisions of the directive principles of the state policy, then it cannot be declared null and void. So, the court uses the directive principles of the state policy for interpreting the fundamental rights across all branches of the government. Important provisions are matching format. The following are key articles frequently tested in UPSC prelims through matching or assertion reason questions. So, Article 46, the state shall promote special care, the state shall promote with special care the educational and economic interests of the weaker sections of the people, in particular scheduled castes and scheduled tribes, and shall protect them from social injustice and all forms of exploitation. So, Article 46, the state shall promote with special care the educational and economic interests of the weaker sections of the state, including in particular SCs and STs, and shall protect them from social injustice and all forms of exploitation. Article 48, the state shall endeavor to organize agriculture and on animal husbandry on modern and scientific lines, and shall in particular take steps for the preservation and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. So, Article 48 of the Directive Principles of the State Policy, it is the duty of the state, that is, the state should endeavor to organize agriculture and animal husbandry on modern and scientific lines, and it shall in particular take steps for preservation and improving the breeds and prohibiting the slaughter of cows and calf and other milch and draught cattle. Article 74, the state shall promote or regard the raising the level of nutrition and standard of living of its people and improvement of the public health as well as among its primary duties. In particular, the state shall endeavor to bring about prohibition of the consumption except for medical purposes of intoxicating drinks and drugs which are injurious to health. Article 38(2), the state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst the individuals but also amongst the groups of people residing in different areas or engaged in different vocations. So, Article 38(2), that is, the state should minimize inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst the individual but also amongst the groups of people residing in different areas or engaging in different vocations. So, Article 46, promotion of educational and economic interests of the weaker sections. This is one of the most important directive principles of the state policy for social justice. It specifically targets the scheduled castes and scheduled tribes and other weaker sections including OBCs, minorities and economically backward groups. In practice, linkages to scheme, post-metric scholarships, Ekalavya model residential schools, Stand Up India, PM Jan Dhan Yojana and various reservation policies in education and employment. They promote Article 46, that is promotion of educational and economic interests for weaker sections. And judicial reference, courts have used Article 46 while upholding the affirmative action, that is reservation and protective discrimination against weaker sections. So those courts, while interpreting or while giving judgments in various cases, it has upheld Article 346, that is in affirmative action and protective discrimination for weaker sections. Article 48, organization of agriculture and animal husbandry. This article reflects the constitutional emphasis on scientific agriculture and animal welfare. The key elements, that is modernization of farming techniques, breed improvement and prohibition of slaughter of cows, calves and other milch and draught cattle. Significance, it provides for constitutional backing to cow protection laws enacted by several states, balances agricultural development with cultural and economic considerations, that is dairy and draught power. Related, Article 48A added by 42nd Constitutional Amendment Act, Article 48A extends this framework for environmental protection. So, the Article 48A extension, that is Article 48 extension, that is Article 48A through the 42nd Constitutional Amendment Act, it extends this framework for environmental protection. Article 47, duty to improve nutrition and standard of living and public health. This article elevates public health and nutrition to the status of primary duties of the state. It explicitly promotes prohibition of intoxicating drinks and injurious drugs except for medical purposes. National Health Mission, a flagship scheme directly rooted in the state's duty under Article 47 to improve public health infrastructure Poshan Abhiyan and midday meal scheme directly address the mandate to raise the level of nutrition and standard of living of the people. Ayushman Bharat and state prohibition policies. Ayushman Bharat and state prohibition policies, in example in states like Gujarat and Bihar, implements Article 74 directives, and Article 74 underscores the welfare state character of the Constitution. Article 38(2), minimization of inequalities, added by 44th Constitutional Amendment Act 1978. This clause strengthens Article 38 Clause 1. It directs to reduce the inequalities not only among the individuals but also among the groups based on religion, region, vocation or area. That is, example, regional imbalances between states or rural-urban divide. What it directs? It strives to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst the individuals but also amongst the groups of people residing in different areas or engaged in different vocations. Relevance and policy impact: supports policies for inclusive growth, federal balancing, that is special category states, reduction of interstate disparities, and addresses rural-urban divide and regional importance or regional imbalance. So, classification of directive principles of the state policy. These articles fall under two major categories of directive principles of the state policy, that is socialist principle, that is welfare-oriented directives. So, they are aimed at reducing inequality, improving public health and ensuring social justice for all sections of the society. Key articles: Article 38 Clause 2 and Article 47. Gandhian principles: Article 46, 47 and 48. They reflect the Gandhian vision of village economy, cow protection and upliftment of the weakened sections including SC, ST and OBC. Key articles 46, 47 and 48. So, the relationship between fundamental rights. While directive principles of the state policies were initially subordinate to fundamental rights, the Supreme Court evolved the doctrine of harmonious construction. That is, when two provisions of the Constitution are against each other, then the court uses the doctrine of harmonious construction so that both can have a harmonious relation. So, Keshavananda Bharati case 1973, it established the basic structure doctrine, beginning the evolution of directive principles of the state policies relations with fundamental rights. And in Minerva Mills case 1980, directive principles of the state policy were held to be part of the basic structure of the Constitution when read with the fundamental rights, a landmark shift. That is, it provides for a harmonious relationship or harmonious balance between fundamental rights and directive principles of the state policy is a part of the basic structure of the Constitution. And RTE, Right to Education Act, modern example, the Right to Education Act links Article 21 fundamental right and Article 41. That is, Article 21A by 86th Constitutional Amendment Act 2002 has introduced the right to education, that is, right to free and compulsory education for all the children in the age group of 6 to 14 years. And it has changed the subject matter of Article 45 Directive Principles of the State Policy and also added a new fundamental duty, the 11th one, under Article 51A, Part 4A, showing how Directive Principles of the State Policies are given effect through legislation that also protects fundamental rights. So, implementation gaps and challenges. Despite progress through schemes, significant challenges remain in realizing the vision of these directive principles of the state policy articles. So, Article 32, Clause 2, persistent inequalities, income and opportunity gap between individuals and groups, regions and vocations remain a major challenge despite inclusive growth policies. And Article 46, exploitation of SCs and STs. Despite constitutional protection and affirmative action, exploitation of SCs and STs continues in many parts of the country. And Article 48, cow slaughter debates. The ongoing debates on cow slaughter bans versus farmer and livestock economies create tension between constitutional ideas and ground realities. So, current affairs angle and UPSC relevance. So, questions often link these directive principles of the state policy articles to contemporary government schemes and policies. The following corrections are frequently tested. So, Pradhan Mantri Awas Yojana linked to state duty to reduce inequality in status and facilities under Article 38(2). Ayushman Bharat directly implements the primary duty of improving the public health and standard of living under Article 47. And National Livestock Mission reflects the constitutional mandate of scientific animal husbandry and breed improvement under Article 48. State prohibition laws, Gujarat, Bihar and other states enact prohibition policies drawing constitutional authority under Article 47. And directive principles of the state policy through non-justiciable, though non-justiciable, they remain fundamental in the governance of the country, shaping every major welfare scheme and judicial interpretation in India's constitutional journey. Evolution of right to property in Indian Constitution from fundamental right to a constitutional right. So, from fundamental right to a constitutional right, the right to property has undergone one of the most significant transformations in the constitutional history of India, reflecting the ongoing tension between the individual rights and the socio-economic justice. At the commencement of the Constitution on 26 January 1950, the right was explicitly, that is right to property was explicitly guaranteed as a fundamental right under Part 3. So, original position 1950 Constitution. The Constitution of India came into being on 26 January 1950. So, at the founding of the Republic, the right to property was enshrined with two key provisions. That is Article 19(1)(f). That is, it was a fundamental right. Article 19(1)(f) and Article 31. Article 19(1)(f) guaranteed to all the citizens the right to acquire, hold and dispose of property, and Article 31 that it provided protection against deprivation of property, stipulating that no person shall be deprived of his property except by authority of law and with the compensation in most cases. However, this right was not absolute. That is, right to property under Article 31 and 19(1)(f) was not absolute. That is, Article 19 Clause 6 allowed the union and state legislature to impose reasonable restrictions. That is, fundamental rights are not absolute, they are qualified. Reasonable restrictions are imposed on the fundamental rights. So, allowed the union and state legislatures to impose reasonable restrictions on this right in the interest of the general public or for the protection of scheduled tribes in certain areas. So, the inherent conflict, that is the individual rights versus the development agenda, that is the state's development agenda. So, post-independence India has adopted a socialistic and welfare-oriented vision reflected in the preambles, objectives of socio-economic and political justice, and enshrined in the directive principles of the state policy under the Article 38 and 39. The state pursued the ambitious land reform programs and abolition of zamindari, that is sealing laws, redistribution to tillers, and the state-led industrialization and infrastructure projects. So, at the commencement, that is post-independence, there is an inherent conflict between the individual rights and the state's development agenda. That is the individual right of right to property and the state's development agenda, that is the post-independence India has adopted a socialist and welfare-oriented vision reflected in the preamble's objectives of socio-economic and political justice and the directive principles of the state policy under Article 38 and 39. The state pursued ambitious land reforms. Okay, so in order to bring about the socialistic and welfare-oriented vision, the state has pursued the ambitious land reforms programs, that is abolition of zamindari system, land reforms, land to the tiller, redistribution to tillers, and state-led industrialization and infrastructure projects. This created predictable and persistent conflicts. The state and the legislature and the executive, it sought to implement the socio-economic reforms for larger public interest and social justice. The judiciary, so the legislature and executive, they sought to implement the socio-economic reforms, the legislature by enacting laws and executive by implementing those laws. So sought to implement socio-economic reforms for larger public interest and social justice. The judiciary, acting as a guardian for fundamental rights, frequently struck down or diluted such laws when they infringed upon the property rights. So, over the decades, the Supreme Court nullified and severely restricted many progressive laws related to land reforms, acquisition for public purposes, and economic restructuring. This judicial intervention was seen by political executive as an obstacle to implement the directive principles of the state policy, achieving the socialistic goals of the Constitution. So, earlier amendments, that is earlier attempts to resolve the deadlock, that is the deadlock between individual rights and the state's development agenda. So, that is the directive principles of the state policy. So, to resolve this deadlock, several earlier amendments were made which introduced protective clauses, yet the core tension remained. So, first Constitutional Amendment Act 1951 was introduced, that is earlier protective clauses were introduced for agrarian reform laws, that is the laws, Zamindari, Abolition and Land Reforms Act to the first Constitutional Amendment Act, it gave immunity to these laws from judicial scrutiny, and the 4th and 17th amendments further strengthened the protections for land reform legislation, and the 25th Constitutional Amendment Act, which inserted Article 31C, giving privacy to certain directive principles of the state policy over the fundamental rights, and Article 29 and 42nd Amendments continued the expansion of Article 31A, that is saving laws related to agrarian reforms. Despite these amendments, the core tension between the property rights and the socio-economic reform remained unresolved, necessitating a more decisive constitutional intervention. So, many amendments were brought about to resolve the deadlock. So, the first Constitutional Amendment Act 14 and 17, the 25th Constitutional Amendment Act 29 and the 42nd Constitutional Amendment Act. But still, the core tension between property rights and social and economic reform, they remained unresolved, necessitating the decisive constitutional intervention. The 44th Amendment Act 1978, landmark shift, that is, it was enacted by Janata government in the post-emergency period 1975-77. The 44th Constitutional Amendment Act 1978 brought a decisive change, that is, it deleted Article 19(1)F and Article 31, that is right to property, and removed from Part 3 of the fundamental rights. It removed the subheading right to property, that was removed from Part 3 entirely, and it inserted a new article, Article 300A, Part 12, under the new chapter, that is Part 12 under the new chapter, Part 4, title Right to Property. So, the right to property was now made a constitutional right. Previously, it was a fundamental right because it was enshrined in the Constitution, Part 3, Article 12 to 35. So, it was taken away from the fundamental rights and now it is being inserted in Article 300A, Part 12 under the Chapter 4 titled Right to Property. So, Article 300A states that no person shall be deprived of his property save by authority of law. Key implications of the 44th Amendment Act, that is, it downgraded the status, that is, right to property was downgraded from a fundamental right to a constitutional or legal right. Restricted judicial remedy. Earlier, as a fundamental right, an aggrieved person could directly approach the Supreme Court or High Court. Approach the Supreme Court under Article 32. That is right to constitutional remedies for enforcement. Post the amendment, post the 44th Constitutional Amendment Act 1978, the right can be enforced only through the High Courts under Article 226. It no longer enjoys elevated status or direct Supreme Court access that other fundamental rights command. So, as the right to property now is taken away from the fundamental rights, so and it has been made a constitutional right under Article 300A, Chapter 12. So, it does not enjoy the provisions of the fundamental right. That is, when a fundamental right of a citizen is violated, he can approach the Supreme Court or High Court. But when the right to property is violated, he has to approach only the High Court under Article 226. No mandatory compensation, that is, the state no longer constitutionally obliged or obligated to provide compensation in all cases of acquisition except in specific situations such as acquisition of minority educational institutions under Article 331A or certain personal cultivation lands. So, no compulsory or no mandatory compensation. That is, state is no longer constitutionally obligated to provide compensation in all the cases of acquisition except in specific situation, that when the state is acquiring or the property of minority educational institutions under Article 30 Clause 1A or certain personal cultivation lands. So, the objective and rationale of the amendment, the primary aim was to strike a better balance between the competing constitutional values, that is, individual rights and the state's need, that is, the individual right to own and enjoy property, a cornerstone of personal liberty and dignity, and the state's need to acquire property for public purpose, social welfare and land reforms, redistribution of resources, infrastructure development, and overall socio-economic justice. So, the main intention is to strike a balance between competing constitutional values of individual rights, that is, right to own and enjoy property, which is the cornerstone of personal liberty and dignity, and the state's need, that is, state's need to acquire property for public purpose, social welfare, land reforms, redistribution of resources, infrastructure development, and overall socio-economic justice. By reducing the status of the right, the government gained greater discretion and flexibility in implementing the policies aimed at reducing inequalities and promoting the common good without the constant threat of individual invalidation of the ground of violating a fundamental right. This change aligned the Constitution more closely with its socialist and welfare philosophy, giving primacy to directive principles in matters of property acquisition while still providing basic legal protection against arbitrary deprivation. So, before Article 19(1)(f) and Article 31 were fundamental rights, that is part 3 fundamental rights, and so when the fundamental rights are violated, Article 32, that is, an aggrieved person can approach the Supreme Court, and mandatory compensation and also highest protection. After the constitutional right. Now the fundamental right, right to property, is taken away, and now it is a legal right or a constitutional right under Article 300A, Part 12. So the right of the aggrieved person to approach the Supreme Court is not available to a constitutional right. So only Article 226, High Court, a person should approach the High Court. And also basic legal protection, and here you have highest protection, here you have basic legal protection, and compensation not mandatory. Here compensation is mandatory, compensation is not mandatory. So the transformation from fundamental right to a constitutional right fundamentally altered the scope of judicial protection and the state's power to acquire property for public purposes. So the current status and judicial interpretation post 1978, that is 44th Constitutional Amendment Act. So Article 300A as a constitutional safeguard. So Article 300A Part 12 remains a constitutional safeguard. Any deprivation of property must be backed by a valid law. It incorporates the principle of due process. It incorporates the principle of due process in a limited sense, that is authority of law, and expansive judicial interpretation. The Supreme Court has interpreted Article 300A expansively in several cases, that is, in several cases emphasizing that the law must be just, fair and reasonable, linking to Article 21, that is right to life and dignity in some contexts, and the Land Acquisition Act 2013, the right to fair compensation, transparency in land, the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013, replacing the Colonial Land Acquisition Act of 1894, further strengthened the procedural safeguards, transparency and compensation mechanisms. So the current status and the judicial interpretation post 1978, that is Article 300 as a constitutional safeguard, and expansive judicial interpretation, that is any law, the Supreme Court has interpreted that Article 300A expansive, that is it is interpreted Article 300A expansively in several cases, emphasizing that now the law must be fair, just and reasonable. And Land Acquisition Act, the Land Acquisition Act 2013, that is right to fair compensation, transparency in land acquisition and rehabilitation and resettlement Act 2013, it is replaced the Colonial Land Acquisition Act 1894, further strengthening procedural safeguards, transparency and compensation mechanisms. So conclusion, a transformative constitutional journey, that is the evolution of right to property in India, represents a carefully calibrated constitutional journey from an absolute fundamental right in 1950 through decades of conflict between judicial protection and legislative reform to its current status as a constitutional or legal right under Article 300A. This transformation reflects the Constitution's living character and its capacity to adapt to the nation's socio-economic aspirations while still preserving the basic legal protection against arbitrary deprivation of property. In 1950, fundamental right under Part 3, that is right to property is a fundamental right under Part 3, that is Article 19(1)(f) and Article 31. In 1951 to 1977, a series of amendments to resolve judicial and legislative conflicts. In 1978, 44th Constitutional Amendment Act, the right to property was taken away as a fundamental right and it has been inserted as a constitutional right under Article 300A Part 12. So, 2013 Land Acquisition Act strengthens procedural safeguards. Next topic, Foreign Contribution Regulatory Act. The Foreign Contribution Regulatory Act 2010 regulating foreign funding for national security and transparency. So the Foreign Contribution Regulation Act 2010, FCRA 2010, is a central legislation administered by the Ministry of Home Affairs, MHA. Its primary objective is to regulate the acceptance, utilization and accounting of the foreign funds or contributions, donations by individuals, associations, NGOs and other entities in India. It ensures that such inflows do not adversely affect internal security, sovereignty and public order or friendly relations within foreign states while preventing misuse for anti-national or disruptive activities. So, this Foreign Contribution Regulation Act 2010 is a central legislation and it is administered by Ministry of Home Affairs. Its primary objective is to regulate donations or contributions by individuals, associations, NGOs and other entities in India to regulate the acceptance, utilization and accounting of foreign contributions or donations. So, it ensures that such flows, such foreign donations or contributions does not adversely affect the internal security, sovereignty, public order and friendly relations with the foreign states while preventing the misuse of for anti-national and disruptive activities. So, historical background, in 1976, the law was first enacted in 1976 during the emergency period to curb foreign funding that could influence political and social activity. In 2010, it was reenacted and strengthened. It was comprehensively reenacted and strengthened in 2010 with stricter provisions for registration, monitoring and penalties. And 2020 key amendments, that is key amendment is mandatory SBI, that is the SBI's main branch in Delhi account for the receipt of funds, ban on subgranting, that is subgranting is not allowed, and reduction in administrative expenses, that is cap from 50% to 20%. So the cap on administrative expenses as the total foreign funding previously was 50, now it is being reduced to 20, and ban on subgranting. The organization or the NGO or the association which is receiving the foreign grants, contributions or donations, it cannot subgrant to other organizations, and a mandatory SBI account in the main branch, SBI's main branch in Delhi account to receive the funds. And 2025 rules updates, that is subsequent rules updates including in 2025 for enhanced disclosures. So the applicability of Foreign Contribution Regulation Act, FCRA applies to whom does it applies? It applies to all associations, groups, NGOs, trusts, societies and other persons intended to receive foreign contributions for cultural, economic, educational, religious or social programs. Registration valid for 5 years and it is renewable, or prior permission is mandatory. So, applicability, Foreign Contribution Regulation Act is applicable for all associations, groups, NGOs, societies and other persons, trusts intended to receive foreign contributions or donations for what purposes? Cultural, educational, economic, religious or social programs, and the registration is valid for 5 years and it is renewable, or prior permission is mandatory. Dedicated bank account, to maintain a dedicated Foreign Contribution Regulation Act bank account, now primarily at SBI main branch in New Delhi post 2020 amendments. And annual returns, to file annual returns similar to the income tax returns with complete documentation, that is 2025 rules updates, subsequent rules updates including in 2025 for enhanced disclosure. So now the associations, groups, NGOs, trusts, society and other persons receiving foreign contributions should file annual returns similar to that income tax returns with complete documentation. Permitted purposes only, to utilize funds only for permitted purposes and submit audited accounts. So the funds that these associations, groups, NGOs, trusts, societies and other persons they receive they should be only permitted for the purposes, for the permitted purposes only, and they should submit audited accounts. So definition of foreign sources under section 2(1), that is section 2 clause 1 subclause J. Foreign source has an inclusive definition under FCRA 2010. It covers a wide range of entities and individuals. So government and institution, government of any country and territory or its agency, international, any international agency, that is the World Bank except UN, World Bank, IMF and other regional agencies noted by the central government or as exempt, and trade union in a foreign country. So the definition of foreign source as mentioned in the section 2 clause 1 and subclause J. So foreign source has an inclusive definition under FCRA 2010. It covers a wide range of entities and individuals, that is governmental and institutions, that is government of any foreign country, territory or its agency, any international agency except UN, World Bank, IMF or other agencies notified by the central government as exempt, and trade union in foreign. Corporate and organizational, a foreign company, a corporation incorporated outside India, a multinational corporation as specified, a company under the Companies Act where more than 50% of the share capital is held by the foreign governments, foreign citizens, foreign corporations and foreign trusts or societies. A foreign trust or foundation or one mainly financed by a foreign country, and a society, club or association formed, registered outside India and a citizen of a foreign country. Key exemptions and clarifications. So all the international contributions or donations, do they qualify as foreign contributions? No. Under FCRA, no. Not all the foreign contributions, not all the international contributions qualify as foreign contributions under Foreign Contributions Regulatory Act. The following contributions are critical for understanding the law scope, that is World Bank, IMF and UN. That is the World Bank, IMF and UN, they are exempt. That is the contribution from World Bank, IMF, UN and its specialized agencies are not treated as foreign sources, hence not foreign contributions. The foreign trusts and societies are foreign sources. So the trusts, societies and associations formed or registered in the foreign country are foreign sources. And what about foreign government? Is it a foreign source? Yes. Foreign government donations or contributions is a foreign source. So government of a foreign country or its agency is a foreign source, and foreign citizen is a foreign source. A citizen of a foreign country is a foreign source. So the foreign trust and societies are foreign sources. Foreign government is a foreign source. Foreign citizen is a foreign source, but the World Bank, IMF and UN are exempt, and its specialized agency are not treated as foreign sources, hence not foreign contributions. So not all foreign contributions qualify as contributions under FCRA. So important note on NRIs. So what about the contributions made by NRIs? Is it a foreign source? No. The contribution made by NRIs, non-residential Indian. So who is a non-residential Indian? NRI. NRI is a non-residential Indian. That is, he is a citizen of India, but he is living abroad. So from his or her personal savings through normal banking channels are not treated as foreign contributions. So contributions made by NRIs, non-resident Indians, that is an Indian citizen living abroad, from his or her personal savings through normal banking channels are not treated as foreign contributions. Why NRI contributions are different? An NRI holds citizenship, an NRI holds Indian citizenship and therefore does not qualify as a foreign source under FCRA, because NRI has an Indian citizenship, he does not qualify as a foreign source under Foreign Contribution Regulation Act. These contributions from personal savings via normal banking channels are exempt from the FCRA regulations. So, verification best practice. However, it is advisable to obtain the passport details to confirm the Indian citizenship as opposed to foreign citizenship, overseas citizen of India, card holders, persons of Indian origin status, which would make it a foreign source. So, in order to confirm, you have to verify his passport, take his passport, verify whether he is an Indian citizen, and if he is not an Indian citizen, if he is a foreign citizen or overseas citizen of India card holder or a person of Indian origin status, would make it a foreign source. So, implying NRI contributions are treated as foreign, implying that NRI contributions cannot be treated as foreign. So, NRI contributions, the contributions made by non-resident India who is residing in India cannot be treated as a foreign source. So, entities prohibited from receiving foreign contributions. That is, what are the entities which have been prohibited from receiving foreign contributions? That is Section 3 of Foreign Contribution Regulation Act 2010. The following cannot accept foreign contributions under any circumstances. So, who are they? Election candidates. The candidates who for elections are strictly prohibited from receiving foreign contributions. The media personnel, that is correspondents, editors, owners, printers, publishers of registered newspapers. The judges and government service. The judges and government servants and employees of the government-owned corporations or bodies, they cannot receive foreign contributions. Legislative members, members of the Lok Sabha, members of the legislature, that is parliament and state assemblies, both the houses, they can't receive. Political parties or their office bearers are completely banned from receiving foreign contributions, and political organizations of a political nature as notified by the central government they cannot receive foreign contributions. That is, they cannot accept foreign contributions under any circumstances. FCRA registration requirement at a glance. So, the registration under FCRA is valid for 5 years and is renewable. Entities must comply with all the conditions, including maintaining a dedicated FCRA bank account at the SBI's main branch, Delhi, filing annual returns, ensuring funds are used only for permitted cultural, economic, educational, religious or social purposes. So, the registration under FCRA is for 5 years and it is renewable, and the money that has been, the donations that have been received should be used for the specific purposes only, that is the permitted cultural, economic, educational, religious or social purposes. A bank account, that is they should maintain a bank account, that is FCRA bank account at the SBI's New Delhi main branch, and they should file annual returns. So 2020 amendments and key changes. The 2020 amendments significantly tightened the Foreign Contribution Regulation Act framework. Here are the most important impactful changes, that is a mandatory SBI Delhi account, that is an account, FCRA account in the SBI New Delhi main branch. That is, all foreign contributions must be received exclusively at the SBI New Delhi main branch. FCRA designated account should be maintained. Ban on subgranting, that is, the FCRA registered entities are prohibited from transferring foreign contributions to other organizations, that is subgranting is banned, and administrative expenses cap, that is the cap on administrative expenses was reduced from 50% to 20% of the total foreign contributions received, and the subsequent rules update 2025, including in 2025, introduced the requirements of enhanced disclosures to further strengthen transparency and accountability. So the subsequent rules updated including in 2025, it has introduced requirements for enhanced disclosures to further strengthen transparency and accountability. Summary: that is the purpose and significance of Foreign Contribution Regulation Act. So Foreign Contribution Regulation Act 2010, it serves as India's primary legislative safeguard against misuse of foreign funds for anti-national disruptive activities. Its core pillars are national security, diplomatic integrity, transparency and accountability, and regulated access. So the national security, it ensures that the foreign inflows do not adversely affect the internal security, sovereignty and public order. Diplomatic integrity prevents foreign funding from disrupting friendly relations with foreign states. And transparency and accountability, it mandates registration, annual returns, audited accounts and strict utilization norms for all recipients, and regulated access, that is defines clearly who can receive foreign contributions and who is exempt and who is prohibited under section 3. So regulated access. So administered by the Ministry of Home Affairs, and the FCRA, Foreign Contribution Regulation Act, remains a cornerstone of India's regulatory framework for civil society and foreign funding governance. So this Foreign Contribution Regulation Act is administered by Ministry of Home Affairs. So FCRA remains a cornerstone of India's regulatory framework for civil society and foreign funding governance. Fundamental rights, fundamental duties and directive principles of the state policy. All these, they reflect the individual dignity, public interest and national unity. So the fundamental rights enshrined in the Constitution Part 3, Article 12 to 35, the directive principles of the state policy enshrined in the Constitution Part 4, Article 36 to 51, and the fundamental duties enshrined in the Constitution Part 4A and one article, only single article, Article 51A, the reflection of the individual dignity, public interest and national unity. So the Constitution is a unique document that balances the individual liberties with collective welfare and national integrity. The preamble explicitly declares the resolve to secure the dignity of the individual and unity and integrity of the nation, along with justice, liberty, equality and fraternity. Liberty, equality and fraternity are the French tribe. So our Constitution is a unique document that balances the individual liberties with the collective welfare and national integrity, and the preamble explicitly declares the resolve to secure the dignity of the individual and unity and integrity of the nation, along with justice, liberty, equality and fraternity. So an interconnected constitutional framework. The core values are not confined to one part of the Constitution but permeate fundamental rights, the directive principles of the state policy, fundamental rights in Part 3, directive principles of the state policy Part 4 and the fundamental duties Part 4A. This interconnected framework ensures that the state promotes both individual development as well as national cohesion while preventing authoritarian tendencies. So fundamental rights part 3, article 12 to 35, justiciable, that is they are enforceable by the courts of law. Directive principles of the state policy part 4, article 36 to 51, non-justiciable but fundamental in governance. And fundamental duties part 4a, article 51a, non-justiciable moral compass for citizens. So when the fundamental rights of a citizen are violated, he can approach the Supreme Court or High Court. Supreme Court under Article 32 and High Court under Article 226. So they are enforceable by the courts. Whereas the directive principles of the state policy and fundamental duties, they are not enforceable. They are not justiciable by the court of law. So all these three parts together reflects the values of individual dignity, larger public interest and national unity. The three pillars of the preamble promise. So fundamental duties, article 51a, that is the dignity of the individual, the larger public interest and the unity of the nation can be traced to the fundamental rights. So the dignity of the individual, larger public interest and the unity of the nation can be traced to the fundamental duties. So fundamental duties, explanation and context. The origin. The fundamental duties were added. They were not part of the original constitution. They were added by the 42nd Constitutional Amendment Act 1976, inspired by the Swaran Singh Committee, enshrined in Part 4A, Article 51A. Though non-justiciable, that is not enforceable by the courts like the fundamental rights, they serve as the moral compass for citizens and aid in interpretation of laws and policies. So, fundamental duties, they were not part of the original constitution. They were added by the 42nd Constitutional Amendment Act 1976, inspired by on the recommendations of the Swaran Singh Committee, and they were enshrined in Part 4A and a single article, Article 51A. And though the fundamental rights are not justiciable, that is, they are not enforceable by courts like the fundamental rights, they serve as moral compass and for citizens and aid in interpreting of laws and policies. That is, if any law gives effect to any of the fundamental duties, then they shall not be declared as null and void by the courts. So, the relevant clauses directly reflecting the values. So, the clauses that are reflecting the values of individual dignity, larger public interest and unity of the nation. So, what are the provisions in the fundamental duties? Relevant clauses directly reflecting the values. So, clause C, that is 51A clause C, to uphold and protect the sovereignty, unity and integrity of India. Clause E, to promote harmony and spirit of common brotherhood amongst all people of India, transcending religious, linguistic, regional or sectional diversities, and to renounce practices derogatory to the dignity of women. So, these relevant clauses, that is these clauses, they directly reflect the value of dignity of the individual, larger public interest and national unity. So, these duties emphasize that individual actions must align with national integrity and respect for human dignity, especially gender dignity. In a diverse society like India, they counter fissiparous tendencies, that is separatist tendencies, and promote fraternity. So, the courts have occasionally referred to them while interpreting laws, that is environmental or educational matters. So, these duties explicitly link individual conduct to national integrity and dignity. Fundamental duties are citizen-centric obligations, that is, they are obligations of the citizens that complement rights and directive principles of the state policies in building a responsible democracy. So, fundamental rights enshrined in the Constitution, Part 3, Article 12 to 35. So, the dignity of the individual. The dignity of the individual, again, the dignity of the individual, larger public interest, and the unity of nation. So these values can also be traced to the fundamental rights enshrined in Part 3, Article 12 to 35. So, fundamental rights explanation and context. Fundamental rights are the cornerstone of the Indian Constitution, often called as the Magna Carta or soul. They are justiciable and enforceable by the Supreme Court and High Courts under Article 32, that is right to constitutional remedies, and Article 32 is called the heart and soul of the Constitution by Dr. B.R. Ambedkar. So, fundamental rights are the cornerstone of Indian Constitution, often called as its Magna Carta or soul. They are justiciable, that is enforceable by the courts, Supreme Court and the High Courts under Article 32, Supreme Court under Article 32 and High Court under Article 226. That is, Article 32 is right to constitutional remedies. It is called the heart and soul of the Constitution by Dr. B.R. Ambedkar. Article 14, equality before law and equal protection of the law. Article 15 and 16, prohibition of discrimination on the grounds of religion, race, caste, sex and place of birth. Article 16, that is equality of opportunity in matters of public employment. Article 21, protection of life and personal liberty. So, this is widely interpreted by the Supreme Court to include right to dignity, privacy, livelihood, health, education, etc. Example in Maneka Gandhi case 19, Maneka Gandhi case and Francis Corelli, Mullin and Puttaswamy cases. So, Article 21 was widely interpreted by the Supreme Court to include right to dignity, right to livelihood, right to health, right to education, right to privacy. In cases like Maneka Gandhi case, Francis Corelli, Mullin case and Puttaswamy case. Article 23-24, right to exploitation, that is right against exploitation, and 29-30, that is cultural and educational rights, further protect the vulnerable sections while promoting national unity. So, key features: guaranteed to all the persons, not just citizens, without discrimination. They uphold equality of all the individuals, dignity of the individual, larger public interest, unity of the nation. They act as the bulwark against authoritarian and despotic rule by limiting state power. Fundamental rights promotes political democracy while ensuring individual all-round development. They can be suspended during the national emergency, except Article 20 and 21, reflecting a balance between individual liberty and national security. So, fundamental rights are the primary vehicle for protecting individual dignity and preventing the majoritarian or state excesses while focusing or fostering equality that strengthens the national unity. Directive principles of the state policy enshrined in the Constitution, Part 4, Article 36 to 51. So, the dignity of the individual, again the values of dignity of the individual, larger public interest and the unity of the nation can be traced to the directive principles of the state policy. So, the directive principles of the state policies are the instruments of instructions to the state. That is, they resemble the instruments of instructions present in the Government of India Act 1935, which are these instruments of instructions are precursor to the directive principles of the state policy, and they are influenced by the Irish Constitution. They are non-justiciable but are declared fundamental in the governance of the country, that is Article 37. That is, for the non-implementation of the directive principles of the state policy, the courts, they are not justiciable by the courts. That is, if the state is not implementing directive principles of the state policy, you cannot approach the court. So, they are not justiciable but are declared fundamental in the governance of the country. Article 37. These principles are fundamental in the governance of the country, and it shall be the duty of the state to implement these principles in making laws, formulating policies. So, the aim of these directive principles of the state policy is to establish a welfare state based on socio-economic justice and complementing the political justice secured through fundamental rights. So, the fundamental rights promotes political democracy, whereas directive principles of the state policy promote social and economic democracy. So, Article 38, according to Article 38, the state shall strive to promote welfare of the people by securing a social order permeated by socio-economic and political justice. It must minimize inequalities in income, status and facilities and opportunities not only among individuals but also among groups and regions. And Article 39, it directs policy towards right to adequate means of livelihood, right to equitable distribution of material resources of the community for common good, prevention of concentration of the wealth, and equal pay for equal work for men and women, protection of health and strength of workers and children, opportunity for the healthy development of children in conditions of freedom and dignity. Article 44, secure for all its citizens a uniform civil code throughout the territory of India, promotes national unity by reducing religion-based personal laws. So, DPSPs, other provisions and implementation. So, other relevant directive principles of the state policies, promotion of educational and economic interests of the weaker sections, that is scheduled castes and scheduled tribes, Article 46. Formation of village panchayats, that is organization of village panchayats, Article 40. And promotion of international peace, Article 51. Directive principles of the state policy, they embody socialist and welfare ideals of the Constitution. That is, they promote social and economic democracy. So, implementation through laws. So, many directive principles of the state policies have been implemented through laws like MG Narega 2005, which has been replaced in 2025 by a new act, that is VB Jairamji, and RTE Act 2009 land reforms have influenced judicial interpretation. Example, harmonious construction with fundamental rights in the cases like Minerva Mills. Directive principles of the state policies provide the positive obligations on the state to actively promote dignity, reduce inequality, and work towards national integration and common good. So, the summary, all these three that is provisions, that is fundamental rights, directive principles of the state policies and fundamental duties, all the three provisions are correct. That is, they are providing all the fundamental rights, directive principles of the state policy and fundamental duties, they are correct. That is, the values of individual dignity, larger public interest and the national unity are woven throughout all these three pillars of the Indian Constitution. That is fundamental duties, that is citizen-centric obligations. These are the duties of the citizen, and they act as moral compass linking individual conduct to national integrity and dignity. Fundamental rights, primary vehicle for protecting individual dignity, preventing state excesses and fostering equality that strengthens national unity. Directive principles, positive obligations on the state, that is, it is the duty of the state to actively promote the dignity, reduce inequalities and work toward national integration and common good. So, remember, for UPSC, remember that fundamental duties are citizen-centric obligations that complement rights and directive principles in building a responsible democracy. Together, these three parts, that is fundamental rights, directive principles of the state policy and fundamental duties, they reflect the preamble's promise of justice, liberty, equality and fraternity. So, fundamental rights in the Indian Constitution. The current status, that is the current status of the right to freedom and constitutional provisions under Part 3, Article 12 to 35. So, the overview of fundamental rights. The overview of the Indian Constitution originally guaranteed how many fundamental rights? 7 fundamental rights. Under Part 3, Article 12 to 35. These rights act as limitations on the state power and are justiciable with the Supreme Court and High Court empowered to enforce them. That is, under Article 32 and Article 226, the Supreme Court and High Court can issue writs. So, the right, so originally how many fundamental rights are there? 7 fundamental rights. Now, now how many fundamental rights are there? 6, because the right to property in Article 19(1)(f) and Article 31, right to property under Article 19(1)(f) and Article 31 was taken away from the fundamental rights by the 44th Constitutional Amendment Act, and now right to property is a constitutional right under Article 300A, Part 12. Okay, so the right to property was removed from the list of the fundamental rights by 44th Constitutional Amendment Act 1978. It was downgraded and inserted as Article 300A in Part 12, making it a constitutional or legal right rather than a fundamental right. So, now right to property is a constitutional or legal right, not a fundamental right. As a result, there are now 6 fundamental rights, that is right to equality under Article 14 to 18, that is Article 14, equality before law and equal protection of law. Article 15, prohibition of discrimination on the grounds of religion, race, caste, sex and place of birth. Article 16, equality of opportunities in the matters of public employment. Article 17, prohibition of prohibition of untouchability. And Article 18, that is abolition of untouchability. And Article 17, Article 18 is abolition of titles. Right to freedom, that is 19 to 22. Article 19, 6 freedoms. That is freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form associations, unions and cooperative societies by 97th Constitutional Amendment Act 2011, freedom to move freely throughout the territory of India, freedom to reside and settle, and freedom to carry on any occupation. And Article 20, protection against conviction from certain offences, and Article 21, right to life and personal liberty. Article 22, that is protection against arrest and preventive detention. Right against exploitation, Article 22, that is prohibition of traffic and forced labor in human beings, including beggar. And Article 24, that is with regarding to prohibition of employment of children below 14 years in hazardous industries, mines. Right to freedom of religion, Article 25. Freedom 25 to 28, that is freedom of religion, freedom to profess, practice and propagate one's religion, Article 26. Right to manage religious affairs, Article 27. Freedom from taxation for the promotion of any particular religion, and Article 28. Freedom of religious instructions in educational institution. And cultural and educational rights, Article 29 and Article 30. Article 29, that is right of the minorities having distinct language, right of the minorities to conserve their distinct language, scripture and culture. And Article 30, right of minorities to establish their educational institutions of their choice and administer. So Article 32, right to constitutional remedies. So focus on right to freedom, that is Article 19 to 22. So the right to freedom is one of the most vital fundamental rights and forms the bedrock of individual liberty in a democracy. So, it guarantees 6 specific freedoms to citizens under Article 19(1), Art 19 Clause 1, that is freedom of speech and expression, that is right to freely express opinions and ideas, freedom to assemble peacefully without arms, and freedom to form associations, that is freedom to form associations, unions and cooperative societies. 97th Constitutional Amendment Act 2011, freedom to move freely throughout the territory of India, freedom to reside and settle in any part of the territory of India, and freedom to practice any profession, to carry on any occupation, trade or business. So, the freedoms are not absolute, they are subject to reasonable restrictions, that is, they are not absolute, they are qualified, that is, reasonable restrictions can be imposed by the state in the interest of sovereignty, integrity of India, public order, decency, morality, etc. So, the reasonable restrictions are enshrined in the fundamental rights itself, that is Article 19 Clause 2 to Article 19 Clause 6. Article 20 and 22, important protections. Right to freedom, Article 20 and 20 to 22 provide crucial safeguards for individuals against state overreach. Article 20, protection in respect of conviction for offences, that is no ex post facto law, that is a person cannot be punished for an act that was not an offence when committed. No double jeopardy, that is no person shall be prosecuted and punished for the same offence more than once, and no self-incrimination, that is no person shall be compelled to be a witness against himself. Article 21, protection of life and personal liberty, that is no person shall be deprived of his life and personal liberty except according to the procedure established by law. And Article 22, protection against arrest and detention, that is protection provides protection against arrest and detention in certain cases, including the right to be informed of the grounds of arrest, the right to consult a legal practitioner. So, Article 21, protection of life and personal liberty. So, no person shall be deprived of his life or personal liberty except according to the procedure established by law. Key features available to all the persons. Article 21 is available to all the persons. The right is available to both citizens and non-citizens, that is foreigner, as it uses the word person instead of citizen. And protection against arbitrary deprivation. It ensures that life and personal liberty cannot be taken away arbitrarily or at the whims of executive authority. It should be backed by valid law, and any deprivation must be backed by valid law, and the law should be just, fair and reasonable. In M.K. Gandhi, Maneka Gandhi case, the scope of Article 21 was expanded, and punishment only for violation of the law, that is a person cannot be punished or imprisoned only for violation of law, that is a person can be punished or imprisoned only for violation of law and not merely on the discretion of any authority. And the phrase procedure established by law, originally borrowed from the Japanese Constitution, is central to Article 21 and falls under the right to freedom category. So, evolution of Article 21 through judicial interpretation. So, the judiciary has interpreted Article 21. The Article 21 is the most interpreted article of the Constitution, and Article 19 is the second most interpreted article of the Constitution. So, the interpretation of Article 21 has evolved dramatically over the decades through landmark Supreme Court judgment. The Supreme Court is the final interpreter of the Constitution. So, through various judgments, it has interpreted and expanded the scope of Article 21. So, in 1950, A.K. Gopalan case, the Supreme Court gave a narrow interpretation, that is procedure established by law. There is no person shall be deprived of his life or personal liberty except by procedure established by law. Meant any procedure prescribed by law, even if the procedure is unfair. And 1978 Menaka Gandhi case, this was overruled. It has overruled. This has overruled the 1950 A.K. Gopalan case, that is, it was overruled in the landmark Menaka Gandhi case. The court expanded Article 21 dramatically, and it held that the procedure must be fair, just, and reasonable, and must satisfy the test of due process American influence. So, the scope of Article 21 has been expanded, and the Supreme Court has overruled the 1950 A.K. Gopalan case in Menaka Gandhi case, and it has held that the procedure must be fair, just, and reasonable, and must satisfy the due process American influence. The Golden Triangle. Article 21 was linked with Article 14, that is equality before law and equal protection of law, and Article 19, 6 freedoms, creating the Golden Triangle of fundamental rights. So, unenumerated rights under Article 21. So, the Supreme Court has interpreted Article 21. Article 21 is the most interpreted article of the Constitution. So, what are the unenumerated rights? Means the Supreme Court, what are the rights that have been interpreted by the Supreme Court in various judgments? So, over the years, Article 21 has been interpreted to include several unenumerated rights not explicitly mentioned in the Constitution. So, what are they? Right to dignity. Every person has the right to live with dignity. Right to privacy recognized in the landmark Puttaswamy case, and right to livelihood, that is right to earn a livelihood, is integral to right to life under Article 21. Right to clean environment, a clean and healthy environment is part of right to life, that is Article 21. Right to health, access to health and medical care is protected or is integral to Article 21, and right to education is essential to a meaningful life, and right to shelter, that is right to a roof over one's head, is protected, and right to die with dignity, that is passive euthanasia, is recognized in Arunachal and common cause cases. So, passive euthanasia is withdrawal or withholding the life support systems, and providing there is dignity, that is right to die with dignity. So, these are all the unenumerated rights which are interpreted by the Supreme Court and not explicitly mentioned in the Constitution. So, Article 21A, right to education. Right to education was made a fundamental right by adding Article 21A by 86th Constitutional Amendment Act 2002. Article 21A was inserted by 86th Constitutional Amendment Act 2002 as an additional important provision under right to freedom. What Article 21A provides, it made free and compulsory education for all children in the age group of 6 to 14 years as a fundamental right. Earlier, this was part of the Directive Principles of the State Policy, Article 45. That is, it also imposes a duty. 86th Constitutional Amendment Act has changed the subject matter of Article 45, and it has introduced a new fundamental duty. That is, originally there were 10 fundamental duties under Part 4A, Article 51A. Now, the 11th fundamental duty was added by 86th Constitutional Amendment Act 2003, and it has added a fundamental right, that is Article 21A. That is right to compulsory education, free and compulsory education for all the children in the age group of 6 to 14 years. So, it also imposes a duty on the parents and guardians to provide educational opportunities to their children and wards in this age group, that is 6 to 14 years. So, legislative outcome, this constitutional provision led to the enactment of Right of Children to Free and Compulsory Education Act 2009, which operationalized the right to lay down detailed provisions for its implementation across India. So, the golden triangle of fundamental rights, the Maneka Gandhi case 1978 established a powerful constitutional linkage between the three fundamental rights, creating what is known as the golden triangle. So, what are the three fundamental rights? Article 14, Article 19 and Article 21. So, the Maneka Gandhi case has established a powerful constitutional linkage between these three fundamental rights, which is known as golden triangle. So, Article 14, right to equality, equality before law and equal protection of law. Article 19, right to freedoms, that is 6 freedoms including freedom of speech, movement and profession. And Article 21, right to life and liberty, that is the fair, just and reasonable provision, golden triangle. All three must be satisfied together for law to be valid. So, after the Maneka Gandhi case, any law or procedure that deprives a person of life or personal liberty must satisfy the requirements of all three articles simultaneously. It must be equally responsible, reasonable and procedurally fair. So, summary, right to freedom at a glance, a consolidated overview of the right to freedom and its key provisions under the Indian Constitution. So, 6 fundamental rights remain. After 44th Constitutional Amendment Act 1978 removed the right to property, 6 fundamental rights, that is 6 right to freedom, now exist under the Part 3 of the Constitution. Article 19, 6 freedoms, that is the citizen enjoys 6 freedoms including the freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form associations, unions and cooperative societies, freedom of movement throughout the territory of India, freedom to reside and settle in any part of territory of India and freedom to practice any profession. These are subject to reasonable restrictions, that is the state can impose reasonable restrictions, they are not absolute. Article 20 to 22, protective safeguards, protection against ex post facto laws, double jeopardy and also no self-incrimination. And Article 21, right to life and personal liberty. Article 22, that is protection against arbitrary arrest and detention. Protections of right to be informed on the grounds of arrest, right to be to have an access to the advocate or right to be represented by a legal practitioner, and right to be presented before a judicial magistrate within 24 hours of arrest, excluding the travel time. So, Article 21, expansive interpretation. From narrow A.K. Gopalan case 1950 to the landmark Maneka Gandhi case 1978, Article 21 now encompasses right to dignity, right to privacy, right to livelihood, right to health and more. Article 21A, right to education, that is free and compulsory education for all the children in the age group of 6 to 14 years, operationalized through RTE Act 2009. So, right to freedom, especially Article 21, remains a most extensively interpreted fundamental right. That is most interpreted fundamental right in the Constitution is Article 21, continuously evolving through judicial interpretations to protect individual liberty in a democratic India. So, Article 21 is right now evolving. Indian Constitution, a unique blend of rigidity and flexibility. So, the framers of Indian Constitution were deeply conscious of the challenges of maintaining unity and integrity. In a vast, diverse and newly independent country, they designed a constitution that gives a predominant role to the center while simultaneously establishing a system of cooperative federalism. Cooperative federalism is a model of governance where the national, state and local governments, they share power and work together for the resolution of the conflicts and to implement the program. So the framers of the constitution deliberately were deeply conscious and of the challenges of maintaining unity and integrity, because India is a diverse country, and so because of the vast diversity and the newly independent status, they designed a constitution that gave predominance to the center while simultaneously establishing a system of cooperative federalism. So Indian constitution is neither purely rigid nor purely flexible. One of the most distinctive feature of the Indian constitution is that it is neither purely rigid or purely flexible. It represents a judicious blend of both. So rigid constitution, that is, the amendment is difficult. How can you say that whether a constitution is rigid or flexible? It is on the basis of the procedure for amendment of the constitution. So rigid constitution, the amendment is difficult and requires a special cumbersome process. Example, USA, Switzerland or Australia. In USA, US constitution is a rigid constitution, and the procedure for amendment of the constitution is mentioned in Article 5, and it is a two-step process, that is the proposal and ratification. For the proposal of an amendment, you need 2/3 of the votes in both the houses of the Congress or the convention of 2/3 of the state legislatures, and for ratification 3/4 of the state legislatures should ratify, or a special convention. So the procedure to amend the constitution is difficult and requires a special cumbersome procedure. Example, USA, Switzerland or Australia. Flexible, the amendment is relatively easy and can be done through ordinary legislative process like United Kingdom. The procedure to amend the constitution is not mentioned in the constitution of UK. So the British Parliament can amend any provision of the constitution through an ordinary legislative process, that is by simple majority of the members present plus voting. So a constitution is classified as rigid or flexible depending upon the procedure of amendment of the constitution. So the Indian middle path, that is the amendment procedure. The Indian constitution strikes a middle path through a three-tier amendment structure, that is simple majority, special majority and special majority plus ratification by half of the state legislatures. So simple majority, some provisions of the constitution can be amended by simple majority. These are not considered as amendments under Article 368. That is, some provisions of the constitution are amended by simple majority, that is majority of the members present plus voting, and the amendment of the constitution by simple majority is not considered as an amendment under Article 368. The procedure to amend the constitution is mentioned in Article 368. So it is not considered as an amendment under Article 368. Special majority. Most of the provisions of the constitution can be amended by the parliament through a special majority as mentioned in Article 368. Special majority, that is absolute majority plus working majority. Absolute majority, majority of total membership of the house, that is more than 50% of the total membership of the house, plus working majority, a majority of not less than 2/3 of the members present plus voting, and the special majority plus ratification by half of the state. Special majority for non-federal features. Non-federal features like amendment of the fundamental rights, directive principles of the state policy, etc. And for federal features, you need special majority plus ratification by at least half of the state legislatures. That is, certain federal provisions require ratification by at least half of the state legislatures in addition to the special majority in the parliament. So this makes the Indian constitution partly rigid and partly flexible. So, rigidity in the federal structure. The federal character of the constitution has been given a significant degree of rigidity to protect the basic federal frameworks. That is, those provisions, the federal provisions of the constitution are amended by special majority and ratification by half of the state legislatures, like the provisions of center-state relations, GST, like provisions relating to the president. So, the provisions, that is the federal provisions, they can be amended by special majority plus ratification by half of the state legislation. So, the federal character of the constitution has been given a significant degree of rigidity. Federal character, that is dealing with center and states to protect the basic federal framework. So, clear division of powers. Federal polity, there is division of powers. So, between union and states enumerated in the 7th schedule, that is union list, state list and concurrent list. The supremacy of the constitution. Both the center and the states must abide or must function within the limits of prescribed by the constitution. So, in our parliamentary democracy, it is the supremacy of the constitution. No organ is supreme in our democracy. It is the supremacy of the constitution, and consent of the state legislates is required. That is, consent of the state is required affecting the federal structure, like distribution of powers between center and states, require constitutional amendment, and in many cases the consent of the states. Supreme Court as the guardian. The Supreme Court acts as the final interpreter and guarantor of the federal scheme. So, to the process of judicial review. That is, if any provision or any legislative enactments and executive action is not according to the provision of the constitution, then they will be declared null and void. The Supreme Court is the final interpreter and guardian of the federal scheme. This rigidity ensures that the federal balance cannot be disturbed arbitrarily by the center alone. So, you need the consent of the state legislatures. Any provisions that deals with the division of powers between the center and states, they require consent by the state legislatures. That is, special majority plus ratification by at least half of the state legislatures. Unitary non-federal features. Despite having federal structure, the Indian Constitution has several strong unitary features. So, our polity is a federal polity. That is, there is division of powers between the center and the states. That is, the Constitution itself provides for the division of powers between center and the states. That is, 7th schedule provides for 3 lists: union list, state list and concurrent list. So, despite having federal features, the Indian Constitution has several strong unitary features. So, what are the strong unitary features? Strong center, a very strong center with overriding powers in many areas. That is, the 7th schedule consists of the union list. The union most important subjects are mentioned in the union list. So, very strong center with overriding powers in many areas, and single constitution, that is for both union and states, unlike the USA. So, in USA you have to federal constitution and also constitutions. Every state has its own constitution. So, in India it is single constitution both for union and state. Unified judiciary, that is single integrated judiciary with Supreme Court at the apex. So, our judiciary is single and integrated judiciary. Single set of courts, that is the Supreme Court at the apex. Below the Supreme Court there is high courts, and below the high courts there is hierarchy of subordinate courts. They implement both center and state laws. That is, they enforce both central and state laws. Single set of courts. All India services, whereas in USA you have parallel set of courts. That is, you have federal courts and state courts. So, federal courts enforce federal law and state courts enforce state law. All India services, IAS, IPS and IFS, Indian IFOS, Indian Foreign Service, they are controlled by the states. So, this All India services which are recruited by the center, they are controlled by the center, and the members of the All India services, they occupy the highest administrative positions in the states. So, the All India services is controlled by the center. It is also a strong unitary feature. Appointment of the governor by the president, that is center. So the governor is appointed by the center, strong unitary feature, and emergency provisions. During an emergency, the federal structure is automatically converted into a unitary structure without the amendment of the constitution, is also a strong unitary feature. And residue of powers, the powers that are not vested with union or state, vest with the center, that is vest with the center, unlike most federations where they vest with the states. So the residuary powers are mentioned, or residuary powers in the parliamentary democracy are vested with the center, unlike most federation. In most federations, the residuary powers are vest with the states, but whereas in India, the residual powers they vest with the center. So because of these features, the Indian political system is often described as quasi-federal, federal in form but unitary in spirit, and cooperative federalism. So because of these strong unitary features, our Indian political system is often described as quasi-federal, federal in form but unitary in spirit, and cooperative federalism. So federal features of the constitution. What are the federal features of the constitution? Supremacy of the constitution. The constitution is the supreme law of the land, binding on both center and states. Bicameralism at both center and states. At the center you have Lok Sabha and Rajya Sabha. So Rajya Sabha represents the states in the Parliament of India. And division of powers between center and states through the 7th schedule. 7th schedule consists of union list, state list, and concurrent list. And independent judiciary. The Supreme Court serves as the final arbiter of the federal disputes between center and states. So, current affairs context, one nation, one election, that is the one nation, one election, that is the proposal and simultaneous polls debate, that is the proposal, that is the simultaneous elections to both Lok Sabha and state legislatures, has raised questions about center-state relations. Delimitation post 2026, that is the possible increase in Lok Sabha seats after 2026 census, may affect the federal balance. Recently, in the month of April, that is recently in April 17th, the 31st Constitutional Amendment Act 2026 as that is the 31st Constitutional Amendment Act could not be passed by the Parliament. This 131 Constitutional Amendment Act, it proposed to increase the number of seats in the Lok Sabha from 543 to 850, and linking it with delimitation, that is linking it with the census 2011 census. So it was defeated. So Article 356 and the governor's role, frequent use of president's rule. Under Article 350, president's rule, that is under Article 356, state emergency, and disputes over the governor's role continue to highlight the tensions between federalism and unitary tendencies. And GST and cooperative federalism, the Goods and Services Tax and GST Council, Article 279A is a constitutional body, that is GST, introduced to 101 Constitutional Amendment Act, remain important examples of cooperative federalism in practice. And Supreme Court judgments on federal issues regarding mining rights, taxation power, governor's discretion continue to shape the evolving nature of Indian federalism. So, the UPSC relevance for prelims, the key topics for prelims is federal versus unitary features of the Indian Constitution. So, what are the federal features and what are the unitary features? Article 368, the procedure for amendment of the Constitution. 7th schedule, division of powers between center and states, and rigid and flexible constitution. So, what are the key takeaways? the Indian Constitution's unique design balancing rigidity to protect the federal framework with flexibility to adopt the changing needs reflect the wisdom of its framers in crafting a document fit for vast, diverse and dynamic democracy. Understanding this blend is central to both the prelims and mains preparation. So, next topic is key constitutional provisions on fundamental rights and press freedom and judicial role. So, a comprehensive overview of India's constitutional framework covering the writ jurisdiction, freedom of press and a doctrine of essential religious practice and the broader context of judicial review with respect to UPSC preliminary. So, the writ jurisdiction of the Supreme Court under Article 32, that is, when the fundamental rights of an aggrieved citizen are violated, the aggrieved citizen can approach the Supreme Court under Article 32. That is, the Supreme Court can issue writs for the enforcement of fundamental rights. So, the enforcement of fundamental rights is a cornerstone of the constitutional remedies in India. The Supreme Court under Article 32, that is, every citizen has the right to move the Supreme Court directly for the enforcement of fundamental rights, not by the way of appeal. This right itself is a fundamental right. So, Article 32 is itself a fundamental right. The Supreme Court can issue directions, writs or orders like habeas corpus, mandamus, prohibition, quo warranto and certiorari. So, because it is a guaranteed fundamental right, that is Article 32 is itself a fundamental right, the Supreme Court cannot refuse to entertain a petition under Article 32 except in exceptional cases of abuse of process. So, nature of the jurisdiction, the Supreme Court's jurisdiction under Article 32 is virginal, that is the right to approach the Supreme Court directly, not by the way of appeal, or to hear the cases, the right of the Supreme Court to hear the cases in the first instance, not by the way of appeal, but not exclusive. That is, when the fundamental rights of a person are violated, citizen are violated, he can approach the Supreme Court or the High Court. So, both Supreme Court and High Court can issue writs. So, the Supreme Court's jurisdiction under Article 32 is original but not exclusive. That is, both Supreme Court and High Court can issue writs for the enforcement of fundamental rights. It is concurrent with the jurisdiction of the High Courts under Article 226. An aggrieved person has the option to approach either court, either Supreme Court under Article 32 or High Court under Article 226. Writ jurisdiction of the High Courts under Article 226. High Court's power under Article 226, the High Courts also have the power to issue writs for the enforcement of fundamental rights as well as for any other purpose. So, the Supreme Court under Article 32 can issue writs only for the enforcement of fundamental rights, whereas under Article 226, the High Courts can issue writs not only for the enforcement of fundamental rights but for any other purpose. However, this jurisdiction is discretionary, that is, the High Court may refuse to exercise it in appropriate cases, whereas under Article 32, the right of the Supreme Court, that is the Supreme Court issues writ for the enforcement of fundamental rights, is not a discretionary power. Dual mechanism. This dual mechanism under Article 32 and Article 226, that is Article 32 Supreme Court and 226 High Court, strengthens the protection of fundamental rights while maintaining the judicial federalism. And key distinction, Article 32's jurisdiction is non-discretionary, whereas Article 226 is discretionary, that is, the High Court may refuse to exercise in appropriate cases, whereas Article 32 jurisdiction is non-discretionary. The Supreme Court must entertain the petition, and Article 226 jurisdiction is discretionary. The High Court may refuse in appropriate cases. So the Supreme Court has cautioned against, recently the Supreme Court has cautioned against routine bypassing of the high courts and has emphasized the doctrine of alternative remedy in several recent cases, 2024 to 26. So that is, the Supreme Court has ruled asked recently to approach the High Court first rather than directly approaching the Supreme Court. So doctrine of alternative remedy in recent cases. So freedom of press. Is the freedom of press explicitly mentioned in the Constitution? No, the freedom of press is not explicitly mentioned in the Constitution. It is implicitly protected as an essential part of freedom of free speech and expression guaranteed under Article 19(1)(a). So, the freedom of press is not explicitly mentioned in the Constitution, but it is implicit in the provisions of Article 19(1)(a), that is implicitly protected as an essential part of freedom of speech and expression guaranteed under Article 19(1)(a). So, landmark case in Brijbhushan versus State of Delhi 1950, the Supreme Court held that freedom of press is a vital component of Article 19(1)(a). The press is the fourth pillar of democracy, and the press is often described as the fourth pillar of democracy because it plays a crucial role in informing the citizens, exposing the corruption, and ensuring the government accountability. So, what are the reasonable restrictions under Article 19? So, the fundamental rights are not absolute, they are qualified. Reasonable restrictions are imposed by the state. So, the reasonable restrictions under Article 19(2), that is, restrictions can be imposed on the grounds, that is, the reasonable restrictions are mentioned in the fundamental rights itself, Article 19(2) to 19(6). So, the reasonable restrictions under Article 19(2), restrictions can be imposed on grounds such as sovereignty and integrity of India, public order, decency and morality, contempt of court, and defamation. So, the contemporary challenges, that is, increasing concerns over media regulation, sedition cases, IT rules 2021 amended, and generalist arrests have kept Article 19(1)(a) in sharp focus. So recently, because of the increasing concerns over media regulation, media is supposed to be the fourth pillar of the democracy because it plays a crucial role in informing the citizens, exposing corruption, and ensuring governmental accountability. But recently, there are increasing cases of media regulation, sedition cases, IT rules 2021 amended, and generalist arrest have kept Article 19(1)(a) in sharp focus. So, the doctrine of essential religious practices. The doctrine of essential religious practices is a judicial innovation, and it is developed by the Supreme Court to determine the extent of state interference in religious matters. So, the doctrine of essential religious practice is not mentioned in the Constitution. It is a judicial innovation, like the basic structure of the Constitution. So, the judiciary has invented it. Why? That is, it is developed by the Supreme Court to determine the extent of state interference in religious matters. So, the origin in Shirur Mutt case 1954, first articulated by a 7-bench judge in the Commissioner Hindu Religious Endowments, Madras versus Sri Lakshmendra Tirtha Swamiyar of Sri Shirur Mutt. The court held that religion under Article 25 includes not only beliefs but also rituals and practices that are integral and essential to that religion. So, religion under Article 35. So, right to religious freedom, Article 25 to 28. So, Article 25 includes, so the court held that religion under Article 25 includes not only beliefs but also rituals and practices that are integral and essential to that religion. And the state power under Article 25 Clause 2, the state can regulate economic, financial, political and secular activities associated with the religion, but it cannot interfere in an essential religious practice. So, the state has the power under Article 25 Clause 2 to regulate economic, financial, political or secular activities associated with the religion, but cannot interfere with the essential religious practices. Who decides? The responsibility to decide what constitutes an essential religious practice ultimately lies with the courts, not religious authorities. So, the court decides what is an essential religious practice. So, the responsibility to determine what constitutes an essential religious practice ultimately lies with the courts and not religious authorities. So, essential religious practice, key cases. So, the doctrine has been applied in several important cases, balancing the right to religious freedom with the state's power of social reform. So, what are the important cases? So, important cases balancing the right to religious freedom as well as the state's power of social reform. So, Triple Talaq case 2017, the Supreme Court examined whether instant talaq was an essential religious practice and struck it down as unconstitutional. Whereas Shabarimala temple case 2018, the court ruled on whether the exclusion of women of menstruating age from Shabarimala temple was an essential religious practice. So, the court ruled on whether the exclusion of women of menstruating age from Shabarimala temple was an essential religious practice. So, the court ruled against this practice. And hijab case Karnataka 2022, the court examined whether wearing of hijab was an essential religious practice under Islam and protected by Article 25. And the temple management disputes, that is, various temple management and religious denomination disputes have tested the boundaries of state regulation versus the essential religious practice. So, the Supreme Court continues to be called upon to decide what is essential versus non-essential in ongoing cases related to religious practices, temple entry and management of religious institutions. So, broader context, judicial review in India. Though the term judicial review is not mentioned in the Constitution, it is implicitly provided through several provisions. Judicial review empowers the judiciary to act as the guardian of the Constitution and protector of the fundamental rights. So, Article 13, the judicial review is implicit in Article 13, 32, 226, 131 to 143. So judicial review is not mentioned in the Constitution. What is judicial review? Judicial review is the power of the judiciary to scrutinize the legislative enactments and executive actions, whether they are according to the provisions of the Constitution or not. That is, if they are not in consonant or if they are not according to the provisions of the Constitution, then they can be declared null and void. So, though the term judicial review is not mentioned in the Constitution, it is implicitly provided to several provisions. Judicial review empowers the judiciary to act as the guardian or protector of the fundamentals. Article 13, laws that are inconsistent with or in abrogation of fundamental rights can be declared null and void to the extent of inconsistency. Article 32, right to constitutional remedies It is called as the heart or and soul of the Constitution by Dr. B.R. Ambedkar. And Article 226, that is the power of the High Courts to issue writs. Article 131 to 136, that is the original and appellate jurisdiction of the Supreme Court. Original jurisdiction, the right or the power of the Supreme Court to hear the cases in the first instance, not by the way of appeal, and appellate jurisdiction. Article 136, that is special leave petition. Article 143, advisory jurisdiction of the Supreme Court, that is the President can seek the advice or opinion of the Supreme Court on any question of law, or fact. Article 143, advisory jurisdiction of the Supreme Court. And Article 373, continuance of pre-constitutional laws only if they are consistent with the provisions of the Constitution. So, any pre-constitutional law can continue if consistent with the Constitution. Otherwise, they will be declared null and void. Current affairs context, Article 32 and Article 226. The Supreme Court has cautioned against the routine bypassing of high courts and has emphasized the doctrine of alternative remedy in several cases. Freedom of press, that is increasing concerns over media regulation, sedition cases, IT rules 2021 amended, and journalist arrest have kept the Article 19(1)(a) in focus. And essential religious practice, the doctrine continues to be tested in ongoing cases related to religious practices, temple entry, management of religious institutions. The Supreme Court is often called upon to decide the essential versus non-essential. So, with regarding to UPSC prelims, the key articles, cases and distinctions to remember. So, key articles, Article 32, 226, 19(1)(a), 25, their scope, nature and distinctions. Key cases, Shirur Mutt 1954 and Brij Bhushan versus State of Delhi 1950. Landmark judgments to remember. And Article 32 and Article 226, that is the difference in nature, non-discretionary, Article 32 versus discretionary, Article 226, scope of writs, concurrent jurisdiction. So, the most important is this, Article 32 and 226. So, the feature, court, Article 32 is issued, writs are issued by the Supreme Court. Article 226, writs, directions or order are issued by the High Courts. When an aggrieved person approaches aggrieved person, when his fundamental rights are violated, he can approach both Supreme Court or the High Court. Supreme Court under Article 32 and High Court under Article 226. And this power of the Supreme Court is non-discretionary. That is, the Supreme Court has to issue an order or writ, and this power of High Court is discretionary. It may not issue a writ in appropriate cases. Scope, only fundamental rights. The Supreme Court issues writs, orders or directions for the enforcement of only fundamental rights, whereas under Article 226, the High Court issues writs not only for the enforcement of fundamental rights, for any other purpose also. And is it a fundamental right? Article 32? Yes, the Article 32 is in itself a fundamental right, whereas Article 226 is not a fundamental right. Overlap between fundamental rights and directive principles of the state policy. Indian Constitution uniquely balances the justiciable and non-justiciable provisions by placing certain ideals in both fundamental rights, Part 3, Article 12 to 35, and Directive Principles of the State Policy, Part 4, Article 36 to 51. This overlap reflects the Constitution's vision of achieving both political democracy, that is fundamental rights, through fundamental rights, and socio-economic democracy through directive principles of the state policy. So, right to education as a fundamental right. The right to education was made a fundamental right by Article 21A, Article 21A by the 86th Constitutional Amendment Act 2002. It inserted Article 21A in Part 3, making right to education a fundamental right. It states the state shall provide free and compulsory education to all the children in the age group of 6 to 14 years in such manner as the state may by law determine. This is backed by the Right of Children to Free and Compulsory Education Act 2009, which operationalizes the constitutional mandate. So, the right to education as a directive principle. So, right to education was a directive principle before the 86th Constitutional Amendment Act 2002 has inserted Article 21A and made it a fundamental right. So, originally Article 45 directed the state to endeavor to provide within 10 years from the commencement of the Constitution free and compulsory education for all children until they complete the age of 14 years. So this was the original provision of Article 45. So 86th Constitutional Amendment Act 2002, it not only introduced Article 21A of fundamental right, but it also changed the subject matter of Article 45 of the directive principle of the state policy. So after 86th Constitutional Amendment, so the original Article 45, that is, it directed the state to endeavor to provide within 10 years from the commencement of the Constitution the free and compulsory education for all children until they complete the age of 14 years. So after 86th Constitutional Amendment Act, Article 45 was amended to focus on early childhood care and education for the children below 6 years. So the 86th Constitutional Amendment Act 2002, it has changed the subject matter of Article 45. So the Article 45 was amended to focus on early childhood care and education for children below 6 years, shifting its focus after the right to education for 6 to 14 years olds was elevated to a fundamental rights. So significance, this is a classic example of directive principle being elevated to a status of fundamental right to constitutional amendment. So this is a classical example of a directive principle of the state policy, that is Article 45, directive principle of the state policy being elevated to the status of a fundamental right through constitutional amendment. So cooperative societies here is another example. So cooperative societies, that is Article 19, Clause 1, Subclause C, that is right to form associations, unions and cooperative societies. So it was added by 97th Constitutional Amendment Act 2011. That is right to form a cooperative societies is a fundamental right. So as a fundamental rights, Article 19(1)(c) guarantees to all citizens the right to form associations, unions or cooperative societies. Reasonable restrictions can be imposed by the state under Article 19(4) in the interest of public order, morality, sovereignty and integrity of India. As directive principle, Article 43B. So the 97th Constitutional Amendment Act 2011 has introduced a new directive principle of the state policy, Article 43B. So it was introduced by 94th Constitutional Amendment Act 2011. It directs the state to endeavor to promote the voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. So 97th Constitutional Amendment Act 2011, it directs the state to endeavor to promote the voluntary formation, democratic functioning, professional management and autonomous functioning and democratic control of cooperative societies. Significance. This overlap strengthens the cooperative movement in India, which plays a vital role in agricultural dairy example, the Amul model, credit and rural development. So protection of environment, forest and wildlife. The directive principle as directive principle, Article 48A was inserted by the 42nd Constitutional Amendment Act 1976. It directs the state to endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. So, the Article 48A of the Directive Principle of the State Policy was inserted by 42nd Constitutional Amendment Act 1976. So, it directs the state to endeavor to protect and improve the forest, that is the environment, and safeguard the forest and wildlife of the country. As a fundamental right, Article 21, that is the judicial interpretation of Article 21, right to life and personal liberty, there is no explicit provision in Part 3 specially mentioning environment or wildlife. However, the court has interpreted Article 21, that is right to life and personal liberty, expansively to include right to clean and healthy environment as a part of right to life with dignity. So, the Article 21 is the most inferred article of the Constitution. So, the Supreme Court has interpreted it expansively to include right to a clean and healthy environment as a part of right to life with dignity. Subhash Kumar versus State of Bihar, MC Mehta cases and Virendra Gaur case. So, while environmental protection has a strong backing of directive principles and judicial interpretation of the fundamental rights, it is not explicitly mentioned in the chapter on fundamental rights. So, fundamental rights versus directive principles, key differences. So, nature, fundamental rights part 3, directive principles part 4, Article 12 to 35. Article 36 to 51. So, what are the key differences between fundamental rights and directive principles of the state policy? Nature. The fundamental rights are negative, that is, they prohibit the state from doing certain acts. Whereas directive principles of the state policy are positive, they direct the state to do certain things. Justiciable. Yes, fundamental rights are justiciable, they are enforceable by the courts. If the fundamental rights of a person are violated, then the aggrieved person can approach the Supreme Court under Article 32 and Article 226. So, they are justiciable, enforced by the courts. Non-justiciable, directive principles are not justiciable and not enforceable by the courts. Objective, establish political democracy. The fundamental rights establish political. The objective of the fundamental rights to establish political democracy, and the objective of directive principles of the state policy is to establish social and economic democracy. And sanction. What is the sanction behind this? There is a legal sanction, and here it is a moral and political sanctions. That is, fundamental rights should not be violated. If they are violated, there is a legal sanction, that is, the courts will issue writs. And whereas directive principles of the state policy, if they are not implemented, that is, they are not justiciable, not enforceable. So, if the state is not implementing them, what is the sanction behind them? It is moral and political sanction. Focus is on welfare of the individual. Fundamental rights, here the focus is the welfare of the community under directive principles of the state policy. Implementation, fundamental rights are automatically enforced. There are provisions in the Constitution, whereas the directive principles of the state policy, most of the fundamental rights are automatically enforced, while some fundamental rights, they require the legislation. For example, untouchability. Okay. So, the directive principles of the state policy, they require legislation for implementation. And judicial role, the courts can strike down violating laws. If any law, it is violating Article 13, laws that are inconsistent with or an abrogation of fundamental rights can be declared null and void, and courts can uphold the laws enacted to implement the directive principles of state policy. That is, any law that it is giving effect to directive principles of the state policy, the courts will uphold it as void. The court will not declare those laws as null and void. So, current affairs context 24-26, the Right to education, that is implementation of RTE Act 2009, continues to face challenges such as poor learning outcomes, teacher vacancies, infrastructure gaps. So the National Educational Policy NEP 2020 aims to strengthen the foundational literacy and integrate early childhood care, aligning with amended Article 45. So cooperative societies, the Ministry of Cooperation, created in 2021, has been actively promoting the sector. The Multi-State Cooperative Societies Amendment Act 2023 and initiatives like Sahakar Se Samriddhi reflect the push towards strengthening Article 43B. The Article 43B of Directive Principles of the State Policy was introduced by 97th Constitutional Amendment Act 2011. So, the Ministry of Cooperation was created in 2021 and been active in promoting the cooperative sector. So, the Multi-State Cooperative Societies Amendment Act 2023 and initiatives like Sahakar Se Samriddhi reflect the push towards strengthening Article 43B. Environment. Article 48A of the Directive Principles of the State Policy, introduced by 42nd Constitutional Amendment Act 1976, has gained prominence with climate change, forest conservation amendments 2023 and Supreme Court's ruling on ecological restoration, sustainable development and polluters pay principle. So, the UPSC relevance, that is for preliminary, key constitutional amendments and articles to remember for prelims, that is 86th Constitutional Amendment Act 2002 has inserted the fundamental right, Article 21A, and amended the directive principles, changed the subject matter of the directive principle of the state policy, Article 45, to focus on children below 6 years and added a new fundamental duty, that is 11th fundamental duty. 97th Constitutional Amendment Act 2011 has introduced the cooperative societies, that is, it has inserted an Article 43B as a directive principle, and right to form cooperative society is a fundamental right now under Article 19(1), Clause 1, Clause C. Article 48A, that is environment, inserted, that is 42nd Constitutional Amendment Act 1976, it has inserted Article 48A, directing protection of environment, forests and wildlife. So, the key articles, Article 21A, education as a fundamental right, Article 19, Clause 1, Clause C, cooperative societies, right to form cooperative societies is a fundamental right. Right to education is a fundamental right under Article 28A, and 43B, cooperative societies as a directive principle of the state policy. 45, education as a directive principle of the state policy. Article 48A, environment as a directive principle of the state policy. So, what are the key takeaways? The unique constitutional balance. The Indian Constitution uniquely balances justifiable fundamental rights and non-justifiable directive principles of the state policy, together pursuing political, social and economic democracy. Elevation of directive principles of the state policy to fundamental rights. Right to education is a landmark legislation or landmark example of a directive principle being elevated to a fundamental right through the 86th Constitutional Amendment Act 2002. Judicial interpretation as a bridge. The Supreme Court has played a crucial role in bridging the gap between fundamental rights and directive principles of the state policy, especially through the expansive interpretation of Article 21 to include the environmental rights. So, the most inferred article in the Constitution is Article 21. So, the expansive interpretation of the Supreme Court to include environmental rights. And contemporary relevance, from the Ministry of Cooperation established in 2021 to National Education Policy 2020 and the Forest Conservation Amendments 2023, the overlap between fundamental rights and directive principles of the state policy continue to shape India's policy landscape. Public interest litigation. Public interest litigation is a landmark innovation, that is, it's a judicial innovation that emerged in India in early 1980s, representing one of the finest examples of judicial activism by the Supreme Court of India. Judicial activism is a proactive role played by the Supreme Court in interpreting the Constitution. So, the origins and pioneers, that is, in scrutinizing the legislative enactments and executive actions if they are not according to the provisions of the Constitution. So, the origins and pioneers of public interest litigation. Public interest litigation is also known as social action litigation or social interest litigation. It emerged in India in early 1980s as a transformative judicial tool. Justice V.R. Krishna Iyer, regarded as one of the founding fathers of the public interest litigation movement in India, his progressive judicial philosophy laid the groundwork for expanding access to justice. And Justice P.N. Bhagavati, the other founding father of public interest litigation in India, he championed the cause of the poor and marginalized through bold judicial innovation and expansive interpretation of the rights. So, access of justice, judicial innovation and expansive interpretation of the rights. So, both Justice V.R. Krishna Iyer and Justice P.N. Bhagavati are the founding fathers of PIL in India. With their progressive judicial philosophy, laid the groundwork for expanding access to justice, and they championed the cause of the poor and marginalized sections through bold judicial innovations and expansive interpretation of rights. So, meaning and purpose of PIL. PIL is a legal action initiated in the court of law for the enforcement of public interest or general interest. So, it is a legal action initiated in the court of law for public interest or general interest, where the rights or liabilities of a section of the public or community at large are affected. It is primarily a tool to provide access to justice to the poor, marginalized and disadvantaged sections of the society who cannot approach the court themselves due to poverty, those who lack the financial resources to pursue legal remedies through conventional means, illiteracy, those who are unaware of their legal rights, are unable to navigate the judicial system, and social backwardness, those who face systematic barriers that prevent them from seeking justice independently. Key features of the PIL. PIL introduced several groundbreaking procedural innovations that distinguish it from ordinary legislation. Relaxation of locus standi, that is relaxation of traditional rules of local standi, that is right to sue. Any public spirited person or organization can file a PIL on the behalf of aggrieved person. So, to file a PIL, you did not be a party to the case. So, any public spirited person or organization can file a PIL on the behalf of an aggrieved person. So, the principle of local standi has been relaxed. That is relaxation of the traditional rule of local standi. Letter as PIL. So, the Supreme Court and High Courts can treat even a letter, postcard or a telegram as a PIL. It raises issues on public, if it raises issue on public interest or public importance. Relaxed procedural rules. Procedural rules and strict rules of pleading are relaxed, making it easier for ordinary citizens to seek judicial intervention and constitutional and international protections. The court can invoke Article 14 and Article 21 and international human rights conventions to protect rights to the underprivileged, and filling jurisdiction Bills can be filed in the Supreme Court under Article 32 and in the High Courts under Article 226. So, under Article 32 and Article 226, you can file bills under the Supreme Court and High Court respectively. And constitutional and international protections, the court can invoke Article 14, right to equality before law and equal protection of law. Article 21, right to life and personal liberty, and international human rights conventions to protect rights of the underprivileged. So, pill and fundamental rights, an important distinction. So, common misconception, that is, pills are frequently filed under Article 32 for enforcement of fundamental rights, especially Article 21, right to life and personal liberty. This leads many to assume that pill itself is a fundamental right. So, this is a misconception, because pills, public interest litigations, are frequently filed under Article 32 for the enforcement of fundamental rights and Article 21, right to life and personal liberty. So, the pill, this leads many to assume pill as a fundamental right. No, pill is not a fundamental right. And the correct position, pill itself is not a fundamental right guaranteed under Article 21 or any other article of the Constitution. It is a judicially evolved mechanism, that is, it is a judicial innovation for expanding access to justice, a product of judicial creativity and not constitutional text. So, it is not explicitly mentioned, but it is a judicially innovation. So, pill is a tool to enforce fundamental rights and not a fundamental right in itself. So, fundamental rights, the 6 pillars, that is the fundamental rights enshrined in the Constitution Part 3, Article 12 to 35, are cornerstone of the Indian democracy. At present, there are 6 fundamental rights. Originally 7 fundamental rights, that is Article 31, Article 19(1)(f) and Article 31, right to property, are taken away by 44th Constitutional Amendment Act 1978. So, 44th Constitutional Amendment Act, and the right to property is now made a constitutional or legal right under Article 300A, Part 12. So, originally there are 7 fundamental rights, now only 6 fundamental rights. Right to equality, Article 14 to 18. Right to freedom, Article 19 to 22. Right against exploitation, 23 to 24. Right to freedom of religion, 25 to 28. And cultural and educational rights of minorities, 29-30. Right to constitutional remedies, Article 32. So, right to property was originally a fundamental right under Article 31, but was removed by 44th Constitutional Amendment Act 1978 and is now constitutional or legal right under Article 300A. So, the core objective of fundamental rights, the fundamental rights serve multiple vital purposes in a constitutional democracy, that is, promote political democracy. They are meant to promote the ideal of political democracy and ensure equal participation of all citizens, limit state powers. They act as limitations on the powers of the state and prevent the establishment of authoritarian or despotic government, and they protect the individual liberty. They protect the individual liberty and freedom against arbitrary actions of the executive and unreasonable laws made by the legislature. So, in the words of Dr. B.R. Ambedkar, fundamental rights establish a government of laws, not of men, and they operate as a bulwark, that is, protection against the tyranny of majority and safeguard the dignity and liberty of the individual. So, the pill in current affairs, the pill continues to be widely used across a broad spectrum of public interest issues like environmental protection, air protection, NCAP, ecological conservation, climate accountability, rights and welfares, custodial deaths, women's rights, child rights, implementation of welfare schemes. The pill is used widely. and digital and electoral, online safety, digital rights, electoral reforms, challenges to arbitrary executive action. So, pill continues to be widely used as a broad spectrum of public interest. So, misuse of pill and judicial caution. So, the Supreme Court has increasingly cautioned against the misuse of pill, recognizing that the tool must not be weaponized for private or political ends. So, grounds of misuse: private interest disguised as public interest litigation, political motives aimed at targeting the opponents or disrupting governance, frivolous petty litigation that wastes judicial time and resources. So, pill is a powerful tool. Its misuse undermines the very access to justice it was designed to protect. So, pill must not be misused because it undermines the very access to justice it has been designed to protect. And judicial response: the Supreme Court has imposed costs in several cases of abuse of pill, sending a strong signal that the mechanism must be used responsibly and in genuine public interest. It cannot be used for private interest. It cannot be used for political motives aimed at targeting opponents and disrupting governments, and frivolous litigation that wastes judicial time and resources. So, the Supreme Court has imposed cost on several cases of abuse of pill, sending a strong signal that mechanisms must be used responsibly. That is, this tool of pill must be used responsibly and in genuine public interest. So, pill is a powerful tool. Its misuse undermines the very reason or the very excess of justice it was designed to protect. So, pill and Article 21, that is expanding socio-economic rights. So, the judiciary continues to use pill as an effective tool for enforcing socio-economic rights through expansive interpretation of Article 21, that is right to life and personal liberty. Though through pill, the right to life under Article 21 has been interpreted to include right to livelihood, right to health, right to education, a clean environment and human dignity, transforming it into a comprehensive guarantee of life with meaning and purpose. So, pill as a mechanism, a judicially evolved tool, not a fundamental right that expands access to justice for all. Article 22 as a canvas, that is the expansive interpretation of the right to life and personal liberty, continues to be the primary vehicle for pill-driven socio-economic justice, and the ongoing relevance from environmental protection to digital rights. Pill remains India's most dynamic judicial instrument for public good. So, rights against exploitation, Article 23 and 24. The Indian Constitution provides strong safeguards against exploitation through Article 23 and 24, which forms part of Fundamental Rights, Part 3. These provisions are designed to protect the dignity and freedom of the individuals, especially the vulnerable sections of the society. So, Article 23 and 24, right to exploitation. So, Article 23, prohibition. So, Article 23, prohibition of traffic in human beings and forced labor. So, Article 23 is broader in scope and prohibits three major forms of exploitation, that is traffic in human beings, that is selling or buying of men, women and children, immoral traffic in women and children including prostitution, and Devadasi system and slavery, beggar, compulsive work without any remuneration, a traditional exploitative practice where landlords forced tenants to work without payment, and other forms of forced labor. This includes bonded labor, any form of labor extracted through physical, legal or economic compulsion. Example, forcing someone to work below the minimal wages due to poverty or debt. So, Article 23 prohibits traffic in human beings and forced labor. So, it is broader in scope. It prohibits three major forms of exploitation: traffic in human beings, beggar and other forms of forced labor. Key features of Article 23, that is its universal applicability. The right is available to both citizens and non-citizens. Protection against all. It protects individuals not only against the state but also against the private persons. Punishable offense. Any contravention of Article 23 is a punishable offense. Important supporting laws, that is Immoral Traffic Prevention Act 1956 for human trafficking and prostitution, Bonded Labor System Abolition Act 1976, Minimum Wages Act 1948, Contract Labor Regulation and Abolition Act 1970, and Equal Remuneration Act 1976. So, child labor, Article 24, prohibition of employment of children. So, Article 24 prohibits the employment of children below the age of 14 years in any factory, mine or in any other hazardous employment. So, what it targets is specifically targets hazardous occupation such as construction work, railways, beadi making and fireworks, etc. How it permits, however, what it permits, however, it does not prohibit children from being engaged in non-hazardous or innocent work. Example, helping in family enterprises or light domestic work. Its aim, this provision aims to protect children from economic exploitation, ensure they get opportunities for education and healthy development. Supporting laws for Article 24, several important legislations have been enacted to implement and strengthen the protection under Article 24. So, Child Labor Act, Child Labor Prohibition and Regulation 1986, now strengthened by Child Labor Amendment Act 2016, Factories Act 1948, Mines Act 1952, Plantation Labor Act 1951, Apprentice Act 1961, Motor Transport Act, Motor Transport Workers Act 1951. So, current affairs context, child labor and human trafficking. Despite legal prohibitions, child labor persists in informal sectors, agriculture, domestic work. The government has strengthened enforcement through National Child Labor Project NCLP and integration with schemes like Samagra Shiksha and PM Poshan. However, the impact of COVID-19 and economic distress has led to a rise in child labor cases in several states. Human trafficking, India remains a source, transit and destination country for human trafficking. The Trafficking in Persons Prevention, Care and Rehabilitation Bill has been under discussion. States like West Bengal, Bihar, Odisha and Maharashtra report high numbers of trafficking cases. So, the Trafficking in Persons Prevention, Care and Rehabilitation Bill is still under discussion, and states like West Bengal, Bihar, Odisha and Maharashtra report high number of trafficking cases. So, India remains a source of transit and destination country for human trafficking. So, current affairs context, bonded labor and judicial interventions. Bonded labor, despite the 1976 Act, bonded labor continues in brick kilns, agriculture and garment industries. The Supreme Court has periodically directed states to identify, rescue and rehabilitate bonded laborers. So, judiciary has directed periodically, that is the Supreme Court has directed periodically, that is directed the states to identify, rescue and rehabilitate bonded laborers. And judicial interventions, the Supreme Court and High Courts have taken suo motu cognizance on itself, that is by itself, suo motu cognizance on issues of child labor in hazardous industries and forced labor during migrant crisis. So, for UPSC prelims, the provisions of Article 23 and 24, difference between Article 23 and 24, and the key laws associated with the prohibition of child labor and bonded labor, meaning of beggar, traffic in human beings, and forced labor. So, quick comparison between 23 and 24. Article 23 deals with traffic in human beings and forced labor. Article 24, prohibition of child employment, that is below 14 years of age in hazardous employment. Scope broader. Article 23 covers beggar, bounded labor, and trafficking and slavery. It is narrow, focused on children below 14 years. And who is protected? Citizens and non-citizens. Article 23. Here, children before 14 years. And against whom? State and private persons under Article 23. And employers. Article 24. Employers in hazardous industries. And the key law, Bonded Labor System Abolition Act 1976. And key law under Article 24, Child Labor Prohibition and Regulation Act 1986. Both articles together form right against exploitation under Part 3 of the Indian Constitution, safeguarding the dignity and freedom of most vulnerable sections of the society. Indian Councils Act 1909. Morley Minto reforms. So, Indian Councils Act 1909, popularly known as Morley Minto reforms, was a significant constitutional reform introduced by the British government in India. It was named after Lord John Morley, the Secretary of State for India, and Lord Minto, the Viceroy of India. The Act was a relatively short legal document consisting of 8 articles and 2 schedules. So, it was a relatively short document consisting of 8 articles and 2 schedules. It marked an important step towards the gradual inclusion of Indians in the legislative and executive processes of British India. So, it is an important step towards introducing or the inclusion of Indians in legislative and executive processes of British India. So, who were Lord Morley and Minto? So, Lord John Morley, the Secretary of State for India, the British Cabinet Minister responsible for overseas Indian affairs from London, and Lord Minto, the Viceroy of India, that is the Crown representative and the highest authority in British India, based in Calcutta. So together, these 2 figures lent their names to the landmark reforms of 1909, which shaped the trajectory of constitutional development in colonial India. So, the expansion of legislative councils. One of the most important, notable major features of the Act was the significant enlargement of legislative bodies at the central and provincial level. That is both central and provincial levels. That is 16, that is the previous size of the members of the Central Legislative Council before the Act, and 60, the new size, that is the number of members in the Central Legislative Council was increased from 16 to 60. The new size that is the members in the Central Legislative Council is now increased to 60. That is a dramatic increase, and not only the Central Legislative Council, but the size of provincial legislative councils was also enlarged, though the numbers were not uniform across the provinces. So, the Government of India Act 1909, that is the Morley and Minto reforms, included the expansion of legislative council at both the levels, that is Central Legislative Council and Provincial Legislative Councils. The Central Legislative Councils, the number of members were increased from 16 to 60, and in the Provincial Legislative Council also the size was enlarged, but the numbers were not uniform, that is across the provinces. So the composition of the council. The act introduced a crucial distinction between the composition of the central and provincial legislative councils. That is, the central legislative councils retained official majority, ensuring that the British executive maintained firm control over the central level, and the provincial legislative councils allowed for the non-official majority for the first time, a limited but significant concession to Indian representation at the provincial level. So, the composition of the councils, that is, the act introduced a crucial distinction between the composition of the central legislative council and the provincial legislative council. The central legislative councils, they retained official majority, whereas provincial legislative council were allowed non-official majority for the first time. The central legislative council retained official majority, that is ensuring that the British executive maintained firm control at the central level, whereas the provincial legislative council allowed non-official majority for the first time, a limited but significant concession to the Indian representation at the provincial level. So, the executive councils and the Indian inclusion. The act made landmark provisions regarding the executive councils and the association of Indians with the governance. So, the new executive councils were created, that is, executive councils were created in the provinces of Bombay, Madras and Bengal, that is West Bengal, and Indians in the executive councils. For the first time, provision was made for the association of Indians in the executive councils of the Viceroy and the governors. So, not only new executive councils were created, that is in the provinces of Bombay, Madras and West Bengal, but also Indians in the executive councils. That is, for the first times, provision was made for the association of Indians with the Viceroy's executive council and the governor's executive council. So, Satyendranath Prasad Sinha became the first Indian to join the Viceroy's executive council as a law member, a historical milestone. So, association of Indians with the executive councils, Viceroy's executive councils and the governor's executive council. So, the act made landmark provisions regarding the executive councils, that is, new executive councils were created for the provinces of Bombay, Madras and West Bengal, and association of Indians with the governors, that is, Indians, for the first time provision was made for the association of Indians with the Viceroy's executive council and governors, with the executive councils of Viceroys and the governors. And Satyendranath Prasad Sinha became the first Indian to join, or for the first Indian to join the Viceroy's Executive Council as a law member. The other important provisions, that is, enlarged deliberate functions, that is, the deliberative functions were enlarged, that is, members, the deliberative functions of the council were enlarged, that is, members were now allowed to ask supplementary questions and move resolutions on the budget, that is, expanding the deliberative role of the legislative councils. So, it enlarged, the Government of India Act 1909, it enlarged the deliberative functions of the executive legislative councils, that is, the members were allowed to ask supplementary questions on the and move resolutions on the budget, expanding the deliberative role of the legislative councils. And office of the Vice President was introduced in the central and provincial legislative councils. And the separate representation was for groups was also allowed, that is, it provided separate representation for presidents of corporations, chambers of commerce, universities and zamindars. So, other important provisions, that is, enlarge the deliberative functions of the central legislative, that is the legislative councils, that is the member were allowed to ask supplementary questions and move resolutions on the budget, expanding the deliberative functions of the legislative councils. And office of the vice president was introduced in the central and provincial legislative councils, and the separate representation for groups, that is provided separate representation for presidents of corporations, chambers of commerce, universities and zamindars. So separate electorate, the most controversial provision of Government of India Act 1909, that is, it provided for separate electorate for Muslims, a highly controversial move that legalized communalism in Indian politics. So this is a highly controversial move providing for separate representation for Muslims, and it legalized communalism in Indian politics. So Lord Minto is often called the father of communal electorate. For this reason, by introducing separate electorates on religious lines, the act sowed the seeds of communal division, which later contributed to the demand for Pakistan and the eventual partition of India in 1949. So Lord Minto, he is called the father of communal electorate, and by introducing separate electorate on religious lines, the act sowed the seed of communal division, and which later contributed to the demand of Pakistan and later division of the country, that is partition of India in 1947. So historical significance, the Morley Minto reforms were the first serious attempt by the British to introduce limited representative elements in India. So it also introduced limited representative elements in India, that is limited representation, that is increased Indians' participation in legislative bodies as a step forward in constitutional development during the British period. Power remained in British, that is real power remained firmly in the hands of British executives. The reforms were largely constitutional in the form but conservative in spirit, and the seeds of partition, that is the communal electorate introduced by Government of India Act 1909, the communal electorate provision contributed to the growth of communal politics and ultimately the demand for Pakistan. The act represented a shift from Indian Councils Act 1892 while still maintaining the British control, embodying the divide and rule policy through constitutional reforms. So it is of historical significance, the Government of India Act 1909, and it is the first serious attempt by the British to introduce the representative, limited representative element in India, that is limited representatives, that is it increased the Indians' participation in legislative bodies, a step forward in constitutional development during the British period, and power remained with British. Though they increased the Indians' participation in legislative bodies, the real power remained with the firmly in the hands of British executives. The reforms were largely constitutional but conservative in spirit, and it sowed the seeds of partition, that is the communal electorate provision, contributed to the growth of communal politics and ultimately the demand for Pakistan. So this Government of India Act 1919, it shifted from represented a shift from Indian Councils Act 1892 while still maintaining British control, embodied the British control, embodying the divide and rule policy through the constitutional reforms. So UPSC relevance for prelims, that is the key topics from the Morley Minto reforms that are frequently tested in the exam, that is key provisions of the Indian Councils Act 1909, council composition, that is the changes in the size and composition of the central and provincial legislative councils, separate electorates, introduction of separate electorates and long-term impact on Indian politics and society, first Indian member of the Viceroy's Executive Council, Satyendra Prasad Sinha. John Stuart Mill's harm principle and its reflection in Article 19 of the Constitution. So, John Stuart Mill's harm principle and how it is reflected in Article 19 of the Indian Constitution, Fundamental Rights, Part 3, Article 12 to 25. So, an exploration of one of the most influential ideas of individual liberty and how it finds a constitutional echo in the fundamental freedoms guaranteed to every Indian citizen. So, John Stuart Mill and the harm principle. John Stuart Mill, 1806 to 1973, a prominent 19th century British philosopher and political economist, articulated one of the most influential ideas on individual liberty in his seminal work on Liberty, 1859. The only purpose, so according to John Stuart Mill's harm principle, so John Stuart Mill was a prominent 19th century British philosopher and a political economist. He articulated the most influential idea on individual liberty in his seminal work on Liberty, 1859. So, according to him, the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. So his own good, either physical or moral, is not a sufficient warrant. So the only purpose for which a power can be rightfully used against any member of a civilized society is to prevent harm to others. Even his own good, power cannot be used even for his own good, either physical or moral. So, even for his own good, physical or moral, is not a sufficient warrant. So, the harm principle in simple terms, that is, individuals should be free to think, speak and act as they wish. The state should not interfere in an individual's liberty unless their actions cause harm to others. Mill strongly advocated for the minimal state intervention in personal matters, emphasizing the individual autonomy and the freedom of thought and expression. So, the harm principle of John Stuart Mill in simple terms, that is, the individual is free to think, act, speak as they wish, and the state should not interfere in individuals' liberty unless their actions cause harm to others, and Mill strongly advocates for minimal state intervention in personal matter, emphasizing the individual autonomy and freedom of thought and expression. So the harm principle became a foundational concept in classical liberalism and constitutes to influence modern debates on freedom of speech, privacy, morality and state regulation. So, the harm principle became a foundational concept in classical liberalism. So, what is classical liberalism? Classical liberalism is 17th and 19th century political and economic ideology advocating for individual liberty, limited government intervention and the free market capitalism. So, it is the classical liberalism is the 17th to 19th century political and economic ideology that emphasizes on individual liberty, minimal state intervention individual liberty, minimal state intervention or limited government intervention, and free market capitalism. So now how the harm principle is resonated in Article 19. Article 19, part of fundamental rights. Fundamental rights are enshrined in the Constitution, Part 3, Article 12 to 35. So, Article 19, 6 fundamental rights. The Article 19 of the Indian Constitution guarantees 6 fundamental freedoms to all the citizens. Article 19, 1A to Article 19, 1F. Article 19, 1G, I think this is G. Article 19, 1G. So, Article 19, 1A, freedom of speech and expression. Article 19, 1B, that is Article 19, Clause 1 and Subclause B, freedom to assemble peacefully without arms. Article 19, Clause 1, Subclause C, freedom to form associations, unions and cooperative societies. Cooperative societies, 97th Constitutional Amendment Act 2011, and Article 19, Clause 1, Subclause D, freedom to move freely throughout the territory of India. Article 19, Clause 1, Subclause E, freedom to reside and settle in any part of territory of India. And Article 19, 1F, right to property, was taken away by 44th Constitutional Amendment Act 1948. So, Article 19, Clause 1, Clause G, freedom to practice any profession or to carry on any occupation, trade or business. These freedoms are not absolute. These Article 19 or fundamental rights are not absolute, they are qualified. That is, reasonable restrictions can be imposed by the state. That is Articles 19 Clause 2 to 19 Clause C. They empower the state to impose reasonable restrictions on these rights on specified grounds. So, these freedoms under Article 19, originally they were 7, but now they are 6 because Article 19, 1F, right to property, was taken away. That is, the individual rights to acquire, hold and dispose of property was taken away by 44th Constitutional Amendment Act 1948. So, now there are 6 freedoms under Article 19. So, these freedoms are not absolute, they are qualified. That is, the state can impose reasonable restrictions. So, reasonable restrictions are mentioned in Article 19 itself, that is Article 19, Clause 2 to 19, Clause 6. They empower the state to impose reasonable restrictions on these rights on specified grounds. So, what are the key grounds of for reasonable restrictions? That is under Article 19, Clause 2 and Article 2, Article 19, Clause 6. The state can impose reasonable restrictions on the basis of following grounds. So, what are the following grounds? Sovereignty and integrity of India, security of the state, public order, that is maintenance of public order, so foreign relations, that is friendly relations with foreign states, decency and morality, contempt of court, defamation and incitement to an offence. So, these are the key grounds for reasonable restrictions, that is under Article 19, Clause 2 to Clause 6. The state can impose reasonable restrictions on the fundamental right, Article 19. So, these are the grounds: security and integrity of India, security of the state, public order, maintenance of public order, foreign relations, that is friendly relations with foreign states, decency and morality, contempt of court, defamation and incitement to violence. So, how the harm principle aligns with Article 19? So, there is a clear alignment, philosophical alignment between John Stuart Mill's harm principle and the scheme of Article 19. Mill's harm principle, that is, liberty can be restricted only to to prevent harm to others, the state has no right to intervene in personal matters that do not affect others. John Stuart Mill's harm principle. And Article 19, the state may impose reasonable restrictions on the individual freedoms only when such exercise of freedom is likely to cause harm to public order, security of the state, decency and morality and rights of others. So, Article 19. So, thus Article 19, it embodies a balanced approach. It guarantees maximum individual liberty in line with harm's ideas while permitting the state to intervene only when harm to society or others is anticipated. So, harm's principle in practice. So, the Supreme Court and the spirit of the harm's principle. The Supreme Court has often invoked this spirit while interpreting Article 19. For instance, striking down overly broad restrictions. That is, in cases involving freedom of speech, the court has struck down overly broad restrictions, that is, overly broad reasonable restrictions curtailing the individual liberty that go beyond preventing actual harm. So, the state can only impose reasonable restrictions when it anticipates that the actions of the individual will harm others. So, when the state imposes reasonable restrictions, overly broad restrictions that go beyond preventing actual harm, so the Supreme Court has struck down overly broad restrictions, and reasonable restrictions has constitutional safeguard. The concept of reasonable restrictions acts as a constitutional safeguard against the arbitrary state interference, much like the Mill's caution against excessive state power. So, the judicial approach ensures that the constitutional framework remains true to the philosophical spirit of harm's principle, that is, protecting liberty while guarding against genuine harm. So, the contemporary relevance, that is, freedom of speech versus harm principle, that is, the debate around hate speech, fake news, sedition under section 124A and IT rules, though now it is changed with BNS, so, and IT rules continue to test the limits of harm's principle. The Supreme Court has emphasized that restrictions should be reasonable, proportionate and directly linked to preventing tangible harm. And moral policing and decency, issues like dress codes, public display of affection and content regulation often raise questions whether the state is protecting public morality or unnecessarily restricting personal liberty. So, there is always that is between moral policing and decency. Digital age challenges. So, with the rise of social media, determining what constitutes harms to others. Okay, so what constitutes harm to others? Example, misinformation, deep fakes, online radicalization have become more complex. So, challenges in the digital age, that is, with the rise of social media, what actually constitutes harm to others? Example, like misinformation, deep fakes, online radicalization, so has become more complex. So, the following topics are important for UPSC prelims, that is John Stuart Mill and harm principle, his life 1806 to 1973, his work on liberty 1859, and the central idea that liberty only be restricted to prevent harm to others. 6 freedoms under Article 19, that is Article 19 Clause 1 Subclause A to Article 19 Clause 1 19 Clause 1 Subclause G. Freedom of speech and expressions, freedom to assemble peacefully without arms, freedom to form associations, unions and cooperative societies, freedom of movement throughout the territory of India, freedom to reside and settle in any part of the territory, freedom of profession. So, and grounds for reasonable restrictions are mentioned under Article 19 itself. So, Article 19 Clause 2 to Article 19 Clause 6, sovereignty, security, public order, decency, morality, contempt of court, defamation, incitement and foreign relations. So, these are the reasonable restrictions. That is, Article 19 is not absolute. It is qualified. Reasonable restrictions can be imposed by the state. So, reasonable restrictions are mentioned in the Article 19 itself. That is Article 19 Clause 2 to 19 Clause 2 to 19 Clause 6. That is sovereignty, security, public order, decency and morality, contempt of court, defamation, foreign relations, that is friendly relations with foreign countries, and incitement to an offense. So, what are the key takeaways? John Stuart Mill's core idea, that is, the state may restrict liberty only to prevent harm to others and not for the individual's own good. Article 19's balance, that is, it guarantees 6 fundamental rights while permitting reasonable restrictions only on specified grounds of harm. Philosophical alignment between John Stuart Mill and Article 19, that is, the Indian constitutional scheme of Article 19 is a constitutional embodiment of Mill's harms principle, and contemporary relevance, debate on hate speech, digital harm and moral policing continue to test the limits of harm principle in modern India, and freedom is not absolute, but its restrictions must always be reasonable, proportionate and directly linked to preventing tangible harm to others. So, there is a philosophical alignment between John Stuart Mill's harm principle and Article 19. Article 22, protection. Next topic, Article 22. Article 22, fundamental rights, deals with prevention against arrest and detention. So, Article 22 of the Indian Constitution provides protection against arbitrary arrest and detention. So, it is divided into 2 parts, that is, first part and second part, that is Clause 1 and Clause 2, Article 22, Clause 1 and Clause 2. It deals with punitive detention, that is, arrest and detention under ordinary criminal law, and Part 2, Clause 3 to Clause 7, that is, it deals with preventive detention, that is, detention without trial based on suspicion. So, the Article 22 of the Indian Constitution provides for protection against arrest and detention. So, it is divided into 2 parts, Part 1 and Part 2. Part 1, that is Clause 1 and Clause 2, deals with punitive detention, that is detention after trial under ordinary criminal law, and Clause 3 to 7 deals with preventive detention, that is detention without trial based on suspicion. So, rights under ordinary and punitive detention. So, this part, that is the first part, Article 22, Clause 1 and Clause 2, it deals with, or this part confers the following fundamental rights on any person arrested or detained under ordinary criminal law. So, what are the rights that are being conferred, fundamental safeguards that are being conferred on an individual when he is arrested and detained under ordinary criminal law? So, the detainee has the right to know the grounds, that is, right to be informed on the grounds of arrest as soon as possible, and right to legal counsel, that is right to consult and be represented or defended by a legal practitioner of his or her choice, and 24-hour judicial magistrate rule, that is right to be produced before a judicial magistrate, nearest magistrate, within 24 hours of arrest, excluding the journey time, and right to be released, that the detainee has the right to be released after 24 hours unless the judicial magistrate authorizes further detention. So these are the fundamental safeguards provided under Article 22, that is right under ordinary and punitive detention, that is right to know the grounds, right to a legal counsel, and 24-hour judicial magistrate rule, and right to be released. So, what are the exceptions and clarifications? So, who is not protected under Part 1? That is Article 22, Clause 1 and Clause 2. So, who are the persons who are not protected? That is, what are the exceptions or safeguard, or that is exceptions or safeguards that are not available to enemy aliens? That is, the subjects of any country which is at war with India, and persons arrested or detained under preventive detention law. So, the safeguards, fundamental safeguards available under Part 1, Article 22, Clause 1 and Clause 2 are not available under to these. So, these are the exceptions. These safeguards are not available to enemy aliens, that is subjects of those countries which are at war with India, and persons who are arrested or detained under preventive detention law. So, Supreme Court's clarification, that is, the protections apply only to arrests on criminal or quasi-criminal nature or activities prejudicial to public interest. They do not cover arrest under court orders. So, that is on the orders of the court if the arrest is carried out, and civil arrest, arrest for non-payment of taxes or dues, and deportation of foreigners. So, the Supreme Court has further clarified in what cases the protections do not apply under Article 22, Clause 1 and Clause 2. So, the protections apply only to arrests of a criminal and quasi-criminal nature or activities prejudicial to public interest. They do not cover arrests under court orders, civil arrest, and arrest for non-payment of taxes or dues, and deportation of foreigners. So, Article 22, Part 2. So, preventive detention. Concept and safeguard. Preventive detention, as we already understood, is detention without trial based on suspicion to prevent a person from committing an offense in future. So, it is precautionary and not punitive. So, 3-month limit. So, the detention under preventive detention cannot exceed 3 months unless an advisory board reports sufficient cause for extension, and this advisory board consists of persons qualified to be High Court judges, and grounds communicated. So, the grounds of detention must be communicated or to the detainee as soon as possible, and facts against public interest need not be disclosed. And right to representation, the detainee must be given an opportunity to make a representation against the detention order. So, the 44th Constitutional Amendment Act 1978, it sought to reduce the initial detention period from 3 months without advisory board from 3 months to 2 months. However, this provision has not been notified till date, so the original 3-month limit continues. So, the 44th Constitutional Amendment Act 1978, it has sought to reduce the initial detention period without the advisory board from 3 months to 2 months, but this provision has not been notified till date, and so the original 3-month limit continues. So the Parliament's power and legislative authority. So Article 22 Clause 7, it empowers Parliament to prescribe where detention can exceed 3 months without advisory board's opinion, fix maximum period of detention in different classes of cases, and lay down procedure for advisory board's inquiry. So the Article 22(7), it empowers the Parliament, not the state legislature, to prescribe where detention can exceed 3 months without advisory board opinion. Normally, the detention cannot exceed 3 months, and it can, unless the advisory board reports sufficient cause for extension. So under Article 22(7), the Parliament can prescribe the circumstances where the detention can exceed 3 months without advisory board opinion and fix maximum period of detention in different classes of cases and lay down the procedure for advisory board inquiry. So authority and what is the subject covered and examples. So only Parliament, subjects, defense, foreign affairs and security of India, and examples: National Security Act, Unlawful Activities Prevention Act. So the Parliament can enact laws on subjects, only Parliament, on defense, foreign affairs and security of India, example NSA, UAPA, both Parliament and state legislatures on subjects of security of states, public order, essential supplies and services, that is State Public Security Acts. So punitive detention, that is after trial and conviction, example Bharatiya Nyaya Sanhita. Preventive detention without trial to prevent future harm, that is on the basis of suspicion, that is National Security Act, Unlawful Activities Prevention Act, States Public Security Acts. So the current affairs, the Supreme Court in preventive detention. So Supreme Court has ruled that preventive detention is a draconian measure. Preventive detention continues to generate significant judicial and public debate in contemporary period. So due to alleged misuse of laws like National Security Act 1980, Unlawful Activities Prevention Act UAPA, in 2025, the Supreme Court repeatedly described preventive detention as a draconian measure that must be used sparingly and only as an exception, not as a substitute for ordinary criminal prosecution or to bypass bail orders. Example, Dhanya M versus State of Kerala in June 2025. So the Supreme Court has ruled that the preventive detention is a draconian measure. It should be used sparingly and as an exception, not as a substitute for ordinary criminal prosecution or to bypass bail orders. Example, Dhanya M versus State of Kerala, June 2025. So, key Supreme Court rulings 2025 and early 2026. So, the judicial activism, that is the proactive role of judiciary in checking the misuse of preventive detention, that is strict compliance with Article 22, Clause 5, that is grounds must be communicated properly and in a language understood by the detainee, and failure vitiates the order, violates the order. Orders quash. The several detention orders were squashed by the Supreme Court for lack of application of mind, failure to consider bail conditions, or when the case was merely an law and order issue rather than a threat to the public order. And right to effective representation in Jasila Saji versus Union of India 2024, reaffirmed by the Supreme Court in 2025, the court reiterated the right to effective representation. and the High Courts squashing National Security Act orders. High Courts example, Allahabad, Guwahati have quashed a large percentage of NSA orders, historically around 70 to 78% in some periods, citing procedural violations. So the judiciary has played a proactive role. The judiciary's proactive role in checking the misuse of preventive detention, that is strict compliance with Article 22(5), that is the grounds must be communicated promptly and in a clear language, in a language understood to the detainee. The failure vitiates the order and several detention orders were squashed by the Supreme Court because of lack of application of mind, failure to consider the bail conditions, and when the case was merely a law and order issue rather than a threat to the public order, and right to effective representation, that is in Jasila Saji versus Union of India 2024, reaffirmed by the Supreme Court in 2025, reiterated the right of the detainee to effective representation. And Supreme High Courts, not only the Supreme Court, High Courts have squashed NSA orders, that is the High Courts like Allahabad, Guwahati have squashed a large percentage of NSA, National Security Act orders, historically around 70 to 78 in some periods, citing procedural violations. So, notable incidents and debates. Preventive detention against dissenting voices. Notable incidents, that is detention of climate activist recently Sonam Wangchuk under the National Security Act in late 2025. Ladakh protests sparked debates on using preventive detention against political and dissenting voices. The order faced legal challenges on the grounds of Article 22 safeguards. On the 50th anniversary of the emergency, that is 2025, emergency period 75-77, several legal experts and articles called for reviewing or even deleting Article 22's preventive detention provisions, arguing it provides constitutional sanction for detention without proof of guilt. So, on the 50th anniversary of the emergency, that is 2025, several constitutional experts or legal experts and articles, they have called for reviewing of Article 22, that is preventive detention provisions, arguing that it provides constitutional sanctions for detention without the proof of guilt. These developments highlights the tensions between the state security needs and the individual liberty under Article 21, that is right to life and personal liberty. So, significance for UPSC prelims, that is distinction between part 1 and part 2 of Article 22, 24-hour rule, that is the safeguards, 24-hour rule, advisory board, 3 months limit, that is safeguards under part 1 and part 2, and exceptions and safeguards. So, Article 22 at a glance, quick revision, that is the part 1, Article 22, clause 1, clause 2, ordinary arrest, the grounds should be communicated, represented by a lawyer, magistrate, presented before a magistrate between 24 hours. These are the safeguards under part 1 and not available against enemy aliens and preventive detention cases. Whereas part 2, 22, clause 3 to clause 7, preventive detention, limited safeguards, 3 months period, and beyond 3 months, advisory board should report. And the current affairs 25-26, Supreme Court calls its draconian measure and stresses strict compliance, multiple orders quashed, and debates on misuse against activists. So, Article 22 remains a critical constitutional provision balancing the state's security imperatives with the fundamental rights of individuals. A tension that continues to be tested in India's courts and public discourse. Delimitation in India. Understanding the process of delimitation, that is, delimitation is the process of redrawing of political constituencies, that is, political boundaries, and why the southern states are raising concerns about population-based seat allocation in the Lok Sabha. So, the delimitation exercise after the 2026 census. So, that is understanding what is delimitation. Delimitation is allocation of seats in Lok Sabha and state legislative assemblies and redrawing of the political constituencies of Lok Sabha and state legislative assemblies, and also the reservation of seats for SCs and STs in Lok Sabha and state legislative assemblies. So, understanding the process of redrawing of constituency boundaries and why southern states are raising concerns about population based seat allocation in Lok Sabha. Right now the seat allocation in Lok Sabha is on the basis of population. So southern states, they have controlled population, so they fear that they may lose seats representation in Lok Sabha. So why is it in news? The core concern, southern states have expressed a strong concern that population based delimitation of Lok Sabha is fundamentally unfair to them. The argument states that southern states have successfully controlled the population growth largely in the south, fear they will be penalized by losing political representation relative to states with higher population growth. So, the southern state have controlled their population. Since the allocation of seats in Lok Sabha is on the basis of population, so the southern states, they fear that they may lose their political representation because of the reduced population, whereas the northern states have, because of the higher population growth, they will have more representation. So this creates disincentive for the states that performed well on population controlled policies, that is the southern states. So what is delimitation? Delimitation is the process of fixing the number of seats and boundaries, readjustment of territorial constituencies or boundaries of territorial constituencies in each state for both Lok Sabha and state legislative assemblies. Who does it? Carried out by a high-powered body known as Delimitation Commission, also called as the Boundary Commission. And what is the scope? It covers both parliamentary constituencies, that is Lok Sabha, and state assembly constituencies across all the states of India. So, history of delimitation in India. So, the delimitation has been carried out. How many times the delimitations have been carried out since independence? 4 times. That is 1952, 1963, 1973 and 2002 by the respective Delimitation Commission Acts. So 4 times delimitation has been carried out since independence, each reflecting the demographic, that is the population and political realities of its era. 1952, the first delimitation after independence, establishing the constitutional or foundational constituency map of the new republic. 1963, the second delimitation reflecting the post-independence population changes and states reorganization. And 1973, the third delimitation based on 1971 census. Here it is the 1971 census data reshaping constituencies across the country, and 2002 most recent delimitation based on 2001 census froze the seat counts until after 2026 census. So 4 times delimitation has been carried out: 1952, 1963, 73, 2002, the most recent based on 2001 census, and it froze the seat count, that is allocation of seats after the 2026 census. So constitutional provisions. Delimitation is firmly grounded in the Constitution of India through various provisions, through specific articles that govern both allocation of seats and reserved constituencies. So, Article 82, readjustment after each census. So, the Parliament by law, that is Delimitation Commission Act, provide for the readjustment of allocation of seats in the House of People, that is Lok Sabha, and division of each state into territorial constituencies after each census. Article 170, state legislative assemblies, that is provide for the division of each state into territorial constituencies for the purpose of elections to the state legislative assemblies, readjusted after each census. And Article 330 and Article 332, that is reservation of seats in Lok Sabha, that is it mandates refixing the number of seats reserved for scheduled caste and scheduled tribes in the House of the People. And Article 332, reserved seats in the state assemblies, that is provides for refixing the number of seats reserved for scheduled caste and scheduled tribes in the state legislative assemblies or legislative assemblies of the states. So, Article 82, Article 170, Article 330 and Article 332. Article 82, readjustment after each census, that is the Parliament by law provide for the readjustment of allocation of seats in the House of the People, that is Lok Sabha, and division of each state into parliamentary constituencies after each census. Article 170, state legislative assemblies, that is provides for the division of each state into territorial constituencies for the purpose of elections to the state legislative assembly, readjusted after each census. And Article 330 and 332, reservation of seats for SCs and STs in Lok Sabha and reservation of the seats for SCs and STs in state legislative assemblies. So, Article 82 and Article 170 at a glance. So, the parliamentary constituencies, Article 82 ensures that after each census, that is after every 10 years, Parliament enacts a law to readjust the allocation of seats in Lok Sabha among the states and divide each state into parliamentary constituencies, ensure equitable representation based on population. So, assembly constituencies, likewise, Article 170 mirrors this same for state assemblies, that is, each state is divided into single member territorial constituencies and total seats in the assembly are fixed by law and readjustment follows every census exercise. So, key rules governing delimitations orders. So, cannot be changed, that is the delimitation order passed by the Delimitation Commission cannot be challenged in the court. That is, the orders of the Delimitation Commission are final and binding. They cannot be questioned or challenged in any court of law under ordinary circumstances. No legislative modifications, that is neither the House of the People, that is the Lok Sabha, nor the state legislative assemblies is permitted to make modifications to the Delimitation Commission orders, that is delimitation orders, and presidential notification. The orders come into effect on date specified by the President of India, giving the executive the authority to determine the timing of the implementation. So, these are the key rules governing the delimitation orders. Landmark Judgment 2024. That is, what are the key rules? That is, the orders passed by the Delimitation Commission, that is, delimitation orders cannot be challenged in the court of law under ordinary circumstances, and no legislative modifications, that is, neither the Lok Sabha nor the state legislative assemblies can make any modifications, and the presidential notification. The orders come into force on the date specified by the president through a notification. So there was a Supreme Court's recent landmark judgment in 2024, that is, the constitutional courts have the power to review orders of the Delimitation Commission if an order is manifestly arbitrary, unreasonable and irreconcilable to the constitutional values. So, the Supreme Court in Kishori Chandra Chagganlal Rathod versus Union of India case 2024, it stated or it ruled that the constitutional courts have the power to review orders of the Delimitation Commission if an order is manifestly arbitrary, that is unreasonable and irreconcilable to the constitutional values. In the Kishori Chandra Chagganlal Rathod versus Union of India case. So what has changed? This ruling, it introduced a limited judicial review, that is the judicial scrutiny mechanism for Delimitation Commission's order. Previously, there was no Delimitation Commission orders could not be challenged in court of law under ordinary circumstances, but the Supreme Court in Kishore Chandra Chagganlal Rathod versus Union of India case 2024, it introduced a limited judicial review mechanism for Delimitation Commission orders, a significant departure from the previously absolute bar on court challenges. And the standard has been set, that is, the courts can intervene only when the Delimitation Commission order is manifestly arbitrary, that is clearly unreasonable or capricious, and irreconcilable with the constitutional values, that is fundamentally at odds with the spirit of the Constitution. Then only the court can intervene, that is the court has limited judicial review. So this is a high threshold, that is routine disagreements with the Delimitation Commission decisions will not qualify for judicial review. So previously the Delimitation Commission orders could not be challenged in the court of law under ordinary circumstances, but the Supreme Court in Kishori Chandra Chagganlal Rathod versus Union of India case 2024, the ruling has introduced a limited judicial review mechanism for the Delimitation Commission orders, a significant departure from the previously absolute bar on court challenges. So a standard has been set. What is the standard? The courts can interfere only when the order is manifestly arbitrary, that is clearly unreasonable and capricious and irreconcilable with the constitutional values, that is fundamentally or at odds with the spirits of the Constitution. This is a very high threshold, and routine disagreements with the Delimitation Commission orders will not qualify for the judicial review. So the North-South divide, the upcoming delimitation exercise has reignited a political debate about the fairness and representation in the Indian democracy, and the southern states and the northern states, the southern states of Telangana, Andhra Pradesh, Karnataka, Tamil Nadu and Kerala, northern state Rajasthan, Uttar Pradesh, Bihar, Madhya Pradesh. So the lower population growth rate and better development, successful planning of the southern states, and higher population growth rates based delimitation, fear of the southern state fear losing states, whereas the northern states, the number of seats may increase for the northern states because of the higher population growth, though the southern states were successful in carrying out family planning. So the core tension, should political representation reward population size or should it account for development performance and the governance outcome? So this is the core tension. So what are the key takeaways? Delimitation, redrawing boundaries, that is it fixes the number of seats, and allocation of boundaries, that is readjustment of territorial constituencies for both Lok Sabha and state legislative assemblies done by an independent Delimitation Commission, Article 82, Article 110. So 4 times in history delimitation exercise has been conducted in 1952, 63, 73 and 2002, with the next exercise expected after 2026 census, And constitutional backbone, Article 82, Article 170, Article 82 with relating to the Parliament, Article 170 State Legislative Assemblies and reservation of seats in Lok Sabha, and State Legislative Assemblies, Article 330 and 332 respectively for SCs and STs, provide the legal framework for delimitation and reservation of seats for SCs and STs, and orders of the Delimitation Commission are near final, that is, cannot be challenged in the courts or modified by the legislatures, though a 2024 Supreme Court ruling allows limited judicial review for manifestly arbitrary orders, that is unreasonable, clearly unreasonable and capricious orders. So the political controversy, that is southern states, they fear losing representation due to their success in controlling population growth, a key issue in upcoming delimitation update. The next topic, the Constituent Assembly of India. So, the story of how India wrote its own destiny from November 1946, the Constituent Assembly was established, to January 1950. So, the Constituent Assembly is a body that was established for drafting the Constitution of India. So, the story of how India wrote its own destiny from November 1946, that is the Constituent Assembly was established, and January 1950 when the Constitution came into being. So, how it all began? It began in November 1946, that is the Constituent Assembly was constituted in November 46 under the scheme of the Cabinet Mission Plan 1942, and the first meeting was held, that is the elections were held, and the first meeting was held in 9th December 1946. So, the first meeting 9 December 1946, the Muslim League boycotted the session and demanded the separate state of Pakistan, and the members present, there were only 211 members present. That is, the members attending the first meeting, that is, the members who attended the first meeting are far less, and the temporary president, Dr. Sachidananda Sinha, the oldest member, was elected as a temporary president of the Constituent Assembly. So, leadership of the Assembly, the permanent president was Dr. Rajendra Prasad, and it had two vice presidents, the Constituent Assembly, that is Harendra Kumar Mukherjee and B.T. Krishnamar Shari. So, the objectives resolution, 13th December, the objective resolution was passed by Jawaharlal Nehru. That is, he drafted and moved objectives resolution on 13th December 1946, which laid down the fundamentals and philosophies of the Indian Constitution. Major outcome, the Assembly appointed 8 major committees to handle the different tasks of the Constitution making. So, the first committee is Union Powers Committee, Jawaharlal Nehru. The Union Constitutional Committee, Jawaharlal Nehru. The Provincial Constitutional Committee headed by Sardar Vallabhbhai Patel. Drafting Committee, Dr. B.R. Ambedkar. The fifth committee, that is Advisory Committee, that is the Fundamental Rights, Minorities and Tribal Areas. The Advisory Committee on Fundamental Rights, Minorities and Tribal Areas, Sardar Patel. And the Rules of Procedure Committee, Dr. Rajendra Prasad. The States Committee, Committee for Negotiating with the States, Jawaharlal Nehru. And the Steering Committee, Dr. Rajendra Prasad. So, there were 8 major committees and advisory committees or subcommittees. The advisory committee had 5 subcommittees. So, the advisory committee had 5 subcommittees, that is Fundamental Rights Subcommittee chaired by J.B. Kripalani, and Minorities Subcommittee, that is chaired by H.C. Harendra Kumar Mukherjee, and Northeast Frontier Tribal Areas Subcommittee chaired by Gopinath Bardolai, and Excluded Areas Other than Assam Subcommittee chaired by A.V. Thakkar, and Northwest Frontier Tribal Areas Subcommittee, that is Special Committee for Frontier Tribal Regions. So, So the historical milestones. So the national flag was adopted on 22nd July 1947 and the India's membership of the Commonwealth was ratified on May 1949 and national anthem, national flag were adopted on 24th January 1950 and Dr. Rajendra Prasad was elected as the first president of India on 24th January 1950. So these are the historical milestones. So by the numbers, how many sessions were held? The Constituent Assembly, it held 11 sessions over 2 years, 11 months and 18 days, and 60 constitutions have been studied from around the world. Ours is the borrowed constitution, so we studied 60 constitutions around the world and 114 days of discussion. The draft constitution was debated for 114 days and 64 lakh total expenditure, that is cost of making the constitution. So after the constitution on 24th January 1950, the Constituent Assembly held its final session. 26th January 1950, the Constituent Assembly continued as the Provincial Parliament of India, that is Free Parliament of India, so the first Parliament of India, and 1951-1952, it served until the formation of the new Parliament after the first general elections 1952. So a legacy written in 2 years, 11 months and 18 days. The Constituent Assembly of India stands as a remarkable achievement, a diverse group of leaders who came together to craft one of the world's most comprehensive constitutions, studying 60 nations, debated for 114 days and gave India its democratic foundation. So it was constituted, Constituent Assembly was constituted in November 1946 and the constitution was adopted on 26 November 1949. It came into force on 26 January 1950, that is India became a republic on 26 January 1950. The next topic is Prevention of Corruption Act 1998. This is a landmark legislation governing the anti-corruption measures for public servants in India, now at the center of a landmark Supreme Court verdict. So, the Prevention of Corruption Act 1988, it is a landmark judgment, or landmark legislation governing the prevention anti-corruption measures for civil servants, and now at the center, this act is at the center of a landmark Supreme Court verdict. So why is it in the news? The Center for Public Interest Litigation versus Union of India 2026 case, the Supreme Court delivered a split verdict on the constitutionality of Section 17A of the Prevention of Corruption Act 1988. So, Section 17A, the controversy. What is the controversy? What is Section 17A? Section 17A was inserted by the Prevention of Corruption Act, Prevention of Corruption Amendment Act 2018. So, Section 17A mandates prior sanction from the government before launching any investigation against a public servant under the Act. So, before launching any investigation against a public servant under the Act, prior sanction of the government is required. That is mandated by Section 17A. Section 17A was inserted by the Prevention of Corruption Amendment Act 2018. Why it is controversial? The Supreme Court has previously invalidated provisions requiring prior sanction before investigation against the senior public servants, creating a direct legal tension between Section 78. So, the Supreme Court, it has previously invalidated the requirement of prior sanction for investigating any senior civil servant. So it created a direct legal tension with section 17A of the Prevention of Corruption Act. So landmark precedents on prior sanction, two pivotal Supreme Court verdicts or judgments shaped the legal landscape before the 2026 split verdict. So in 2026 also there is a split verdict. So before this 2026 split verdict by the Supreme Court in the Center for Public Interest Litigation versus Union of India, there were two landmark judgments which shaped the legal landscape. So what are they? Vineet Narayan versus Union of India case 1997. The Supreme Court invalidated the provisions requiring prior sanction before investigating against senior civil servants, reinforcing the independence of investigative agencies. And the another case, Dr. Subramanian Swamy versus Director CBI, year 2014, the court again struck down requirements of prior sanction before investigating, emphasizing that such conditions impede the fight against corruption at the highest levels. So in both the cases, Vineet Narayan versus Union of India case 1997 and Dr. Subramanian Swamy versus Director CBI 2014, the court has, in the Vineet Narayan case, the court invalidated the provisions requiring prior sanction before investigation against senior civil servants or public servants, reinforcing the independence of the investigating agencies. And in Dr. Subramanian Swamy versus Director CBI, year 2014, the court again struck down requirements for prior sanction before investigation, that is emphasizing that such conditions impede the fight against corruption at the higher levels. So, key provisions of the Prevention of Corruption Act 1988. The Act lays down clear punishment and procedural safeguards for corruption-related offence involving public servants. So, aspect and the detail. The punishment for bribery of a public servant. So, what is the punishment under Prevention of Corruption Act 1988? So, Prevention of Corruption Act 1988, it lays down clear punishment and procedural safeguards for corruption-related offences involved by public servants. So, what is the aspect? So, punishment for bribery of a public servant. So, what is the punishment? So, imprisonment not less than 3 years, extendable for 7 years, and fine. Habitual offender, the imprisonment not less than 5 years, extendable to 10 years plus fine. Persons authorized to investigate, that is Delhi Special Police Establishment, no police officer below the Inspector of Police without the magistrate orders, and the persons authorized to investigate in metro areas. Who are the authorized persons to investigate cases on the Prevention of Corruption Act 1988 in metro areas? That is, no police officer below Assistant Commissioner of Police without magistrate orders, and persons authorized to investigate elsewhere, that is, no police officer below Deputy Superintendent of Police without magistrate orders. So, punishment at a glance, Prevention of Corruption Act 1988, it prescribes escalating penalties to deter corruption at every level, that is 3 years minimum sentence for a public servant convicted of bribery related offences under the Act, extendable imprisonment for standard bribery offences plus fine, that is a maximum of 7 years, and 5 years for minimum for habitual offenders, that is minimum imprisonment for those convicted as habitual offenders, and 10 years maximum for habitual offenders, that is maximum imprisonment for habitual offenders plus fine. So, it prescribes escalating penalties to deter at every level, that is for public servants convicted of bribery, minimum 3 and maximum 7 years plus fine. For habitual offenders, minimum 5, maximum 7 plus fine. So, who can investigate the Prevention of Corruption Act under Prevention of Corruption Act? So, Prevention of Corruption Act 1988 strictly regulates which police officers are authorized to investigate corruption cases, ensuring accountability and preventing misuse of investigative powers. So, Delhi Special Police Establishment, so no police officer below the rank of the Inspector of the Police can investigate without a magistrate's order. In metropolitan areas, no police officer below the rank of Assistant Commissioner of Police can investigate without magistrate's order, and other areas, no police officer below the rank of Deputy Superintendent of Police can investigate without magistrate's order. So, UN Convention Against Corruption. Only legally binding instrument, that is UN Convention Against Corruption, is the only legally binding universal anti-corruption instrument in the world, adopted and enforced, adopted in 2003 by United Nations General Assembly, New York, and entered into force in 2005. India's status, that is India is party to the convention. As of September 2025, 140 signatories and 192 parties. So, United Nations Convention on Corruption is the only legally binding instrument, that is only legally universal anti-corruption instrument in the world. It was adopted in 2003 by the United Nations General Assembly in New York and entered into force in 2005. Is India a signatory? Yes, India is a party to the convention. As of September 2025, there are 140 signatories to the convention and 192 parties. So, objectives of United Nations Convention Against Corruption. So, United Nations Convention Against Corruption was designed with 4 core objectives to build a global framework for integrity and accountability. First pillar or core objective, that is prevent and combat corruptions, that is to establish measures to prevent corruption in both public and private sectors across all member states. Second core objective is to promote integrity and accountability, to foster a culture of transparency, ethical governance and accountability in public institutions, and facilitate international cooperation to enable cross-border collaboration between law enforcement and judicial authorities to tackle corruption globally, recover corruption assets, that is, provide mechanism to trace, freeze, seize and return assets obtained through corrupt practices. So, these are the 4 core objectives of the United Nations Convention Against Corruption to build a global framework for integrity and accountability, that is prevent and combat corruption, promote integrity and accountability, and facilitate international cooperation and recover corrupt assets. So, COS, Conference of State Parties 11 and the Doha Declaration 2025. So, the 11th Conference of State Parties COSP 11 concluded with the adoption of the landmark Doha Declaration 2025, that is digital technologies and AI. The declaration calls on states to leverage digital technologies including artificial intelligence to strengthen the international law enforcement cooperation in cross-border corruption cases, and United Nations Office on Drugs and Crime UNODC acts UNODC as Secretariat, that is United Nations Office on Drugs and Crime, acts as a secretariat of the Conference of the State Parties, coordinating the global anti-corruption efforts and global commitment with 192 parties to United Nations Convention Against Corruption. The Doha Declaration reinforces the international community's unified commitment to fighting corruption through modern tools and cooperation frameworks. Key takeaway. So, a quick summary of the most important points from the Prevention of Corruption Act 1988 and its global context. Section 17A the prior governmental sanction required before investigating the public servant, now under constitutional scrutiny via the Supreme Court split verdict in 2026, that is Center for Public Interest Litigation versus Union of India case 2026, and strict penalties, that is for bribery, minimum of 3 years, maximum of 7 years imprisonment plus fine, and for habitual offenders, minimum 5, maximum 10 with fine. Investigations restrictions restricted to senior ranked officers only, that is only senior ranked officers can investigate the crimes under Prevention of Corruption Act. And United Nations Convention Against Corruption, that is the only legally binding global anti-corruption treaty. India is a party signatory, and 192 parties as of 2025, and Doha Declaration 2025 adds AI-driven enforcement tools. So the interplay between investigative independence and the procedural safeguards for public servants remains a defining tension in India's anti-corruption legal framework. So the investigative independence and the procedural safeguards for public servants remains a defining tension in India's anti-corruption legal framework. So another topic, that is second schedule of the Indian Constitution. So the Constitution contains of articles divided into parts plus schedules. So the second schedule of the Indian Constitution, that is, it consists of the salaries, allowances, emoluments, privileges and pensions of India's highest constitutional authorities, ensuring financial independence and dignity of the office. So these the Constitution, which consists of the preamble is a part of the Constitution, preamble plus articles divided into parts plus schedules. So the second schedule of the Indian Constitution deals with the emoluments, allowances, privileges, pensions of the India's highest constitutional authorities, and this ensures financial independence and dignity of the office. So what is the second schedule? The core purpose. The second schedule lays down detailed provisions of the salaries, allowances, emoluments, privileges and the pensions of the highest constitutional authorities in India. The second schedule guarantees financial independence to these offices and can function without undue influence or pleasure. So, say the second schedule, it provides financial independence, and because of this financial independence, the constitutional authorities, they can function without pressure, that is without undue influence or pressure, though it facilitates independent function. So what are the linked articles? Article 59(3) related to the President, Article 65(3) related to the Vice President of India, 75(6) related to the Ministers, Article 97 presiding officers of the legislative bodies, that is the Speaker and Deputy Speaker in case of Lok Sabha, and Chairman and Deputy Chairman in case of Rajya Sabha, likewise the State Legislative Assemblies, and Article 25 the Supreme Court judges, and Article 148 Clause 3 Controller and Auditor General of India. So what are the officers that are covered under the second schedule? That is, what are the constitutional authorities? So 9 categories of the highest constitutional authorities or posts are covered, from the President to the Controller General of India. So the President of India, the highest constitutional authority of the nation, the governors of the state, the constitutional heads of each state in India, the Speaker and Deputy Speaker of the Lok Sabha, that is the House of the People, the Chairman and Deputy Chairman of the Rajya Sabha, that is the Council of States, the State Legislative Assembly, the Speaker and Deputy Speaker of the State Legislative Assemblies across India, and State Legislative Council, the Chairman and Deputy Chairman of the State Legislative Councils, the presiding officers, and judges of the Supreme Court, including the Chief Justice of India, the apex judicial authority, and judges of the High Court, the judges serving in the High Courts across all states and union territories. So it also covers the Controller and Auditor General of India, CAG, linked to Article 148, Clause 3. So these are the highest constitutional authorities whose allowances, emoluments, salaries, privileges and pensions are mentioned in the second schedule. So the structure of the second schedule is divided into distinct parts, each covering a special category of constitutional authority. So part A deals with the presidents and the governors, covers emoluments, allowances and privileges of the presidents and governors. Part C, presiding officers, covers the salaries and allowances of the speaker, deputy speaker, chairman and deputy chairman of the parliament and state legislatures. That is the presiding officers of the legislative bodies at both center and states. And part D deals with the judges. It covers the salaries, pensions, allowances, leaves of the judges of the Supreme Court and High Court. And CAG, the Controller and Auditor General provisions for the Controller and Auditor also included linked to Article 148. So the part B, as you can see, the part B is omitted. So the part B, the omitted part. So the original constitution, so what was the part B? The part B of the second schedule originally contained the provisions related to the ministers' salary and allowances. It was a part of the original constitution which came into force in 1950, 26 January 1950. So this part, which part B relating to the salary and allowances of the ministers contained in the original constitution was omitted. So why was it omitted? The part B was omitted by the 7th Constitutional Amendment Act 1956. After this amendment, the ministers' salaries are determined separately by the parliament and state legislatures through independent legislation, not through the second schedule. So the part B of the second schedule, consisting of the salaries and allowances of the ministers, was omitted by the 7th Constitutional Amendment Act 1956. After this amendment, the ministers' salaries and allowances are determined separately by the parliament and state legislatures through independent legislation, not through the second schedule. So this is why the second schedule jumps from part C to part A to part C, and part B no longer exists. So salary revisions over time. So there is provision of salary revisions also over time. So salary and allowances mentioned in the original second schedule have been revised upwards from time to time through separate acts of the parliament. So the president's salary is revised multiple times through dedicated parliamentary acts to reflect the changing economic conditions. Governors' emoluments periodically enhanced to maintain dignity and prestige of the governor's office or gubernatorial office, and judges' salaries upward to support, revised upward to attract and retain the best legal minds in the judiciary, and CAG, Controller and Auditor General's remuneration, upgrade or updated to ensure CAG's financial independence and operational effectiveness. So these revisions are always upwards. Salaries of the judges and Controller and Auditor General cannot be varied to their disadvantage after their appointment. So significance of the second schedule of the Constitution, that is the second schedule, plays a pivotal role in upholding the constitutional framework of India. So financial independence, it ensures constitutional functionaries are financially secure and free from executive pressure and interference, and judicial impartiality. It protects the dignity and impartiality of the offices like judges of the Supreme Court, High Courts and CAG. Protection against reduction. The salaries of the judges of the High Court and Supreme Court and the Controller and Auditor General cannot be varied to the disadvantage after their appointment except during financial emergency under Article 360. And legislative framework, the parliament and the state legislatures can determine the salaries of the presiding officers, but the framework is provided by the second schedule. So the legislative framework, that is the parliament and state legislatures, can determine the salaries of the presiding officers of the Lok Sabha, Rajya Sabha, State Legislative Assembly and State Legislative Council, but the framework is provided by the second schedule. So, what the second schedule does not cover? A common misconception to avoid in UPSC, the second schedule does not deal with the salaries of ordinary MPs and MLAs, that is the salaries of the members of the parliament and state legislatures are determined separately by the parliament and state legislature, and the ministers, the salaries of the ministers are determined by the parliament or the state legislature through independent legislation, not the second schedule. So remember, the second schedule focuses exclusively on the highest constitutional posts, not ordinary elected representatives. So it does not cover the ordinary MPs and MLAs, that is salaries of the members of the parliament and state legislatures. It is not covered. It is determined by separately by the parliament and state legislature, and ministers' salaries are determined by the parliament and state legislature through independent legislation, not the second legislature. So what are the key points for UPSC 2026? So to master these critical facts about the second schedule to score in prelims, so 9 categories of the constitutional authorities are covered from President to C&AG. 3 active parts, A, C and D. B has been omitted, are active, and B was omitted by the 7th Constitutional Amendment Act 1956, and 10 articles, that is linked to articles 59 clause 3, 65 clause 3, 75 clause 6, 97, 125, 148 clause C, 158 clause C, 164 clause 5, 186 and 221. The golden rule, the salary of the judges, including the salary of the judges and the judges of the Supreme Court, High Court, including the Chief Justice and the Comptroller and Auditor General, cannot be reduced after the appointment except during financial emergency under Article 360. And the exclusion, the second schedule does not cover ordinary MPs, MLAs or ministers. Only the highest constitutional posts are included. And revision rule, the salaries in the second schedule are revised upwards only through separate acts of the parliament, never through a constitutional amendment. These are the critical facts regarding second schedule that you have to remember. Fundamental duties. A citizen's fundamental duties enshrined in the Constitution, Part 4A, Article 51A. So, fundamental duties, a citizen's commitment to the nation. Understanding Article 51A, fundamental duties enshrined in the Constitution, Part 4A, consists of single article, Article 51A, and its significance for India and UPSC. So, where are fundamental duties? Fundamental duties are enshrined in the Part 4A. Fundamental duties are enshrined in Part 4A of the Constitution of India. A single article, Article 51A. All fundamental duties are listed under Article 51A of the Constitution. Fundamental duties were not part of the original Constitution. They were added by the Swaran Singh Committee. And rights and duties. The fundamental duties, they remember citizens that fundamental rights come with the corresponding duties to the nation and society. So, these fundamental duties, they remind to the citizens that the fundamental rights that the citizen enjoy, they comes with the corresponding duties to the nation and society. So, key features at a glance. So, fundamental duties are not justiciable, that is like directive principles of the state policy. Fundamental duties are not justiciable. They cannot be directly enforced by the courts. no built-in sanction, that is the constitution itself does not prescribe penalties for their violation. They are not justiciable, cannot be enforced by the court of law for the implementation, and the constitution does not prescribe penalties for the violation. Parliamentary power. So now the constitution does not prescribe penalties for their violation. So the parliament is empowered to enforce any fundamental right through a suitable legislation, and penalties possible. The parliament can prescribe appropriate penalties and punishments for non-compliance. So Article 51A, the first duty, that is, every citizen must abide by the constitution and respect its ideals and institutions, the national flag and national anthem. So the duty, respect the constitution, abide by the constitution, respect the constitution, national flag, national anthem at all times. The law, the parliament enacted the Prevention of Insults to National Honours Act 1975 to give effect to this duty, and the penalty, the act provides for penalties for disrespect to the constitution, national flag and national anthem. So Prevention of Insults to National Honours Act 1971, enacted by the Parliament of India in the year 1971, purpose to enforce Article 51A, Clause A through legal sanction. So what it covers? Disrespect to the Constitution of India, insult to the national flag, disrespect to the national anthem. So this is a prime example of the parliament converting a non-justiciable duty, that is fundamental duties are non-justiciable, that is they cannot be enforced in the court of law. So the parliament, through this act, it has converted this duty into a enforceable legal obligation. So if it is not implemented, then there will be penalties. So why do fundamental duties matter? So they are warning against anti-national acts, that is, acts like burning the national flag, destroying the public property are discouraged. Discipline and commitment, they promote active participation of the citizens and a sense of responsibility among citizens. Source of inspirations, citizens are not mere spectators, they are active contributors to the national goals. So fundamental rights do matter because they act as warning against anti-national acts. They provide discipline and commitment to the citizens, and they are source of inspiration to the citizens, that is active contribution to the national goals. So the Supreme Court ruling in 1992, the Supreme Court ruled in 1992 that if a law gives effect to any fundamental duty, the court may consider such law as reasonable and save it from being declared as unconstitutional. So the Supreme Court has ruled in 1992 that any law which gives effect to any fundamental rights, the court may consider such law as reasonable and it saved it from being declared as unconstitutional. So Article 14 link, that is right to equality and equality before law. Any law reinforcing a fundamental duty may be upheld as reasonable under right to equality. And Article 19 link, such a law may also be saved from challenging under right to freedom provisions. So the fundamental duty, according to the Supreme Court ruling in 1992, any law that gives effect to any fundamental rights, the court may consider that law to be reasonable and it may not declare it as unconstitutional, save it from being declared as unconstitutional. And even if that law which enforces fundamental duty, even if it that is, it may be held as reasonable under right to equality also, and also Article 19, that is, it saves, such a law also be saved from challenge under right to freedom provisions. So this 1992 ruling is a landmark observation connecting fundamental duties to the constitutional validity of legislation. So it connects both fundamental duties and constitutional validity of any legislation. So non-justiciable versus non-enforceable. Fundamental duties are non-justiciable, that is non-enforceable, no direct court enforcement, and they are enforceable by law, that is the parliament can legislate penalties, and both values guide legislation and conduct. So the fundamental duties, they are non-justiciable, no direct court enforcement, and the parliament by law can make them enforceable, that is the parliament can legislate penalties, and both values guide legislation and conduct. This distinction is most important concept to understand both the fundamental duties, they are non-justiciable in the constitution but fully enforceable through the parliamentary legislation. So the key linkages for UPSC exam, that is fundamental rights, fundamental duties complement rights. Both exist together in the constitutional framework. Directive principle of the state policy connection with fundamental duties, like directive principles of the state policy, fundamental duties are non-justiciable, not enforceable in a court of law, a frequent tested parallel, and national symbols, that is Article 51A, Clause A, the prevention of insults to National Honours Act 1971, and the Supreme Court case 1992 ruling on using fundamental duties to test reasonability under Article 19. So, quick revision, must know facts, fundamental duties, part 4A of the Constitution, single article, Article 51A, the governing article, non-justiciable, not directly enforceable by the courts, and Act of 1971, the Prevention of Insults to National Honour Act 1971, and 1992 ruling. The Supreme Court links duties to reasonableness under Article 14 and 19, and UPSC prelims. So statement based and assertion reason questions on enforceability and non-justiciable nature of the fundamental rights should be watched for. Poxo Act 2012, Protecting Children from Sexual Offences Act, a landmark law amended in 2019. So, the Poxo Act 2012, Protection of Children from Sexual Offences Act, was amended in 2019. So, why the Poxo Act is in news? So, the Supreme Court recently highlighted the misuse of the Poxo Act in consensual adolescent relationships, that is consensual adolescent romantic relationships, and urged the center to consider a Romeo-Juliet clause to balance child protection with personal liberty. So, the problem, the POSCO being applied to consensual sexual or consensual teen relationships, criminalizing the adolescents, and the proposal, a Romeo-Juliet clause to distinguish between consensual, that is exploitation, and consensual adolescent relationships. The goal to balance the robust child protection with respect for professional liberty. So, under the POSCO Act, the consensual relationship, adolescent relationships are being criminalized. So, to protect the to have a balance between the robust child protection and respect for personal liberty, that is in terms of consensual adolescent relationships, the court has urged the center to introduce a Romeo-Juliet clause to balance child protection with personal liberty. So, the POSCO being applied to consensual teen relationships, criminalizing adolescents, and the proposal a Romeo-Juliet clause to distinguish between exploitation and consensual adolescent relationships. So what is the Poxo Act? The core purpose, it is enacted to protect the children below 18 years from sexual assault, sexual harassment and pornography across India, and the act has been amended in 2019. The Poxo Act 2012 has been amended in 2019 to strengthen the provisions and increase penalties. So the key features of the at a glance, that is the 2019 amendment. So the key features at a glance, it applies to all children under 18 years of age. It is completely gender neutral in scope, covers both child victims and offenders of any gender, and mandates special courts for speedy trial and ensures child-friendly investigating procedures. So these are some of the key features. So it applies to all children under 18 years of age, completely gender neutral in scope, covers both child victims and offenders of any gender, and mandates special courts for speedy trials and ensures child-friendly investigation procedures. So the categories of offences under the Poxo Act. So penetrative sexual act, severe offences with stringent punishment including long-term imprisonment. Non-penetrative sexual assault covers a wide range of physical sexual offense against children, and aggravated forms, that is enhanced penalties when offense is committed by a person who is in a position of trust or authority, and sexual offense or harassment and pornography includes storage of child pornographic materials, fines up to starting at 5,000 and repeat offences 10,000. So punishment under Poxo, that is 18-year threshold, that is below anyone, children below 18 years is that is anyone below 18 years is a child under this act. And what is the fine for storage of child pornographic material? It is 5,000 in the first instance, minimum fine, and 10,000 for repeat offences, that is minimum fine for repeat storage of pornographic material involving a child, and the life imprisonment for most aggravated forms of sexual assault. So reporting of offences. So the offences under Poxo, so there is a mandatory reporting, that is any person including the child who has the knowledge of any offence must report it to the special juvenile police unit or the local police. 24-hour escalation, that is special juvenile police unit or the local police must report the case to the child welfare committee and the special court within 24 hours of receiving the complaint, and penalty for non-reporting, that is failure to report the offence, is punishable with imprisonment up to 6 months or fine or both. So there is a provision for mandatory reporting, 24-hour escalation and penalty for non-reporting. So the statement recording, child-friendly statement recording, that is at a comfortable location. Statement is recorded, or the statement recorded at the child's residence or at a place of their choice, never at a police station at night. So child-friendly statement recording at a comfortable location, statement recorded at child's residence or place of their choice, never at the police station at night, and woman officer, preferably recorded by a woman police officer of at least the sub-inspector rank, not in uniform, and no contact with the accused. That is, the police must ensure that the child does not come in contact with the accused during the examination, and no night detention. That is, no child shall be detained in the police station during the night for any reason whatsoever. Special courts under Poxo. So, the speedy trials, in-camera trials to be completed within 1 year of cognizance of the offence, and child safeguards, children protected from exposure to the accused and hostile or aggressive questioning. Compensation, courts mandated to award compensation and rehabilitation support to the child victims. So there is a provision of special courts under POSCO to facilitate speedy trials, in-camera trials completed within 1 year of cognizance, and there are child safeguards. That is, children are protected from exposure to accused and hostile or aggressive questioning. And compensation, courts mandated to award compensation and rehabilitation to support the child victims. So, monitoring and implementation at the national level, National Commission for Protection of Child Rights, NCPCR, oversees the implementation of the Poxo across India at the national level, and state level, National Commission for Protection of Child Rights monitors implementation within their respective states and union territories. So, offence reported, speedy court trials, and National Commission for Protection of Child Rights and State Commission of Protection of Child Rights review. And this layered oversight ensures accountability at every stage of the children protection process. So, related social media ban for children. Australia became the first country in the world to enforce a nationwide social media ban for children under 16 years. So, children under 16 years in Australia are, a ban has been imposed for the social media, for the usage of social media. So, the law, the Australian law, Online Safety Amendment, Social Media Minimum Age Act 2024, enacted to protect minors from online harms, and age limit below under 16 years, that is, children under 16 years are prohibited from accessing social media platforms nationwide. Global significance, set as a landmark or precedent for other nations considering similar legislation to protect children in the digital age. So, Australia became the first country in the world to ensure a nationwide social media ban for children under 16 years. So, it set a precedent for all those countries who want a similar legislation to protect children in the digital age. The next topic, Panchayat, extension to the Scheduled Areas Act, that is Pisa Act 1996. So, Pisa Act empowering the tribal communities to self-governance. So, why Pisa matters? Recently in reviews, the Ministry of Panchayat Raj has celebrated 30 years of the Pisa Act 1996, a landmark milestone in India's journey towards tribal self-governance. So, recently the Ministry of Panchayat Raj has celebrated 30 years of Pisa Act 1996, a landmark milestone in India's journey towards tribal self-government. Constitutional foundation, that is, the Pisa operationalizes Article 243M, Clause 4, Subclause B, extending the provisions of Part 9 Panchayat Raj to the scheduled areas, that is 5th scheduled areas, giving constitutional teeth to the tribal autonomy. So, the Pisa operationalizes Article 243M, Clause 4, Clause B, extending the provisions of Part 9, that is Panchayat Raj, to the 5th scheduled areas, giving constitutional status to tribal autonomy. So, the Pisa legally recognizes the right of the tribal communities to govern themselves through their own customary laws and traditions. So, scheduled areas. Geographical scope, that is Pisa applies to 10 states that contain scheduled or tribal areas across India. So, the states Andhra Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, Rajasthan and Telangana. So, these 10 states have scheduled areas. So, current implementation status, 10 states, total 10 states with scheduled tribal areas covered under Pisa, and 9 states they have framed rules, that is states have officially framed rules through Pisa rules, and 1 state, Odisha, has created draft rules yet to be finalized. And recently, the Ministry of Panchayat Raj has celebrated 30 years of Panchayat extension to the Scheduled Areas Act. That is a landmark anniversary, 30th anniversary celebration in 2026. So, 9 out of 10 states have framed Pisa rules. Odisha remains at the draft stage. So, proportional representation of seats. So, reservation of seats for SCs and STs and others must be in proportion to their actual population percentage in the panchayat areas. So, minimum 50% ST seats. So, scheduled tribes are guaranteed at least 50% of the seats in every panchayat within the scheduled areas, and ST chairman's mandatory. Every chairperson position at all levels of the panchayat in these areas must be held by a member of scheduled tribe, and nomination of unrepresented tribes. If a certain tribal group lacks elected members, the state government has power to nominate them to block or district level bodies. So, the proportional representation of the seats under Pisa, it provides minimum 50% seats for STs, and ST chairmen, that is the every chairperson position at all the levels should be reserved for STs, and nomination of unrepresented tribes. If any tribe or any tribal group lacks elected members, then the state government has power to nominate them to block or district level bodies. So, the powers of the Gram Sabha. The Gram Sabha is the cornerstone of the Pisa. Cornerstone of the Pisa, that is, it is a body which is a cornerstone of the Pisa. It is a primary body of self-governance for tribal communities endowed with wide-ranging mandatory powers, that is the intoxicant control, that is prohibit or regulate the sale and consumption, land acquisition. The Gram Sabha should be consulted for developmental projects, forest produce, absolute ownership of minor forest produce, water bodies, planning and management of water bodies, mining lease, granting minor, mineral prospecting licenses, and land acquisition consultation for developmental projects. So, the Gram Sabha is the cornerstone of Pisa. It is the primary body of self-governing for tribal communities endowed with wide range of mandatory powers. So, natural resources rights, that is minor forest produce, the Gram Sabhas have absolute ownership rights over the minor forest produce, a critical livelihood source for tribal communities. Minor water bodies, Gram Sabhas are empowered to plan and manage minor water bodies within their jurisdiction, and minor minerals, Gram Sabhas have the authorities to grant prospecting mineral license, that is licenses and mining leases for minor minerals in scheduled areas. So, land and social protection. land alienation protection prevention, that is Gram Sabhas have the power to prevent, that is have the powers for prevention of tribal land and can take direct action to restore land that has been wrongfully transferred away from the tribal ownership. So the Gram Sabha, they prevent land alienation, that is they have the power to prevent alienation of tribal land and can direct action to restore the land that has been wrongfully transferred away from the tribal community. And land acquisition consultation, that is before any land acquisition for developmental projects or for resettlement or rehabilitation of affected people, mandatory consultation with the Gram Sabha is required. And the land alienation has historically been one of the most serious threats to tribal communities, and Pisa provides a legal shield against it. So land alienation has been historically been one of the most serious threats to tribal communities, and Pisa provides a legal shield against it. Economic and social governance powers, that is beyond natural resources, Gram Sabhas under Pisa are empowered to manage key aspects of local economic and social life. So village markets, authority to manage and regulate village markets within the scheduled areas, and money lending control, power to control and regulate money lending to scheduled tribes, protecting them from exploitation, and intoxicant regulation, that is power to prohibit, regulate or restrict the sale and consumption of any intoxicants, and local developmental plan, that is manage local developmental plans and resources for community benefits. So beyond natural resources, the Gram Sabhas under Pisa are empowered to manage key aspects of local economic and social life, that is village markets, money lending control, that is authority to manage and regulate markets within scheduled areas, money lending control, the power to control and regulate money to the scheduled tribes, protecting them from exploitation, and intoxicant regulation, that is the power to regulate, restrict and prohibit the sale and consumption of any intoxicant, and local developmental plans, that is manage local developmental plans and resources for the community's benefit. So key takeaways, that is the Pisa. Recently the Ministry of Panchayat Raj has celebrated the 30th anniversary of Pisa, Panchayat Extension to the Scheduled Areas Act 1996. So the constitutional empowerment, the Pisa gives constitutional backing to tribal self-governance, that is through Article 243M, Clause 4, Clause B and Part 9. Gram Sabha at the center. The Gram Sabha is the cornerstone or the primary institution endowed with the mandatory consultation rights over land, forest, water and minerals. Guaranteed representation, that is at least 50% of the seats are 50% ST seats, and mandatory ST chairpersons ensure that tribal voices lead their own governance. And ongoing implementation, 9 out of 10 areas. 10 states have scheduled areas, so 9 out of 10 states have framed rules. Framed rules, that is full implementation across all the states remains the goal for the next 30 years. So Pisa remains one of the India's most significant legislations for tribal rights, self-determination and democratic decentralization. Laws of Indian Citizenship, a comprehensive guide to Citizenship Act 1955 and essential for UPSC preliminary 2026. So the constitutional framework, the citizenship, the constitution, the provisions of citizenship are enshrined in the constitution, part 2, article 5 to 1. So Part 2 of the Constitution, Articles 5 to 11, they deal with citizenship, but only at the time of commencement of the Constitution. So, the citizenship, the provisions of the citizenship are contained in the Constitution Part 2, Articles 5 to 11, and these provisions deal with citizenship only at the time of commencement of the Constitution. And the scope, so the scope is limited, that is, the Constitution does not contain any permanent or elaborate provisions with regarding to citizenship. So, the Constitution Part 2, Article 5 to 11 deals with citizenship, but only at the time of commencement of the Constitution, and the scope is limited, that is, the provisions in the Constitution are not permanent and they are not elaborate, that is, with regarding to citizenship. So, what is the Parliament's role? So, the provisions in the Constitution Part 2, Article 5 to 11, they are not elaborate, they are not permanent, and only deal with the provisions of citizenship at the time of commencement of the Constitution. So, the Constitution itself empowers the Parliament to make laws on citizenship. So, the Parliament has enacted Citizenship Act 1955. The Constitution only identifies persons who became citizens at the time of commencement of the Constitution, that is Article 26 January 1950, and it does not deal with the acquisition or loss of citizenship after the commencement of the Constitution. So, the Constitution, as you have already understood, that is, the Constitution, the provisions in the Constitution are not elaborate, they are not permanent, and only deal with the provisions of citizenship at the time of the commencement of the Constitution, that is 26 January 1950. So, the Constitution only identifies persons who became citizens at the time of commencement of the Constitution, that is, it does not deal with the acquisition or loss of citizenship after the commencement of the Constitution. So, citizens at the time of commencement of the Constitution, so who became citizens on 26 January 1950, that is at the time of commencement of the Constitution. So, 4 types of persons became citizens at the time of commencement of the Constitution, that is, the persons who are domiciled in India, that is, persons domiciled in the territory of India at the time of commencement of the Constitution, that is domicile, that is the person who is resident in India permanently or with an intention to make India as its home, and migrated from Pakistan, the persons who migrated from Pakistan to India and returned from Pakistan, that is the persons who migrated from India to Pakistan but later returned to India, and Indian origin abroad, that is the persons of Indian origin who are residing outside India. So, these 4 categories of persons became citizens at the time of commencement of the Constitution. So, the Constitution only deals with or identifies persons, that is, the Constitution only identifies persons who became citizens at the time of commencement of the Constitution, that is 26 January 1950. It does not deal with the acquisition or loss of citizenship after that date. So, citizens at the commencement, that is the Constitution, it identifies these categories of persons, 4 categories of persons as citizens at the time of commencement of the Constitution, that is citizens, the persons who are domiciled in India, persons who migrated from Pakistan, persons who migrated from India to Pakistan, later returned to India, and Indian origin abroad, that is the person of Indian origin living outside India or residing outside India. So, what are the 5 ways to acquire citizenship under the Citizenship Act 1955? So, the 5 ways to acquire citizenship, as you already understood, that the Constitution only does not have elaborate or permanent provisions, and it does not deal with the termination or acquisition of citizenship after the commencement of the Constitution. It only identifies those persons who became citizens at the time of commencement of the Constitution. So, what are the 5 ways? So, the Constitution has empowered the Parliament to enact a law. So the Parliament has enacted Citizenship Act 1955. So what are the 5 ways to acquire Indian citizenship under Citizenship Act 1955? That is by birth, by descent, by registration, by naturalization, and by incorporation of territory. These are the 5 ways to acquire Indian citizenship under the Indian Citizenship Act 1955. That is by birth, by descent, by registration, by naturalization, and by incorporation of territory. Laws of citizenship overview, that is Citizenship Act 1955 prescribes the following 3 ways of losing Indian citizenship. So acquiring citizenship 5 ways: by birth, by descent, by registration, by naturalization or incorporation of territory. And laws of citizenship according to the Citizenship Act 1955 prescribes 3 ways of losing Indian citizenship, that is by renunciation, by termination, and by deprivation. Renunciation, that is the citizen voluntarily gives up the Indian citizenship, and by termination, that is automatic termination, that is if a citizen acquires a foreign citizenship, then his Indian citizenship will be automatically terminated. And deprivation, that is compulsory termination by the central government. So these are the 3 ways in which an Indian citizenship can lose his citizenship under Indian Citizenship Act 1955, that is renunciation, termination, and deprivation. So these provisions, as in the Citizenship Act 1955, are not in the Constitution itself. So these provisions, that is the 5 ways of acquiring citizenship or the 5 ways of losing citizenship, they are the provisions under Indian Citizenship Act or the Citizenship Act 1955, not in the Constitution itself. So the 3 ways of losing citizenship under the Indian Citizenship Act 1955, that is laws by renunciation, that is who can renounce? Any Indian citizen of full age and capacity can make renunciation or can make a declaration renouncing the citizenship. And effect of registration: upon registration of the declaration, the person ceases to be a citizen of India immediately. So first, the person has to, any Indian citizen of full age and capacity, he has to voluntarily renounce the Indian citizenship. That is, he has to make a declaration renouncing the Indian citizenship, and upon the registration of such declaration, the person ceases to be a citizen of India immediately. And there is an exception, that is during wartime. So wartime exception, that is if the declaration is made during a war, that is an Indian citizenship, any Indian citizen of full age and capacity, if he renounces his Indian citizenship and makes a declaration to that effect, and if the declaration is during a wartime, then registration is withheld by the central government. So there is a wartime exception, that is if the declaration is made during a war, then the central government may withhold the registration. And the effect on minor children: every minor child also loses citizenship, and however they can resume citizenship upon turning 18 years. That is, if an Indian citizen voluntarily of full age and capacity, if he voluntarily renounces the Indian citizenship and he makes a declaration to that effect, and that declaration is registered by the central government, then he ceases to be an Indian citizen immediately. And there is a war exception, that is if a declaration is made by an Indian citizen during a war, the central government may not register such declaration. And what is the effect on minor children? That is all the minor children, every minor children of that person who renounces the Indian citizenship, they also lose the citizenship. However, these minor children can resume their citizenship upon turning a major, upon 18 years. So the second way in which an Indian citizen can lose his citizenship under Indian Citizenship Act 1955, that is laws by termination, automatic process. So this termination is automatic process. So if any Indian citizen of full age and capacity, if he acquires the citizenship of any other country, then his Indian citizenship is automatically terminated. So Indian citizenship automatically terminates when a citizen voluntarily acquires the citizenship of another country and no formal order is required. Automatic termination. And wartime exception, here in this case also you have wartime exception, that is during war this provision does not apply during a war in which India is engaged, and citizenship is regained during wartime even if foreign citizenship is acquired. So there is a wartime exception, that is even if a citizen of full age and capacity, Indian citizen of full age and capacity, if he acquires a foreign citizenship during wartime, then this provision of automatic termination does not apply during a war in which India is engaged. That is, his citizenship is retained during wartime even if foreign citizenship is acquired. So the key distinction, that is termination is automatic, whereas the deprivation requires government order. So the third way of losing citizenship, Indian citizen of full age and capacity losing his citizenship is by deprivation, that is compulsory termination by the central government on specific grounds. So central government compulsorily terminates the citizenship under specific grounds. So what are the grounds? Fraud, that is the citizenship is obtained by fraudulent means, that is the citizenship obtained by fraud or misinterpretation. Disloyalty, shown disloyalty to the Constitution of India. Enemy trade, unlawfully traded with the enemy during the time of war or during a war, traded or enemy trade, that is unlawfully traded or communicated with the enemy during a war. And imprisonment, imprisoned for 2 years in any country within 5 years of acquiring, of registration or naturalization, obtaining citizenship by registration or naturalization. So one loss of deprivation, that is deprivation is by compulsory termination by the central government upon specific grounds. So what are the specific grounds? Fraud, disloyalty, enemy trade and imprisonment. Imprisonment for 2 years, within 2 years in any country within 5 years of registration, obtaining the citizenship by registration or naturalization, and long absence, that is ordinarily resident outside India continuously for a period of 7 years. So the deprivation, loss of Indian citizenship by deprivation, that is the compulsory termination by central government on specified grounds. So what are the specified grounds? By fraud, that is obtaining citizenship by fraud or misinterpretation. Disloyalty, shown disloyalty to the Constitution. Enemy trade, that is unlawfully traded or communicated with the enemy during a war. And imprisonment, imprisoned for 2 years within 5 years of acquiring citizenship by registration or naturalization. And long absence, ordinarily resident outside India for a period, continuous period of 7 years. So quick comparison between 3 modes of loss of Indian citizenship, that is nature, that is feature, renunciation, termination or deprivation. These are the 3 ways or 3 modes by which a Indian citizen can lose his citizenship. So quick comparison between 3 modes of losses, that is nature, that is renunciation, that is voluntarily, if a citizen voluntarily gives up the citizenship. Termination, it is automatic termination on acquiring the foreign citizenship. Deprivation, that is compulsory termination by the central government on specific grounds. Initiated, that is under renunciation, who initiates? The citizen. It is a voluntary renunciation, giving up of citizenship. And termination, who initiates? It's on the citizen's action of acquiring a citizenship of a foreign country, his Indian citizenship will be automatically terminated. And deprivation, that is compulsory termination by the central government on specific grounds. Wartime exception, yes, Even if a citizen voluntarily renounces the Indian citizenship, it is withheld by the central government may not terminate or may not, the declaration given by the citizen may not be registered. And termination, yes, does not apply during wartime. That is, if a citizen voluntarily acquires the citizenship of foreign country, his Indian citizenship will not be terminated during wartime. And deprivation, that is no exception. That is, the central government can compulsorily terminate the Indian citizenship on specific grounds even during wartime. So, effect on minor children, renunciation, minor children also lose citizenship. Effect of termination not specified, and deprivation not specified. Resumption possible, yes. The minor children who have lost citizenship can resume their citizenship at the age of 18, and not directly under termination and no under deprivation. So the UPSC 2026 preliminary exam, so high yield focus points are constitutional and statutory, constitutional versus statutory, that is citizenship provisions in part 2 article 5 to 11 of the constitution, but loss or acquisition after the commencement of the constitution is governed by Citizenship Act 1955. 3 modes of losses, that is renunciation, termination and deprivation, that is the differences, especially wartime expenses and who initiates it. Grounds for deprivation, all 5 grounds of deprivations, that is by fraud, disloyalty to the constitution, enemy traded with the enemy or communicated during a war, imprisonment for 2 years within 5 years of acquiring citizenship by registration or naturalization, and long absence, ordinarily resident outside India continuously for a period of 7 years. So, grounds of deprivation and 5 modes of acquisition. What are the 5 modes of acquisition under the Citizenship Act 1955? By birth, by descent, by naturalization, by registration and incorporation of the territory. So, these topics are frequently asked in UPSC prelims and especially in statement based and matching type questions. So, next, right to fair compensation, Land Acquisition, Rehabilitation and Resettlement Act 2013. So, right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act. So, why is it in news? The Standing Committee on Rural Development and Panchayat Raj, it released a major report on right to fair compensation and transparency in land acquisition, rehabilitation and resettlement. So this act was in news recently because the Standing Committee on Rural Development and Panchayat has released a major report on RFCTLARR Act 2013, reigniting the debate on land rights, compensation and resettlement in India. So, what is right to fair compensation and transparency in Land Rehabilitation and Resettlement Act 2013? So, this act, it replaced the Land Acquisition Act 1984, a colonial 1894, a colonial era law widely criticized for being unfair to landowners and displaced communities. So this RFCTLARR Act, it replaced the Land Acquisition Act 1894. This Land Acquisition Act 1894 is a colonial legacy, that is the colonial era law widely criticized for being unfair to landowners and displaced communities. Purpose of the right to fair compensation and transparency right to fair compensation, transparency, Land Acquisition, Rehabilitation and Resettlement Act. What is the purpose? Right to fair compensation, or provide fair compensation to those whose land is acquired, bring transparency to the land acquisition process, and ensure proper rehabilitation of all affected people. So, the purpose of RFCTLARR Act is fair compensation, that is to provide fair compensation to those whose land is acquired and bring transparency to the land acquisition process and ensure proper rehabilitation of all the affected persons. So, defining public purpose. So, the land is acquired for public purpose. So, the Act prevents arbitrary, unreasonable acquisitions by clearly defining what qualifies as public purpose. So, the Act, right to fair compensation and transparency of land acquisition, Rehabilitation and Resettlement Act. It clearly defines what qualifies as public purpose and preventing arbitrary acquisition. So, infrastructure projects, that is roads, highways, bridges, essential public infrastructure projects, urbanization, planned urban development and housing schemes for the public, industrial corridors, designated industrial corridors and economic corridors approved by the government. So, these qualify, that is infrastructure, urbanization and industrial corridors, they qualify as public purpose for the right to fair compensation and transparency, land acquisition, rehabilitation and resettlement. So, the Act prevents arbitrary acquisition by clearly defining what constitutes public purpose. So, infrastructure, urbanization and industrial corridors. So, fair compensation. So, the purpose of RFCTLARR Act is to provide fair compensation to those whose land has been acquired. That is, in rural areas, it is 4 times the market value of land acquired in rural regions, and in urban areas, it is 2 times, that is up to 2 times the market value of land acquired in urban regions. So, consent requirement. Before land can be acquired, consent requirements. So, before land can be acquired, a mandatory consent from the affected families must be obtained. That is, in case of private company projects, 80% of the affected families must give consent before the acquisition proceeds. And in case of PPP, public-private partnership, 70% of the affected families must give their consent before or for the public-private partnership projects. So, the consent requirements, mandatory consent from affected families must be obtained. So, for private company projects, it is 80% of the affected families must give their consent before acquisition process, and for PPPs, 70% of the affected families must give consent for public-private partnership projects, and consent must be obtained alongside the social impact assessment process, not after. So, the consent must be obtained alongside the social impact assessment, not after. So, protecting farmers and agricultural lands. So, the multi-cropped lands, that is, special safeguards apply for the acquisition of multi-cropped farmlands. That is, multi-crop farmlands is permitted only as a last resort. So, for multi-crop farmlands, special safeguards exist. That is, the acquisition of the multi-cropped farmlands should be permitted only as a last resort, and return of unused land. If the acquired land is not used within 5 years, it must be returned to the original owners are placed in a land bank. And scheduled areas, so no acquisition of land in scheduled areas that violates laws protecting the indigenous land rights. So protecting the farmers and agricultural land, that is the multi-cropped land, they have special safeguards. That is, the multi-crop land should be acquired as only as a last resort. And return of the unused land, if the land that is being acquired is not used within 5 years, then it should be returned to the original owners or should be placed in a land bank. Or scheduled areas, no acquisition in scheduled areas that violates the laws protecting the indigenous tribal rights or indigenous land rights. So the social impact assessment, a mandatory social impact assessment study must be conducted before any land acquisition can begin. So before any land acquisition can begin, a mandatory social impact assessment study should be conducted. So conduct social impact assessment, obtain consent from the affected families, that is in case of private companies, private company projects, it is 80% of the affected families must give consent. In case of public-private projects, 70% of the affected families must give consent. So the social impact assessment is mandatory before any land acquisition can begin. So social impact assessment should be conducted and consent should be obtained from the affected families, and the acquisition should be then carried out. So the social impact assessment ensures that the human and social costs of land acquisition are fully understood and addressed before any action is taken. So by conducting social impact assessment, it ensures that human and social costs of land acquisition can be fully understood and addressed before any acquisition of land or any action is taken. So rehabilitation and resettlement. So the Act also has provisions for rehabilitation and resettlement, that is, the affected families are entitled to comprehensive package of support, that is housing. A house is provided to every displaced family as a part of resettlement package, and financial assistance, monetary compensation should be provided for livelihood loss and disruption caused by displacement, and livelihood support, employment and skill development support to help families rebuild their livelihood. So the Act also contains provisions with regarding to rehabilitation and resettlement, that is, the affected families are entitled to comprehensive package of support or support package, that is housing. A house is provided for every affected family or displaced family as a part of the resettlement package. Financial assistance, that is financial compensation, should be provided for livelihood loss and disruptions caused by displacement, and livelihood support, that is employment and skill development support, should be to help the families rebuild their livelihoods. So institutional setup and oversight, the monitoring committees, that is both national and state level monitoring committees, are established to oversee the implementation of the Act, and LARRA, Land Acquisition, Rehabilitation and Resettlement Authority, is set for the speedy disposal of disputes between the affected families and the government, and exemptions. The defense, railways and atomic energy projects are exempted from the Act's procedural requirements. However, compensation and rehabilitation and resettlement provisions still apply to the affected families. So institutional setup and oversight, that is both national and state level monitoring committees, are established to oversee the implementation of the Act, and LARRA, that is Land Acquisition, Rehabilitation and Resettlement Authority, is set for the speedy disposal of disputes between the affected families and the government, and exemptions, that is the defense, railways and atomic energy projects, are exempted from the procedural requirements. However, compensation, rehabilitation and resettlement are still applied to the affected families. So key provisions at a glance, that is the provision and key detail of the right to fair compensation and transparency, Land Acquisition and Rehabilitation and Resettlement Act. So what are the So 2013. So what are the key details? That is the provision and key detail. Fair compensation, that is 4 times market value in rural areas and 2 times the market value in urban areas. Consent requirement in case of public private company projects, 80% for private projects, 80% consent from the affected families for private projects, and for public private partnership projects 70%. Unused land, that is the acquired land should be used within 5 years, otherwise it has to be given back to the owners, or it should be placed in a land bank. Returned to the owners if not used within 5 years, or placed in the land bank. Agricultural land, there are safeguards for multi-cropped agricultural lands. They cannot be acquired, or they can be acquired only as a last resort, and special safeguards applied. Scheduled areas, no acquisition of the land in scheduled areas violating the land rights, indigenous land rights, and social impact assessment study should be conducted before the acquisition process to understand the human and social costs of the project. So mandatory and before any acquisition, and conducted with the consent process. And RR, rehabilitation and resettlement entitlements, that is house should be provided, financial aid should be provided, livelihood support for affected families, and there are exemptions, that is defense, railways and atomic energy projects. The procedural exemptions are given, but the rehabilitation and resettlement provisions still apply. So the next topic, Directive Principles of the State Policy, Article 38 and classification. So the Directive Principles of the State Policy enshrined in the Constitution, Part 4, Article 36 to 51. So Directive Principles of the State Policy, Article 38 and classification, a comprehensive guide for the UPSC preliminary understanding the soul of India's welfare state. So Article 38 is the heart of the Directive Principles of the State Policy. So it lays down the primary objective of all directive. Article 38 lays down that the primary objective of all Directive Principles of the State Policy, that is, it is the guiding spirit of the entire Directive Principles of the State Policy framework. So it lays down the primary objective of all the Directive Principles of the State Policy, and it's a guiding spirit of the entire Directive Principles of the State Policy framework. So the Article 38(1), the state shall strive to promote the welfare of the people by securing to all its citizens justice, that is socio-economic and political, and shall permeate all institutions of national life. So Article 38(1), the state shall strive to promote the welfare of the people by securing to all its citizens a social order in which justice, socio-economic and political justice, shall permeate all institutions of national life, And Article 38(2), the state shall strive to minimize inequalities in income, status, facilities and opportunities, not only amongst the people, individuals, but also amongst group in different areas or occasions. So, Article 38 is the heart of the directive principles of the state policy. It lays down the primary objectives of all directive principles of the state policy. That is, it is the guiding spirit of the entire directive principles of the state policy. So, Article 38, Clause 1, that is, the state shall strive to promote the welfare of the people by securing securing a social order in which justice, socio-economic, political justice shall permeate all institutions of national life. And Article 38, Clause 2, the state shall strive to minimize inequalities in income, status, facilities and opportunities, not only amongst the individuals but also amongst the group in different areas or occasions. So, the key phrase to remember here is justice, socio-economic and political justice. This phrase flows directly from the preamble of the Constitution and finds its concrete expression in Article 38. So, justice, social justice, that is equal treatment regardless of caste, religion, gender or birth. Economic justice, that is fair distribution of wealth and resources among all the citizens. And political justice, equal political rights and participation of every citizen. So, the key phrase of Article 38 is justice, socio-economic and political justice. So, this provisions flow directly from the preamble of the Constitution and finds its concrete expression in Article 38. So, social justice, that is equal treatment regardless of caste, religion, gender or birth. Economic justice, fair distribution of resources and wealth among all the citizens. And political justice, equal political rights and participation for every citizen. So, the Constitution does not provide for the classification of directive principles of the state policy. So, we have classified the directive principles of the state policy for our convenience. So, the broadly into three types, that is the socialistic principles, that is welfare state, reduce inequality, Gandhian principle, decentralization, rural development, and liberal intellectual, that is uniform civil code, environmental protection and separation of judiciary from executive. And under the liberal intellectual, you also have international peace and security, that is the global relations and arbitration. So, the social and economic principles. So, the socialist directive principles of the state policy, that is, they aim to establish a welfare state. So, socialist directive principles of the state policy, they aim to establish the welfare state, focus on economic and social justice. So, also called socialistic principles, they aim to establish a welfare state and reduce socio-economic inequalities. Article 38, to promote the welfare of the people and minimize inequalities in income, status, facilities and opportunities. Article 39, the right to adequate means of livelihood, equal distribution of resources, equal pay for equal work, protection of workers and children. Article 39A, that is right to equal justice and free legal aid, that is ensure equal justice and free legal aid to all the citizens, that is to economically backward citizens, ensure equal justice and free legal aid to economically backward citizens. So, Article 39A and Article 42, that is Article 41, guarantees the right to work. Article 41, Article 39A, Article 41. Article 41, it guarantees the right to work, education and public assistance during unemployment, old age, sickness and disability. That is Article 41. It guarantees the right to work, education and public assistance during old age, sickness, unemployment, etc. That is old age, sickness, unemployment and disability. And Article 42 to provide just and human conditions of work and maternity relief for workers. Article 43 to secure a living wage, decent standard of life, full enjoyment of leisure and socio-cultural opportunities. And Article 43A, participation of the workers in the management of the industries. And Article 47, that is focusing on raising the level of nutrition and improving the public health. So these are the socialistic directive principles of the state policy. They aim to establish the welfare state and reduce socio-economic inequalities. So the Gandhian principles, Gandhian directive principles of the state policy are based on the ideals of Mahatma Gandhi, focusing on decentralization, rural development and social upliftment. So Article 40 to organize village panchayats, as units of self-government. And Article 43 to promote cottage industries on individual and corporate basis in rural areas. Article 46 to promote educational and economic interests of SCs, STs and weaker sections. And Article 47 to improve public health and prohibit consumption of intoxicating drinks and drugs. And Article 48 prohibit the slaughter of cows, calves and other milch and drought cattle. And Article 43B, cooperative societies. That is Article 43B by 97th Constitutional Amendment Act. That is the promotion of voluntary formation and autonomous functioning of cooperative societies. And 48 prohibit the slaughter of cows, calves and other milch and draught cattle. So the liberal and intellectual principles, also known as miscellaneous principles, these reflect the progressive, liberal and intellectual values of the Constitution. So these liberal and intellectual principles, Article 44, that is Uniform Civil Code, to secure a uniform civil code throughout the territory of India for all citizens. And Article 45, that is early childhood care, and Article 45 was added by 86th Constitutional Amendment Act. That is, it changed the subject matter of Article 45 of the Directive Principles of the State Policy. That is, early childhood, providing free and compulsory education for all children until they complete the age 6 years of age. That is, until 6 years of age. And Article 48A, that is environmental protection, to protect and improve the environment, safeguard the forest and wildlife. Article 49, the heritage protection, that is protect monuments, places and objects of artistic or historic interest declared to be of national importance. And Article 50, separation of powers, that is separation of the powers between judiciary and executive in public services of the state. So these are the liberal intellectual principles. And scientific agriculture, Article 48, organizing agriculture and animal husbandry on modern and scientific lines. So Article 48 also is a liberal intellectual principle, that is organizing agriculture and animal husbandry on modern and scientific lines. So these are the liberal intellectual principles. And you also have another liberal intellectual principle, that is international peace and security. Article 51, the state shall endeavor to promote India's role in global community through peaceful and honorable conduct, that is peace and security, that is promote international peace and security amongst all the nations, just relations, maintain just and honorable relations between the nations, and international law, that is respect, foster respect for international law and treaty obligations, and arbitration, encourage settlement of international disputes by arbitration. So the international peace and security under Article 51 is a liberal intellectual principle. So the state shall endeavor to promote India's role in the global community through the peaceful and honorable conduct, that is peace and security, promote international peace and security amongst all the nations, just relations, maintain just and honorable relations between the nations, international law, foster respect for international law and treaty obligations, and arbitration, that is encourage settlement of international disputes by arbitration. So quick revision, all key articles, that is Article 38. So that is the directive principles of the state policy. So a consolidated view of all directive principles articles by category for rapid revision. So the socialist, Gandhian and liberal intellectual, international peace and security is also part of liberal intellectual. So socialistic, Article 38, 39, 39A, 41, 47, 42, 43 and 43A. And liberal intellectual 44, 48, 48A, 49, 50 and Article 51, and Gandhian principles 40, 44, 40, 43, 46, 43B, 47 and 48. So socialistic principles, they promote welfare state, equal pay for equal work, living wage, workers participate in minimal inequalities. Gandhian principles, panchayats, rural development, cottage industries, child education, social and welfare, so SC and ST welfare, public health, prohibition of intoxicating drugs and drugs, cattle protection, liberal intellectual 44, 48, 49, 50, Uniform Civil Code, environment, protection of environment, heritage, monuments, separation of judiciary from executive, and international peace and security, Article 51, that is peace, security, international law, treaty obligations and arbitration of disputes. So UPSC relevance and key takeaways, that is the prelims, Article 38 is frequently asked directly or indirectly, and classification of the directive principles of the state policy, that is specific articles and their linkages with fundamental rights. Article 38, must remember, Article 38 is the primary objective of all the directive principles of the state policy: justice, socio-economic and political, preamble and Article 38 linkage, and Article 39 has the most subclauses, learn from each, and Article 40Y now partly covered under fundamental right to education, that is fundamental right to education, that is the 86th Constitutional Amendment Act has introduced, 2002 has introduced Article 21A and changed the subject matter of Article 45 and introduced a new fundamental duty. So Article 51, India's commitment to international peace. So justice, socio-economic and political flows from the preamble and finds concrete expression in Article 38 of the Indian Constitution. So Article 35 of the Indian Constitution, that is the Parliament's exclusive power to legislate on fundamental rights, is a key pillar of national uniformity. So in order to bring about national uniformity, the Parliament has empowered only the parliament. It has given the exclusive power to legislate on fundamental rights. Article 35. So what is Article 35? Article 35 empowers or ensures that the power to make laws giving effect to certain specified fundamental rights vests exclusively in the parliament and not in the state legislatures. This provision guarantees uniformity across the entire country in the nature of those rights and punishment for their infringement. So, the Constitution under Article 35 has exclusively conferred the power to make laws on fundamental rights, make laws on certain fundamental rights to the parliament and not in the state legislature. And this provision, what it guarantees? It guarantees uniformity across the entire country in the nature of these rights and the punishments for the infringement of the fundamental rights. So, two main parts of Article 35. That is, Part A, that is the exclusive power of the parliament, and state legislatures have no power of legislation on these matters. And Part B, again, the power of the parliament to prescribe punishment. So, the parliament alone can prescribe the punishment for offences under certain fundamental rights. So, together, these two parts make Article 35 a cornerstone of constitutional uniformity in India. So, Part A, the exclusive power of the parliament, that is, the parliament has the exclusive power to make laws on fundamental rights, certain specified fundamental rights, not the state legislature. So, under Article 16(3), residence-based employment, that is, the parliament can prescribe residence as a condition for certain employment under the state, union, territory or authority, linked to Article 16, Clause 3, equality of opportunity. Empowering the courts, that is, the parliament can empower courts other than the Supreme Court and High Court to issue directions, orders and writs for the enforcement of fundamental rights, linked to Article 32. Normally, if the fundamental rights of a citizen are violated, the citizen can approach the Supreme Court or the High Court. Supreme Court under Article 32 and High Court under Article 226. But the Constitution has empowered the Parliament under Article 35 to, that is, the Parliament can empower courts other than the Supreme Court and High Courts to issue directions, orders and writs for the enforcement of fundamental rights, linked to Article 32. And armed forces restrictions. The Parliament can, by law, by making or enacting a law, the Parliament can restrict or abrogate the application of fundamental rights to armed forces, police forces, intelligence agencies and analogous agencies for maintaining public order, and linked to Article 33 and the martial law indemnity. That is, the Parliament can indemnify, make a law, enact a law and indemnify government servants or any person for acts done during martial law in any area, linked to Article 34. So, in all these cases, only the Parliament can enact a law, not the state legislature, to bring about uniformity. So, Part B, the Parliament empowers, or the Parliament has power to punish. That is, the Parliament alone has the authority to enact laws or to prescribe punishment for acts declared as offences under these fundamental rights. So, the Constitution has empowered only the Parliament to enact laws to prescribe punishment for the violation of fundamental rights. So, Article 17, that is abolition of untouchability. Practicing untouchability in any form is an offence punishable under Parliament made law or Parliament enacted law. Article 23, that is right against exploitation, that is prohibits traffic in human beings and forced labour. that is trafficking and forced labor are offences and punishments are prescribed exclusively by the Parliament. The key significance of Article 35, that is it prevents state divergence, that is the states cannot make different or conflicting laws on sensitive matters related to fundamental rights. And national uniformity, it maintains uniform implementation and protection of core rights across all states and territories. And national importance, it reinforces that certain aspects of fundamental rights are a matter of national concern and not regional discretion. So the key significance of Article 35 is that it promotes national uniformity. So salient features of the fundamental rights. So the fundamental rights are justiciable rights, that is the fundamental rights are enforced by courts, that is they are justiciable by courts, that is if a citizen's fundamental rights are violated, he can approach the courts for their enforcement. So they are justiciable rights, that is the fundamental rights are enforceable by the courts. Citizen can approach courts if their rights are violated. And judicial review, the Supreme Court and the High Court can declare any law as unconstitutional if they violate fundamental rights. Judicial review. And universal and citizen specific, some rights are available to all the both citizens and foreigners. Example, Article 14, equality before law and equal protection of law. Right to religion, Article 25 to 28, right to freedom of religion. And some fundamental rights are available only to the citizens like 15, 16, 19, 29 and 30. So fundamental rights are not absolute, they are qualified, that is reasonable restrictions can be imposed by the states. So not absolute, reasonable restrictions can be imposed by the state in the interest of the public order, morality, security of the states. So evolution of the fundamental right. Originally the constitution contained the provisions of the fundamental rights under part 3, article 12 to 35 and the 44th Constitutional Amendment Act 1978, it has taken away right to property under article 31 of the fundamental rights, and so now there are only 6 fundamental rights. So present day currently there are 6 fundamental rights enshrined in the part 3 of the constitution. The 6 fundamental rights today are right to equality, article 14 to 18, right to freedom, article 19 to 22, right against exploitation, 23 to 24, right for freedom of religion, article 25 to 28, and cultural and educational rights, article 29 to 30, and right to constitutional remedies, article 32. So a quick revision or summary, that is article 35, only parliament, not state legislature, can legislate on certain fundamental rights matters, and articles linked to part A, that is article 16, article 32, article 16(3), article 32, article 33 and article 34. Parliament has exclusive power to legislate, that is residence as a qualification for certain employments, and empower the courts other than the Supreme Court and High Court to give directions, orders and writs. And article 33, the Parliament can make a law and restrict or abrogate the application of fundamental right to armed forces, police forces, intelligence forces and analogous agencies. And article 34, indemnity, providing indemnity. The Parliament can enact a law providing indemnity to civil servants or other persons acting during when the martial law is in force in a particular area. So the Parliament has exclusive powers to legislate. And articles linking part B, that is the Parliament has exclusive powers to punish for the violation of fundamental rights by enacting law, that is article 17, untouchability, abolition, and article 23, prohibition of forced labor and beggar. The Parliament alone prescribes the punishment for offences, not the state legislature. And 6 fundamental rights in part 3, right to property was removed by 44th Constitutional Amendment Act 1978, and now it is a legal right under Article 300A, Part 12. So this is regarding Article 35 and criticisms and mechanisms of fundamental rights. So a deep dive into Part 3 of the Indian Constitution, examining the criticisms, restrictions and the legal framework that these rights, about these rights. So the criticism and mechanism of fundamental rights. So the core criticism of the fundamental rights, that is vagueness and ambiguity. One of the most significant criticisms of the fundamental right enshrined in the Part 3 is that they are stated in vague, indefinite and ambiguous manner. The language used is often complicated and beyond the easy comprehension of the common man. So undefined phrases, the key terms as public order, minorities, reasonable restrictions, public interest are used throughout the Part 3, but they are never clearly defined in the Constitution itself. So some key phrases, they are used throughout the Part 3, like the public order, minorities, reasonable restrictions, public interest, they are used throughout Part 3, but they are not clearly defined in the Constitution itself. And complex language, the language employed is often technical and legalistic, making it difficult for the ordinary citizens to understand their own rights without professional legal assistance. So the language is often technical and legalistic, so it is making it difficult for a common man to understand their own rights without professional legal assistance, and it is a paradise for lawyers. Sir Ivor Jennings famously described the Constitution of India as a paradise for lawyers. A pointed criticism or critic of its complexity and litigation it inevitably generates. So Ivor Jennings, the Constitution of India is a paradise for lawyer. That is, he is criticizing or the Indian Constitution for its complexity and the litigation it inevitably generates. So this is the criticism of fundamental rights. That is, the fundamental rights are vague, indefinite and ambiguous. The language used is complex and beyond easy comprehension of the common man. Undefined phrases, key terms such as public interest, the reasonable restrictions, minorities, public order, they are not clearly defined in the Constitution itself. And the complex language, the language used is technical and legalistic, so it is difficult for a common man to understand his own rights without professional legal assistance. And Sir Ivor Jennings is describing the Indian Constitution as a paradise for lawyers. He is pointing a pointed critic of its complexity and the litigation it inevitably generates. So Article 19, freedoms and their restrictions. The freedoms guaranteed, Article 19, right to 6 freedoms. Originally there were 7, but Article 19(1)(f), that is the right of a person to acquire, hold and dispose of property, was taken away by 44th Constitutional Amendment Act 1978, right to property. So the freedoms guaranteed under Article 19 are not absolute. That is, the fundamental rights are not absolute. They are qualified. That is, the state can impose reasonable restrictions. They can be restricted, but only through the force of law. The Constitution carefully channels this power to through specific legislative authorities. So the freedom guaranteed under Article 19 are not absolute. They can be restricted, but only through the force of law. And the Constitution carefully channels these powers through specific legislative authorities. So who can impose restrictions? That is, restrictions on Article 19 freedoms may only be imposed through formally enacted law, not executive orders or administrative discretions alone. So the reasonable restrictions can be only imposed by an enacted law, but not by administrative discretion or executive orders alone. So, laws enacted by the parliament can impose reasonable restrictions, laws passed by the state legislatures can impose reasonable restrictions, and the ordinances promulgated by the executive, that is the president or the governor, they can impose reasonable restrictions, but not administrative discretion and executive orders alone. They cannot impose reasonable restrictions. So, judicial safeguard, the constitutionality of any restriction imposed under Article 19 freedoms is always subject to judicial review by the courts. This ensures that the legislature cannot arbitrarily curtail the fundamental rights without constitutional justification. So, the legislature, it can impose reasonable resistance by enacting a law, and that law will be scrutinized by the judiciary whether the restrictions are reasonable. So, the constitutionality of any restriction imposed by the state on Article 19 freedom is always subject to judicial review by the courts. This ensures that the legislature cannot arbitrarily curtail the fundamental rights without constitutional justification. So, courts act as the ultimate guardian, and any law restricting Article 19 freedom must pass the test of reasonableness. So, Article 19, the freedoms and their restrictions. Viksit Bharat Shiksha Adhishthan Bill 2025, a landmark reform reshaping the regulatory architecture of higher education in India. This bill was introduced in Lok Sabha and referred to the Joint Committee or Joint Parliamentary Committee. So, the Viksit Bharat Shiksha Adhishthan Bill 2025 is a landmark legislation reshaping the regulatory architecture of higher education, and it was introduced in the Lok Sabha and referred to a Joint Parliamentary Committee. So, why it matters? The constitutional basis. The subject of higher education is present in the list 1, that is the union list of the 7th schedule of the Constitution, entry 66. So, the Constitution empowers the Parliament to legislate on higher education standards. So, the constitutional basis of this bill is the higher education is a union list subject, that is list 1 in the 7th schedule of the Constitution, entry 66, and the Parliament is empowered to legislate on higher education standards. So, what entry 66 covers? Entry 66 covers coordination of higher education standards, determination of standards in research institution and scientific and technical institutions. So, the Viksit Bharat Shiksha Adhishthan, an apex regulatory body, the Viksit Bharat Shiksha Adhishthan will serve as a single apex body overseeing all higher education regulation in India. So, Viksit Bharat Shiksha Adhishthan is a single apex body overseeing all higher education regulation in India, and apex authority. It unifies or unified regulatory architecture for all higher educational institutions across India. No funding control. The Viksit Bharat Shiksha Adhishthan does not control the funding of institution. It regulates the standards and exemptions. The legal and medical education are exempted, regulated under their own separate acts. So, Viksit Bharat Shiksha Adhishthan is the apex regulatory body, that is a single apex body overseeing all higher education regulation in India, and it is an apex authority, that is a unified regulatory architecture for all higher education institutions in India, and no funding control, that is it will regulate standards. The VBSA, that is Viksit Bharat Shiksha Adhishthan, will regulate standards, but it will not control funding of institutions, and exemptions the legal and medical exemptions are regulated under their own separate acts. So, 3 vertical councils under Viksit Bharat Shiksha Adhishtan, that is, the Viksit Bharat Shiksha Adhishtan operates through 3 specialized councils, each with their distinct mandate. That is, the first specialized council, that is Viksit Bharat Shiksha Viniyaman Parishad, that is regulation, overseeing the compliance and governance of higher educational institutions, and Viksit Bharat Shiksha Gunvatta Parishad, that is accreditation, that is it evaluates and certifies the quality of institutions and programs, and Vikasit Bharat Manak Parishad, that is academic standards, sets and maintains curriculum and academic benchmarks. So, 3 vertical councils under Viksit Bharat Shiksha Adhishtan, that is the Viksit Bharat Shiksha Adhishtan, it operates through 3 specialized councils, each with a distinct mandate, that is Viksit Bharat Shiksha Viniyaman Parishad, that is it oversees the regulation, that is it oversees the compliance and governance of higher educational institutions. Viksit Bharat Shiksha Gunvatta Parishad, accreditation, that is it evaluates and certifies the quality of institutions and programs, and Viksit Bharat Shiksha Manak Parishad, academic standards, that is it sets and maintains curriculum and academic benchmarks. So, the acts to be replaced, the acts to be replaced, that is Vikasit Bharat Shiksha Adhishtan Bill, it proposes to consolidate the existing regulatory bodies by repealing the 3 landmark acts. So, the UGC Act 1956, the AICTE Act 1987 and NCTE Act 1993. So, all the 3 bodies, that is Universities Grants Commission, the All India Council for Technical Education and National Council for Teacher Education, all these 3 councils will be subsumed under the uniformed VBSA framework, streamlining regulation and reducing overlap. So, Viksit Bharat Shiksha Adhishtan, the bill proposes to consolidate the existing regulatory bodies by repealing the 3 landmark acts. So, the University Grants Commission Act 1956, the UGC, that is University Grants Commission, regulator of university education for nearly 70 years, and All India Council for Technical Education Act 1987, that is All India Council for Technical Education governing technical and management education, and NCTE, National Council for Teacher Education, overseeing teacher training institutions. So, all these 3 bodies will be subsumed under the unified Vikasit Bharat Shiksha Adhishtan framework, strengthening regulation and reducing overlap. So, these 3 bodies will be unified under the VBSA framework, that is a single apex body, single apex regulatory body. So, the Supreme Court ruling on RTE Act, Right to Education Act 2009, that is the Supreme Court directed that all the schools should allot or make available at least, that is 25% free seats for children from weaker and disadvantaged sections under section 12 clause 1 subclause C of the RTE Act. So, the Supreme Court has directed that all the schools must make available 25% free seats for students from weaker and disadvantaged sections under the section 12 clause 1 clause C of the RTE Act. So, the government action required, that is both central and state governments, must frame and notify the rules under the section 38 for implementation of section 12 clause 1 subclause 3 and consultation mandate. The rules to be framed in consultation with National Commission for Protection of Child Rights, State Commission for Protection of Child Rights and national and state advisory councils. So, about the RTE Act 2009, that is the constitutional foundation, the it is enacted, RTE Act 2009 is enacted to give effect to Article 21A, that is right to education as a fundamental right in the Constitution of India, and the key provisions, that is Section 3 of RTE Act 2009, that is every child aged 6 to 14 years has the right to free and compulsory education in a neighborhood school, and the government must establish neighborhood schools with proper infrastructure, teachers and learning facilities, and schools entitled to reimbursement of per child expenditure by the state. So, constitutional provisions, right to education. So, multiple constitutional provisions collectively protect and promote right to education in India. So, what are the multiple constitutional provisions that protect and promote the right to education in India? That is Article 21A, fundamental right, that is guarantees the right to free and compulsory education for all the children in the age group of 6 to 14 years. That is 86th Constitutional Amendment Act 2002 has introduced Article 21A, that is fundamental right, that is guarantee right to free and compulsory education for all the children in the age group of 6 to 14 years, and Article 15 Clause A subclause K, that is fundamental duty, that is the 86th Constitutional Amendment Act 2002 and has added a Article 21A fundamental right, and has also added the 11th fundamental duty, that is Article 51A Clause K. So, the fundamental duty, that is, it specifies the duties of parent and guardians to provide opportunities for their education to their child in the age group of 6 to 14 years. So, it specifies the duty of parents and guardians to provide opportunities for the education to their children aged 6 to 14 years, and 86th Constitutional Amendment Act 2002 not only added Article 21A of fundamental rights and a fundamental duty, 11th fundamental duty, but it also changed the subject matter of Article 45, Directive Principles of the State Policy. So, now the Directive Principle of the State Policy reads that it directs the state to provide early childhood care and education to all the children below the age of 6 years. Below the age of 6 years. So, these are the multiple constitutional provisions to protect and promote the right to education in India. So, Convention Against Discrimination in Education. So, according to UNESCO report, that is UNESCO report, that is United Nations Educational, Scientific and Cultural Organization report 2025, that is right to education past, present and future, reflecting on 65 years of achievements since 1960 convention. So, about the convention, that is Convention Against Discrimination in Education. So, it was adopted in 1960 by UNESCO, United Nations Educational, Scientific and Cultural Organization, and it is the first legally binding international instrument entirely dedicated to right to education, and it reaffirms education as a fundamental human right, and India has not ratified it. So, Convention Against Discrimination in Education, according to UNESCO report 2025, that is right to education past, present and future, reflecting on 65 years of achievements since the 1960 convention. So, the convention was adopted in 1960 by UNESCO, first legally binding international instrument entirely dedicated to right to education, and this convention reaffirms education as a fundamental human right, and India has not ratified it. So, what the convention obligates states to ensure? So, the 1960 UNESCO convention obligates or sets the binding obligations on signatory states across all the levels of education, that is free primary education, free and compulsory primary education for all the children without exception, and accessible secondary education, that is secondary education made accessible and available to every student, and the equal higher education equally accessible on the basis of individual capacity and merit, and zero discrimination bans any form of discrimination in education based on race, gender, religion or origin. And India has not ratified the 1960 Convention Against Discrimination in Education, a significant gap in its international education commitments. So, other important news, that is key updates in governance, polity and demographics. So, electoral trusts. So, electoral trust, that is election commission, why is it in news? So, recently election commission released the annual report of contributions received by electoral trusts and donations to political parties for financial year 2024-2025. So, recently election commission has released a report, that is annual report of contributions received by electoral trusts and donations to the political parties for financial year 24-25. So, electoral trust scheme 2013, what are they? So, the trusts registered under the Companies Act to receive donations from the individuals and companies and distribute them to the registered political parties. And what is the objective of this electoral trust scheme 2013? So, under the electoral trust scheme 2013, trusts which are registered under the Companies Act to receive donations from individuals and organizations and to distribute them to registered political parties. So, what is the objective of electoral trust scheme 2013? That is to enhance transparency, accountability in political funding across India. And what is the mandate? Mandate is it must distribute 95% of the total contributions received within a financial year to registered political parties. So, the Electoral Trust Scheme 2013, its objective is to enhance transparency and accountability in political funding in India, and the mandate is it must distribute, that is the trusts established to receive donations from individuals and organizations or companies, the trusts which are registered under Companies Act, to receive donations from individuals and organizations or companies and to distribute them to the registered political parties. So, the mandate is to distribute the 95% of total donations or contributions received within a financial year to registered political parties. So, electoral trusts, regulation and disclosures. So, regulation required to report all the contributions to the Election Commission of India, and it is governed by Income Tax Act 1965. So, this electoral trust, that is the trust established under the Companies Act to receive the donations from individuals and companies, they must report all the donations or contributions to the Election Commission of India, and they are governed by Income Tax Act 1961. And disclosure requirements, the donors and the amounts must be mandatory. Both donors and what amount they have donated must be mandatorily reported, and ensuring full traceability of political funding. This ensures no anonymous donations can flow through the electoral trust. Okay, so the disclosure requirements, that is donors and amounts, must be mandatorily reported, ensuring full traceability of political funding, and this ensures no anonymous donations can flow through electoral trusts. So, The next topic, the presidential address to the parliament. That is, the president addresses a joint sitting of joint sitting. Article 108 relates to joint sitting. So the president addresses the joint sitting of both the houses at the start of the budget session or a constitutional mandated occupation. So Article 86 and 87 of the Constitution regarding presidential address. So Article 86, that is, it is discretionary, that is, right to address. It allows the president to address either house of the parliament or both the houses together at any time, and he can also send messages to the houses. And Article 87, special address, that is, it is mandatory address at the beginning of the first session after each general election and to the Lok Sabha and at the first session of each year. So Article 86, that is right to address, the president addresses either houses of the parliament or both the houses of the parliament at any time, and he can also send messages to both the houses. Article 87, special address, that is, it is mandatory address at the beginning of the first session after each general elections to the Lok Sabha and at the first session of each year. So Article 87 is mandatory and Article 86 is discretionary. Likewise, at the state level, you have governor. So Article 175 and 176, governor's address. So certain states have seen issues regarding the governor's address to the state legislature at the commencement of the first session of the year, especially the Tamil Nadu. So the governor's address, key distinctions, Article 175 and Article 176. Article 175, it is discretionary, same as Article 86. That is, it is discretionary, that is, the right of the governor to address either houses or either house or both the houses of state legislature and send messages to the house or houses at any time. So not all the states have bicameral legislature. Okay. So the Article 175, that is discretionary, that is only 6 states have bicameral legislature. So the governor under Article 175, that is, it is its discretionary power, that is right of the governor to address either house or both the houses or send messages to either house or both the houses at any time. And Article 175, that is, it is mandatory, special address of the governor, that is, the governor mandatory special address at the commencement of first session after each general election and at the first session of each year. So as per the Nebam Rabia versus Deputy Speaker 2016, the Supreme Court ruled that the address under Article 175 and 176 must be performed by the governor on the aid and advice of the Council of Ministers. So as per the Nebam Rabia versus Deputy Speaker 2016, the address under Article 175 and 176 must be performed by the governor on the aid and advice of the Council of Ministers. 50th meeting of Pragati, that is proactive governance and timely implementation. Pragati was launched in 2015 to integrate accountability, transparency and timely decision making into administrative process. So the 50th meeting of Pragati, that is proactive governance and timely implementation, that is, it was launched in 2015 to integrate accountability, transparency and timely decision making into administrative process. So Pragati, what are the key features? That is multimodal platform, that is It spans all the three tiers of the government, that is central, state and local, that is district levels, in a single integrated system, and Prime Minister chaired reviews, that is the review meetings are chaired by the Prime Minister with direct engagement with state and central ministers. And governance tools, it hosts PM Gati Shakti, Parivesh and PM reference portal under one umbrella. And so these are the key features of Pragati. So multi-modal platform spans all the three tiers of the government, central, state and local, that is district level in single integrated system. PM chaired reviews, that is review meetings chaired by the Prime Minister with direct engagement with the state and central ministers. And governance tools, that is it hosts PM Gati Shakti, Parivesh and PM reference portal under one umbrella. And next is Pankudi portal. So launched by Ministry of Women and Child Development and integrated CSR, corporate social responsibility and partnership facilitation, single window digital platform. So who it connects? It connects individuals, NRIs, NGOs, corporates, government agencies on one platform. So it is launched, Pankudi portal is launched by Ministry of Women and Child Development. It is an integrated CSR, corporate social responsibility and partnership facilitation, single window digital platform. So it is a single window digital platform. And who it connects? Individuals, NRIs, NGOs, corporates and government agencies on one platform. So what is its focus? Its focus area is health, nutrition and early childhood care and education, ECCE, child welfare and more. And what does it aim? It aims to strengthen transparency and structured stakeholder participation. So coordination, transparency and structured stakeholder participation, and focuses on health, nutrition, early childhood care, education, child welfare and more. It connects individuals, NRIs, NGOs, companies, government agencies on one platform. So Pankudi is launched by Ministry, Pankudi portal is launched by Ministry of Women and Child Development, and integrated CSR and partnership facilitation, single window digital platform. So demographic transition in India. The RBI reports. So the RBI report, that is the state finances study of state budgets of 25-26, provides a detailed analysis of India's demographic transition. So the RBI's report, the state finances a study of budgets, that is state budgets of 2025-26, provides a detailed analysis of India's demographic transition. So with a median age of 28 years, India's working age population is at a historic peak, a critical inflection point. So with a median age of 28 years, India's working age population is at the historic peak, a critical inflection point. So demographic transition model, according to the demographic transition model, or it describes the shift from high birth and high death to low birth and low death as societies industrialize and develop, a pattern now visible across Indian states. So stage 1, you have, that is the states, the societies, they industrialize and develop. So as they industrialize and develop, they move from stage 1, 2, 3 and 4. Demographic transition model, that is it emphasizes on a shift from high birth and high death to low birth and low death due to industrialization and development. and this pattern is now visible in Indian states. So stage 1, high birth and high death. So both births are high and deaths are high. Second stage, death rates fall because of development, industrialization, and birth rates also fall. Stage 3 and stage 4, that is low birth and low death rate. And this pattern now is visible across Indian states. Demographic transition model, that is states move from stage 1, 2, 3 and 4 as they develop and industrialize. So societies, they shift from high birth rate to low birth rate and low death rate as they industrialize and develop. This pattern is now visible across the Indian states. So interstate demographic divergence, that is the youthful states Bihar and UP, high share of young population and wide window of opportunity. The intermediate states of Telangana and Uttarakhand, narrowing window of opportunity, and aging states Kerala and Tamil Nadu, they cross the demographic turning point and working age population is declining. So interstate demographic divergence. So what are the fiscal implications of aging states like Tamil Nadu and Kerala? So shrinking tax base, that is shrinking labor force, lowers long time growth rates, eroding the tax base in aging states. Rising committed expenditure, that is aging states, face upward pressures on pensions and interest payments. That is in 2024-25, nearly 30% of the social sector spending in these states went to pensions, and fiscal vulnerability, that is higher debt to state gross state domestic product ratios and higher interest payment to revenue receipt ratios in aging states. So these are the fiscal implications of aging states, that is shrinking tax base because of shrinking labor force, that is shrinking labor force, it lowers the long term growth rates and eroding the tax base in aging states, and rising committed expenditure, that is aging states, that is old age population, faces upward pressures of pension and interest payments. In 24-25, nearly 30% of the social sector spending went on pensions, and fiscal vulnerability, that is high debt to gross state domestic product ratios and higher interest payments to revenue receipt ratios in aging states. So what is demographic winter? Demographic winter is a demographic phase characterized by persistent and structural decline in population growth. So demographic winter is a demographic phase which is characterized by persistent and structural decline in population growth. So key indicators are birth rates below replacement rate of fertility, that is 2.1, and an inverted population pyramid. Inverted population pyramid, that means more number of old age people. Inverted pyramid, more number of old age people. So the key indicators are birth rates below replacement rate of fertility, that is 2.1, and inverted population pyramid. And key affected countries are Japan, South Korea, Italy, Germany, and China. So demographic winter is a demographic phase characterized by persistent and structural decline in population growth. Key indicators, that is birth rates below the replacement level of fertility or replacement rate of fertility, that is 2.1, and inverted population pyramid, that is where you have higher old age people, higher percentage of old age people in the population. And key affected countries are Italy, Germany, China, South Korea and Japan. So next, aspirational districts program 2018, it aims to quickly and effectively transform 112 districts across India. The progress is measured on 49 indicators of development. So nutrition, some of them are nutrition and health, education, agriculture and water, financial inclusion and skills and infrastructure. So aspirational districts program, that is 2018, it aims to quickly and effectively transform 112 districts across India, and progress is measured on 49 indicators of development, and some of them are nutrition, health, education, agriculture and water, in financial inclusion and skills and infrastructure. The aspirational program, what are the broad contours? So governance, that is at central and state schemes for maximum impact, that is convergence of central and state schemes for maximum impact, collaboration between central and state nodal officers, district collectors working together, and the competition, that is among the districts through monthly delta ranking to drive performance. So these are the broad contours: convergence between central and state schemes for maximum impact, collaboration between central, state nodal officers and district collectors working together, and competition among districts through monthly delta ranking to drive performance. And aspirational block program 2023, it's a Niti Aayog initiative, aims for saturation of essential government services in 513 blocks in 329 districts across the country. Niti Aayog launched Sampurnatha Abhiyan 2.0 to achieve saturation of key performance indicators. So aspirational block program is an initiative, Niti Aayog initiative, launched in 2023, and it aims for saturation of essential government services in 513 blocks in 329 districts across the country. And Niti Aayog launched Sampurnatha Abhiyan 2.0 to achieve saturation of key performance indicators. Reports in the news. So what are the recent reports in the news? So the World Inequality Report 2026 by World Inequality Lab. So what are the key findings? In India, top 1% holds approximately 40% and top 10% holds approximately 65% of total wealth, and Global South transfers more than 1% of world GDP to the Global North annually, that is 3 times more than the developmental aid. And Employment and Social Trends 2026 report by ILO, International Labour Organization. So global unemployment rate is projected to remain historically low at 4.9, and India accounts for 3% of world's manufacturing, and demand for skilled workers in India exceeds supply. So demand for green skilled workers in India exceeds supply. So the Employment and Social Trends 2026 report by ILO, that is global unemployment rate projected to remain at a historical low of 4.9%, and India accounts for 3% of world's manufacturing, and demand for green skilled workers in India exceeds supply. And World Inequality Report 2026, World Inequality by World Inequality Lab, that is India. In India, top 1% holds approximately 40% and top 10% holds approximately 65% of total wealth. And Global South transfers more than 1% of world GDP to the Global North annually, that is 3 times more than the developmental aid Global South receives from the Global North. So Doping in sports in India. So, India ranks highest in the world for doping violations for the third consecutive year, according to World Anti-Doping Agency, the WADA Annual Report 2025. So, according to World Anti-Doping Agency WADA Annual Report 2024, India ranks highest in the world for doping violations for the third consecutive year. So, why is this in news? According to the WADA Annual Report 2024, that is WADA, World Anti-Doping Agency Annual Report 2024, India has the highest number of dope cheats in the world for the third consecutive year in a row. What is the source? World Anti-Doping Agency WADA Annual Report 2024, and India holds the first spot globally for doping violation and the streak third year in a row at the top of this unwanted list. So, India's doping numbers at a glance. So, how many violations? 260 positive cases, that is prohibited performance enhancing drugs detected in India, and 3.6% positivity rate, that is share of tests returning positive doping events, a positive doping result, and rank 1, global rank, India leads the world in absolute number of doping offences. So, global comparison, India leads the world followed by two major sporting nations, that is India, 260 cases, highest globally, second highest in absolute doping offenders, France, and third highest in absolute doping offences, Italy. So, the initiatives to combat doping in India. So, India has launched several programs and tools to fight doping at every level of the sport, that is NIDAMS portal, that is centralized anti-data for efficient management, NADA, National Doping Agency, National Anti-Doping Agency India app, instant rules and results access, and HPTC focus, that is high performance training centers focus, that is targeted education at high performance training centers, and the testing regimen, that is rigorous in and out of competition athlete testing, and the social campaigns, that is know your medicine promotion across social media. So, the incentives to combat doping in India. India has launched several programs and tools to fight doping at every level in the sport, that is NIDAMS portal, NADA India app for instant rules and results access, high performance testing training centers focus, that is targeted education at HPTC focus, testing regimen, that is rigorous in and out of competition athlete testing, and social campaigns, that is know your medicine promotion across social media. NIDAMS portal, that is NADA, National Anti-Doping Agency India Data Administration and Management System, the backbone of authorized anti-doping operations in India. What it does, that is centralizes and manages all anti-doping data and operations across India's sporting ecosystem. Who uses it? That is authorized anti-doping officials, sports federations, and NADA, National Anti-Doping Agency administrators. So, NIDAMS portal, that is NADA India Data Administration and Management System. It is the backbone of authorized anti-doping operations in India, and it centralizes and manages all anti-doping data and operations across India's sporting ecosystem, and it authorized anti-doping officials use this data along with sports federations and NADA administrations. So, NADA, NADA Indian Mobile App, a dedicated mobile application empowering athletes with the knowledge they need to stay clean. That is anti-doping rules, complete up-to-date anti-doping regulations available at athletes' fingertips on the NADA India mobile app, and prohibited substances, full list of banned substances, so athletes can make informed decisions, and test results, athletes can access their own testing results quickly and transparently. So NADA India, National Anti-Doping Agency India mobile app, it is a dedicated mobile application empowering the athletes with the knowledge they need to stay clean, anti-doping rules, that is complete up-to-date anti-doping regulations available at the athlete's fingertips, and prohibited substances, a full list of banned substances, so athletes can make informed decisions, and test results, athletes can access their own testing results quickly and transparently. So focus on high performance testing centers. So high performance testing centers are a key target for anti-doping education and outreach. So anti-doping booths, dedicated booths set up at major national and international sporting events, outreach programs, direct engagement with athletes, coaches and support staff at training venues, and on-site education, that is real-time awareness sessions conducted during competitions and training camps. So testing in and out of competition, that is the NADA conducts rigorous testing both during and outside of competitions to ensure a level playing field. In competition testing, that is athletes are tested during official competitions to detect prohibited substances for performance enhancement, and out of competition testing is also conducted outside competitions, including at training avenues and high performance training centers, to catch year-round violations. And this dual approach, that is both during and outside of competitions, to ensure level playing field, ensures no athlete can time their doping to avoid detection. Okay. So social media and the Know Your Medicine campaign. So NADA actively uses digital platforms to spread awareness and prevent accidental doping. That is, social media campaigns actively promoting clean sport values across platforms to reach athletes at all the levels. And Know Your Medicine app, each athlete, that is, it will help athlete verify whether their medications contain any prohibited substances before use, and grassroots awareness targeting young and emerging athletes to build a culture of clean sport from the ground up. So social media and Know Your Medicine campaign. So NADA is actively using digital platforms to spread awareness and prevent accidental doping through social media campaigns, Know Your Medicine app and grassroots awareness. So the next topic, Amrut 2.0, that is Atal Mission for Rejuvenation and Transformation. So Amrut 2.0 is a landmark centrally sponsored scheme transforming India's urban water and infrastructure landscape under the Ministry of Housing and Urban Affairs. So Amrut 2.0 is a landmark centrally sponsored scheme transforming India's urban water and infrastructure landscape and implemented by Ministry of Housing and Urban Affairs. So Atal Mission for Rejuvenation and Urban Transformation 2.0. Why is it in news? The Standing Committee on Housing and Urban Affairs in the 18th Lok Sabha, it presented a review report on Amrut 2.0, bringing new focus on India's urban transformation mission. So, nodal ministry, Ministry of Housing and Urban Affairs. Scheme type, it is a centrally sponsored scheme and funding is made by or shared by both center and states. So, key features of Amrut 2.0, that is, it has 6 powerful pillars that define how cities are funded, monitored and transformed. So, outcome-based fundings, cities must submit a roadmap to achieve set of targets before receiving funds. And community participation, special emphasis on women's and self-help groups in planning and execution. And the Pay-Jal Survection, competitive monitoring tool assessing cities on water quality, quantity and reuse. So, more key features, that is PPP mandate, that is cities with a population of over 1 million, that is 10 lakh, must implement at least 10% of their allotment to PPP, public-private partnership. Technology submission, focus on lighthouse projects and supporting water sector startups through innovation. And the Amrit Mitra initiative, that is gig economy model, that is youth and women co-opted for feedback and assessment roles across the cities, and mandatory reforms. Funds tied to performance, that is funds tied to specified reforms including fiscal, health and water efficiency benchmarks. So, implementation and planning hierarchy under Amrut 2.0. Amrut 2.0, it follows bottom-up planning from city level assessment all the way to the national approval. So, city and apex, that is state action, water action plan and apex approval, city water action plan, city core, that is city water balance plan. So, this structured hierarchy ensures every city's unique water needs are captured before national level decisions are made. So, this bottom up planning approach, that is structured hierarchy approach from bottom up, it ensures cities' unique water needs are captured before national level decisions are made. So, planning levels in detail, that is city water balance plan. City assesses the current water supply and demand and existing gaps at the local level, and city water action plan, that projects are formulated specifically to bridge the gaps and identify the city water balance plan, and state water action plan, that is aggregation of all the city plans submitted to the center's apex committee for approval, and urban aquifer management plan, that is the focus on maintaining a positive groundwater balance in urban aquifer systems. So, the Pay-Jal Survection spotlight. So, what is it? Pay-Jal Survection is a competitive monitoring tool mandated or modeled on the success of Swachh Survekshan, but focused entirely on water, that is 3 pillars of assessment: water quality, water quantity and water reuse. So, it emphasizes Pay-Jal Survekshan, it emphasizes on 3 pillars, that is this is a management, or it is a competitive monitoring tool, and it is modeled on the success of Swachh Survekshan but focused entirely on water. So, 3 pillars of assessment: water quality, water quantity and water reuse. So, Amrit Mitra and technology submission. So, Amrit Mitra, the gig economy for governance, both youth and women are co-opted as Amrit Mitras, playing active roles in feedback collection and city assessment. And technology submission, innovation at the core, that is dedicated focus on lighthouse projects and pilot innovations that can be scaled across the cities, active support for water sector startups to bring cutting edge solutions to urban water challenges. So it empowers communities while improving data quality and ground level monitoring. So water urbanization prospects, that is World Urbanization Prospects 2025, UNDESA. Okay, the United Nations DESA report. According to it, the 45% of urban population share, that is share of global population now living in cities, is approximately 8.2 billion people. So according to this World Urbanization Prospects, that is UNDESA report. So UNDESA report, according to the UNDESA report, the World Urbanization Prospects 2025, 45%, that is the share of global population now living in the cities is 45% of the world population, that is approximately 8.2 billion people. And Jakarta, Indonesia, capital of Indonesia, Jakarta, now the world's most populous city, and New Delhi, the India's capital, ranks among the world's most populous cities. So according to the United Nations most populous cities 2025, that is the UNDESA, United Nations Department of Economic and Social Affairs report. So the world's most popular cities 2025, that is the global urban hierarchy is shifting and Asian megacities now dominate the top rankings. So according to the UNDESA, United Nations Department of Economic and Social Affairs, the global urban hierarchy is shifting, that is Asian megacities are now dominating the top ranking. So first the most populous city, Indonesia, Jakarta, Indonesia, second Dhaka, Bangladesh, and third Tokyo, Japan, fourth New Delhi, India. So the world's most populous cities 2025, the global urban hierarchy is shifting according to the UNDESA report, though the Asian megacities now dominate the top rankings. So the first is Jakarta, Indonesia, second Dhaka, Bangladesh, third Tokyo, Japan, and fourth New Delhi, India. Article 12 of Indian Constitution. So Article 12, that is, it is part of the fundamental rights. So fundamental rights are enshrined in the Constitution, Part 3, Article 12 to 35. So Article 12 defines the term state for the purposes of the fundamental rights. So Article 12 of the Indian Constitution defining state for fundamental rights, that is scope, significance, and landmark rulings. So what is Article 12? Article 12 defines the term state for the purposes of Part 3 fundamental rights of the Indian Constitution. It gives a very wide and inclusive interpretation to the state so that fundamental rights can be effectively enforced against all the agencies exercising government power. So Article 12, it defines what actually constitutes the state. So it gives a very wide and broad or inclusive interpretation of the state so that fundamental rights can be enforced by all the agencies or against all the agencies exercising the government power. So who is included in the term state? So under Article 12, the state includes all of the following, that is the union government, that is the government and parliament of India, both Lok Sabha and Rajya Sabha. So the executive and legislature or legislative organs of the at the center, and state governments. Okay, the governments and legislature of each state, executive and legislative organs of all the states, and local authorities, that is municipalities, panchayats, district boards, improvement trusts within India, and other authorities, that is it includes both statutory and non-statutory bodies under the control of the government of India. So fundamental rights are enshrined in the Constitution Part 3, Article 12 to 35. So Article 12 defines the term states for the purpose of fundamental rights. So what it includes? It includes all the following, that is the union governments, that is the government and legislature at the of India, that is the executive and legislative organs at the center, the state governments, that is the government and legislatures of each state, executive and legislative organs of all the states, and local authorities, that is municipalities, panchayats, district boards, improvement trusts within India. And it also includes other authorities. Other authorities, that is, it is a very vague term, so it includes both statutory and non-statutory bodies under the control of the government of India. So, are public sector undertakings included? Yes, public sector undertakings are also included as states, that is the bodies performing public functions or under deep government control are included under Article 12, that is LIC, Life Insurance Corporation, ONGC, Oil and Natural Gas Corporation, SAIL, Steel Authority of India, and BHEL, Bharat Heavy Electronics Electricals Limited, and Indian Oil Corporation Limited, IOCL. So it includes both statutory bodies, government companies and agencies performing the functions are all covered. So performing the public functions are all covered. So there is statutory bodies, government companies and agencies performing public functions are all covered. So what are the key features of Article 12? So it is wide and comprehensive definition. So Article 12 defines the term state for the purposes of fundamental rights. So it is very wide and inclusive. That is a comprehensive definition that is covers not only traditional government organs but also all its instrumentalities and agencies. That is all those agencies which works as the instruments of the government. And it includes both executive and legislative organs, that is it applies to both executive and legislative actions of the union government and the state government. And private bodies can qualify. Yes, private bodies can qualify, even a private body can be a state if acting as an instrumentality or agency of the government. So if a private agency works as an instrument of the state, then it also is considered as a state, or agency which works for the government also is considered as state. So the Supreme Court has come up with a functionality test. That is, the Supreme Court has established a functionality test to determine if a body qualifies as a state under Article 12. So criteria 1, public function. If a body performs a public functions, then it is included under the state. And criteria 2, whether the body has deep and persuasive control. So if either or both criterions are met, that is whether if it performs a public function or it has deep and persuasive control of the government, if either or both conditions are met, the body can be treated as state and made accountable for fundamental rights violation. So if the fundamental rights are violated by these agencies, then they can be made accountable. So either if an agency satisfies the condition 1, criterion 1, either 1 or 2 or both, then they can be treated as state and held accountable for violation of fundamental rights. So scope of application, That is, Article 12 applies to fundamental rights. Part 3, Part 4, Directive Principles of the State Policy, Relevant Context, and writ jurisdiction under Article 32 and writ jurisdiction under Article 226. That is, when the fundamental rights of an individual are violated, they can approach the Supreme Court under Article 32, that is writ jurisdiction of the Supreme Court, and Article 226, writ jurisdiction of the High Court. That is, the courts can issue writs, orders, or directions for the enforcement of fundamental rights. So, where this Article 12 does not apply, it does not apply to other parts of the Constitution unless specifically mentioned, and private entities with no governmental control and privatized companies after disinvestment, they do not come under the definition of the state, and purely commercial entities with no public function, they do not come under the definition of the state. So, purely commercial entities with no public function, privatized companies after disinvestment, and private entities with no governmental control and other part of the Constitution unless mentioned. So, the definition of the state does not apply to all this. So, the recent landmark judgment of the Supreme Court in Air India Limited versus Cabin Crew 2024, the Supreme Court's ruling on 16th May 2024, a bench of Justice B.R. Gavai, Chief Justice, or bench of Justices B.R. Gavai and Sandeep Mehta delivered a landmark judgment on the state status of Air India after privatization. So, Air India has been privatized. So, the judges, they have given a judgment on the status of the state, whether Air India comes under the definition of the state. In that landmark judgment, Air India Limited versus Cabin Crew 2024. So, the cabin crew, they filed writ petitions alleging stagnations in their career or stagnation in their pay, non-promotion, claiming violation of their fundamental rights against Air India. So, the Supreme Court held that Air India ceased to be a state after its disinvestment and takeover by Tata Group in January 2022. So, the outcome, the writ petitions cannot be filed in the Supreme Court or cannot be filed against Air India anymore, either in Supreme Court or High Court, and it is not amenable to writ jurisdictions under Article 32 and Article 226. So, since the Air India is privatized and it is taken over by Tata Group, it ceased to be a state. It does not come under the definition of the state. So, writ petitions cannot be filed against Air India anymore, and it is not amenable to writ jurisdiction under Article 32 and Article 226. So, significance of Air India judgment, that is loss of state character by Air India and private entity status has been given to Air India, and no fundamental right writs, that is writs cannot be enforced for the violation of fundamental rights against Air India. So, the ruling has wide implications for all privatized entities in India. That is, once disinvested, they can no longer be subject to the rigors of fundamental rights enforcement through writ petitions. After disinvestment, citizens cannot approach the Supreme Court under Article 32 and High Court under Article 226 against such entities for fundamental rights violation. So, the judgment has wide implications for all privatized entities in India. That is, once disinvested, they are no longer subject to the rigors of the fundamental rights enforcement through writ jurisdiction. That is, after disinvestment, citizens cannot approach the Supreme Court under Article 32 or High Court under Article 226 against the entities for fundamental rights violation. So, why Article 12 matters? That is, it expands the judicial review. That is, it expands the scope of judicial review to cover all agencies exercising governmental power and not just traditional governmental bodies, and it protects citizens. Citizens can directly approach the Supreme Court under Article 32 and High Courts under Article 226 Directly approach, not by the way of appeal not by the way of appeal. Approach the Supreme Court not by the way of appeal, Article 32, and High Courts, Article 226, against the state entity violating the fundamental right, and it ensures accountability, that is, the governmental power, even when exercised through corporations, boards, or authorities, that is, private entities, remains accountable to constitutional limitations. So, Article 12 is the gateway to the fundamental rights. Without its definition or its wide definition of state, the rights guaranteed in Part 3 would remain hollow and unenforceable against the powerful governmental agencies. So, Article 12 is the gateway to the fundamental rights, that is, without its wider definition of states, the rights guaranteed under Article 3, the rights guaranteed under Fundamental Rights Part 3, they remain hollow and unenforceable against powerful governmental agencies. So, Article 37 of the Directive Principles. Next topic, Article 37 of the Directive Principles of the State Policy. This article is the conscience of the Indian Constitution. So, Directive Principles of the State Policy are enshrined in Part 4, Article 36 to 51. So, what is Article 37? Article 37, that is, these principles are, it is the duty of these principles are fundamental in the governance of the country, and it is the duty of the state to implement these principles in the formulation of policies and programs. So, Article 37, the provision contained in this part shall not be enforceable by any court. Means it is not justiciable, but still the principles therein laid down are nevertheless fundamental. These principles are fundamental in the governance of the country, and it shall be the duty of the state to implement these principles in formulation of the policy and implementation of the program. So, Article 37, though, that is, the provisions of this part are not enforceable by the court, but these principles therein laid down are nevertheless fundamental in the governance of the country. They are non-justiciable, that is, they cannot be enforced by the court of law for their violation, and fundamental, that is, these principles are fundamental in the governance of the country, that is, though they are non-justiciable, that is, they are not enforceable by the court of law, they are fundamental, essential in the governance of the nation, and it is the duty of the state to apply these principles in making laws. That is Article 37. Non-justiciable, key facts. So, what non-justiciable means? The directive principles of the state policy cannot be enforced by the court of law. No citizen can approach the Supreme Court or High Court for the violation of, or for the direct enforcement. That is, they cannot be enforced. And important clarification, the non-justiciability of the directive principles of the state policy was not a rigid stand of the Supreme Court, but it was a deliberate and conscious decision of the framers of the Constitution. A pragmatic choice, not a legal limitation. So, our framers of the Constitution, they made a deliberate and conscious decision to make the directive principles of the state policy non-justiciable. So, it was not a rigid stand of the Supreme Court. It is a pragmatic choice, not a legal limitation. So, why were the directive principles of the state policy made non-justiciable? So, the constitutional makers, they faced practical realities at the time of the independence that made immediate enforcement impossible. So, lack of financial resources, that is, the newly independent country lacked sufficient funds to implement all the principles immediately, and vast diversity and backwardness. The India's immense social, economic and regional diversity made uniform implementation of directive principles of the state policy extremely difficult, and overburdening the new state, that is, the infant or the newly independent Indian state faced many problems like partition, rehabilitation and integration of princely states, legally enforceable duties would have been crushing. That is, it would have overburdened the newly independent state. So, these are the reasons why the framers of the constitution made the directive principles of the state policy non-justiciable. That is because of the practical realities at the time of independence that made immediate enforcement impossible. So, lack of financial resources, vast diversity and backwardness, and overburdening the new state. So, the framers' vision, that is the makers of the Indian Constitution, their vision, that is the framers took a pragmatic view. They believed that awakened public opinion would be better sanctioned than the court's procedures by making it non-justiciable, and the political pressure would drive implementation more effectively. That is Article 37. That is, these principles are fundamental in the governance of the country, and it is the duty of the state to implement these principles, use these principles or implement these principles in the formation of the policy. So, political pressure would drive implementation more effectively, and the state should implement principles gradually according to its capacity and priorities. So, since India was a newly independent state, in infant new state, so it should implement it gradually, that is according to its capacity and priorities. Immediate implementation would have overburdened it. So, this is the framers' vision. And directive principles of the state policy, the big picture, that is location in the constitution. Yes, they are enshrined in the constitution, part of the original constitution, part 4, article 36 to 51, and the main objective is to realize the ideals of the preamble: socio-economic and political justice, and it is the conscience of the constitution together with the fundamental rights, called the conscience of the constitution by Granville Austin. And what is the goal of the directive principles of the state policy? To build socio-economic welfare state, that is social and economic democracy. Objective. So, classification of directive principles of the state policy. The constitution does not contain the classification of the directive principles of the state policy. So, for our convenience, we have classified the directive principles of the state policy into socialistic principles, socialistic economic principles, the Gandhian principles, liberal intellectual principles, including the international peace. So, directive principles of the state policy are broadly classified into 3 for easy understanding and implementation. The constitution does not contain the classification, so it is for our convenience that we have classified. So, socio-economic principles, social and economic principles, that is, they are socialistic in nature, aimed at promoting the welfare and reducing inequalities. Adequate means of livelihood for men and women, prevent exploitation of children and youth, prevent concentration of wealth in the hands of few, and right to work, education and public assistance in the event of unemployment, old age and sickness, equal pay for equal work for men and women, and maternity relief and human conditions of work, Article 42, and secure healthy working conditions and protect workers, early childhood care and education for children till the age of 6 years, and Gandhian principles based on the ideals and philosophy of Mahatma Gandhi. That is Article 40, village panchayats, organize village panchayats as units of self-government, cottage industries, Article 40, promote cottage industries in rural areas on individual or corporate basis. Prohibition, Article 47, that is prohibit consumption of intoxicating drinks and drugs injurious to health. Cattle protection, Article 48, preserve cattle breeds and prohibit slaughter of calves, milch animals. And the liberal intellectual, Article 44, uniform civil code, promotion of uniform civil code throughout India. Article 49, protect monuments of historical importance, that is protect historical monuments of artistic or historical importance, Article 49. And Article 48, protect and improvement environment, forests and wildlife. And Article 39, equal justice and free legal aid, provide free equal legal aid to ensure justice is not denied due to economic disabilities. So, international peace and security, Article 51, that is promotion of international peace and security, maintain just and honorable relations between nations and foster respect for international law and treaty obligations, encourage settlement of disputes by arbitration. So, together, directive principles of the state policy and fundamental rights, they form the conscience of the Indian Constitution, guiding India towards a just and equitable welfare state according to Granville Austin. And the next topic, that is the fundamental duties in the Indian Constitution, a comprehensive guide for UPSC 2026, that is understanding the Article 51A, its history and contemporary relevance. So, the historical background. So, the historical background, whether fundamental duties were part of the original constitution? No. So, 4950, original constitution adopted and original constitution contained the provisions of fundamental rights, part 3, article 12 to 35, and directive principles of the state policy, but not fundamental duties. And 1975 to 1977, that is internal emergency period, there was a strong need felt for balance rights or with responsibilities. So, a strong need was felt to balance rights with responsibilities. So, the government, it established, it constituted Swaran Singh Committee in 1976. Swaran Singh Committee was set up by the Congress government to recommend the inclusion of fundamental duties. That is, during the internal emergency, a strong need was felt to balance the rights with responsibilities. So, in 1976, the government, the Congress government, it appointed Swaran Singh Committee to recommend the inclusion of fundamental duties. So, the fundamental duties were added to the Constitution by 42nd Constitutional Amendment Act 1976. That is, they inserted the fundamental duties, part 4A, and a single article, Article 51A, with 10 fundamental duties. And 86th Constitutional Amendment Act 2002, which introduced Article 21A, that is, right to free and compulsory education for all the children in the age group of 6 to 14 years. So, it not only added a fundamental right, changed the subject matter of directive principles of the state policy, Article 45, but also introduced or added 11th fundamental duty related to providing education to children in the age group of, that is, parents and guardians. They should provide opportunities for the education to the children in the age group of 6 to 14 years. So, what are fundamental duties? Fundamental duties, the core definition. Fundamental duties are the basic moral and civic responsibilities of every Indian citizen, a reminder that rights come with obligations and they serve to promote discipline and patriotism, unity, that is national unity and integrity, responsible citizenship, and environmental consciousness. So, fundamental duties are the basic moral compass or basic moral and civic responsibility of every Indian citizen, a reminder that rights come with obligations, that is responsibilities, and they serve to promote not only discipline and patriotism but also national unity, integrity, responsible citizenship, and environmental consciousness. So, part 4A, the constitutional. So, where are the fundamental rights enshrined in the Constitution? Part 4A and Article 51A, the specific article, single article listing all 10 duties, and the 11th duty was added by 86th Constitutional Amendment Act 2002. So, total duties 10 in 1946 by 42nd Constitutional Amendment Act on the recommendations of Swaran Singh Committee, and another duty, 11th duty, was added by 86th Constitutional Amendment Act 2002. So, fundamental duties regarding nation and freedom, that is, for the respect the Constitution, that is, abide by the Constitution and respect its ideals, institutions, and the national flag and national anthem. The Second fundamental duty, that is to cherish freedom ideals, that is follow the noble ideals that inspired our national struggle for independence or freedom. Third duty, to protect the sovereignty, to uphold and protect the sovereignty, unity and integrity of India. And the next duty is to defend the country, and to render national service when called upon. Fundamental duty 5, to promote harmony, to promote brotherhood, transcending religious, linguistic and regional diversities, and to renounce practices derogatory to the dignity of women, and to preserve heritage, to value and preserve the rich heritage of our composite culture, and to protect environment, that is to protect and improve natural environment like forests, lakes, rivers, wildlife, and have compassion for living creatures, and scientific temper, to develop scientific temper, humanism, and a spirit of inquiry and reform. Fundamental duties 9 and 11, that is property, excellence, and education, that is public property, that is to safeguard public property and abjure violence in all forms, to strive towards excellence in all fields or all spheres of individual, not only individual but also collective activity, so that the nation rises towards or rises to a higher levels of achievement. And duty 11, to provide opportunities, that is the 11th duty was added by 86th Constitutional Amendment Act 2002, to provide opportunities for the education of children between the age of 6 to 14 years, added by 86th Constitutional Amendment Act 2002. So the duty 11 is directly linked to right to education, that is Article 21A, a critical connection for UPSC prelims. So key features of fundamental duties. So are the fundamental duties justifiable? No, they are non-justifiable, that is cannot be directly enforced by the court of law, similar in nature to the directive principles of the state policy. They are adjuncts to the directive principles of the state policy. Directive principles of the state policy are enshrined in Part 4, Article 36 to 51, whereas fundamental rights are enshrined in the Constitution, Part 4A, Article 51A, a single article. So, like the directive principles of the state policy, they are non-justiciable, that is cannot be directly enforced by the court of law. And judicial interpretation tool, that is the Supreme Court uses the fundamental duties to interpret laws and test the reasonableness of restrictions on fundamental rights. So fundamental rights are not absolute, they are justiciable or they are qualified. That is, the fundamental rights, reasonable restrictions can be imposed on the fundamental rights by the state. So the Supreme Court uses the fundamental duties to interpret the laws and to test the reasonable restrictions on fundamental rights. So any law, if it gives effect to any of the fundamental duties, then the law shall not be declared null and void. So the Parliament can enforce. The Parliament can enforce fundamental duties by enacting a law. That is, the Parliament can enact a law or enact laws to enforce fundamental duties and also to prescribe penalties for violation. So an example, that is enforcement law, that is Prevention of Insults to National Honors Act 1971, that is penalizes disrespect to national flag and national anthem, the fundamental duty 1. So the fundamental duties are available to only citizens or they are available to foreigners? No. Fundamental rights are only available to citizens, only for citizens, apply only to Indian citizens. Foreigners are not bound by these duties and moral obligations. These fundamental duties are moral obligations, that is, they serve as moral compass, reminding the citizens of their obligations. That is, they not only enjoy rights, but they have the corresponding responsibilities, that is duties, obligations to the nation, society and environment. So current affairs 25-26. So the Constitution Day, November 26, every year, 26 November 1949, the Constitution was adopted by the Constituent Assembly and it came into force on January 26, 1950. So the Constitution Day 2025, the Prime Minister urged citizens to uphold the fundamental duties, emphasizing democracy, patriotism and balancing rights with responsibilities. And Supreme Court 2025, that is the Supreme Court ruled in 2025, that is the Attorney General in Supreme Court 2025, R. Venkataramani, stressed the need for duty-specific legislation and continuous supervision of Article 51A compliance. And the Great Indian Bustard Judgment, the Supreme Court ruled that corporations have a fundamental duties to protect the environment, expanding the corporate social responsibility to include constitutional obligations under Article 51A, Clause G, and National Education Policy 2020 link, that is, the National Education Policy integrates the fundamental duties, especially the education duty and the scientific temper into the school curricula. So, these are all the current affairs regarding to the fundamental duties. So, with regarding to the UPSC CSE 2026 exam strategy, key focus points for 2026, 42nd Constitutional Amendment Act 1976, Sardar Swaran Singh Committee recommendations, and 86th Constitutional Amendment Act, the 11th fundamental duty was added on education and non-justiciable nature of the fundamental duties versus parliamentary power to enforce them through legislation, and Supreme Court judgments, that is the Prime Minister and Attorney General calls on effectuation of duties and linkage between fundamental rights, environmental education and national symbols. So the high weightage areas, that is statement based questions on Article 51A, matching duties to their descriptions, assertion reason type questions, amendment based questions, 42nd and 86th Constitutional Amendment Act. So quick revision for summary. The original constitution which came into force, or the original constitution, was adopted by the Constituent Assembly on 26 November 1949. No fundamental rights in the original text. No fundamental duties in the original text. So fundamental duties were added by 42nd Constitutional Amendment Act, or included or inserted by 42nd Constitutional Amendment Act 1976. Part 4A, 10 duties under Article 51A, single article. So 86th Constitutional Amendment Act 2002 added the 11th duty on child education, that is 6 to 14 years, right to free and compulsory education for all the children in age group of 6 to 14 years. So total 11 duties currently listed under Article 51A of the Constitution. So fundamental duties are non-justiciable, but the Parliament can legislate to enforce them. They apply only to Indians or Indian citizens, and the Supreme Court increasingly uses them as an interpretative tool, that is to interpret laws and also to test the reasonableness of the restrictions on fundamental rights. So Article 46 and Article 16, that is protection of weaker sections, a deep dive into constitutional provisions for social justice, equality and inclusive developments in India. So let us try to understand Article 46 and Article 16. So the two pillars of protection of weaker sections. Article 46 is a part, Article 46 is a part of Directive Principles of the State Policy, Part 4, and it is Directive Principles of the State Policy are non-justiciable. Those are moral obligations on the state. And Article 16, part of fundamental rights, that is enshrined in the Constitution, Part 3, and it is justiciable, that is legally enforceable right for their violation. So together these articles form the constitutional backbone for protecting the scheduled castes, scheduled tribes and other weaker sections of the society. So this is Article 46 and Article 16. 46 part of Directive Principles of the State Policy, they are moral obligation. Article 16 fundamental rights and they are legally enforceable. So these form the constitutional backbone for protecting the rights of scheduled caste, scheduled tribe and other weaker sections of the society. So Article 46 Directive Principles of the State Policy, Part 4 DPSP Gandhian Directive Principles. So Article 46, it directs the state to promote educational and economic interests of scheduled castes, scheduled tribes and other weaker sections of the society. So protection from exploitation, it guards SCs, STs and weaker sections from social injustice and all forms of exploitation. And educational interest, to promote access to education for historically disadvantaged communities, and economic interests, to uplift the economic conditions of vulnerable groups through state action. So Article 46 directs the state to promote the educational and economic interest. Educational, to promote access to education for historically disadvantaged communities, and economic interest, to uplift the economic conditions of vulnerable groups through state action, that is interest of SC, STs and other weaker sections, that is to protect them from exploitation, guards SCs, STs and other weaker sections from social injustice and all forms of exploitation. So Article 16 of the fundamental right, that is Part 3 fundamental rights. So Article 16 guarantees equality of opportunity for all citizens in matters of public employment or appointment to any office under the state. So equality of opportunity in matters of public employment or appointment to any office under the state. So it guarantees equality of opportunities for all citizens in matters of public employment or appointment to any office under the state. So no citizen shall be discriminated against or made ineligible for any employment or office under the state on the grounds only of religion, race, caste, sex, descent, place of birth or residence. So no citizen shall be discriminated against or made ineligible for any employment or office under the state on the grounds only of religion, race, caste, sex, place of birth or descent, residence. So exceptions to Article 16. The Constitution provides for 4 important exceptions to the general rule of equality in public employment. So Article 16 provides equality of opportunity for all citizens in public employment. So there are 4 exceptions. What are the 4 exceptions? Residence as a requirement. The Parliament can prescribe any residence. So the Parliament may prescribe residence as a condition for certain employments under the state or local authority. So currently it is applicable only in the states of Andhra Pradesh and Telangana. And reservation for backward classes, that is the state can provide reservation for any backward class not adequately represented in the state service. Article 16.3, this is Article 16 clause 3, Article 16.4. So reservation for backward classes, that is the state can provide reservation for any backward class not adequately represented in state services. Article 16.4. And religious institutions, incumbent of an office in a religious or denominational institution may be required to belong to that particular religion or denomination. So religious denomination, an office in a religious denomination, that is incumbent of an office in a religious denomination or religious institution, may be required to belong to that particular religion or denomination. And EWS reservation, that is 10% up to 10% reservation for economically weaker sections added by 1 or 3rd Constitutional Amendment Act 2019. So these are the 4 exceptions to the general rule of equality. That is, Article 16 provides for equality of opportunity for all citizens in matters of public employment or any office under the state. So there are 4 exceptions. Article 16 clause 3, that is, Parliament can make a residence as a qualification for certain employments under the state, now currently applicable only in Telangana, Andhra Pradesh and Telangana, and Article 16 clause 3, and it can provide reservation for backward classes, that is, any backward class not adequately represented in the state services. The state can provide reservation. Article 16 clause 4, and religious institutions, that is, offices in the religious institution or denomination may require, that is, the incumbent to that office should be of that particular religious denomination or particular religion. And EWS reservation up to 10% reservation for economically weaker sections. This was added by 1 or 3rd Constitutional Amendment Act 2019. So comparison between Article 46 and Article 16, most frequently asked comparison in the UPSC prelims. So Article 46 of the Directive Principles of the State Policy, Article 16 of the Fundamental Rights. So enshrined in the Part 4 of the Constitution, Directive Principles of the State Policy, enshrined in Part 3, Fundamental Rights. And what is the nature? Directive Principles of the State Policy are not justiciable, whereas Fundamental Rights, Article 16 is justiciable. And enforceability, this is a moral obligation on the state. That is, it is the duty of the state, and these are legally enforceable. That is, the aggrieved person can approach the court for their violation. And beneficiaries under Article 46, SCs, STs and weaker section. Under Article 16, all citizens. And reservation, not the basis for reservation. So Article 46 is not the basis of reservation, but Article 64 is basis for SC and ST reservation. And the type of the Directive Principles of the State Policy, it is a Gandhian principle, and here it is equality. Article 16, Article 14 to 18, right to equality. So it is a equality right. So the reservation for SCs and STs in public employment is under Article 16 clause 4, a fundamental rights, and it is not Article 46, Directive Principles of the State Policy. So 1 or 3rd Constitutional Amendment Act 2019 provided for EWS reservation, that is the 2019th Amendment, Article 16. So what was added? A new provision allowing the state to provide up to 10% reservation in appointments for economically weaker sections of its citizens. So key features added by 1 or 3rd Constitutional Amendment Act 2019, and it is separate from the existing SC, ST and OBC reservation, and it is separate from the existing SC, ST and OBC reservation and based on economic criteria, not based on caste, and applies to both appointments and admissions. So this is regarding 1 or 3rd Constitutional Amendment Act, that is EWS reservation, and the Gandhian principles under the DPSPs. So Gandhian principles reflect Mahatma Gandhi's vision for self-reliant, just and equitable India. So Article 40, village panchayats, that is to organize village panchayats as units of self-government. Article 43, to promote cottage industries in the rural areas, and Article 43B, cooperative societies, 97th Constitutional Amendment Act 2011, promotion of cooperative societies added by 97th Constitutional Amendment Act 2011, and Article 46, to promote educational and economic interests of SCs, STs and weaker sections, and Article 47, to improve public health and prohibit intoxicating drinks and drugs. Article 48, prohibit slaughter of cows, calves and their milch and drought cattle. So the Gandhian principles of Directive Principles of the State Policy, Article 40, village panchayats, 43, cottage industries, 43B, cooperative societies, And Article 46, educational and economic interests of SCs, STs and weaker sections. 47, improve public health and prohibit intoxicating drinks and drugs. 48, prohibit slaughter of cows, calves and other milch and drought cattle. So UPSC preliminary 2026. So the key value topics are fundamental rights versus directive principles of the state policy comparison, a direct comparison between Article 46, directive principles of the state policy, moral obligation. Article 16, fundamental rights, legally enforceable, is a favorite prelims topic. And SC/ST reservation source frequently tested is reservation for SCs and STs under fundamental rights or directive principles of the state policy. So it is Article 16, Clause 4, a fundamental right, reservation for SCs and STs. And 103rd Constitutional Amendment Act provides for 10% EWS reservation. And year Article 2009, year Article 16, and its distinction from reservations are commonly tested, and justiciable and non-justiciable. So understanding the difference between enforceable fundamental rights and non-enforceable directive principles of the state policy is essential. And the key takeaways, remember the points to remember for the exam, that is 46, directive principles of the state policy. It guides the state to protect and promote the interests of the weaker section. Non-enforceable, moral obligation only. Article 16, Clause 4 of the fundamental rights, it empowers the state to provide reservation in public services for backward classes, including SCs and STs. Enforceable fundamental right. And the conscience of the Constitution, both fundamental rights and directive principles of the state policy together are described as conscience of the Constitution by Granville Austin, and the directive principles of the state policy are enumerated in Article 36 to 51. Along with the fundamental rights, they constitute the philosophy and the soul of the Indian Constitution. The Controller and Auditor General of India, the guardian of the public purse and India's supreme audit institution. So, the Controller and Auditor General of India, constitutional provision, the Constitution Article 148 establishes the independent office of the Controller and Auditor General of India. And the Controller and Auditor General of India is the head of which department? He is the head of the Indian Audit and Accounts Department, and he plays a guardian role, that he audits the entire financial system at both union and state levels, and the core duty is to uphold the Constitution and laws in financial administration. So, the independence of the CAG, Controller and Auditor General of India. So, the Constitution provides 4 powerful safeguards to ensure complete independence of the office of the Controller and Auditor General. So, the first safeguard is regarding the appointment, that is the Controller and Auditor General is appointed by the President of India. So, the CAG, Controller and Auditor General, is directly appointed by the President of India, ensuring the highest level of constitutional authority. And removal, another safeguard, removal. The CAG, Controller and Auditor General, is removed or can only be removed on the same grounds and in the same manner as the Judge of the Supreme Court of India. So, can only be removed on the grounds of proved misbehavior and incapacity through the process of impeachment. So, on the same grounds, that is proved misbehavior or incapacity, and in the same manner, that is impeachment, as that of the Supreme Court judge, or same as that of the Supreme Court judge. And the third safeguard is regarding the salary of the Controller and Auditor General of India. So, the salary and expenses of the office of the Controller and Auditor General are charged on the Consolidated Fund of India, and it is not subject to the vote of the Parliament, and no post-retirement office. That is, after retirement, the Controller and Auditor General is not eligible for any further appointment or any further government office, preventing conflict of interest. So, these four powerful safeguards, they provide independence of the Controller Auditor General, that is complete independence in the function. So, the first one is appointment, directly appointed by the President, and the second one, removed on the same grounds and in the same manner as that of the Judge of the Supreme Court, that is by on the grounds of proved misbehavior and incapacity and through the process of impeachment. And the salary and expenses of the Controller and Auditor General are charged on the Consolidated Fund of India, that is, they are not subject to the vote of the Parliament. And the post-retirement, that is, no post-retirement office, that is, after retirement, the CAG is not eligible for any further appointment or any further government office, preventing conflict of interest. So, what are the key constitutional articles? That is, Article 148. It establishes the office of the Controller and Auditor General of India. Article 149. It deals with the duties and powers of the C&AG. And Article 150. That is the form of accounts of the Union and states. So, the form of accounts and the Union and states are maintained as prescribed by the President of India based on the advice of the Controller and Auditor General of India. And Article 151, the audit reports of the Controller and Auditor General, that is, it is regarding the audit reports, that is submission and tabling of the audit reports before the Parliament. So, these are the key constitutional articles. So, organizations subject to the CAG audit. So, what are the organizations which are subject to the CAG audit? That is, union and state departments, railways, defense, post, telecommunications, and all government departments. And public enterprises are also subject to the CAG audit, that is approximately 1500 public enterprises, that is government companies and corporations under union or state governments. And what about autonomous bodies? Yes, they are subject to the C&AG audit, that is approximately 400 autonomous bodies, that is non-commercial bodies owned and substantially financed by the union or states. So, autonomous bodies are also subject to the C&AG audit, and local bodies and Panchayat Raj institutions. So, Panchayat Raj institutions substantially financed by the union and state governments are also subject to the audit, C&AG audit. So, union and state departments, around 1500 public enterprises, around 400 autonomous bodies, and local bodies and PRIs are subject to the audit of the CAG. So, what are the types of audits performed by the Controller and Auditor General? So, three types of audits performed mainly by the Controller and Auditor General. Compliance audit, that is to check the compliance of the expenditure, receipts, liabilities, etc. With whether they follow the rules, regulations and laws. So, compliance audit checks whether the rules, regulations and laws have been followed. And financial attest audit, that is, it certifies the accuracy and completeness of the financial statements of appropriation accounts and finance accounts. And performance audit, it evaluates the performance of the programs and schemes to ensure that the objectives have been met. That is, it evaluates 3 E's, that is economy, efficiency and effectiveness of the government programs. So, the Controller and Auditor General, he performs 3 types of audits, that is compliance audit, compliance with the rules, regular transactions, whether they are in compliance, the government transactions or the transactions, whether they are in compliance with the rules, regulations and laws. Financial attest audit, that is it certifies the accuracy and correctness of the financial statements of the appropriation accounts, financial accounts, finance accounts, and performance audit whether the programs and schemes they have achieved the objectives. That is, it evaluates the economy, effectiveness, efficiency, effectiveness of government programs. So, the CAG also conducts specialized audits on information technology systems and environmental issues, expanding its oversight into modern government challenges. So, the C&AG also conducts specialized audits with regarding to information technology systems and environmental issues and expanding its oversight into modern governance challenges. So, the audit reports of the CAG. So, there are three major audit reports of the CAG. That is, the CAG submits three key reports for the union government. That is the audit report on appropriation account, audit report on finance accounts, and audit report on public sector undertakings. So, these are the three key reports for the union government. That is, audit report on appropriation accounts. That is, it compares the actual expenditure with the amount sanctioned by the Parliament through the Appropriation Act. And audit report on finance accounts, that is, it shows the annual receipts and disbursements of the union government. And the audit report on public undertakings covers the performance and finances of public sector undertakings. So, the C&AG, he performs three major audit reports. He submits three major audit reports to the union government. That is, audit report on appropriation account, audit report on financial accounts, and audit report on public sector undertaking. Audit report on appropriation accounts, it compares the expenditure with the amount sanctioned by the Parliament through the Appropriation Act. Audit report on financial accounts, it shows the annual receipts and disbursements of the union government. Audit report on public undertakings covers the performance and finances of public sector undertakings. So, submissions and tabling of the reports. So, the C&AG submits the reports to the President of the union government, and the reports with regarding to the state government to the governor, and the President or the governor lays the reports of the Comptroller Auditor General before the legislature, that is the President before the Parliament and the Governor before the state legislature, and it is referred to the Public Accounts Committee or Committee on Public Sector Undertakings. So, the reports are submitted to the President, Union with regarding to Union, Governor with regard to the states, who then cause them to be laid before the respective legislatures, automatically triggering referral to Public Accounts Committee or Committee on Public Sector Undertakings. The reports do not go to the Central or Cabinet Secretariat. They are examined exclusively by the Public Accounts Committee and Committee on Public Sector Undertakings. So, role of Public Accounts Committee and Committee on Public Sector Undertakings. So, Public Accounts Committee is a standing committee of the Parliament and state legislatures that scrutinizes the CAG's audit reports on government's accounts and expenditure. So, the reports of the C&AG are scrutinized by the Public Accounts Committee. So, what these committees do, they select important findings from the C&AG reports for detailed scrutiny. They conduct hearing where executive officers explain their actions. They receive technical assistance from CAG. That is, The CAG is the friend, philosopher and guide of the Public Accounts Committee. So they receive technical assistance from the CAG and submit their reports. The Public Accounts Committee submits the reports to the legislature with observation and recommendations, and it recommends improvements in administrative practices. So this is the role of Public Accounts Committee. And quick revision or summary. So the constitutional basis: Controller and Auditor General of India, Article 148, independent office appointed by the 148, 149, 150, 151, independent office appointed by the President. Independence is removed like on the same grounds and in the same manner as the judge of the Supreme Court, and the salary charged and expenses are charged on the Consolidated Fund of India, that is, they are not subject to the vote of the Parliament. And no post-retirement office, that is, after retirement he cannot hold any office under the Government of India. So audit scope: union and state departments, approximately around 1500 enterprises and approximately 400 autonomous bodies, Panchayat Raj institutions. And audit type: compliance audit, financial assent audit, performance audit, and IT and environment audits. 3 reports: appropriation accounts, finance accounts, and accounts on public sector undertakings. And submission part: the CAG submits the reports of the union to the President and state to the Governor, and they cause the reports to be laid before the Parliament or state legislatures, and it is exclusively considered by the Public Accounts Committee and Committee on Public Sector Undertakings. And the key and the reports, they do not go to the Cabinet Secretariat, they only go to the Public Accounts Committee and Committee on Public Sector Undertakings. Next topic: registration of political parties in India, that is, registration and recognition of the political parties in India. So how the Election Commission of India, Article 324, how the Election Commission of India shapes the landscape of political partition, Election Commission of India, and Representation of the People's Act 1951. So, role of the Election Commission of India in registration and recognition of the political parties. So, Election Commission of India is a regulatory authority. Election Commission of India plays a crucial role in the registration and recognition of political parties across India, and the electoral impact. This process directly determines the privileges and facilities available to the parties during elections. So, the registration and recognition of the political parties by the Election Commission of India, which is the regulatory authority, in this process of registration and recognition, it directly determines the privileges and facilities that are available to the political parties during elections. And the legal framework, the registration and recognition is governed by Section 29A of Representation of the People's Act 1951. So, registration of political parties. So, the key facts: the Indian Constitution does not mandate. So, there is no provision in the Constitution mandating the registration of political parties with the Election Commission of India. So, the registration is entirely voluntary. It is taken up by the party. It is up to the party whether to register or not. So, the registration of the political parties is voluntary. That is, it is up to the political party whether to register or not, and there is no provision of the Constitution with regarding to the mandatory registration of the political party with the Election Commission of India. So, what happens after registration? The party comes after registration. The party comes on the regulatory framework of the Election Commission of India for the electoral purposes, and the registration is done under Section 29A of the Representation of the People's Act 1951, and the registered parties, they gain access to the privileges, or they gain access to the registration criteria and associated privileges. So, after registration, the parties come, the registration is voluntary. no constitutional provision, that is the constitution does not mandate the political parties to register with the Election Commission of India, and this is a completely entirely voluntary process, that is it is up to the political party to register. So after registration, what happens? That is the party which has registered comes under the regulatory framework of Election Commission of India for electoral purposes, and registration is done under section 29A of Representation of the People's Act 1951. So the registered parties gain access to the registration criteria and associated privileges. So types of party recognition, that is after recognition, the Election Commission of India classifies political parties into three categories based on the electoral performance. So based on the electoral performance, that is after registration, the Election Commission of India classifies the political parties into three categories based on electoral performance: national party, state party, and registered unrecognized party. So national party is recognized across the entire country, and it is the highest level of recognition with maximum privileges. State party recognized in specific states where they meet the electoral performance criteria, required electoral performance criteria, and registered with the Election Commission of India but not recognized. That is registered and unrecognized political party. They are registered with the Election Commission of India, but they do not meet the criteria for national or state party recognition. So as of now, that is as early as 2026, there are 6 national parties and around 58 or 60 state parties in India, and the number changes after every general election based on performance. So around 6 national party and around 60 state party. This number changes after every election. So what are the privileges of recognition? That is, there are some privileges to the recognized political parties. So what are the privileges? That is reserved party symbols, that is recognized parties, recognized as national party or state party. So recognized parties receive exclusively reserved symbols, that is national parties nationwide and state parties within their states. And media broadcast time, access to political broadcasts on Doordarshan and All India Radio state-owned platforms, and electoral roll access, that is recognized parties get direct access to the electoral rolls, significant operational advantage, and nomination is only one proposer needed for nomination or filing nomination papers compared to the 10 for unrecognized parties. So these are some of the privileges of recognition, that is reserved party symbols, that is exclusively reserved symbols, national parties nationwide and state parties within the state, media broadcast time, that is access to political broadcast on Doordarshan and All India Radio state-owned platforms, electoral roll access, that is registered parties have direct access to electoral rolls, a significant operational advantage, and nomination is only one proposer for filing nomination papers compared to 10 for unrecognized parties. So another privilege, that is star campaigners, a key privilege. So the recognized parties can appoint star campaigners whose travel expenses are not counted in the election expenses of the party candidates. So the recognized parties, they appoint star campaigners whose travel expenses are not included in the election expenses of the party candidates. So 40 star campaigners, that is a national party can have up to 40 star campaigners are allowed, state party up to 40 campaigners allowed, and unrecognized party up to 20 star campaigners allowed. So the travel expenses of the star campaigner are excluded excluded from the total expenditure of candidates, a major financial advantage for recognized parties. So, star campaigner is a key privilege. That is, the political parties, recognized parties, they appoint star campaigners whose travel expenses are excluded from the candidate's election expenditure. Up to 40 star campaigners allowed for national party, up to 40 star campaigners allowed for state parties, and up to 20 star campaigners allowed for unrecognized parties. So, it is a major financial advantage for recognized parties. And another privilege is symbol allocation rules. So, symbol allocation rules, reserved symbols. National party symbol reserved exclusively for use throughout the entire country, and state parties symbols reserved exclusively for use in the states where recognized, and free symbols, that is registered unrecognized political parties may choose a symbol from the list of free symbols notified by the Election Commission of India, and Election Commission of India maintains two categories: reserved symbols for recognized parties, that is national parties, symbols reserved exclusively for use throughout the entire country; state parties, symbol reserved exclusively for use in the states where recognized. So, the Election Commission of India maintains two categories, that is reserved symbols for recognized parties and free symbols for other candidates. So, conditions for national party recognition. So, a party qualifies as a national party if it fulfills any one of the following condition. So, condition 1, votes plus seats, that is, if a political party secures at least 6% of valid votes in 4 or more states in a Lok Sabha or assembly election and wins at least 4 Lok Sabha seats from any state or states. So, condition 2, Lok Sabha seats, that is, a political party, if it wins at least 2% of the total Lok Sabha seats, that is 11 out of 543 seats from at least 3 different states. So, condition 2 is Lok Sabha seats, that is, if a political party wins at least 2% of total Lok Sabha seats, that is 11 out of 543 from at least 3 different states. And third condition is state recognition, that is already recognized as a state party in 4 or more states. So, a party qualifies as a national party if it fulfills any one of the following conditions. And conditions for state party recognition: a party is recognized as a state party in a particular state if it fulfills any one of the following conditions, that is assembly seats plus votes, secures 6% of valid votes in a state in an assembly election, and wins at least 2 seats in assembly, at least 2 assembly seats, or Lok Sabha seats, votes plus seats, that is secures 6% of valid votes in the state in a Lok Sabha election and win at least 1 Lok Sabha seat from that state, and assembly seat share wins at least 3% of total assembly seats in the state, or 3 seats whichever is higher, and Lok Sabha seat ratio, that is wins at least 1 Lok Sabha seat for every 25 seats or fraction thereof allotted to that state, and 8% vote share, that is in 2011 added in by Election Commission of India 2011, that is secures at least 8% of the total votes in the state in a Lok Sabha or assembly election. So, a party is recognized as a state party in a particular state if it fulfills any one of the following conditions. So, what are the key takeaways and important points? Dynamic recognition, that is a number of recognized and state parties. About dynamic recognition, that is the recognition keeps on changing after every election. So, the number of recognized national parties and state parties, they change after any general elections based on electoral performance. So, the recognition is based on electoral performance. And objective criteria, the Election Commission of India recognition is based purely on objective electoral performance, and no discretion of the Election Commission of India is involved, and fewer facilities for unrecognized parties, that is registered unrecognized parties have fewer facilities and must contest on free election symbols only, whereas national and state parties have exclusive symbols. And no internal election mandate. The Election Commission of India has no statutory mandate to conduct or supervise internal elections of political parties. Very important one. So, the Election Commission of India has no statutory mandate or to conduct or supervise internal elections of political parties. And Representation of the People's Act 1950 mainly deals with the delimitation of constituency and preparation of electoral rolls. It does not contain provisions regarding the internal or organizational elections of political parties. So, Representation of the People's Act 1950, it contains only provisions with regarding to the delimitation of constituencies and preparation of electoral rolls, but it does not contain provisions with regarding to the internal or organizational elections of political parties. So, currently as early as 2026, there are 6 national parties and around 58-60 state parties. Next topic is right to disconnect. So, the case for work-life balance in India, a deep dive into overwork culture, mental health, and the emerging legal framework shaping India's workforce future. So, the right to disconnect, that is, in India, there is overwork culture, mental stress and or mental health problem, and emerging legal. What is the emerging legal framework that is shaping India's workforce future? So, working conditions in India, women in white collar jobs, that is women in auditing, IT and media, often work more than 55 hours per week, among the highest globally. And IT and media sector, the average working hours reaching up to 56.5 hours per week in IT and media, a staggering burden on professionals and marginalized workers from marginalized sections in unrecognized sector face even more demanding and irregular hours. So, the burnout epidemic, the digital tools blurring boundaries, so emails, WhatsApp, messages and calls follow employees home, erasing the line between professional and personal life. The always on culture has made it nearly impossible for workers to truly rest and recover. So, the result is widespread burnout of the employees, that is, the constant connectivity through emails, WhatsApp messages and calls, that is, the digital tools are blurring the boundary between professional and personal life. The always on culture had made it nearly impossible for the workers to truly rest and recover. So, the result is the widespread burnout. The constant connectivity leads to chronic stress, exhaustion and declining mental health across India's workforce. So, burnout is no longer an exception. It has become the norm of millions of Indian professionals. So, what the data says, as per the ADP Research Institute People at Work survey, 49% of Indian workers say workplace stress negatively impacts their mental health. That is 49% of the Indian workers, they have mental health impact because of the workplace stress. That is, Indian workers say workplace stress negatively impacts their mental health. That is, it is affecting their mental health. That is, the stress at workplace is impacting their mental health. What percentage of Indians? 49%. And 76% work performance hit. That is, Indian workers say the stress at workplace adversely affects their work performance, the highest share globally. So, India ranks highest among all the countries surveyed for stress-related impact on work performance. This demands urgent action. So, what is right to disconnect? The right to disconnect is a legal entitlement of an employee, that is a legal right of an employee to not to engage with work-related communications outside the official working hours without facing any penalty or adverse consequence. So, the switch off after work, that is, the employees can fully disconnect from the emails, calls or messages after the working hours, on weekends or on holidays, and emergency exceptions. Employers may contact employees in genuine emergencies, but the employees are not obliged to respond. And overtime compensation, if employees choose to work beyond the working hours, they must be entitled to fair overtime compensation. So, right to disconnect is a legal entitlement of an employee not to engage with work-related communications outside the official working hours without facing any penalty or adverse consequences. So, the switch off after the work, that is, employees can fully disconnect from emails, calls and messages after working hours, on weekends and on holidays. And emergency exceptions, the employers may contact employees in genuine emergencies, but employees are not obliged to respond. And overtime compensation, that is, if employees choose to work beyond the working hours, they must be entitled to fair overtime compensation. So, benefits of right to disconnect, that is, better mental health, reduced anxiety, stress and burnout across the workforce, and boosted productivity because rested employees perform better and deliver high quality work, and the stronger family life, more time for personal relationships, caregiving and self-care, and also employee protection, legal safeguards against exploitation and constant availability pressures. So, these are the benefits of right to disconnect. So, legal foundation in India. So, is there any specific law in India with regarding to right to disconnect? No. India has no specific central law yet, but constitutional provisions may lay an implicit foundation. So, there are some constitutional provisions which lay an implicit foundation, but no central law yet. So, Parliament has not enacted a central law with regarding to right to disconnect, but constitutional provisions are there. Implicit constitutional provisions are there which lay a foundation. So, what are the constitutional articles? That is Article 38, social justice. The state shall promote the welfare of the people by securing social order based on justice. And Article 39 clause E, that is worker health. The state policy must secure the health and strength of the workers from exploitation. And Article 42, human conditions, just and human conditions, that is the state shall secure just and human conditions of work and maternity relief. And the Article 21, the important article, that is right to life and personal liberty, it includes the most inferred article in the Constitution, so it includes right to live with dignity, mental health, privacy and personal autonomy. Experts argue that right to disconnect flows naturally from Article 21. So, as of now, India does not have a central law, that is the Parliament has not yet enacted a law regarding right to disconnect, but there are constitutional provisions which lay implicit foundations. So, Article 38, social justice, that is, it is a duty of the state to promote welfare of the people by securing a social order based on justice. And Article 39 clause E, that is with regarding to the worker health, the state policy must secure health and strength of the workers from exploitation. And Article 42, just and human conditions or conditions for workers, that is the state shall secure just and human conditions of work and maternity relief. And finally, the important Article 21, right to life and personal liberty, that is experts argue that right to disconnect flows naturally from Article 21. Article 21 includes right to life with dignity, mental health, privacy and personal autonomy. So, right to disconnect bill 2025, right to disconnect bill 2025 was introduced by a private member, that is, it is a private member's bill in Lok Sabha. So, private member is a member of the Lok Sabha who is not a minister. So, in December 2025, NCP MP Supriya Sule introduced the right to disconnect bill in Lok Sabha, and this bill, it has gave statutory recognition to statutory right to ignore, that is right to disconnect, that is employees gain legal right to ignore work communications outside the agreed working hours, and no penalizations, that is the employees are or the employers are prohibited from penalizing the employees for exercising the right to ignore work communications outside the agreed working hours. And this right to ignore has been given a statutory recognition. And Employees Welfare Authority, that is a dedicated authority to be established for implementation and oversight and clear hours and overtime pay. That is, the companies or the management must define out of work hours and provide overtime pay, compensation for extra work. So, as of now, this remains a proposed bill and has not yet been enacted into a law. So, the private members bill, since it is not introduced by a minister or the government, so the chances of it being passed in the parliament are low. So, it is a proposed bill and not yet been enacted into a law. So, why India urgently needs this law? The 24/7 work culture problem, the rise of remote and hybrid work combined with smartphones has created an always on work with no clear boundaries, without legal protection, no clear professional and personal boundaries. So, without legal protection, employees face immense pressure to remain constantly available, harming mental health and family life, and its disproportionate impact on women. That is, the long working hours hit women the hardest. They often bear additional unpaid care work and domestic responsibilities at home, and legal protection is essential to ensure gender equity in the workplace and beyond. So, what are the legal precedents and path forward? So, several countries have already enacted right to disconnect laws with measurable positive outcomes. Countries like France, Italy, Portugal and Australia. So, in France, the pioneer since 2017, companies with 50 plus employees must negotiate disconnect policies, and Italy, right to disconnect enshrined for remote workers with clear legal protections, and Portugal, employers banned from contacting employees after hours with financial penalties, and Australia, employees have the legal right to refuse unreasonable out of hours contact since 2024, most recent. So India has the constitutional foundation, that is many constitutional provisions are there. Article 38, Article 39, Clause E, Article 42, Article 21. The data also, that is the ADP, that is the ADP Research Institute, Work People at Work Survey, that is 49% of Indian workers say workplace stress negatively impacts their mental health, and 76% of Indian workers say stress adversely affects their work performance, the highest share globally. So India not only has the constitutional foundation but also the data and the global examples also of France, Italy, Portugal and Australia. So the time is to act now. Enacting the right to disconnect will protect millions of workers and build a healthier and more protective workforce and nation. So the next topic is Delimitation Commission of India, understanding the process of redrawing India's electoral boundaries. So what is delimitation? Delimitation is the act of fixing limits or boundaries of electoral constituencies. Delimitation includes allocation of seats, that is seat determination, that is the fixing the number of seats in Lok Sabha and state legislative assemblies, and territorial readjustment of territorial constituencies, that is the boundaries redrawing territorial boundaries of parliamentary and assembly constituencies, and seat reservations, that is allocating seats to the scheduled caste and scheduled tribes. So delimitation exercise means allocation of seats to Lok Sabha and state legislative assemblies, readjustment of territorial constituencies of Lok Sabha and state legislative assemblies, and the allocation of seats reserved for SCs and STs. So delimitation exercise is carried out after every census to ensure each constituency has, as far as possible, equal population. So to ensure after each census there is increase in population. So after each census, in order to ensure that each constituency as far as possible has an equal population. So Delimitation Commission. What kind of a body is Delimitation Commission? Is it a constitutional body or a statutory body? So Delimitation Commission is a statutory body. Statutory body created by an act of the parliament and not a constitutional body. It is established by the central government under the provisions of Article 82 for Lok Sabha and Article 170 for state legislative assemblies. So what are the primary functions of Delimitation Commission? That is to demarcate the boundaries of parliamentary constituencies, to demarcate the boundaries of assembly constituencies, to readjust the allocation of seats across the country, both Lok Sabha and state legislative assemblies, and to further reservation of seats for SCs and STs, and it is set up after each census to reflect the updated population data. So what are the key features of the commission? That is, it is statutory, not constitutional, created by an act of the parliament. The constitution does not directly mention the commission, and the orders of the Delimitation Commission are final. That is, the orders of the Delimitation Commission cannot be questioned in any court of law. They carry the force of law, and presidential notification, that is, the orders of the Delimitation Commission come into force on a date specified by the President of India, that is through a presidential notification, and no modification of the Delimitation Commission order by the Parliament. That is, the orders are laid before Lok Sabha and state assemblies, but no modifications are permitted by the houses. So these are the key features of the commission. And what is the composition of the Delimitation Commission? That is the structure of the 4th Delimitation Commission 2002, that is chairperson. The chairperson is serving or retired judge of the Supreme Court of India, the chief election commissioner, or an election commissioner nominated by the chief election commissioner serves as an ex officio member, and the state election commissioner of the concerned state or union territory serves as an ex officio member. So, associate members, who are they? Each state has 10 associate members, that is 5 members of the parliament, Lok Sabha, elected from that state, and 5 members of the state legislative assembly. If the Lok Sabha seats from the state were fewer than 5, all such MPs become associated members, and these associate members are nominated by the Speaker of the Lok Sabha and Speaker of the State Legislative Assembly. And important limitation, that is, associate members do not have the voting right and cannot sign the final orders of the commission. They serve an advisory and consultative capacity only. So associate members, they serve on advisory and consultative capacity only, and associate members, they do not have the right to vote and cannot sign the orders of the final orders of the commission. They serve in an advisory and consultative capacity only. And 4 delimitation commissions in India. India has constituted 4 delimitation commissions. The first commission after 1951 sections, the 1952, the second commission after 1961 census, 62, and the third census after 1971 census, and the fourth commission after 2001 census. So each commission was tasked. So 4 times the delimitation commission exercise has happened, and each commission was tasked with redrawing the constitutional boundaries to reflect the updated population from the respective census and constitutional provisions, that is the key articles with regarding to delimitation in India. Article 81, the composition of the House of the People Lok Sabha. Article 82, readjustment of the seats in Lok Sabha after each census. And 170, composition of the state legislative assemblies. And Article 330, reservation of seats for scheduled castes and scheduled tribes in Lok Sabha. Article 332, reservation of seats for SCs and STs in state legislative assemblies. So this was amended. The Delimitation Commission was amended by 84th Constitutional Amendment Act 2001 and 87th Constitutional Amendment Act 2003. So the current freeze on delimitation, that is due to 84th Constitutional Amendment Act 2001 and 87th Constitutional Amendment Act 2003. So the delimitation is frozen until the first census after 2026. So the delimitation exercise was frozen by 84th and 87th Constitutional Amendment Act until first census after 2026. So the seat allocation of seats is frozen, that is the total seats in Lok Sabha and state assemblies fixed on the basis of 1971 census remain unaltered after 2026, and boundaries frozen, that is the constituency boundaries as delimited on the basis of 2001 census remain frozen until after 2020. So, allocation of seats in Lok Sabha and State Legislative Assembly frozen on the basis of 1971 census till what time? Until after 2026 census. And frozen of constituency boundaries are delimited on the basis of 2001 census and remain frozen until after 2026. And reservation of seats for SCs and SCs were readjusted on the basis of 2001 census. As according to 84th Constitutional Amendment Act, it has frozen the allocation of seats until after 2026 based on 1971 census, and the constituency boundaries were delimited on the basis of 2001 census and they remain frozen until after 2026 on the basis of 87th Constitutional Amendment Act. So this phrase was introduced to encourage population control and prevent states with higher population growth from gaining more political seats at the expense of the states that have successfully controlled their population. So, recent developments and what's next. The census 2026, the government of India is expected to conduct the long delayed census 2026 due to the COVID, and also the central government has delayed it, which will trigger the next delimitation exercise. So, delimitation exercise is carried out after each census. So, fresh delimitation exercise after the census, a fresh delimitation will redraw the territorial boundaries or the constituency boundaries and reallocations of the seats based on population figures. So, both reallocation of seats, that is allocation of seats to Lok Sabha and State Legislative Assemblies, and also readjustment of the territorial constituencies. And caste enumeration debate. There is an ongoing discussion on whether caste enumeration will also be included in the upcoming census 2026, and historical significance. This upcoming delimitation will be the first major readjustment since 1971 census freeze, making it by 84th Constitutional Amendment Act and making it one of the most significant electoral reforms in decades.